was necessary to fight off incursion has shown over history to be an asset to a nation, not a detriment. And I appreciate your bringing that issue up. And was there something that you were trying to get in your last moment of your statement that you'd like to?
Well, basically what I was trying to get in is that we have the largest militia in the world by those hunters that we have. So if we ever take away our guns in Connecticut, we're going to lose that militia. That's the only point I wanted to make. That militia will be gone if you take our guns away.
When you say militia, you're
hunters.
Right, and that's established under federal law that all able-bodied citizens between, I believe it's 18 and 45 are considered being militia under federal law. That's the militia you're talking about, right?
No, basically it's everybody that holds a hunting license throughout the country.
Or people who don't hunt also.
Correct. There's even more. So that's the point I wanted to make. We don't want to take our guns away because we'll be like Ukraine today.
Well, thank you very much.
Thank you.
Appreciate
Thank you very much, Senator.
Thank you both. Further questions or comments? If not, enjoy your answer. I went too quick. Sarah Egan, I skipped over. Sarah, there you are. I apologize for that.
Thank you. My Zoom was a little slow promoting me to panelists, that's all. Thank you very much. Senator Winfield, Representative Fishbein, Senator Kissel, Representative Staffstrom, and distinguished members of the Judiciary Committee. This testimony is submitted on behalf of the Office of the Child Advocate, the obligations of which are to review, investigate, and make recommendations regarding how publicly funded state and local systems meet the needs of vulnerable children, and also to investigate conditions of confinement for incarcerated youth aged 15 to 20. As a foundational matter, the OCA notes that several bills presented today address a concern about juvenile crime, in particular car thefts and violence associated with car thefts. I wanted to note that prior to the global pandemic, state shutdown in March 2020, juvenile crime had been overall trending downward in Connecticut for decades, and these downward trends continued during a decade plus of nation-leading reforms in our juvenile justice system. The uptick in crime seen in Connecticut in 2020 was part of a national and international trend during the same time period. Critically, the global pandemic led to unprecedented and abrupt changes in children's lives and services, the shutdown of schools, courts, in-person probation supervision, in-person community services, recreation, and even basic social interaction, jarring to all children and families, but particularly difficult for children and families already struggling with basic needs. As the pandemic continues into a third year, we are seeing with painful clarity the gaps in services that help children thrive and provide treatment where needed. As we wrestle to respond to what the Surgeon General has referred to as a nationwide mental health crisis, we must remember that justice-involved children, disproportionately Black, brown, and biracial, are also significantly affected by loss and trauma and in need of intensive re-engagement, reconnection, and support. Focusing on restoration and enhancement of services, supports, investing in children and communities will reap dividends for youth and communities. Too many children still worry for their families' basic needs, lack access to after-school programs, job training, mental health care, and substance use treatment. Enhancements to programs serving justice-involved children, children affected by urban trauma, and traditionally underserved children living in urban centers will be an essential component of the legislature's children mental health bills, laudably undertaken this session. Briefly on Bill 387, the OCA supports strongly the act concerning the recommendations of the JJPOC. We're members of this group, and the recommendations before you were overwhelmingly approved by JPOC membership. I also wanted to highlight that multiple bills, including 365 and 5418, recommend transferring more youth, including youth as young as 13, to the adult criminal justice system. OCA strongly opposes any proposal that increases the likelihood of young children being transferred to the adult system or that lower the age of transfer. Research over many years, conducted partly by the CDC and the U.S. Department of Justice, have made repeated findings that there's strong evidence that transfer of youth to the adult system leads to greater rates of subsequent violence than children who are retained in the juvenile system. OCA also urgently highlights two additional concerns. One is that the majority of children currently incarcerated in the adult correctional system in Connecticut are Black boys, a foundational and critical problem in our justice system that remains unresolved. And the second is that the only prison in Connecticut that confines boys, which is Manson Youth Institution, was only 3 months ago the subject of findings by the U.S. Department of Justice that conditions in the facility violate the U.S. Constitution, and no resolution to these findings has yet been determined. The Department of Justice completed its investigation.
Ms. Egan, we're past the 3-minute mark.
Okay, and then I will summarize and end just bringing the committee's attention to that investigation, which was released in December 2021.
Thank you.
2022 in my testimony. Happy to answer any questions.
Yep. Senator Kiss.
Thank you very much, Mr. Chair. I'll be very brief because I know we have a ton of speakers. Ms. Egan, I just have one question. One of the things in the proposal in Senate Bill 365, which came from Senate Republicans, you talked about services and supports for these wayward youth, that the pandemic had an impact, or maybe was the critical impact to cause the uptick in crime. I'm going to set that issue aside. One of the proposals is next day arraignment. This would allow an assessment of the youth and at the beginning of the provision of support services, an assessment of maybe not going to school, activities in the home and things like that. We have next day arraignments for domestic violence matters. Do you have any problem with that, just that isolated proposal regarding arrested juveniles?
I appreciate that question, and I did say in our written testimony that we do support timely arraignment, and I think looking closely to make sure there aren't unnecessary lags in time between a charge and arraignment and then disposition, so that the child and the public are not well served by that, I think is really important. I think for kids who are already detained because there's been a judicial finding that they pose a public safety risk, they're already available for next day arraignment. So the question is extending that next day arraignment criteria to more children beyond those already detained. I think timely arraignment is important, Senator Kissel. I would agree with that. And I think for the reasons that you articulated, though I appreciate the caution that some folks have on the legal defense side, right? That there's a balance that has to be struck between assessing the needs of a detained but not yet adjudicated child for services. The OCA still would like to see, kids who are in pretrial supervision and pretrial detention given meaningful supports and services quicker rather than later. The only caution I would say about next day arraignment beyond the children who are already detained for public safety reasons is whether that creates an insurmountable burden for some families. We know that low-income children are disproportionately involved in the justice system. So I think setting a goal for timely arraignment but being careful about who needs to be there for next day arraignment is what I would recommend.
Thank you very much, and I appreciate that. And you're essentially saying that we have to work out the mechanics, but sooner is better than later. And I have been in conversations with the chief public defender before she got nominated to be a judge, but I think that we're making great headway on that issue. So thank you very much for your advocation for those that can't advocate for themselves. Before she got nominated to be a judge, but I think that we're making.
Representative Fishman.
Thank you, Mr. Chairman. Good afternoon, Sarah. Nice to see you. Sarah, I wanted to expand a little bit on that exchange involving the expedited arraignments.
Yep.
I would think that a family member, a parent, their child has been arrested for a serious crime. We're talking about, Class A misdemeanors, felonies, that if we were to impose just a blanket next day arraignment, I would think that parents would prioritize getting to court with their child. Might you hear something different? Because that was the balance that you were giving us. That you were claiming that a parent would not prioritize that.
I'm just looking at my notes on that bill quickly, Representative Fishbein, thank you. No, I don't think it's that they wouldn't prioritize it. Obviously, parents are called to court for their children or to important things for their children, but just thinking about Since right now, children who are detained because there's been a public safety finding or because they're charged with serious offense are available for next day arraignment. As the committee looks to the possibility of extending that to other or all crimes, as I'm sure many folks on the committee are aware, low-income families, people who may not have access to transportation, and who may have to work the very next day. At next day arraignment for children who have not already been found to be a public safety risk and need to be detained may be burdensome, and there may be or difficult to do from a practicality standpoint. And there may be ways to achieve the goal of that legislation, which is addressing the timeliness of arraignment and the access of children to services quicker. That doesn't necessarily create a next day requirement.
Well, I'm just trying to figure out, a child has been arrested. How do we get them into services without some sort of arraignment, right? That's the jurisdiction the court has over them, that the legal system has over them. So I think we're all in favor, or at least myself, I think Senator Kissel, in favor of getting these kids into diversionary programs. It would appear, an expedited arraignment for, let's say stealing a motor vehicle, something I would never contemplated when I was a kid, right? I don't see a harm, unless you can convince me otherwise, to have a next day arraignment. We have a diversionary program that is specifically addressed to kids stealing cars. You get that kid into that program the next day. What's the problem with that?
No, I think we share the same goal for timely arraignment. My only caution is what the timeliness requirement is. And that next day could be a hardship from a practicality standpoint for some children and families. I'm not disagreeing with you about the public policy goal of timely arraignment and timely connection to appropriate diversion services, but really just what that timeliness is. Whether it's, so that's the only narrow point that I'm making.
Yeah, and I just, you seem to indicate, and I share the concern, certainly larceny 6 wouldn't have a next day arraignment. That's the balance, right? But the language that, in particular, the Senate bill, SB 365, and I think there's similar language in 5418, which is the House Republican bill. It merely says if they're arrested for a felony, a Class A misdemeanor, an offense for which another person suffers a serious physical injury or loss of life, a sex assault, or a serious juvenile offense, or one involving a firearm, that those are expedited arraignments. So I think the question from Senator Kissel was, are you in favor of expedited arraignments just for those classifications?
That Representative Fishbein, expedited or timely arraignments I would support, and I think it's just what the definition of that statute.
Okay, and that's that, not to belabor this, that becomes part of the problem. Efficiency is subjective. So, presently the statute says up to no more than 14 days. I will share with you that kids that are being held, detained, are being arraigned the next day. So we know that's happening. I'm just trying to get us together on some language here. But I understand your answers, and I thank you, Mr. Chairman, for the opportunity.
Thank you. And Representative Fishbein, I'll just note on this point, obviously this has been a topic that's been heavily discussed, not just today, but over the past several months in this committee. In fact, Chairman Winfield and I have had ongoing discussions with the judicial branch who can speed a bunch of this up on their own. And in fact, they have been moving quicker in arraignments over the last several months, particularly with respect to certain types of offenses. So I look forward certainly to working in a bipartisan manner on crafting language around this arraignment issue as we move forward from here today. Further questions for Ms. Egan? If not, appreciate you being with us today.
Thank you very much.
Marissa Helm.
Good afternoon. Can you hear me?
We can. Yep.
Okay. Good afternoon, Chairman and members of the committee. Thank you. My name is Marisa Halm, and I'm an attorney and the director of the Youth Justice Project at the Center for Children's Advocacy. We are a nonprofit law firm. We exclusively represent children and young adults across many different areas, and we have the privilege of sitting on the Juvenile Justice Policy and Oversight Committee. My executive director and any other staff, including myself, sit on the various subcommittees and work groups. Today, my colleague Leanne Neal will be speaking in support of SB 387, as well as some youth that work with us. I will be speaking and have submitted testimony in opposition to a number of bills that are on today: SB 16, SB 365, HB 5417, and HB 5418. Just as an aside, I work almost exclusively with justice-involved youth, many of whom are in the adult system, and that's the vantage point from which I am speaking today. I did submit written testimony, and happy to have folks look at that. I would like to focus my oral testimony in particular on SB 365 and HB 5418, and the sections in Section 7, I believe, in both of those bills, which substantially increases the number of offenses and youth that would be transferred to the adult court. One thing that I can assure the committee is that transferring additional youth from our juvenile justice system to the adult system is not in the best interest of those youth, nor is it in the best interest of public safety. Our adult system is simply unequipped to handle these young people. Adult courts and related staff, as well as the Department of Corrections and its staff, have no specialized training to work with this population. As an example, it's not atypical for an order in the adult court to prohibit a young person from attending school, a young person who has federal educational rights to attend school. Youth who are placed in the adult system sit for many months, pre-trial, still innocent, unconvicted, without access to any meaningful programs or services. What we know from national data, as Child Advocate Egan just mentioned, is that youth whose cases are heard in adult court and youth who are served by adult prisons are much more likely to reoffend and recidivate. So by placing them in this system, we're actually increasing the opportunity or the chance that they will reoffend down the line. As Attorney Egan also mentioned, we cannot ignore the Department of Justice report and findings on the Manson Youth Institution that were released just a few months ago that showed how the Department of Corrections is currently violating the constitutional and federal education rights of students with disabilities, and in many cases subjecting them.
Somewhere at the 3-minute mark.
Thank you. I'll wrap up. In many cases subjecting them to long periods of isolation. For all of these reasons, we would urge the committee not to pass these pieces of legislation, in particular the enhanced transfer components.
I think we have some questions for you from Representative Fishman, so I'm going to get to those. Representative Fishman.
Thank you, Mr. Chairman. Marissa, just trying to, what's the benefit of keeping a 13-year-old, let's say, arrested for murder? What's the benefit of keeping that case in juvenile court as opposed to going to adult court?
Thank you, Vice Chair Fishman. I can tell you what the detriment is to putting that child in the adult system. There are, as outlined in my testimony, there are no services for this young person. There's no training on behalf of the staff to provide appropriate and developmentally meaningful services. There are, this is a young person at the age of 13 that has the propensity to rehabilitate, and there are no programs that I'm aware of in the adult system that are successful at doing that. So person in the juvenile system at least would give them the opportunity to access programs and services that will be developmentally appropriate, and ideally not subject them to extended periods of isolation.
So you fundamentally believe that a 13-year-old arrested for murder, even though they may have been convicted of various felonies up to the age of 13, is still rehabilitatable?
Representative Fishbein, that's a difficult question. So we're presuming that this young person is still is pending trial and they're still considered innocent, correct?
That would be the procedure, yes. But my question to you is, what is the benefit of keeping that case in juvenile court as opposed to going to adult court? And you've indicated to me that there's no services for that 13-year-old in the adult court. Okay, so what services are available in the juvenile court that would not be available in the adult court for that juvenile who has been arrested for murder at the age of 13?
So I understand. I understand that this is a complicated question, a difficult question, right? And I know that there are many carve-outs, right, for the most serious crimes. I wish I had I wish I had a really clear-cut answer for you. I mean, what we're talking about is a really specific crime and the most harsh of all crimes, which renders it, a difficult topic. But I think your question is what you were trying to get at is what services are currently available in the juvenile system. I would say, there's a likelihood that young person may have trauma in their background. There's a likelihood that young person may have, some DCF involvement. So programs that are available through the juvenile court are more trauma informed. They would have more access to a regular therapy, and that youth, would be able to, ideally engage in those services while sitting pretrial.
Okay, so let's unpack that.
Okay.
We're talking, the question specifically is what services are available in juvenile court that are not available in adult court? And you said that the child may be a victim of trauma. So what program and services are specifically available to that juvenile in juvenile court that are not available in adult court as a result of the trauma?
Well, for example, there's trauma informed therapy available to that youth through the juvenile court system, through various CSSD programs.
But that's also available through the adult court.
Not while that child is sitting pretrial.
Are you sure about that?
I'm quite sure about that.
That a judge cannot order a child to participate in those programs pre-trial if there's a request from, let's say, a public defender on behalf of that child, for that child to attend that program and be part of that program that would be available in juvenile court. That's your testimony here today.
I'm not saying.
We're looking at the distinction, ma'am.
Mm-hmm.
You made a representation to this committee that there are no services available in adult court for a juvenile who's been arrested at the age of 13 for murder. And I'm trying to get to, we've identified services available in juvenile court. I'm of the understanding that particular service is available in adult court also. And I'm just trying to get to the facts here. So I specifically asked you about the services, and I'm just trying to figure out because, to my knowledge, the same services at some level that are available in juvenile court are available in adult court to a 13-year-old that is arrested for murder. And I'm just trying to get to the facts here.
So I speak practically from my experience working with the young people who are currently at Manson and Youth Institution, which is where these young people are housed, or where this 13-year-old would hypothetically be housed. And in terms of the availability of those services at the present time at that facility, there may be a particular staff person that has some sort of background in trauma-informed training that could in fact provide those services, but as a matter of course, that is not as what's offered to the young people that are there. So by no means am I trying to misrepresent information to the committee, Representative Fishbein. I'm just speaking practically based on my experience of young clients that are there.
Okay, I'm just going to give you an opportunity because you said that there were no services available to a 13-year-old arrested for murder in the adult court. But do you stand on that statement, or are you telling us something different?
There are definitely services available to young people through adult court. Yes, there's a particular program called MST TAY, which is for young people, emerging adults. So I think it's age 16 to 24. For example, that is one program that's available or that could be ordered in adult court.
I'm talking specifically about a 13-year-old arrested for murder. That's where we started.
Right.
And you said there's no services available. So am I to understand there's no service available for that child in adult court? I don't want to keep on having to ask the question, but I'm just trying to get to there's a lot of anecdotal talk about our juvenile justice system. And unfortunately, a lot of people aren't involved in the system. They're outside. And I'm just trying to get to why is it of benefit to have that case adjudicated in the juvenile court. I mean, I'm going to give you one of the harms, okay? Which we'll just shift to one of the harms. Let's just say that 13-year-old is convicted of murder.
Yes.
Could have been their 20th conviction up to the age of 13. At the age of 22, that murder conviction and the other 20 convictions are going to be automatically erased off of that juvenile's record. That's one of the benefits, I guess, to keeping the case in juvenile court. But I don't know that serves a public policy point. As I mentioned early on, I don't know that a juvenile 13 who's been convicted of 20 different crimes and then they're convicted of murder is rehabilitatable. I don't know that. So how do I explain that to my constituents? Because you're fighting the transfer of a 13-year-old arrested for murder going to the adult court. How do I explain the erasure aspect?
So in terms of the erasure, Representative Fishbein, and I'm gonna go back and double check. However, so right now the way that matters work is that his case, or hypothetically his or her case, this hypothetical 13-year-old, their case would remain in juvenile court because there's no exception for any. There are no carve-outs currently for a 13-year-old. So you are correct that their matter would that unless there was an exception, their case would remain completely confidential. It would actually, under current law, I believe it would be erased at the age of 18 if they didn't have any subsequent offenses. The age of 22 that you're referring to is actually, I believe what you're referring to is the erasure of records for individuals who are convicted as youthful offenders in the adult court. So youthful offenders who get that status have their records, are supposed to have their records automatically erased after they turn, after their 21st birthday. Whereas minors in the juvenile court have matters erased if they have an SJO, it would be 4 years after that point in time. So your question sounds like your question is around erasure, right? Well, how can you justify erasure for this to your constituents for a young person who committed murder?
As well as the other 20 crimes they've been convicted of.
Representative Fishbein, that's a difficult question. You know, I wish we were talking about a different. I wish we were talking about a different offense, because I think it would be easier. But the idea around keeping this matter, these matters confidential, is based in many years of brain science that show that this population is much more likely to rehabilitate and developmentally able to do so. And that the earlier that you are able to engage with them in rehabilitation, the more likely they will rehabilitate.
So and it sort of comes back to where I started with this.
Mm-hmm.
You're of the understanding that a 13-year-old who's been convicted of murder, as well as 20 other heinous crimes, is rehabilitatable.
I'm having a hard time imagining the 20 other crimes. That's what I'm having a hard time imagining, that there's a 13-year-old that is there. So maybe that's my struggle.
Let's say 10. I know of a case right now where he's 14. He's now, and would fall into the same standard. He's been arrested for murder, as well, and he's already been convicted of assault of a police officer, various levels of assaults, at least one case involving a firearm, use of a firearm, and now it's escalated to murder. Rehabilitatable. I mean,
it sounds like this young person in this particular case has proven that they are not rehabilitatable. And I think I have to tell you, Representative Fishbein, this is not a typical case that I would see. It's not a typical client of mine, right? My typical clients, especially most of my clients are not in this age bracket. You're very familiar with the data. I know you're familiar with the data on this age group, especially, the data related to the younger youth and when we raised the minimum age last year. This is a small population. So if what you're asking is, are there particular situations where there should be carve-outs, I feel like that's what you're asking. I mean, I can't disagree with that. I think the problem is that making these blanket changes will not serve the vast majority of youth that really will be impacted by them. They're going to actually do worse.
Understood, and that once again is anecdotal. I mean, the concern is that we do have certainly an uptick in the arrests of juveniles for stealing motor vehicles and the collateral things that happen with regard to that over the last 8 years. We have had that uptick. in conjunction with various juvenile justice procedures that have been changed. And that's very troubling. It's troubling to my constituents, it's troubling to me. And, you know, I think the proposal that's before us says, you know, you've been arrested for a Class A felony, Class B felony, or one that constitutes murder, violent sexual assault, or violent crime involving a firearm. Those are all very serious cases. That there's an automatic transfer. You know, I understand that some people don't want any kids to go to jail no matter what, but, you know, at some point, somebody's got to say what you're doing is wrong and do something about it. So, you know, not so much a question as a comment. It's very frustrating out here. You know, but I thank you for coming here today. Thank you, Mr. Chairman, for the opportunity.
Representative Walker.
Thank you, Mr. Thank you, Mr. Chair. Thank you, Marissa, for coming to testify. I think one of the questions that I would like to ask you is, in your passing, the number of kids that you've seen who have been transferred to juvenile court versus the kids that have been transferred to adult court, have you noticed a difference in the outcomes for the two different passages?
Thank you, Representative Walker. Yes, I can say wholeheartedly a vast difference. Many of the young people that I've worked with that have only been involved in the juvenile system, you actually, it's highly unlikely that they end up reoffending as adults. I have 2 or 3 individuals that were repeat offenders as juveniles that received significant programming from the system that are coming to mind, and their experience and my experience with them is that they have not reoffended as adults. Unfortunately, you know, a lot of I have many clients that are in the adult system, and my experience with those young people is that they quite frequently are reoffending and end up in the adult correctional system.
Thank you. I mean, and I just want to make sure that everybody here, these are not anecdotal things. It is statistically, Pew Foundation and several other foundations that have been reviewing and monitoring the activities of juveniles, like in the Council of State Governments and the National Council of State Legislators. They've all come up with the same statistics that show that when children go to children's facilities, the percentage of recidivism is extremely low compared to adults. Because when they're going into adult prisons and adult courts, they are then being exposed to opportunities and things that are far worse than what they probably have done. So, I mean, the most important thing that we do is first of all, we acknowledge the data. Washington Institute of Public Policy has also demonstrated that over the last 10 years with their data, and you can go to their website, and they have gone through all the different types of programs that are evidence-informed. And I don't use evidence-based because evidence-based means that they have the same children that we do. No, it's evidence-informed. And those programs demonstrate how important it is to keep children in a juvenile area because that's what they are. Children doing things that they probably should not have done, but because they had maybe limited adult supervision, they did things with a lack of understanding and empathy. And that's the most important part that we need to demonstrate with our kids. I do know that MST, as you pointed out, was one of the programs that are available. There's also family functional therapy, multifunctional therapy. There's a series of programs that are provided for kids to help them identify their emotions and understand when they have these types of outbursts and how to control them. Those are things that they learn when they go to the juvenile facility. So I thank you for your testimony, and I thank you for coming to us and talking to us about it. One of the other things that I also wanted to ask, and I think as long as you have been working with juveniles currently, how engaged have the parents been in those activities?
Representative Walker, it varies. A large number of the young people that I've worked with that are in the adult correctional system do not have parents that are engaged. They have some significant either DCF referral history or sometimes DCF involvement. I will say that the success stories and the cases where young people, the clients that I can think of that have not reoffended, a lot of them have strong familial connections. Maybe it's not a parent, maybe it's an older sibling. That not in all of those cases, but in a lot of the cases, there is a strong parent involvement and the likelihood of not reoffending.
Thank you. And the other issue that I wanted to ask you, there, I've been told that a lot of the kids that are in the juvenile system, many of them exhibit low IQs. Is that something that you've also experienced with many of your clients that you've been working with? And when I say low, I mean like 70 and below.
So I don't have that many kids on my caseload with IQs that low. I have a few. I have a lot of kids who may present as being smarter, but have a significant learning disability. I mean, a lot of the young people that we work with have a language-based learning disability, and that's why I think the findings in the Department of Justice report about the education of these young people is so important, because what we're talking about is we're talking about unmet needs here in a lot of cases that are language based and end up manifesting in different ways and in behaviors that if those needs were being met, I think we would see different outcomes.
Well, thank you, and thank you for your testimony. Thank you, Mr. Chair. Thank you.
Thank you. Representative Howard.
Thank you, Mr. Chair. Very briefly, good afternoon, Marissa. Thank you for being here. What kind of crimes are being referred to adult court for juveniles now, if you know?
In terms of, burglary 1, larceny 3, home invasion, robbery with a weapon, assault 2nd. Those are just some cases I can think of.
So I asked you that because my question becomes, when you talk about the fact that juveniles who go through the juvenile system are less likely to reoffend, and in the adult system they're more likely to reoffend, do you account for the fact that those individuals in the adult system committed serious offenses to begin with?
I'm not sure if I understand your question. Can you repeat it?
Sure. I think we can agree that a kid who steals a Snickers bar and a kid who commits sexual assault at 13 are different kids, right? It's a different makeup, and I think we could probably be in agreement that there's probably
absolutely. Yeah. And so your question is, are those kids in, I would have to say that I think kids who are accused of harsher crimes, just based on their status as youth, should still be given the opportunity to access services that are developmentally appropriate to them.
I think that there's a good point to be made there. But again, I ask. In other words, let me say it to you this way. In the realm of adults, for example, somebody who's a first-time DWI offender, and somebody who gets arrested for burglary 1, I would say the person arrested for burglary 1 has a different makeup in their history, their mind, whatever, that allows them to commit such a crime as opposed to like a DWI. So it's not inconceivable to think that regardless of the rehabilitative process, that the burglary 1 suspect is more likely to reoffend. So when you account for the recidivism rate being lower among those who go through the juvenile system, is there some sort of a gauge or a scale, if you will, that accounts for that variable, that the original crime itself holds a higher recidivism rate to begin with?
That's a really good question. I wish I had specific data that would look at that question. I think it's really interesting to look at. At one point in my career, I didn't look at all the charges, and now I've looked very closely at the charges. And I will say one thing: they're charges. In the majority of the cases of the young people that are sitting at Manson, they have charges that are serious, but they haven't been convicted of those charges yet. So that I wanna highlight that point, because I think that's important. They're sitting for a long time incarcerated, and I can't tell you how many times I've been contacted by providers in the system who have said, this kid, because of their undocumented status, because of the fact that they're a ward of the state, those scenarios, this kid has sat longer in DOC than his sentence is going to bear. And when you have a system that does that's problematic. I know I just got off on a tangent, but I think what you're asking is that are the individuals who have been charged with these more serious crimes, just by virtue of engaging in that behavior, are they more likely to reoffend with more serious charges? I think that's what you were asking.
Yeah.
I don't think so. And what I can say is a lot of these a lot of the crimes that these kids come in on are crimes that they're committing that are in sort of that group environment, where there might be multiple individuals, or they're being pulled along by their peers. One of the components of their developmental status that they're is weaker, and that when they're much more likely to not think before they're engaging in behaviors.
All right, thank you for that answer. And the other, do you know what percentage of cases in juvenile court are adjudicated pre-trial?
I don't, but I'm sure we could find out for you if you'd like.
Well, I think it's probably high, right? I think most of them are adjudicated pre-trial. And in the adult court, oh, thank you. I love to hear that. In the adult court, the more serious offenses, murders, sex offenses, things, and I don't know if you know my background. I'm a police detective. I deal with victims all the time. And we transfer the more serious cases to the Part A, we call it. And I'm sure you're familiar with that. And we do that because, for a couple of reasons, and certainly not disparaging to our hardworking prosecutors all across our judicial system, but at Part A, they are equipped with more investigators or inspectors, and have a little bit more, the victims' advocates have a little bit more experience and a lighter caseload. So those victims, isn't the best way to say it, but they get a better service from the judicial system for those most serious crimes. What do you say to victims of serious crimes who won't be afforded that opportunity by those juveniles staying in the juvenile system?
I mean, that's a good question. I would go back to my point, before, that I think that the services that are available in the juvenile system are just much more developmentally appropriate. We have cognitive, we have CBT, we have, the family-based MST, we have services where, the children are the youth are able to receive education that is meeting their needs.
I understand how and I think there is a balance, and I don't want you to misunderstand me that I don't put a lot of focus on children right here in my district who work really hard to give kids a better opportunity, including my wife taking children in when necessary. My wife and I do that, and I mentor a lot of children. I think it's important, but I think every kid's different, and in a lot of ways. So, but again, I'll ask you this: we have to strike a balance between doing what's best for the juvenile and also public safety in these victims. So, as a representative and as a police officer, frankly, what consideration can I tell my constituents were given to the victims on their side? And I recognize that's not necessarily your purview, but I'm just asking, are we giving enough weight to the victims and the public safety aspect of this, in your opinion?
I think that victims do have they have a lot of access, they have a lot of exceptions, they're able to access information about cases, they're able to come into court and give statements. So I know that is, in the cases that remain in the juvenile court, all of those permissions exist for victims advocates. What I would also suggest that one of the things that we're working very hard through our office is to promote, restorative alternatives. And I think those restorative alternatives that involve when the victim is open to that involve victims, whether it's a restitution or whether it's some form of restoring that harm. I think those options should be available and should be more prolific. And I know that our office has some various initiatives that we're working on to promote that throughout the facilities that are in the juvenile system.
Thank you. Thank you for your answers, and thank you for your work and your testimony here today. Thank you, Mr. Chairman.
Thank you. Further questions or comments from the committee? If not, Ms. Helm, I just super quick, at the risk of belaboring this, but I got a little confused here because you started your testimony by saying you're opposed to Section 7 of 2 of the bills. And those sections purport to amend Connecticut General Statute 46B-127, correct? And under 46B-127, if we look at subsection 2 of that law, that current law, I don't practice in this area, but you do. But my read of that section is it allows a state's attorney to, at any time after an arraignment, file a motion to transfer a case in which a child has been charged with the commission of a B felony. So that would be presumably, some sort of homicide charge, to the regular docket. And so your opposition, as I heard it, was not to existing law per se, but was under these proposals, you basically strip the judge of discretion, right? That you automatically transfer every instance of a serious juvenile offense or a 14-year-old being charged with an A or B felony to adult court. No questions asked. Has to go to adult court if they're charged with that. Even if the charges are later reduced, it first gets transferred. The judge has no discretion. So in your situation, in your circumstance, or the hypothetical you went through with Representative Fishbein, certainly a kid who was charged with murder after 10 prior charges, who's 15 years old, 16 years old, that case is going to go to adult court on a discretionary transfer. What you're saying is there may be other circumstances, there may be less egregious examples than that shouldn't necessarily go to adult court. And so we hire, we train, we vet judges who we vest with a certain level of discretion to make the determination of when a case should be transferred versus when it shouldn't. Did I get that sort of right? Kind of right?
Yeah, thank you, Representative Staffstrom. Yes, I would say, so just to go back to what we were saying is that leave the law the way it is, right? That don't change those in 365 and 5418. It's enhancing auto transfer. So auto transfer cases that would automatically go up, which would, obviously increase pretty quickly the number of cases that would go to adult court. And you said it better than I could have said it. That is not what we'd like to see. We'd like to have these cases be in front of a judge, ideally, a juvenile court judge that can make more youth-specific determinations.
Yeah, no, because I sort of remember I was brand new to the General Assembly at the time, but actually it might have been right before I got here, but I remember the discussion. The current construct of 46B-127 that is being sought to be amended here was essentially written as part of the major juvenile justice reform of 2015. It was actually Public Act 15-183, which is a bill that passed the state House of Representatives 143-1 and passed the state Senate unanimously, with every member of this committee who was here at the time voting for it. So it seems to me we struck the right balance back in 2015. Why we would try to upset that balance now, when we undertook a bipartisan balancing approach back in 2015, I'm struggling. But I appreciate your testimony here today. Thank you for being with us.
Thank you, Chairman.
Next up will be Luke Bronin. How about Cheryl Banks? Kevin Kelly?
Mr. Chair,
Yep. Senator Kissel.
Senator Kelly has to meet with the governor right now. I was hoping he could get weeded in when he gets back.
All right.
Thank you, Mr. Chair.
David Bass. Stephen Levy. Representative Candelara.
Chairman, I would, if I may, I would imagine that the minority leader may be in that same meeting if you report the same opportunity.
Let's hear from the public and then we'll get to those guys towards the end.
Thank you.
John Lott.
Yes, I'm here.
Go ahead, sir.
All right, thank you very much. I'm president of the Crime Prevention Research Center. It's a group of academics who do research on a variety of crime issues and policing. Until last year, I was senior advisor for research and statistics at the U.S. Department of Justice. And prior to that, I've held research or teaching positions at various academic institutions, including Yale, the Wharton Business School, University of Chicago, Stanford, and Rice. And I was also in the past chief economist for the U.S. Sentencing Commission. I'm going to concentrate my comments on SB 16 and HB 5416. Just as a general comment, the focus this morning has been on guns and gun control as a way to solve violent crime. I think it's important to mention two facts. One is that more than 92% of violent crimes in the United States are gun control as a way to solve violent crime. The second thing is the Department of Justice has released data for 2020, and it shows that if you look at crimes reported to police or the National Crime Victimization Survey, crimes committed with guns actually fell by 27% between 2019 and 2020. So if you want to go and deal with crime, there have been a lot of inmates that have been released from prisons in Connecticut. The commissioner earlier mentioned about the cuts in the police force. Those were places that I would try to concentrate on and others. On SB 16, Connecticut's already done a lot to make sure that low-income individuals and minorities disproportionately aren't able to protect themselves. Unfortunately, SB 16 will make this problem significantly worse. The bill proposes banning permanent concealed handguns on any bus, train, or ferry, or other places. The Connecticut Department of Transportation shows that almost 43% of people who use rail systems, for example, are minorities. If you just compare right to carry states generally, their share of the Black population with permanent concealed handguns is very similar to their share of the general population. About 12% of Blacks have concealed handgun permits in those states. However, in Connecticut, Blacks only account for about 6.3% of permits back in 2020, and that's only half their 12.2% share of the state's population. So Connecticut is already well below kind of the national average for the 43 right to carry states. There's simple reasons for this. Connecticut has among the highest permit fees in the country. It has the highest fees, and only Illinois and DC have longer training requirements. The proposed regulations will only make that racial disparity even worse for permit holders. One of the crucial things here is I've heard no examples of permit holders committing crimes with guns on public transportation or at polling places or in municipal buildings.
Sir, your 3 minutes are up. I just need you to summarize for me. I think we have to.
The main point is in this discussion is that there's been no data really provided that the things that this is going to be solving are actually problems that exist, nor that the proposed solutions would actually make anything better.
All right. Well, thank you, sir. Obviously, unfortunately, on that last point, we appear to be just at the beginning of our public hearing, despite the fact we're 4 hours into it. So I'm sure there will be others who will testify on that point as well. Question or comment from Representative Fishman?
Thank you, Mr. Chairman. Professor Lott, it appears that you had some other things you wanted to share with us about SB 16. What else would you like to let us know?
Well, for example, the concern is what crimes with guns are committed by permit holders. There's no example for either transportation, polling, or municipal buildings. The 2 examples that were given by the commissioner earlier were Kyle Rittenhouse in Wisconsin and Dennis Anderson in Portland. Neither of those cases involved somebody with a concealed handgun permit. Rittenhouse was found to have acted in justifiable self-defense. Anderson illegally had a gun, was charged with unlawful possession of a firearm. So he was not the type of person that would have even had a concealed handgun permit. The big problem that you have with these bans on carrying on public transportation and other places is that you're not just stopping, particularly these minorities and poor people, to be able to go and protect themselves on public transportation, but you stop them from protecting themselves on their way to or from those places. And earlier in the testimony was talked about people going to work. People go on public transportation for going shopping, for going to restaurants, for just going out and traveling to the park or someplace else. And so you're going to make it so that those individuals, particularly again, what my research finds are the most vulnerable people in our society, the people who are most likely victims of violent crime, poor minorities, particularly those who live in urban areas, who are going to be defenseless when they're outside of their home. And the other basic point I'll just say quickly, and that is, where do you think criminals, particularly things like mass public shootings, are most likely to occur? They occur in these gun-free zones. 94% of America's mass public shootings since 1950 have occurred in places where civilians were banned from being able to go and have guns. And so if you go and create more gun-free zones, you make it easier for those who want to go and try to kill people, to go and harm them in other ways, to be able to go and do so.
That's an area that I wanted to specifically ask you about. When government posts a sign that says, no guns allowed, let's say in a polling place, I would take it that the moderator of the polling place would also not be able to defend themselves.
Right.
What other than that sign would prevent a bad person from entering the polling place with a firearm and shooting a defenseless election monitor?
Right. Well, what I would argue is that those signs actually are magnets for somebody to go and do the attack. Let me ask you this. Would you put a sign, or would anybody here in this hearing put a sign in front of their home saying that their home is a gun-free zone? Let's say they're being stalked or threatened, really facing a serious threat. Would they put a sign like that in front of their home? My guess is they wouldn't, because that doesn't discourage the attack. It's not like the criminal goes and sees the sign and say, I'm not allowed to have a gun in that home, and so I'm not going to go in there and attack the person. What it actually does is encourages that person to go and do the attack, because they know that the victim there is going to be less able to go and defend themselves. And when I was at the Sentencing Commission, I must have read well over 1,000 trial transcripts. And I have to tell you, these criminals are not dumb in the sense that they are like anybody else. If they can accomplish their crime with less risk to themselves, that is what attracts them to go and commit a crime. And when you're looking at things like mass public shootings, where the whole point of the attack is simply to go and kill or wound as many people as possible. They want to go and try to pick that type of venue where they know victims can't defend themselves. If you have one police officer who's trying to go and defend a particular place, they have an almost impossible job. If you have one person in uniform and they're known to be the only person that has a gun to go and stop the attack, if the attack is going to occur there, who do you think the first person is that they're going to try and take out? Because once they take out that person, they're going to have free reign to go after other people who are there.
And I certainly share your opinion on that. You know, you're aware of a very tragic incident that we had in our state years ago at a school. You know, we were young children, and I to this day believe that place was targeted because defenseless victims were housed inside. You know, I've looked at your testimony, and one of the portions you talked about Connecticut's fees for permits are higher than 43 other states. That's an interesting aspect of this. We heard the commissioner testify this morning. He was asked a question about lawful individuals wanting or needing to transport their firearms to work. And were you here for that?
I was.
And I believe he testified that he had no knowledge of anybody needing to do that. Do you share that opinion?
We collect at Crime Prevention Research Center, we collect many dozens of cases where people use permanent concealed handguns legally outside the home to protect themselves in a wide variety of circumstances. Every place from actually being at work, having a tax stop, including, you know, people don't hear about these things, but there's dozens in just the last few years of what otherwise, according to police, would have been mass public shootings if it hadn't been for the presence of a permanent concealed handgun. And that occurs many times at places at work or other places. It's if the person with the gun hadn't been there and you had what the police believe would have occurred with the number of people killed, that would have gotten international and national news coverage. But you know, there are many cases, and I'm happy to provide you with a long list of cases.
The commissioner also testified, and I believe the lieutenant also, that we are following other states' leads here with regard to guns. Isn't it true that most states have been opening up their residents to what's known as constitutional carry?
Right. Well, most states have been moving in other directions in two different ways. One is getting rid of gun-free zones. When right-to-carry laws were originally being passed, 20, 30 years ago, you'd have a long list of places where people weren't allowed to carry because there'd be concerns about things that might go wrong. And what would happen over time is people would say, look, you were claiming that the world was going to end when we allowed concealed carry, and that's the reason why we banned it in certain places. And that hasn't happened. And then they would gradually reduce the number of restricted places more and more. There's been a huge trend across most of the right-to-carry states, most of the 43 states in that direction. With regard to constitutional carry, we now have 22 constitutional carry states where you no longer need to pay a fee. People who want to be able to go and carry quickly can go and do so. I mean, one of the big problems that you have with concealed carry rules permits is that, let's say you have a woman who's being stalked or threatened. In many states, it could take 60, 90 days for her to be able to go and get a permit. She may not have 60 or 90 days to be able to go and wait, to be able to go through the process, to go and be able to legally defend herself outside of her home. And so we have 22 states, and I think it's very likely with Georgia, Nebraska, Ohio, and Indiana that you will see 26 states having constitutional carry rules where as long as somebody is law-abiding and legally able to go and own a gun, they're going to be able to have the ability to go and carry a concealed handgun for protection. 34 states already allow open carry without a permit. And this will just be a continuation of the liberalization trend.
Thank you, Professor, for showing up here today, and thank you, Mr. Chairman, for the opportunity.
Thank you.
Representative Jablonski.
Thank you, Mr. Chairman. And thank you, Dr. Rod, for coming in. Very much appreciate it. I've read a number of things you've written and find them very interesting because it appears that you actually look at real statistics and science as opposed to what I feel some of the legislation that we see in this committee and in this state deal mostly with people's feelings, and those feelings often contradict what the actual data says. We had some representatives from the administration that's opposing Senate Bill 16 this morning, and I understand that you were watching some of that. Specifically with regard to the statistics that are kept and that are collected. Do you have any thoughts on what statistics would actually be helpful in determining if there is an increasing rate of illegal guns and illegal homicides in this state? It sounded to me like the representatives from the administration are almost deliberately not collecting the right data, and if they are collecting it, they're not acknowledging it. Can you give us an insight into what data should be collected in order to determine whether or not there is indeed an increase in the criminal use of firearms and what to do about it?
Yeah, sure. No, and I appreciate your questions to her earlier. Unfortunately, I didn't have a lot of confidence that she actually understood, that they actually understood the data that they were dealing with. One of the questions you asked was the difference between homicides and murders. There's an important difference, and that is homicides are justifiable homicides plus murders. If I have an increase in homicides because I have an increase in justifiable homicides, because let's say some woman uses a gun in self-defense to stop her children from being killed or her from being killed, or if a police officer uses a gun in justifiable self-defense, those are very different types of cases than a criminal murdering somebody in the commission of a crime. And it seems to me if homicide's increasing because of increasing justifiable homicides, you want to separate that out from murders. They don't do that. But it's even worse than that because it's not clear to me she even understood how justifiable homicide data is collected. She's saying, well, they could go and just look at police reports. Pointing out first that she hasn't been looking at those. But secondly, what most people don't understand is that over 90% of the police departments in the country, and I assume Connecticut is no different than this, don't even collect data on justifiable homicides by civilians. And even the ones that do are very problematic because, she mentioned, for example, that it could be, you could go and look to see what happened in court decisions. Court decisions can be a year or 2 or 3 years after the original case that occurred. Even for the police departments that do collect this data, very rarely do they go back and correct the data that's 1 or 2 or 3 years old. I mean, she's talking about collecting this data in kind of real time that's there. the notion that they're going to have any information on justifiable self-defense, because often people are arrested even if they used a gun in justifiable self-defense, unless the police are completely convinced they know the outcome there and what happened, which they often don't initially know. And so, I'm not sure, or at least from her comments, I'm not really sure that she has a clue on how the data is put together or what the data actually involves. And, and the other thing is they want to concentrate on firearm homicides. And again, I think that's a mistake. I think firearm homicides can be useful, but you need to also look at total homicides. If I have a regulation that, let's say, lowers firearm homicides, but increases total homicides, I'm going to look at that regulation differently. Then I'm going to look at a regulation that, let's say, reduces both murders, total homicides or murders, and firearm homicides or murders. Criminals may, in some cases, substitute in other ways to go and commit crimes. And you have to take that into account. It's not something that seemed to be even mentioned one time during that earlier testimony, that they understood those types of concerns. And I have to say, unfortunately, that's something that you see generally in the public health literature. If it were me and you wanted to have more resources to try to go and target responses to crime, I would make those resources available to the police.
Well, I appreciate that answer. I've noticed a number of times, both in this state and in other places, where the data that is used to justify a new regulation is limited. And whether it's deliberate or negligent, I can't always tell. But things like, perhaps you can talk about what's happened in countries around the world when they have imposed regulations on law-abiding citizens. My understanding is in Canada, when they one of the reasons, the justifications they use was in order to reduce the number of firearm-related suicides, and that that indeed they did reduce the number of firearm-related suicides, but the number of non-firearm-related suicides skyrocketed.
Representative, I've given a lot of leeway. In one of the actual bills before us.
All right.
So Professor Lott, your response will be refrained to that type of restriction. We're not debating gun ownership generally.
Yes, Mr. Chairman, with due respect, I am talking about the imposition of limitations on the ability of law-abiding citizens to possess and carry firearms. That is what is before us today, and I'm asking this gentleman to tell me about what has happened in other places when that has occurred. I think that's a perfectly legitimate question.
As long as it relates to those provisions you outlined in Section 16. That is what we're talking about. We've talked a lot about permit fees. We've talked a lot about how long it takes to get a permit. None of that is in the bills before us.
No, but
Constrain it back to the topics that are in Senate Bill 16. And then your question is appropriately before the committee.
Dr. Lott, if you would.
right, okay. Well, look, there's been a huge amount of research that's been done on concealed carry and constitutional carry. Basically rules that make it easier for people to carry, to get rid of things like gun-free zones. I'll mention which this bill is going to make it more difficult for people, particularly poor people, particularly minorities. Again, my research shows, if it convinces me of anything, it's that the people who are most likely victims of violent crime are the ones who benefit the most from having the option to be able to go and protect themselves and their families. Who do you think is going to be stopped from being able to go and do that if you ban people being able to go and carry on public transportation? The information that I gave on the racial and the racial composition of permit holders in Connecticut was simply to show that the existing rules with regard to concealed carry have already discriminated heavily against minorities, and that the rules that you want to put in would move Connecticut even more. But Connecticut is a real outlier in terms of how it discriminates against minorities, in terms of its concealed carry permitting process. And you're going to make it even more of an outlier by having these types of rules that create these gun-free zones for particularly low-income people who are more likely to go and use buses. The other reason for pointing out fees is because it's something that else also affects low-income people disproportionately, just like those are the ones who are more likely to use public transportation that's there. With regard to the assault weapons ban, I don't need to make comparisons to other countries. There's been a huge amount of academic research that's been done, even research that's been done during the Clinton administration that the Clinton administration paid for, and other research that's been done under the Obama administration that hasn't found any benefits in terms of reducing any type of crime related to any type of assault weapon, the type of rules. So you look at Connecticut, over the 5 years from 2015 to 2019, 0.6% of murders were committed with any type of rifle, whether they were, in the ban category or not. I know of no evidence, not one single case has been mentioned of a pre-1994 weapon that would be now banned under these laws that are being proposed, that was used in any of those 3 murders that were committed over that 5-year period of time. So much of the discussion today has not been based on any facts at all. You're talking about concerns about people having guns on public transportation. Fine, provide one example where someone with a permanent concealed handgun has committed a firearm offense on public transportation in Connecticut or someplace else in the country. What I can tell you is that we do have other states are much better at breaking down the crimes committed by permit holders than Connecticut is. And what you find is that, for example, police officers are convicted of firearms-related violations at a rate 12 times higher than concealed carry permit holders are. And police are rarely convicted of firearms violations. They're convicted of firearm violations at a rate 1/20th the rate of the general population. So you're talking about, and nothing's been provided in any of this testimony that indicates that polling places or any place else that permit holders have posed a danger. But what you're going to do is you're going to be creating gun-free zones, places where the most vulnerable people in our society are going to be prevented from being able to go and protect themselves. And it's kind of interesting to me to listen to all this discussion and no one providing even one case to go and justify any of the regulations that are there. When I can provide, and people can go to our website at crimeresearch.org, literally many dozens of things like mass public shootings that have been stopped by concealed carry permit holders, and places at work and other places that have been stopped by people like that.
Thank you, Dr. Lott. One of the previous representatives who was who asked some of the question to one of the previous witnesses talked about how other states apply gun control, and we were told that it's a good idea to look at what's going on all around the country. Let's stay in New England, places like Maine, New Hampshire, Vermont. What kind of compared to what is in SB 16? How do those states deal with the possession of firearms by law-abiding citizens, the type of firearms, and how do their crime rates compare to the crime rate in Connecticut?
Well, I'm usually reticent just to make a comparison between two places. What I find, because there are lots of reasons why crime rates can vary, what I usually like to look at is to how crime rates change before and after a law has changed, and how it's changing in places that change their laws relative to other places that are there. I mean, generally, the three states that you mentioned, I have many fewer regulations on guns than you have in Connecticut. Their crime rates after New Hampshire and Maine adopt so-called constitutional carry that you mentioned before went down. Nationwide, violent crime and murders went down after those types of rules were loosened up. Again, I would just point to, if you want to focus on things like mass public shootings, it's hard to get away from the fact that 94% of the mass public shootings in the United States take place in those areas where guns were banned for civilians. These attackers aren't stupid. And you have to go and deal with the fact that when you pass laws, when you do things like put up a sign that bans people be able to go and take a gun into a municipal building or other places or on a bus, who's going to obey it? It's going to be the most law-abiding, good citizens, the ones that you have least concerns about, who are going to obey it. Somebody else who's going to go and murder people, what's the additional penalty that you put on them for violating a gun-free zone? So you go and put them in jail for 3 years or something when they're already going to be facing multiple life sentences for killing people? The notion is absurd that they're going to care about that additional penalty. But for a law-abiding citizen that you have, that what you're going to find is that 3 years, that's a real penalty to them, because that's going to be the real penalty that they're going to be facing for violating that gun-free zone. But it's more than just what we've been talking about here. There are other provisions in these bills. So, for example, that's been talked about where police officers without good cause can go and ask somebody if they have a concealed handgun permit. Again, we talk about the racial aspect of this. Who do you think are going to be predominantly, disproportionately, the people who are going to be stopped under those types of circumstances? Does anybody really believe that it's not going to be disproportionately minorities? Why is so much in this bill kind of seem to be focused on punishing poor and minorities? That's not obvious to me why that should be such a central focus of SB 16.
Well, thank you for that. Now, one of the things that I find the most onerous about this bill is the banning of carrying firearms for defensive purposes by law-abiding citizens pretty much anywhere in the public square. Going to what you just said, in a small rural town with a lot of farms, people walking around the streets and being on their properties with firearms and being in our town is not going to be something that the state police are going to come down from Danielson to try to stop. But my guess is that most of this will take place in Bridgeport, Hartford, New Haven, Waterbury, where there are people walking the streets, people on buses and trains and other types of public transit that will be found to be violating this, even though they are doing nothing but exercising their constitutional rights.
Right.
Do you have any? I'm sorry, you were going to say something. Go ahead. I'll ask a question.
Right. Well, I don't know if you listened to the oral arguments in just this last fall in November in the New York concealed carry case, where they have a May issue law. They're one of the 7 states that have so-called May issue laws. One of the lines of questioning between Chief Justice Roberts and the lawyers for the state and for the Biden administration was precisely along the lines that you were saying, because they have a general provision that they take into account in determining whether or not to let people have guns. And they were saying, in public areas, people who live in public areas are going to be a lot more reticent to grant concealed handgun permits to than somebody who lives out in the country. And they were making the same type of public safety type argument that has been made this morning for why you should treat those places differently. And Roberts really wouldn't have much to do with that. Roberts said exactly your point. He said, well, where are the crimes most likely to occur? Isn't it true that violent crimes are much more likely to occur in those urban areas than it is to go and occur in rural areas? And even the attorney for the Biden administration was basically forced to admit that that was the case. He had no real response to that. And so, it's just something to think about when you're thinking about passing laws and having this type of testimony on the record as a reason for this, given that within the next few months you may have a decision coming down from the U.S. Supreme Court that precisely addresses that type of argument, which was so central to New York's defense for their current concealed carry laws that are there.
Do you know if there's any other state that has banned the carrying of firearms on all modes of public transportation?
Well, you have Illinois, for example, has. There are a few places that have done that. But, the thing is, the vast majority of states have not. And even the ones that had originally have gotten rid of those restrictions since then. And what you find is that, just as I mentioned before, just as you can't point, and nobody's pointed to cases where concealed carry permit holders have committed firearms crimes in those places. I don't know of cases across the country where that type of thing has occurred. I'm not saying that permit holders never commit firearms related violations. What I'm saying is that last year, there were 21.5 million concealed carry permit holders in the United States. And that's not even counting the fact that there are 21 at that time constitutional carry states where you don't even need to have a permit to be able to go and carry. And yet, what you find is that permit holders are incredibly law-abiding. So you do have some crimes, but you have to kind of take into account the literally tens of millions of permit holders that are out there. And I would argue it's pretty hard to find almost any other group in the population that's as law-abiding. And that's the reason. If you look at surveys of police officers across the country, Police One, for example, which is the largest private organization of police, they have about 450,000 members. Just to give you context, there's little bit over 600,000 police in the country. 380,000 of their members are full-time law enforcement, over 70,000 are retired. They did a survey of their membership, and basically what you find is about 94% of their members believe in liberal concealed carry laws that made it relatively easy for people to be able to go and carry guns. And the vast majority of police were in favor of getting rid of gun-free zones.
Do you know if the imposition of any of those laws that restricted the carrying of legal firearms on public transportation, did any of them, is there any statistics that show that any of them had any effect in reducing the amount of, or the rate of violent crime on those modes of public transportation?
I've seen no support for that. What I have seen is evidence that indicates that the creation of gun-free zones serves as a target, serves as a magnet for those who want to go and commit crimes. Look, criminals are like anybody else. As I said, I've read over 1,000 trial transcripts in the work that I've done in U.S. justice. And what you find is you'll very frequently hear, this testimony where the prosecution will get one criminal to turn state's evidence against another criminal there. And they'll ask them questions about, how did you pick this particular victim? And they'll say, well, we were thinking about going after the drug dealer down the street, but he has a lot of guns, it'd be crazy to go after him. We talked about going after a cab driver, but a lot of cab drivers carry guns. And then we saw this small woman walking across a parking lot late at night by herself, and she looked like an easy target. And so, I can give you case after case. There's empirical evidence on Florida, for example. Florida used to have the license plates for rental cars had a designation to indicate that it was a rental car. And criminals used to target those rental cars because they would know that those people would be very unlikely to have a concealed handgun permit. You have over 2 million Floridians have a concealed handgun permit, but they don't want to tangle with people who have a concealed handgun permit. And so they would go and target those cars that had the designation on the license plate because they viewed those as relatively safe. And so Florida got rid of that designation on the license plate because they realized it was serving as a magnet for criminals to go and attack those individuals that had those rental cars.
Well, I very much appreciate it. Appreciate your time. Appreciate you coming in. I don't want to dominate the time today, but I very much appreciate you coming in, and I will certainly take a good look at your written testimony.
Thank you very much.
Thank you.
Representative Fiorano.
Mr. Chair. Dr. Lott, I just have one quick question, which is that in regards to bills like SB 16 and the 2013 Act, do you work with individual states, and would you be willing to do independent data collection and analysis on behalf of the Connecticut legislature so that we can understand the impact of all of these gun laws? And also, if you would, what specific areas would you initially analyze?
Right. Well, I look at data from all the states, and the reason why I look at data from all the states is that you want to see how crime rates, suicides, or accidents, or other things change in those states that change their laws relative to neighboring or other similar states that haven't changed their laws. I've been hired before. I've done work for Arizona, the prosecutors there, and other places to go and particularly look at particular crime issues there. I'd be happy to go and do that for Connecticut in any way. I've looked at Connecticut already, focusing on things like your red flag law that you have there in the state. And I've also looked at things like the licensing law that you guys had in the 1990s to see how Connecticut's violent crime rate and murder have changed relative to neighboring states and across the country after you had that was not good. Was the bottom line there. But look, I mean, there's a huge number of issues that are here. To me, the bottom line is pretty simple. If you want to go and reduce crime, you have to make it risky and costly for criminals to commit crime. And you reduce gun crime just as you reduce any other type of crime. You have to have higher arrest rates, higher conviction rates, longer prison sentences for those who are committing those types of crimes. And unfortunately, across the country and including in Connecticut, you've had a large number of inmates being released from jails and prisons in the state and in other places over the last couple of years. You've had a drop in the number of police officers. The commissioner talked about that earlier. It's not really rocket science, but one thing I mentioned earlier, and I want to emphasize, and that is nationally, over 92% of violent crime has nothing to do with guns, absolutely nothing to do with a criminal having a gun in the commission of a crime. And so, you know, I care about all crimes that are committed, all murders, all rapes, all robberies, all aggravated assaults. And if you want to reduce gun crime, you have to focus. But here's the problem that you have. The people so often focus on guns. In many ways, guns are similar to drug type issues, illegal drugs. Where do you think most criminals get their guns? They get them from drug dealers. Drug dealers have guns because they have extremely valuable property. And it's not like a drug dealer can go to the police and say, this other gang stole my drugs. Can you help us get them back? They have to set up their own little militaries in order to go and protect that valuable property that they have there. And the thing is, it's going to be as difficult to stop criminals from getting guns as it is to go and stop criminals from getting illegal drugs. Drug dealers like to make money. If they can make money selling drugs, they do that. If they can make money selling guns, they can go and do that. If you want to see an example of that in practice, I mean, I can point to cases in the United States, but look at a country like Mexico. Mexico, since 1972, has had only one gun store in the country. It's run by the military. Guns are extremely expensive. The most powerful gun that you've been able to legally buy since 1972 in Mexico is a 22 caliber short round rifle. That's not what the drug dealers use there. I've testified before the Mexican Federal Senate and House on their gun control laws. And what you see is that criminals are still getting guns. They're bringing them in from around the world, just as they go and bring in illegal drugs. If I could go and magically click my fingers and cause all illegal drugs to disappear from the United States and all guns, how long do you think it would be before illegal drugs started coming back in the United States? If you're in El Paso, Texas, maybe 20 minutes. And how long would it be before you would start, they would be bringing in the weapons to protect that extremely valuable property that they have? They'd be bringing them in at the same time. And so the notion, so much of this debate is you'll see, well, where do criminals get guns now? And we'll try to stop them. But you're going to be just as successful as the approach that we've had in stopping criminals from getting illegal drugs. Do we really believe that we've stopped criminals from getting illegal drugs in this country? You go to college, I give talks at colleges and ask students to raise their hands and just say, if I give you 2 or 3 days, how likely it is that you could go and find some illegal drugs to be able to go and buy. And you'll find 80% of the students go and raise their hands. And so, you can't just focus on where people go and get guns now or what guns that they use. You have to think outside the box about all the other possible ways that they're going to start to get them once you go and put your finger in the dike for one particular hole that's there.
Thank you, Mr. Chair.
Thank you, Representative Fiorello. Questions or comments from other members of the committee? Questions or comments? Seeing none, thank you very much for joining us today. Next, we'll hear from Brittany Lamar, followed by Walt Cupson, and then Jeremy Stein. Brittany Lamar.
Thank you, Senator Winfield, Representative Stavstrom, and distinguished members of the Judiciary Committee. My name is Brittany Lamar, and I'm a Justice Advisor with CT Justice Alliance. I am writing this testimony to communicate my opposition for SB 365. CTJA is a statewide youth adult partnership working to end the criminalization of youth. The alliance includes justice staff, justice advisors, steering committee members, which include lawyers, researchers, clinicians, social workers, who work across issues such as behavioral health, family advocacy, substance abuse, legal representation, education, and community and residential services. SB 365, with the intention of highlighting the need for public safety, lacks constructive, effective, restorative, and rehabilitative practices that would ensure long-term success and safety of the community. GPS monitoring for young people who are released for delinquency offense but have yet to be adjudicated delinquent until their case is disposed of is an ineffective response to youth crime, and it is costly. GPS monitoring does not address the issues of children who have come in contact with the system. Rather, it creates an additional opportunity for young people to fail as they continue to navigate the same community, situations, and hardships. When a young person commits a delinquency offense, there should be an intensive, holistic approach to target interventions that would enable successful changes in their life. For instance, connecting them to a credible messenger, job opportunities, economic securities, and nonprofits that will help any underlying root issues that a young person is facing. It is possible that if we spent the money it would cost a GPS device to pay for the individual to go to driving school, get their license, pay for college applications, school tutors, food, rent, or transportation, maybe that young person would leave their encounter with the system with more opportunity for success rather than increased opportunity for failure. I write in opposition to SB 365 because it doesn't target interventions that inhibit a young person's success. GPS monitoring is not the most effective use of funds. It essentially kicks the can down the road. Why not spend that money on targeted interventions that might lead a young person to becoming successful and contributing to their society? Thank you for your time.
Thank you. Comment or question from members of the committee? Comment or question? I don't see any. Thank you for being with us today to provide us with your testimony. Next, we'll hear from Walt Cupson, Jeremy Stein, and Robert Goodrich. Walt Cupson.
Yes, good afternoon. Welcome, Judiciary Committee. My name is Dr. Walter Cupson. I'm the outreach coordinator for the Connecticut Citizens Defense League. I am speaking very briefly on my opposition to Senate Bill 16, House Bill 5416, but for my support of Senate Bill 388, House Bill 5412, and lastly, my support for House Bill 5415. This morning I've been listening to the Zoom since the beginning and listening to Commissioner Ravella speak about several times how, in terms of SB 16, he wanted to, quote, tailor and tweak the language several times. And I could not disagree with them more. 85% of this bill is pure gun control, and it's not crime control. And that's what you need, is you do need crime control. And I do want to thank him for his testimony, pointing that out. He said something about the statewide firearms trafficking task force being dormant for some time. And we're all very much aware of that in the gun community. This is despite repeated attempts to get it funded for us to crying from the wilderness that this needs to be done in order to help reduce crime. And I would like all of you, and when I say you, I mean our leaders, our government, to take a good look in the mirror as to why we have this problem with crime. It's a lot easier, I understand, to ban an object, to demonize an object and say that's the cause of the problem. But that's not the cause of the problem. As data has borne out, it's not the instrument, it's the actual disease that's the problem, which is crime. We can all do this together. We can work together to reduce crime, but please do not keep giving us bills like Senate Bill 16, which 85% of it is pure biased gun control. It will not work. and it shouldn't work. It's completely unconstitutional on many grounds. I could spend the next 3 hours discussing why it isn't, but also from a practical point of view, it will not work. It won't do a thing for crime. And then we'll see an additional gun control bill being proposed, because there will be no end to this. I thank you for your time. I'm happy to answer any questions.
Thank you. Senator Kissel.
Thank you very much, Mr. Chair. I just wanted to say thank you for being patient. I know we have a ton of people still left to testify, but I agree with you wholeheartedly on Senate Bill 16. It's pretty much the governor's proposal, and frankly, and I have no disrespect for Governor Lamont, but it's crime, and it's not a knee-jerk reaction regarding guns. And again, the only people that would end up getting caught in a lot of these measures are the law-abiding citizens of the state of Connecticut. So thank you for coming and expressing your opinions. I just wanted you to know that I'm listening and I agree wholeheartedly. Thank you, sir. Thank you, Mr. Chair.
Thank you, Senator Kissel. Representative Trubisky.
Thank you, Mr. Chair. And thank you, Mr. Cupson, for coming in today. You had mentioned a couple of different bills that you were opposing and supporting. I'm sorry, I didn't hear the one you said you were supporting. Could you?
Sure. So for me, they're actually pretty easy support. So Senate Bill 388, an act concerning the defense of a person or person's dwelling place or work or motor vehicle. To me, not only am I obviously a permit holder and I carry everywhere that's allowed by law, but I'm a self-defender, right? I tell people all the time that the firearm is just a tool. It's not your weapon. This is your weapon. And one of the things I don't professionally teach this, but this is something that I learned for myself and try to pass on nuggets of information to friends and family, is, parking lots, gas stations, liquor stores, convenience stores. Those are places, they always have been places where it's a very easy target for criminals. And now more so than ever. So I can absolutely tell you, I can absolutely imagine a situation where I'm in my car and I'm pumping gas, and as I get into my car, someone is going to come in, could even be a juvenile, comes in from the other end to carjack me or to point a weapon at me. I won't, not only do I have no need, or should I have any need to retreat before defending myself, I have no practical way of retreating to defend myself. So for me, 388 is an absolute no-brainer. It should be common sense that my ability to defend myself in that situation, in my vehicle, even in my own home, as someone is trying to steal a catalytic converter and points a weapon at me, I may not be in a situation where I can retreat. So to me, it should be common sense. This should not be conflated with gun violence.
Was that the only one that you were supporting?
No, sir. I also support House Bill 5412, an act concerning the duty to retreat in a religious house of worship. Again, the example I'm going to use is what happened in White Settlement, Texas. Everyone remembers the story of Jack Wilson. For those of you who don't, Jack Wilson was then, at that time, 71 years old. He was a volunteer security team member at the West Freewood Church of Christ in White Settlement. An armed gunman came into the church, leveled his shotgun at one victim. Both that victim and Mr. Wilson drew their pistols. The gunman shot and killed Mr. White with a single shot, and then turned his gun to another victim who was also killed. But then this one armed parishioner, 71 years old, Jack Wilson, was able to end this attack in 6 seconds. So imagine a world where either he wasn't allowed to carry in church or he was required to retreat. How many more people would have died in that church? That's just one other example. And then lastly, my support of House Bill 5415, an act concerning the transfer of assault weapons and large capacity magazines. This to me is a blatant attempt to just make all of these things that people are scared of, that the vast majority do not commit any crimes. None of my firearms have harmed or killed anyone. It's a blatant attempt to get them to disappear from the state. There is no reason why I should not be able to sell. If I am legally able to own these objects, why I cannot sell them to a person who is also equally, by the eyes of the law, able to own that property. So to me, that's a no-brainer.
Now, under the current regulatory scheme of so-called assault weapons and large capacity magazines, each of these devices, the firearms and the magazines, needs to have been declared to law enforcement back many years ago, right?
Correct.
Okay, and is it your understanding that under 5415 that this would only allow the transfer from one individual who already possessed declared firearms or magazines to another person who had already possessed declared firearms and magazines?
That is correct.
Okay, so is it your understanding that this doesn't open up the market? There isn't going to be gun stores with these items in stock. It's just the transfer via a federal firearms license dealer through that dealer from one individual to another.
Sure, and a lateral move, if you will. So the state won't gain any of these demonized objects, nor will they lose them. It would be a lateral switch between two people who have owned these objects and presumably should still have them because they have not committed any crimes, either crimes in general or crimes with these objects. Yes.
Okay. Well, great. Well, I appreciate it. Thank you for your coming in and testifying today. And thank you, Mr. Chairman.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none, thank you very much for joining us today. We will next hear from Jeremy Stein, followed by Robert Goodrich. Then
Mr. Chairman, Representative Palm.
Oh, I see. I'm sorry. I see Representative.
I'm so sorry to interrupt you. My hand function just keeps turning off by itself. I don't know why that is. I'm sorry. I have a couple of questions for Mr. Cupson, please, if you will bear with me.
Dr. Cupson, thank you.
Dr. Cupson, all right. Do you consider yourself, I assume you are an owner of firearms, yes?
Correct.
And you consider yourself a responsible gun owner?
Very much so.
Okay. Can you explain to me why, whenever there is a mass shooting, there is no outcry from CCDL?
Who would ever say there's no?
Well, excuse me, I'm sorry, nothing that I have seen or read, I meant to say.
I think that's I think that can be, I think that's a fairly offensive question because every CCDL has 42,000 members. Our president is a single female with a child. We all have children. We all are just as upset about what happened in Sandy Hook or any other event. I can't comment on our whatever posts or press releases we've had, but we constantly hear from folks that we don't care about these things, and I find that very offensive. Of course we care. I would turn that around and say that every time there is an event like this, it is the other groups that harp on it and call for the demonization of these objects and these tools that we own. None of my guns have committed any violence. So I think that question could be posed both ways.
Representative, before you move, I'm going to say to you the that we've said to others, please.
Senate Bill 388. And having a juvenile presumably with malice of forethought, trying to get into the car. What would happen if a person with, let's say, early onset Alzheimer's who was just confused, who got into your car by mistake? Would you feel that was justified to shoot that person?
I'm not a lawyer, but I think if I could articulate that whether someone had mental illness, evil in their heart, they were under the influence of drugs, if my life is being threatened, I must do what I must do. And that includes retreating, as well as using my firearm. I would do whatever I needed to do to protect my life so I could go home at the end of the day. I would use my judgment, okay, not only as a human being and a responsible gun owner, but as a physician to sum up and make an equation in my mind as to what the issue was. Now, I'm observant enough in these situations where I have enough situational awareness. We're talking about scenarios, right? So I'm in a parking lot, I'm in a gas station rather, 2 in the morning. And if I see someone who is elderly, who is wandering around the parking lot, I already have that person. I'm sort of not profiling them, but doing an assessment, as I do as a physician, as to what is going on. And I can make an assessment that is probably not a danger to me. Now, if that person approaches me, I'm continuing to reassess the situation and figure out what's going on. So,
Sorry, go ahead.
yeah. Whereas in a similar scenario, I see someone who's young, not suffering from Alzheimer's disease, who is clearly scoping out the parking lot looking for victims. I'm already at a heightened sense of awareness. So my hope is to get out of there. My hope is to assess the situation and never have to pull my firearm. But I want to be able to do so without penalization in a situation like that.
Okay, I understand. What about people who don't have your, to use your term, situational awareness?
I couldn't speak for every single gun owner, but all of the gun owners that I know think very much the same way as I do. We don't ever want to use our firearms. We avoid situations like this, okay? This is our weapon. Our eyes are our weapons, okay? The firearm is simply a tool, and a tool of last resort.
Okay, thank you. And then finally, you testified against SB 16, correct? I mean, you're opposed to that.
SB 16 and House Bill 5416.
Do you believe that the data collection that bill would provide would be helpful?
Data collection?
But being able to assess the roots of street crime based on police reports and all would be helpful, yes.
Oh, of course, absolutely. We want data. And I would hope that that data would include not only instances where, we need to know the roots of where these legal firearms were from. What's the ratio of crimes committed with legal firearm owners versus illegal? And conversely, if we're going to look at harm, we also want to look at benefit. So if we're looking at the number of harm caused by any kind of violent crime, whether it's from firearms, fists, knives, bats, we also want to look at the pros, okay, of these things. So I would want that data to include what we call defensive gun uses, which are often not highlighted the way that the other statistics are. So yes, data is everything.
And then finally, I wanted to ask you the same question I asked the commissioner, which has to do with a report from the Gifford Law Center that gun violence causes between $60 and $90 million taxpayer funds each year here in Connecticut. Are you aware of that? And I ask because it figures directly into SB 16 again as data collection to prevent violence.
Sure. So everything is a balance, right? So do we want to reduce the cost of crime in general? Of course we do. But we also want to do it very carefully and thoughtfully without impacting a great many number of the 300,000 legal gun owners in Connecticut and the gun owners across the country. if we're going to do something, we want to do it fairly. We want to make sure it makes financial sense, and we want to make sure it is also not causing harm to our rights and our constitutional rights.
Okay, fair enough. I also think non-gun owners and families of victims also have rights.
Of course. And as I said, we all need to work together to solve this problem. But proposing patently anti-gun measures, like making a .22 rifle illegal because it has a cosmetic feature, is not going to accomplish anything.
Thank you, Representative. Senator Champagne.
Thank you. And Rob, thanks for coming in today.
Thank you, Senator.
Question for you. Can you tell me when people are arrested for gun charges, especially the violent incidents, what's the first charge dropped when they go to court?
I'm going to guess it's probably legal possession of a gun, but I couldn't tell you for sure. I know that I think I'm pronouncing this correctly. Is it the nollie rate?
Yeah.
Okay.
Yes.
So yes. So I've been absolutely appalled, and that's one of the things I believe I included in my testimony. Absolutely appalled at the rate, and I don't know how Connecticut compares to other states. I couldn't tell you, but I was shocked when I read the nollie rate in Connecticut. So we're going to take the laws we already have, and we're going to just ignore them. But let's put on other new laws. It doesn't make sense to me.
Senator Champagne,
Sorry.
admonish you the same way I did Representative Palm and everyone else. Questions about the bill itself.
Yeah, I understand, and it has to do with the bill, because the bill is making more laws that are making more guns illegal. Yet if the bad guy gets arrested with those guns, it's going to be the first thing that's dropped in court. And that was going to be my point. We can make as many laws as we want about firearms, but what it comes down to is the fact that the court's not going to uphold when people are arrested for the use of these illegal guns, then what's the use of making any more laws? And that's what it comes down to. If you do the research, in fact, if we're doing research, that'd be a great thing to research too. How many of the gun cases are the guns the first thing they drop? If we're not going to enforce the laws we have, stop making more laws. And thank you. Well, thanks for coming in today.
Thank you, Senator. Thank you, Representatives.
Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us. Enjoy the rest of your day. We will next hear from Jeremy Stein, followed by Robert Goodrich, and then Warren Stevens. Jeremy Stein.
Thank you, Senator Winfield, Representative Stashram, ranking members Kissel and Fishbein, and distinguished members of the Judiciary. I'm Jeremy Stein, the Executive Director of Connecticut Against Gun Violence. I'm submitting testimony in support with concerns of SB 16 and in support of HB 5416, and as well as in opposition to Senate Bill 388, HB 5392, HB 5412, and HB 5415. I am focusing my testimony today on what we view as the most important aspect of SB 16, which is the funding of community violence prevention and intervention strategies as proposed by Section 33 of the bill, which is around line 1504. This past year, gun homicides were the highest in 25 years, with 118 homicides in Connecticut. The Hartford Courant declared that 2021 was the deadliest year in Hartford since 2003, with 35 homicides. In 2020, gun homicides increased 50% in Connecticut compared to 2019. We must invest more in reducing community gun violence using evidence-informed, community-focused strategies that will employ prevention, intervention, and aftercare initiatives without contributing to mass incarceration. The public health crisis of gun violence disproportionately affects communities of color. Gun shooting incidents, homicides, and injury in Connecticut disproportionately affects Black and brown communities, especially in our largest cities. Young Black men in Connecticut are almost 39 times more likely to be murdered with a gun than white men. If we want to achieve racial justice, we must make people safe in the communities where they live. To do so requires funding evidence-informed solutions to gun violence. We support the governor's proposal to create a statewide community violence intervention program under the Department of Public Health, as well as a $3.6 million and American Rescue Plan Act funding to support this proposal. However, this funding, while we appreciate the governor's efforts, should be increased to maximize the state's efforts to reduce gun violence. Connecticut needs to recognize the severity of the public health crisis before us. The urgency of this crisis would be better addressed by creating an Office of Gun Violence Prevention as proposed by House Bill 5397, which will expand the Department of Public Health's Office of Injury Prevention and establish and administer a grant program to fund organizations that conduct evidence-informed, community-based initiatives to reduce gun violence, collect data on gun violence in Connecticut, and make the data publicly available to researchers and others, collaborate with researchers to enhance evidence-based gun violence prevention solutions, and makes policy recommendations to decrease the effects of gun violence on public health. Across the country, evidence-informed, community-centric prevention, intervention, and aftercare programs have proven records of success. Beyond the loss of life, gun violence has tremendous economic costs. I believe Rep. Palm just mentioned this. It's estimated that the direct cost of Connecticut taxpayers of all forms of gun violence is $90 million per year. The true cost are somewhere around $1.2 billion per year. Investing in prevention, intervention, and aftercare will not only save Connecticut, but will also save lives.
If you could summarize.
Yes, I'm done. Thank you. My last sentence, sorry, I didn't mean to cut you off. Investing in prevention, intervention, and aftercare strategies will not only save Connecticut money, but will also save lives. We're asking that you support these initiatives and fund community-level prevention and intervention strategies.
Thank you. Representative Blumenthal.
Thank you, Mr. Chair. Nice to see you, Jeremy, and thanks for your testimony. Good to see you today.
You too. Thank you.
I just had a couple questions. My first one is focused on the collection aspect of the bill with regard to the Department of Public Health. And I was curious, first of all, if you think it's important for such data on gun violence to be collected, and also whether it's important for it to be collected by entities focused on public health and that are not advocacy organizations, and if so, why?
Yes, it's an excellent question. I do agree that it is important for us to collect the data. It is important if we're going to solve any public health crisis, of which gun violence is, to start with the data. We need to make sure that we understand the problem like any other health problem, and starting with the data is critical. What we have right now, though, is we have the data being siloed in certain organizations, and it's hard to get that data. If you want gun death data, the best source is probably the medical examiner's office. But the police also have some of that information. Hospitals also have some of that information, which may be protected by HIPAA. And I think it's important that we not only look at gun death, right? Because gun death may be a factor of how close a hospital is to a shooting, what type of guns are being used, et cetera, et cetera. We need to also be looking at shooting data. And shooting data is much harder to get. Certain police agencies have that if they have things like ShotSpotter and otherwise. So if we are going to understand this problem and we're going to address root causes of the problem, then we need to look at the data and look at this from a scientific point of view.
I appreciate that, and it's very helpful. I agree with you. I think we need comprehensive data from unbiased institutions that are focused on the public health, on gun violence and gun violence prevention, like all other matters. I think it's especially apropos today, considering, we were hearing earlier from Professor Lott a lot about data, and in particular data that he claims supported his hypothesis that more guns in certain areas lead to less crime. I did some research myself towards the end of his testimony and was surprised to find that his research on that subject had essentially been debunked by a Stanford Law Review article by 2 economists and a law professor that showed that his results were shown to be a result of coding errors in his data collection, and that they, quote, irretrievably undermine every original regression result that was presented. Were you aware of that article and the fact that that research had been debunked?
Yes, I was. I'm very familiar with John Lott. There are many respected researchers who have looked very closely at John Lott's flawed data. One very basic example is when, in part of his research, when he was referring to gun-free zones, he labeled Fort Hood, a military establishment, as a gun-free zone. Obviously, an area that has lots of firearms. Also, they looked at some of his influence. You talked about unbiased data and unbiased research. One of the board members of his research group was Ted Nugent. Ted Nugent was also on the board for the NRA. So, John Lott has an agenda. He has a book that he has put out, More Guns Equals Less Crime, I believe is the name of it. But there are many, many researchers, including researchers from Johns Hopkins and other very respected institutions that have looked at his data and have deemed it to be flawed.
Thank you. And, just in addition to that, I would add that the Stanford Law Review article that I referenced, in addition to finding that the data that Professor Lott had used was flawed, found that it actually resulted in showing the opposite result, that in fact, places in the United States that have looser gun laws and more guns, in fact, have a high rates of violent crime, and the only difference on murders is statistically insignificant. So I think, that just highlights the importance of having comprehensive data from institutions and entities that are built to develop that data for the service of furthering the public health. And I think that's why this particular aspect of the bill is very well taken. And I think why it's important that you're here today testifying on it. So thank you, Jeremy, and thank you, Mr. Chair.
Senator Haskell, followed by Representative Dubowski.
Good afternoon, Mr. Chair, and thank you for the time. Jeremy, thanks so much for your testimony and for the good work that CAGV does. You focused your testimony on a provision of the bill that I wholly support, and I want to just ask you to perhaps comment on another item on the agenda today, given your organization's expertise in gun violence prevention. Curious about CAGV's position on the prohibition of bulk purchases. This is something that seems to have demonstrably reduced crime in Maryland and California, New Jersey by limiting bulk purchases and cracking down on straw purchases. Would you be willing to weigh in on that bill as well?
Sure. We support anything that is going to have an effect on reducing gun violence. While HB 5416 is not our main agenda, it's not. We do support it. You and I have had these conversations before, the idea behind, and I think one of the most dramatic examples of what happens when there's unfettered purchases of firearms is we saw during the pandemic that there was a dramatic increase in purchasing, and it wasn't first-time buyers. Many of the purchases were people that were running to the gun stores because they thought that somehow guns were going to be eliminated or they'd lose the ability to buy guns. And so what's shown in the past is that an increase in guns equals an increase in death. I'm not talking about whether or not gun owners are lawful citizens or not. What I'm talking about is just the strict data of the more guns you have in a state, the more gun death you are going to have. That is supported by data. Handgun purchase limits have shown to be an effective way of reducing gun trafficking. Approximately 20 to 25% of all handguns recovered at crime scenes nationwide were originally purchased as part of a multiple gun sale. And handguns sold in multiple sales are up to 64% more likely to be used in crimes than handguns sold separately. So these are dramatic statistics. 4 states have already had limits, including Virginia, a very conservative state. They introduced a 1 gun per month, where there was a significant reduction in the number of crime guns recovered. While not our priority, we do support the House Bill 5416. 1 gun per month should be sufficient to satisfy people's needs to be able to own a handgun or otherwise.
I would agree, and thank you so much for that testimony. Really helpful for our committee as we continue to deliberate, and we appreciate your time today. Thank you, Mr. Chair.
Thank you, Representative Bisky, followed by Representative Hall.
Thank you, Mr. Chairman, and thank you, Mr. Stein, for coming in. You rattled off a bunch of statistics. At the same time, you said that there wasn't enough data collection. So where did you get your statistics?
I'm sorry, which statistics specifically were you referring to?
Okay, well, you said that that black men were, was it 37% more likely to be killed by a firearm than white people? Is that correct?
Yes, I believe that's from the CDC.
Okay.
The Center for Disease Control.
How many of those are were shot with legal firearms?
How many were shot with legal firearms? Yeah. I don't know that statistic. I don't know if the CDC keeps that statistic, partially because the CDC had been prohibited from studying that data. So a lot of gun violence research we do not have because of the years of Congress prohibiting that, which is why we need more data, more research, so that we can answer questions, relevant questions, to try to reduce gun violence in our country.
Okay, so they were allowed to research that enough to say that it's 37 times higher for black men, but not enough to research whether or not those shootings were with legal or illegal guns. Is that what your testimony is?
I don't know what the CDC's capability was. You would have to ask the CDC. I don't mean that disrespectfully. I don't know the answer to your question as to why. I do know that the Dickey Amendment prohibited the CDC from doing any kind of robust research for years.
Okay. So as far as we know, there might not have been a single legally owned firearm that created that statistic.
Well, all guns start out legal, unless you're stealing them from a manufacturer or manufacturing them yourselves in your basement, which is why we passed a ghost gun ban and a 3D printer ban in Connecticut. All guns start out legal, which is, I believe, the purpose of why they're trying to pass a bulk purchase law is to prevent the sale of guns and then the resell those illegally or the transfer those illegally.
It's not right. All guns don't start legally, do they? There are guns illegally brought across the Mexican border that were never legal, right?
Where do you think they're getting the Mexican guns from?
Just one second, Representative. Please just answer the questions. Thank you.
Sorry. So to answer your question, the guns that are coming across from Mexico, I don't know what the statistics are, but there are guns that are exported from the United States outside to other countries that then end up making their way back to us. So they start, once again, they start out as legal transfers. So the U.S. government would then would be either selling or delivering guns to other countries. Then those guns make their way back illegally into our country. So that's what I mean by they start out as a legal gun.
Okay, but I'm going back to the statistics. We're talking about 37% that black males are 37 times more likely to be shot. And I'm asking you, at the time those firearms were used, you don't know whether they were legally possessed or not, because there aren't the statistics, right?
Yeah, I'm not sure, but to your point, the majority of those violent crimes were probably conducted by people who possess those guns illegally, based on statistics. If that's your point, a lot of the gun crimes that are occurring in our cities, the community violence, are being committed by people who possess firearms illegally.
And as far as you know, none of those firearms involved in creating that statistic were legally owned and possessed and carried at the time that they were used.
I'm sorry, are you saying none of them were? I don't know this. I don't know the breakdown. That statistic is based on the CDC's Whiskers site. It's based on public health data. It's based on data that they received from hospitals, law enforcement. That specific data point was not to address whether the guns were legal or illegal. It was to address the disproportional impact of gun violence on Black and brown communities.
And how many of those, you also said that homicides are up in Hartford to a record this year. Is that correct?
That is correct.
Okay, and how many of those were justifiable homicides?
I assume very few. I don't know if there were any justifiable homicides in that number.
But you don't know.
Once again, the data point is to represent the extent of the impact of gun violence. Whether it's legal or illegal, we're still talking about a loss of life, which is really what we should be concentrating on. Whether you're justified or not in taking a life with a handgun, someone still dies. And I think it is important. There's been a lot of debate that I've heard today about whether firearms are justified, whether people can stand their ground, et cetera, et cetera. The bottom line is, as our organization is trying to reduce all forms of gun violence, justified or unjustified, because we're trying to save lives.
Okay, but if somebody is coming,
I'm gonna keep saying to everyone, if we cut people off, let them finish up, and then you ask your.
I thought it was finished. I apologize. Go ahead, Mr. Stein, if you have more to say.
No, that's fine. Go ahead, Representative Dubitsky.
Okay,
no offense.
I interpret your answer as saying that there is no difference between justifiable homicide and murder. And
no, that's not what I said at all. I'm sorry. That's not what I said at all, Representative Dubitsky. I didn't say there wasn't any difference. What I said was the point that I was making was that gun violence has increased in our cities exponentially. That we need to develop prevention, intervention, and aftercare strategies to try to reduce that. The legal difference between a justified homicide and murder, I understand the difference. I was an attorney, I am an attorney, I was a prosecutor and a public defender for many, many years. So I do understand the legal difference between the two. But what I'm saying is that when we're talking about the loss of life, whether someone is justified in killing someone or someone is not justified, we're still left with a dead body.
Okay, but in the case of a justified shooting, if the person who fired the firearm didn't do so, there very often would still be a dead body. It would just be a different dead body.
I don't think that is true at all, especially when we're talking about that is simply not true. And I think you have to take that as a case-by-case basis. There's been plenty of police shootings that were justified, but that did not need to end in the loss of life. Just because someone was justified in pulling the trigger does not necessarily mean that it was necessary.
Okay. How many of the people shot in Hartford this year were shot by police?
I don't know the exact number.
Representative,
but it wasn't. It was not the majority of the number. Sorry, Representative. I think you know what I'm going to say to you. I'm having a hard time figuring out the connection to the bill, and you may have a connection. I'm just saying to you that it feels like we're getting a little afield from the bill.
I understand, Mr. Chairman. Mr. Stein set out a bunch of statistics early on in his testimony, and I'm just probing the veracity of those statistics and what they mean and how they would affect whether or not to support or oppose bills that are before us. So I'm trying to find out what his statistics are based on and whether he's got information in those statistics that would be relevant to the passage or not of these bills.
I recognize that, and I'm going to let you proceed, but I'm going to listen carefully because I just don't want us to try to dig into information so deep that we are kind of missing the point, considering we still have about 200 plus people left to go.
Understood. So, Mr. Stein, you don't know how many of the people shot in Hartford were shot by police?
No, I don't know the exact number in Hartford. I think from data that I had back in June of 2021, at that time, there were about 5 people that were shot by the police in 2021. But I don't know the specific number in Hartford. I can get that for you.
Do you know how many of them were on public transportation?
No, I do not.
Do you know how many of them were in government buildings?
I do not.
Do you know if any of them were in government buildings or public transportation?
No.
Do you know of any statistic anywhere in the state that would justify banning firearms by legal permit holders from public transportation?
It's a good question. It's not the focus of our organization, that part of the bill. I'm sure there is good reason, but I do not have statistics as to why, as to the number of incidents that have happened on public transportation.
You denied in your testimony that the Fort Hood shooting took place in a gun-free zone. Are you aware that individual soldiers, sailors, airmen, and Marines, when they're on base, are not permitted to carry firearms?
In certain areas in Fort Hood, yes, but there is also are you aware that there is a police force that is present in Fort Hood, and there were armed individuals on Fort Hood that also responded to the shooting? So my point is that regardless of what the military's policy was in terms of who can carry and who can't carry, number one, there were firearms present on the premises. Number two, there was a police force on those premises, so it was not considered. It wasn't a gun-free zone because there were guns in Fort Hood as well as a police force.
Well, in every gun-free zone, it is gun-free because the location is supposedly protected by police. Do you dispute the statistic that 94% of mass shootings take place in places where the average citizen is not allowed to carry a firearm?
Yes, I do, and as do many other researchers across the country.
Okay, but you in denying that, you're changing the definition of gun-free zone to include any place where police have firearms.
No, I'm not changing the definition at all. My point was that it was John Lott who redefined what a gun-free zone was so that his research could establish his agenda that is the NRA's agenda, that to increase the number of gun owners in this country.
Decrease the number of gun-free zones.
I think the definition of what a gun-free zone is self-serving.
What is your definition?
I don't have a definition of a gun-free zone. I use the definitions that other organizations in their research. It's not significant. Definition of what a gun-free zone is something that the NRA and gun advocates use, but it's not essentially something that is defined in real research that is used as gun reduction strategies.
Gun reduction strategies.
Sorry, gun violence reduction strategies, excuse me.
That was a Freudian slip. You say that 25% of guns used in crime were originally part of a bulk purchase. Is that, did I get you right?
I would have to look back. Excuse me 1 second. I believe it's 25%, yes.
Okay. So the vast majority of firearms used in crime were not part of a bulk purchase. 75%.
I'm not sure I follow you.
You said that 25% of the guns used in crime were originally purchased as part of a bulk purchase.
25% of all handguns recovered. Bulk handguns recovered.
So 75% were not.
75% were unable to be tracked as a bulk purchase. It doesn't mean that they weren't.
But you have no evidence that they were.
The police, once again, we don't have that data. We would have better data if that data were more readily available, if it were studied, if agencies were allowed for the last decade and a half to be able to study gun violence reduction and the effects of gun violence on our communities, which is once more why we need to have more funding to be able to look at such numbers if it is important to legislators, public members, etc.
So that 25% statistic is useless because you have no idea what happened with the other 75%.
Well, it's not useless if 25% of the guns recovered is a pretty significant number. If you could reduce the number of guns that are being used in crimes by 25%, then the number of crimes that are being committed by guns by 25%, I don't think that is insignificant at all.
What makes you think that making a law that says you can only buy one gun a month would take that 25% of all firearms used in crimes and take that out of the equation?
I'm not sure that, well, so I think it is something that we have to look at. It's something that would have to be researched as to the effectiveness of the law, but you cannot know what the effectiveness of the law is in a vacuum. Once again, this is something that should be looked at and studied. I do agree that there needs to be more data to decide whether or not a strategy like that would have an effect on reducing gun violence.
So there needs to be more data before we pass this law.
That is a question for you as legislators. I would like to see more data, which is why that bill 5416 is not our prime agenda. This is something that I've discussed with legislators for the last couple of years. I believe that it could be an effective strategy, but I would like to see more data before we, in the past, there has been one, maybe two laws that the legislature has concentrated on. And I think that there are much more effective strategies on reducing gun violence that are currently being proposed that may have a greater chance of reducing community level gun violence specifically. I believe that we do support 5416, but do believe that 5397 would be a better solution at reducing gun violence.
And you also mentioned that there was a ban on doing research by the CDC. That ban didn't affect anything at the state level, right?
No, it absolutely did affect things on the state level, because researchers on the state level seek funding from the CDC and the NIH. So a lot of researchers at the university level, they are getting their funding through those big federal agencies. So if the CDC can't study it, they then can't issue grants either to allow universities and local universities to study that. It doesn't prohibit law enforcement, though. But once again, it is the research arm that is usually conducting these types of research on a deeper level than it is law enforcement.
All right, well, thank you for your time. I appreciate it. Thank you, Mr. Chairman.
Thank you, Representative Dubinsky. Representative Paul.
Thank you, Mr. Chair. Jeremy, hi. I just want to tell you how much I appreciate your work, the work of your organization, and how valuable I find it. And I think I may have missed coming in a little bit late when you said you supported SB 16, but with some modifications. Do I have that right?
That's correct.
Can you just briefly run through those real quickly in the interest of time? Like, if you can simply state how we might improve the bill? Is it too long to do that?
Yeah, I mean, so yes, there are a lot of things in the bill that, yes, there's a lot in the bill. I'd be happy to sit down with the legislators. I think that, I applaud the governor for his efforts on trying to create a policy that would reduce gun violence. So we do applaud the governor for that. But I do think that there could be a greater emphasis on the community level gun violence reduction strategies. So there's a lot in this bill, and as well as some of the juvenile justice aspects of this bill, I think could be troubling. We want to make sure that any of the gun violence reduction strategies are looking to reduce gun violence while not increasing mass incarceration. So first and foremost, our agenda is to make sure that we are concentrating on community level gun violence reduction strategies. And the way that we believe is the best approach to do that is, for years, the legislature has concentrated on the supply side of guns, looking at restrictions and limiting use and limiting access, which are all good strategies and are supported by data. But we do believe that now is the time to start concentrating on the demand side of guns as well, and to be looking at the root causes of gun violence, to fund community level organizations, community violence intervention strategies, as well as aftercare strategies that can provide the assistance that survivors need, that victims of gun violence need, so that the cycle of violence ends.
Thank you. Out of respect for the chairs, I'm going to not do any follow-ups, but I just want you to know again how much many of us appreciate your work. Thank you. Thank you, Mr. Chair.
Thank you, Representative. Senator Champagne.
Sorry about that. On a couple of different meetings. But Mr. Stein, thank you for coming in today. I have a question for you. You said that you support all anything with gun violence. And I asked the previous speaker about the fact that when people get arrested for possession of guns, that is the first charge dropped when they go to court for knowledge. Does your organization did they have a stand on that?
So as a former prosecutor, I think that just looking at a charge that is reduced without looking at the context of the charge does not give you a clear picture of what's going on. So in other words, I understand your concern about charges being dropped, and I share a concern if the police are arresting people for legitimately arresting people for charges and then those charges are being dropped without justification. I would share your concern. However, I think it is important that you have to look at what other charges were being charged at that time. So it is a very common practice in the court system that if somebody is charged with, let's say, a murder, and there was a murder with a handgun, and then et cetera, there may be 10 different charges that they charge, and it is not atypical for someone to be convicted of, let's say, murder, and then in the interest of justice or the interest of time and economy, that they then will either dismiss the charges, the lesser included offenses, or those will be incorporated into a greater charge. So, I would like to see data once again on, I've heard this over the years of that these charges are being dismissed, and it's that is a shame that these charges be dismissed. But I also think it's important to see what is the context under which these charges are being dropped. Are they all like murder cases? Are they all homicide cases, and they're just lesser included charges that are being dismissed? Or are these cases where this is the only charge and they're being dismissed? Once again, I do think that is a question to address to the state's attorney's office and to the court system. And I do think that the coordination between the legislative branch and the judicial branch, as well as the state's attorney's office, is a very important one in making sure that gun violence reduction strategies are as effective as possible.
As I said to the previous speaker, we pass all these gun laws, but we don't uphold them. The fact is, it's not just 1, 2 cases, or 50 to 75% cases. Most cases, the gun charges are dropped. And my point on this is we can pass any law we want, but if we have repeat offenders, they're going out, getting arrested multiple times, and the gun charges are dropped, nobody's safe. Right? And that's a concern that's been brought to me by many people who work in the court system, because it happens over and over and over again. So we can pass any law, like I said, it's not going to help. I'm going to leave it at that. Thank you.
Mr. Chair, if I can respond to that real quickly.
I don't think there was a question. I'm going to keep us moving because we are
sure.
Yeah. And you have several other people who want to talk to you. Representative Fishman.
Thank you, Mr. Chairman. Good afternoon, Mr. Stein.
Good afternoon.
I take it from your testimony that you're in favor of Section 33 of SB 16.
Correct.
Okay. And you also recently stated that you think the best way to deal with this is perhaps 5397, which is not before this committee. The two work together. You would agree?
Yes, I think that the governor's strategy of funding community violence intervention strategies under Section 33 could become part of 5397. The difference between the two is that 5397 is a little more spelled out. It's a little more holistic. It has very specific items in that bill to establish an Office of Gun Violence Prevention, which would be charged with some of the items that were discussed today. Research, a grant source, dedicated funding for staffing, because as we heard from the Department of Public Health earlier, they do not have the resources right now to be tackling this issue. They do a lot, but one of the things that we have heard, is that they need dedicated staff, and which requires funding.
Well, in fact, I think that other bill that the Department of Public Health was talking about earlier today, 5397, provides for grants to outside groups.
It provides for both.
Yes. And I have to ask you, have you been promised or implied that your organization is going to be a recipient of funding that's contemplated by Section 33 or 5397?
No, in fact, and it's a good question. In fact, we have specifically told legislators for the last 2 to 3 years when we've been trying to pass this legislation that
Connecticut Against Gun Violence does not want any of the money, would not be asking for the grant money because we do view it as a conflict of interest. Part of the 5397 is the creation of advisory council. We do believe that advisory council should be made up of partners that will not be getting grants because it does create a conflict of interest.
So the fact that the CAGV created an educational group just last year is of no coincidence to this, and that group will not be receiving any such funds either?
I'm sorry, I'm not familiar with an education group that we created last year. We've had you're referring to Connecticut Against Gun Violence Education Fund?
Yeah, actually.
That organization was founded in I believe, 1996.
Yes, okay, I see the filing of this last year. So am I to understand that that group won't be receiving any funding under this legislation either?
No, yes, that is correct. Neither Connecticut Against Gun Violence, Inc. or Connecticut Against Gun Violence Education Fund is seeking any money from an Office of Violence Prevention. The money that is proposed to fund this is to go to violence intervention, prevention, and aftercare organizations, that some of which already exist and some do not.
Okay, and 5416 having to do with the bulk purchases. Are you aware of individuals who purchase, when somebody dies, they've got a collection of, let's say, World War II firearms, and somebody wants to purchase a few of those in the memory of their family members serving in the military? 5416 would prevent those purchases. Is it fair to say?
I think that I'm not sure, but I think if the idea is to, as we've seen time and time again with legislation, I think if the idea is that you want to cater to specific gun owners or to antique dealers or people who are collectors, then that should be something that is carved out as an exception, rather than kill a bill that could act to reduce gun violence. So I'm not sure the answer to your question, but certainly every bill should be looked at to make sure there aren't unintended consequences. I believe the purpose of the bill is to reduce the cases of bulk purchasing that would then end up in straw purchasing and then more guns being used for the commission of crimes. I believe that's the idea behind the bill, is to reduce the number of illegal guns ultimately.
Yes. So straw purchasing, have you seen any statistics on straw purchase arrests or convictions in the state of Connecticut in the last decade?
I've seen them. I couldn't tell you this. I don't have the statistics before me right now, but I have seen statistics.
Okay. Well,
I don't know what the statistics are. That's your question.
Yeah, I mean, I've seen some.
I do think that, and I think that's the idea behind the other part of SB 16 is to actually put some funding into gun trafficking and to, once again, trace firearms. Once again, if we had better data and better research, and we could actually find the sources of these guns, that could work to reduce gun violence.
So it's interesting because were you here for Commissioner Rivola's testimony?
I had to step away for a second, but I did hear most of his testimony.
Okay, and he was asked specifically about bills that the Republicans have put in over the last 3-4 years, having to do with funding the task force, the gun trafficking task force. It was actually created by the Militia administration in 2012, and that the commissioner didn't even know about, and obviously didn't overtly support. Is there a reason why your organization didn't support those bills also?
As far as I'm aware, those bills that have been introduced were introduced as amendments to other bills that we have already had in place. Whenever I've seen,
and I'm not sure if this happens every year, but I do remember seeing an amendment, I believe by Senator Sampson, that had this type of language as a means to amend a pre-existing bill. That's my recollection as to why we support some legislation and why we don't support other legislation. We prioritize legislation. We prioritize those pieces of legislation that we think are going to have the greatest chances of reducing gun violence in the state of Connecticut. And that means that we support some and not others.
I understand your representation, but I will correct you, sir, in that specific bills were put in. For instance, in the year 2020, HB 5157, which was submitted by 13 various members who happen to all be Republicans, provided for a bill to fund the statewide firearms trafficking task force. And that was a bill. It was not an amendment. Also that year, SB 126 was put in as a bill, not as an amendment, to fund the task force. So I'm just trying to, it appears political. And, the issue has been out there. We've been talking about it for years, and now all of a sudden it becomes a priority. And I'm just trying to figure out why. Is it because Republicans put it in? I guess that's rhetorical. But I don't know if you have a response now that I've pointed out.
No, I do have a response. I think that the point I'm trying to make is that portion of this bill is not our priority. It is not our organization's priority. Our priority is Section 33 of SB 16, which is part of a strategy to fund community level gun violence reduction strategies. We do believe that the better approach would be HB 5397. So that portion of the bill, while we support it, is not our priority.
Understood. Thank you. Thank you, Mr. Chairman.
Thank you, Representative Fishbach. I'll just make a slight commentary because I've listened to that question all day. It has been a frustration of the subcommittee chair over in appropriations that we can't fund those things either, even though money has been at times put into the budget. I will next hear from Representative Howard.
Thank you, Mr. Chairman. Hi, Mr. Stein. Thank you for being here today, and I'll be brief in the interest of everyone else's time. I just want to talk to you a little bit about 5416. I know it's not CAGB's priority. That is the bulk purchase bill. And are you aware, I think Representative Fishbein asked this slightly different, just to make sure I understand. Does CAGB have any statistics on the amount of gun purchases within the state of Connecticut that are being illegally transferred on the street?
No, I don't have specific statistics, and it is something we've requested in the past, when this bill was introduced last year, I believe, that may have been the first time it was introduced, or it may have been introduced the year before, but we did try to get data because, we are serious about what we support and what we don't. We want to make sure that it's supported by evidence. And so we did not have direct data that showed that bulk purchasing laws had a dramatic effect on reducing that type of gun violence that we were trying to reduce, which was community level gun violence. Since then, other states have passed laws like this: California, Maryland, New Jersey, and Virginia. I don't have those statistics at hand, but I believe that Virginia specifically, their 1 gun per month did show a reduction in the number of crime guns that were being recovered, not only inside the state, but outside of the state, that was being traced back to Virginia.
Thank you. So I'm a legal gun owner in this state. Is it your position that every single time I purchase a new firearm, I become an increased risk to public safety?
That each time you purchase a firearm, you pose an increased risk to public safety. According to the data, the more guns there are in any given state, the greater the likelihood of gun violence. Whether you specifically pose a risk, I can't answer that. But it certainly is a factor of training, safe storage, where you live, et cetera, et cetera. So I think saying that one purchase of a gun is going to increase or decrease gun violence is hard to say. I think when you're looking at it holistically and you're looking at purchasing over a long period of time, then I think you have to look at certain strategies that you want to employ to reduce the chances of increased gun violence.
Okay, thank you for that. And I think you testified earlier that each gun starts out as legal. So in Connecticut, as you know, we have some of the strictest gun laws in the nation. It's a pretty robust process to purchase a firearm in the state. Once I purchase a firearm legally, for me to then transfer it to someone who doesn't have a permit or eligibility certificate is an illegal transfer, isn't it?
Yes.
So is it CIGV's position that criminals don't follow gun laws?
Well, you're defining the word criminal. Under your scenario, what do you mean by criminal? Because somebody who doesn't follow the law, who breaks the law, is a criminal. So labeling someone as a criminal in that scenario, it doesn't make sense. And this is the argument that we get all the time as well. Criminals don't follow laws. Well, but people don't follow laws are called criminals because they commit crimes. So it's a circular argument. The point is this. If we didn't pass laws because people don't follow the law, then what would be the point of passing any laws? Because laws don't necessarily prohibit people from breaking them. What they do is they punish people for breaking laws, and they also set a ethical and societal standard of what we want in a society and how people should behave. So there are many laws that don't prevent people from doing that. Speeding laws don't prevent people from speeding. They penalize people for speeding. Murder laws don't prevent the commission of a murder. But we do have an obligation to society to pass laws so that people can govern their behavior, and you have an ethical duty as a legislator to say, this is how we want society to behave, and this is what we want them to do and not want them to do. And so those laws, especially those related to gun ownership and gun purchasing, are vital. Lastly, I'll say data does show that states with strong gun laws, that those states that have stronger gun laws have lower gun death. States like Connecticut have a low gun death rate, and the data has shown that is a direct result of the strength of our gun laws. Those states that have weak gun laws tend to have higher gun death rate. So laws do matter.
Thank you. So, but in that realm, though, when we're talking about this particular bill, it's a chain, right? So if you're testifying in support of that bill on the premise that all guns start as legal guns, right? So if I go purchase a gun legally and then transfer it to somebody illegally, I'm not following the law. I'm already prevented from doing that, regardless of how many guns I purchase. So my point is, if I'm going to purchase guns illegally to go give them to someone, or purchase them legally to give them to someone illegally, then I mean, there's plenty of ways for me to go get guns illegally. That's my point.
I understand your point. Sorry, go ahead.
No, yeah, I'm just trying to say, like, it seems to me like, we're creating a law here. It says to, Greg Howard, the legal gun purchaser, you have two sons, okay? And you want to go buy a 22 for one, you got to wait 30 days to buy a 22 for the other to take your son's target shooting. Okay, that's what this law would do to me, agreed?
It would still allow you to buy a gun. You would just have to plan if you wanted to buy more than one gun, you would have to plan the number of guns that you buy. So yes, if you wanted to buy a gun for you and a gun for your son and a gun for your other child, this law might prohibit or make it difficult for you to do that. And so what I would suggest is that is the area of the law that you were trying to avoid. That scenario where you can buy a gun for your family members, then create an exception to that, but that doesn't change the law that might need to be in place to reduce bulk purchases and illegal transfer of firearms. If I go into a pharmacy today and I want to buy Sudafed, right, I'm limited in not only the number of pills that I can buy, but I have to show my driver's license to get it. You know, there's more regulations about buying over-the-counter cough medicine and cold remedies than there is regarding the purchase of firearms. So, you know, I think it's a minor inconvenience if you can't buy a number of guns, but perhaps you can craft an exception for those types of family hunting outings. You know, the idea behind a lot of these laws are not to make it difficult for legal gun owners or hunters or the sporting community. It's designed to reduce gun violence.
Well, that may be the design, but again, I mean, I think any father would know if you have two sons at home and you come home with one lollipop, you got a problem, right? I mean, that's how it works. But you know, and I understand guns are not lollipops. I get it. Lollipops don't kill people, guns do. I hear what you're going to say. I know that. But the point that I'm driving at is we're creating a law in this particular bill, and this is one I'm talking about, 5416. I would say to CAGV and you that we're creating a law that there's already a law that prohibits somebody from doing what you say that this law is going to prevent, which is buying guns legally and then transfer them illegally. There's already a law that prevents that from happening. And now we're creating a law that takes a legal gun owner and again makes it more difficult for me to purchase guns legally, even though I've gone through this entire robust process to do it. Do you agree or disagree?
This law could make it more, yes, absolutely. This law is going to make it more difficult for legal gun owners to buy more than one gun per month. That is the law.
Right.
So,
well, thank you.
If it's passed, then those people would not be legal gun owners if they purchase more than one gun.
Thank you.
We have a lot of people, and I've taken a lot of time. Thank you, Mr. Chairman.
Thank you, Representative Howard. Representative Gilchrist.
Thank you, Mr. Chair. Sorry. Hi, Mr. Stein. So good to see you. You were asked earlier about the potential of CAGB getting some of the funding that's outlined in Senate Bill 16. Just hoping that you could explain the difference between the work that CAGB does and the work that's these funds are intended to go towards, prevention programs, intervention programs. I think that would be helpful for folks. Thank you.
Sure. So for almost 30 years, Connecticut Against Gun Violence has been an organization that has advocated for common sense gun laws. A lot of times we start the draft of a law, we lobby the laws, we have a relationship with legislators. We also are involved in grading legislators during election cycles. And so the idea of creating the Office of Gun Violence Prevention was to get money to organizations that are boots on the ground organizations that are doing day-to-day work to reduce gun violence in terms of violence intervention strategies.
The great news is it looks like there's only a dozen people that are watching. So you've got a
gun violence intervention groups, community violence intervention
Well,
groups.
I'm going to hang up on you all so I can
Hospital
get in
violence
on
intervention groups would be two. And then other strategies like group violence intervention, which we already fund such an organization, the state does, which is Project Longevity. So those are the kind of the three main types of groups.
I'm going to hang up on you all so I can get in
those
on
groups, some of them exist
You're on my phone.
across Connecticut.
All right.
In New Haven,
Well,
like
just hand
Connecticut
Holly can
Prevention
just hand the
Group
phone over to
would
you.
be one of those groups that does both community and hospital-based work. Compass Youth Collaborative is an organization that does that type of work in Hartford. And then there's other organizations like Survivors of Homicide or Mothers United Against Violence or otherwise that do the type of aftercare that I discussed earlier. So the design is to
Holly can just hand the phone
to have this Office of Violence Prevention create a
So tell us,
grant
so part of the
criteria.
deal today
To have the
was
Department of Public Health
podcasts.
create a grant
And
criteria
these ladies are
to give
pretty
money to
seasoned at
organizations
podcasts
that
and
are
stuff like that, but what
incorporating
did you pick up
evidence
leaving
informed
Amanda Sutton's
solutions
doing podcasts?
that are going to reduce gun violence.
And
it's
let's
not
bring
just
this also
funding
up and-
them, it's also studying the
Oh,
problem.
yeah, Spider.
Developing metrics so that those organizations
That's what
will see
we're-
whether those organizations
exactly.
are doing the work that is effective in reducing gun violence and whether the funding is working to reduce gun violence. So it's not just giving money to organizations, also making sure that there is some type of metrics and follow-up, as well as research involved in making sure that the state employs the most effective gun violence reduction strategies.
All right, today we are coming to you from
So
Mount.
those types of organizations that are doing that kind of work, a lot of times when we sleep, are the types of organizations that we are proposing that the Office of Violence Prevention should be funding, not advocacy groups. It's violence intervention, prevention, and aftercare groups that we're looking at.
Great, thank you so much. Thank you, Mr. Chair.
Thank you, Representative. Senator Ciccarello.
Thank you. And through you, I just have a quick question. I heard a comment in the last set of questions that it was harder to buy cough medicine than a firearm in Connecticut. And I was just curious if you recently attempted to purchase a firearm in Connecticut.
Not recently, but I have purchased a firearm in Connecticut.
Okay, because it's a challenge.
I do have a license. I do have a gun permit. So.
Thank you for answering that. Just because I've been hearing from constituents, not only with COVID and a lot of other challenges with getting people into work, but it's very, very hard first to secure a permit. A lot of people are looking for permits now for probably a lot of different reasons. But once they get the permit, they're having a challenge even getting the firearms. And the gun brokers and shops that sell the firearms are having a hard time even getting through to the state to register these transactions. So when you said that, I was just curious if you recently purchased firearms, because it is quite challenging first to obtain the permit and then ultimately purchase these firearms. It's a long process. So why I ask, and we're discussing the bill that speaks to one purchase per month. You know, when you get them on the phone, it's easier to do a few at a time. I believe a good representative gave another example of, if you want to buy a few guns for a family outing, it's going to impede that. But just sheer amount of time. So when we go to purchase a couple of firearms for whatever reason, it's going to create a more challenging process in already a challenging endeavor to purchase a firearm or multiple firearms. And we talked about the research that we have that would say this really would make a difference in the increase of violence or decreasing the violence. Do you have any response to that?
I'm sorry. Can you tell me what the question? What are you asking? If you rephrase the question, because I'm not sure if I understood it.
Sure. So I do apologize. Basically, I was setting kind of my understanding of the conversation that has been going on through your line of questioning. And my question specifically is, it's going to create a lot of challenges for the pistol permit holder. Okay. And the intended consequences is to reduce gun violence. But you stated that you need more data to see if purchasing guns, multiple guns at one time or bulk purchases would have an effect on decreasing the gun violence. So when hearing what we're talking about of the other challenges, and you saying that you may need more data, do you think that this might not be the best time to put this legislation through?
So I think that as we have to prioritize legislation, it's a short session, and there's very limited time, which and Gary's looking at me saying, yes, we have very limited time. But the idea is that not everything can get a vote, not everything can pass, which is why we as an organization prioritize only certain bills. Our opinion is that if there is one bill that's prioritized, it would be the investment in community violence interruption and intervention strategies, whether it's by SB 16 or the better option, in our opinion, which would be HB 5397. So that is our priority, if that answers your question, Senator.
It does. Thank you for your time.
Thank you, Senator Ciccarello. Comment or question from other members of the committee? Comment or question? If not, Mr. Stein, thank you for joining us this afternoon. I will just remind members of the committee again, it is almost 4:30, which put us at about 6.5 hours. We are not an eighth of the way through the list. I know that people have questions. If we could be circumspect about which questions we ask and which questions we don't, it would be helpful. There are a lot of members of the public who likely, honestly, at this point, will stop trying, and that's not a good thing. Next, we'll hear from Robert Goodrich, followed by Warren Stevens. Mr. Goodrich, you are on.
Thank you, Senator Woodfield, Representative Staffstrom, and members of the Judiciary Committee. My name is Robert Goodrich. I'm an organizational leader for race. We're members of the Community First Coalition, which is convened by the Connecticut Black and Brown Student Union. Our coalition consists of a dozen grassroots youth-led organizations fighting to reimagine public safety in our communities. We represent 8 cities and towns and thousands of youth. First, we recognize that our communities must be safe, and we must also directly address the negative impacts that police and policing has had on our communities. Today, we are submitting testimony on a variety of bills, but we must first identify the inherently oppressive, anti-Black, and seemingly racist rhetoric that has once again been foisted onto the backs of our communities. Secondly, we loudly denounce the anti-crime measures being placed within the People's House as regressive policies concocted to bring us back to the Jim Crow era, or even back further to the birthplace of American policing, the antebellum South. Furthermore, we want to posit this fact. Public safety has never been created or sustained by police, policing, or prisons. Rather, public safety is possible when there are robust anti-poverty measures, racial equity is mandated in our schools, and social services are culturally as well as socially responsive to the people they serve. We are recommending, pursuant to Public Act 18-78, that the Judiciary Committee members and co-chairs request a racial and ethnic impact statement bill be prepared for HB number 5417, 5418, SB 16, and SB 365, and or any amendments for those bills so that legislators and the public know exactly who these bills will impact most. Now, we support SB 387. However, we urge the committee to strengthen the language so that police interventions in schools are collected and reported on in the same exact way. This is because we know that there are thousands of police-led interventions in schools each year that go uncatalogued. Now, we are in opposition to legislation that increases electronic monitoring and GPS monitoring, which is in HB 5417, 5418, SB 365, and 16. We also in opposition to legislation that increases support for training for law enforcement personnel to apply for detention orders for youth accused of crimes in SB 365 and HB 5418. And we're also in opposition to legislation that increases the likelihood that youth are transferred into adult criminal justice system proceedings, which is SB 365 and HB 5418. Finally, we're in opposition to legislation that increases the likelihood of children being placed in detention facilities and the sharing of juvenile records to facilitate incarcerating them. Now, we've included detailed information in our testimony. I'm open for questions. Thank you.
Mr. Goodrich, thank you. Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Mr. Goodrich. Mr. Goodrich, over the past 10 years or so, we've seen a dramatic increase in the arrests of juveniles for stealing cars. In fact, comparing 2010 to 2020, we're about double the amount of arrests of juveniles just for stealing cars. I understand that you're in opposition to all of the juvenile justice reforms that have been sought here. What is your answer to that? How do we address that dramatic increase?
Well, the answer is partly in my testimony, where we talk about robust anti-poverty measures, racial equity in our schools, and social services that are culturally as well as socially responsive to the people they serve, not the systematic and hardened systems that are being proposed and in place now. Those are the solutions to car theft problems.
So a child who, we learned that in the cities in particular, a lot of these car thefts, which many times involve other property crimes, people being run over, that kind of stuff, are repeat offenders. So how do we address the repeat offenders under your theory?
Well, what we're clearly saying is that the way to address this is by supporting the communities and addressing the root causes of crime and not the outcomes or the symptoms. So your focus is wrong. You need to be focusing on anti-poverty measures, making sure that schools are funded equitably so that the conditions, the material conditions that folks have to endure and live in, particularly Black and brown students and Black and brown families, don't have to resort to crime to survive, or in fact, make bad decisions and are unsupported by the systems that are supposed to be built to support them.
So what do we do with the children that refuse to go to school? You've just put millions of dollars into the schools. That's part of your way of dealing with this. But a lot of these kids just don't go to school. In fact, I think in one of our cities, it was recently reported that through the pandemic, the online system they're signing on was about 50%. So take all this money, give it to the schools, but if the kids aren't going to school, how is that going to prevent the repeat stealing of cars?
Look, an interesting point, but I don't think that we can have that conversation in this committee. But last year, our organization did detailed work on student engagement, and we can talk about why students don't go to school. And it's probably because schools, one, don't value them as individuals and their identities, and two, in turn, students and families don't have close connections to schools, which leads to a drop in student engagement. But we're in the judiciary here, sir. If you like to talk about education bills and education spending, more deliberately, we could have that conversation offline.
You're the one who brought up the schools. So you would have nothing be done by this committee on the judiciary aspect of addressing the dramatic increase in children stealing cars.
Well, the first thing that I'm going to go back to, Representative Fishbein, is that our communities are routinely underserved and overburdened with lots of things. Okay, the outcropping of increased stealing of cars by youth in the state of Connecticut is a direct result of the material conditions that they have to exist in. Okay, not because they're inherently evil people. Now, I can tell you the crime statistics in Waterbury, the town that I work and live in, we actually have a reduction in violent crime in 2021. So there isn't much more that we can do to increase policing and increase punishment in Waterbury that actually would serve the public. Because let me remind you that the school to prison pipeline in the city of Waterbury is very robust. We arrest the most amount of students in the state of Connecticut, and we also have the most adults who share home addresses that are incarcerated in our Department of Corrections. So arresting and incarcerating, okay, which has gotten us to this point now, doesn't work. And that's also been cited in Supreme Court cases. And we can take a look at a study that was done in 2004 from the Urban Institute to talk about sort of the myths that you all, and particularly a group of folks, that are attaching it to the super predator myth, and that we need to go back 20 or 30 years to the way that we arrested or tried to incarcerate and arrest ourselves out of similar problems. And guess what? It didn't work. It failed miserably, and it disproportionately burdened Black and brown people.
Okay, so you brought up violent crime. I didn't. I specifically talked about, well, do you consider statistically stealing a motor vehicle to be a violent crime?
I do not consider.
Okay, so I was just focused on what statisticians call property crimes, right? So has property crime in the city of Waterbury increased? And I know you're looking to someone else for answers, but that's fine. Has property crime in the city of Waterbury committed by juveniles increased over that same period of time?
One, my son just entered the room, and he's not going to be answering for me. I'm actually looking at a third screen based on the crime index offenses for the city of Waterbury that was produced by the Waterbury Police Department. So once again, there's a cultural divide here between you and I, Representative Fishbein. I see crime as a result of the material conditions that people are forced to endure. So, and if you want to talk about treating the material conditions, one of the things that we don't want to do, and it's just been proven,
So the question, please, I mean, we've been here a while here today. I asked you you shifted to violent crime. All I asked you about was the increase in property crime committed by juveniles in the city of Waterbury during the same period of time that you referenced.
So I'm going to again assert the facts, okay? From when, the now mayor was police chief to when Police Chief Riddick was in charge, and now when Police Chief Spagnuolo are in charge, they have been cracking heads and arresting people and youth for decades. It has done nothing to change the material conditions in which people live in. And now this year, you have a host of bills that actually increase the amount of policing and potential incarceration for children. It's idiosyncratic. It doesn't make any sense.
So I take it.
So no, I wouldn't. I would say we need to treat.
Hold on. You said no. Representative Fishbein is going to ask the question. I'm trying to get us through the exchange, and we are way behind, and I don't want us crowding each other out and fighting. It's not useful.
Yeah, I'm just trying to get an answer. So my understanding through your chief of police is that there has been an increase in the incidence of juveniles committing property crimes within the city of Waterbury. Is he not telling us the truth?
Well, I'm looking at Mr. Spagnuolo's data right here. So when we talk about increases of auto theft in Waterbury, it went from 52 to 57, right? Okay, in the statistical analysis, crime is up 2.8%. My training from the Strategic Data Project at Harvard tells me that is insignificant. And it doesn't relate to any significant major overhauls of any legislation or the creation of new laws that would stiffen the penalties for juveniles.
What period of time are you looking at the data?
That's from January 1st of 2021 through December 31st of 2021.
Okay, so that's the year of 2021. It was my understanding that in that year there was 84 incidents of juveniles. You're telling me it's 57, something like that?
So I will email you the Waterbury Police crime statistics from 2021.
Okay, that's just motor vehicle theft. I had asked about property crimes. Do you have the data?
Yes.
Okay.
Yes.
So that was the question.
So yes. So burglary was down 55 incidences, down 16.5%. Larceny was up 23%. So we're talking about changes that balance each other out, that leave us at the pinpoint that we were before the pandemic. There hasn't been significant changes. So that's sort of the illegitimate narrative that is being foisted on communities that I talked about in right in the beginning of my testimony. It's unfair.
Okay, so just to be clear, it's your representation that over 1 year there is a negligible increase in juvenile property crimes in Waterbury. Is that what you're saying?
I am telling you that the crime index, which doesn't separate, the police department does not separate that information for the public, is lumped in together. So this is right on the Waterbury Police Department's website. This is not something that I had to FOI or do myself. I can share my screen now and show it to you.
Okay, but that's for that 1 year, correct?
Correct.
Okay. And over the last decade, has the trend been downtrending?
I don't have the last decade of data.
Okay, the last 5 years.
I don't. I have January 1st of 2021 through the end of 21 compared versus 2020.
So I don't want to go in a circle here, but I believe the data shows that there is an increase over the last decade, over the last 5 years, in the incidence of juveniles committing property crimes. I haven't seen data that shows differently. And that's what we're trying to address. That's what I'm trying to address here. But I understand your position that
but our
we
city
shouldn't
is
be passing this stuff.
respectfully, Representative Fishbein, our city's actually safer than it was 10 years ago. And that's where we're getting at the heart of the matter.
Safer is subjective, though.
Okay, I'm gonna intercede because the two of you, I get it. You're trying to get, but we're not uncovering anything new as it relates to the bills before us at this point. So I'm going to ask you, Representative Fishback, if you have another question, please certainly ask it. But if not, I would like us to move on from this.
Yeah, just about the safer issue. By what scale is that representation made? The people in Waterbury are safer.
Well, when I think about safety, okay, in terms of violent crime, we've had a year of unprecedented reductions in violent crime. Murder, negligent manslaughter, rape, aggravated assault.
Okay, so property crimes have no relevance. I understand that. So I disagree, but thank you, Mr. Chairman.
Thank you, Representative O'Day.
Thank you, Mr. Chair, and thank you, sir, for your testimony here. I don't know the Waterbury stats off the top of my head, but I will tell you, Buchanan has seen over 100% increase over the last 3 to 4 years, and just in the last year, we went up from 27 to 39 from 2020 to 2021, and we actually had a couple break-ins, the residential burglary increases as well. So I don't know the Waterbury numbers, but I will tell you, New Canaan, we've had a problem, and our chief told us that they believe that there are juveniles being hired by gangs that are being paid because there's very little prosecution of juveniles. Do you believe there's sufficient prosecution of juveniles at this point in time, and that's not the issue we should be addressed to?
No, I don't believe children, as defined by current statutes, belong in jails or prisons, period.
Okay, but so at what age do you believe a child stops being a child and is an adult, in your mind?
In my mind?
In your opinion, you believe children should not be in jail ever. That's what you said, correct?
Yes. I'm an abolitionist, sir. I don't believe in prisons. I don't believe in the systems of public safety that we have. So whether you ask me about adults or children, you're going to get the same answer.
Okay, fair enough. Then I'll move on. I will point out, I know this is beyond Mr. Chair, but I've only asked, this is my only second question of the day, I believe. Mr. Goodrich, I agree with you. We got to fix our educational system in our Black and brown communities, and I'm a big school choice fan. Colby Cathedral in our Good Chairs district in Bridgeport has a 100% graduation rate at Catholic school, and so I want school choice. Do you believe in school choice?
I believe that choice is at the center of empowerment. So when families have choices to make, they certainly should have choices about the types of education that they get. I do not, forcefully support, without question, charter schools or our public schools here in Connecticut.
All right. Thank you, Mr. Chair. Thanks, sir.
Thank you, Representative. Representative Dubisky.
Thank you, Mr. Chairman, and thank you for coming in. I waited and raised my hand and was waiting to ask that very question that Representative O'Day just asked, but let me just ask you to expound a little on that. You had indicated that that choice is the basis of empowerment. Did I get that right?
Correct. It's sort of a life theory, right? If you're going to have your power acknowledged, that means that you're going to have choices.
Okay. Now, I know you were against the policing enhancement bills that are on the agenda for today, and I understand that your reasoning is that you're an abolitionist and you don't believe in our system of policing and incarceration. The one thing you did say, which I think you and I agree wholeheartedly is crime is the result of cultural conditions people are forced to endure. I think you and I both agree on that one. And but it comes down to the reasons why those cultural conditions exist. And I think you touched on it a little bit with Representative O'Day with regard to education. Is it your feeling that instead of the bills that are on the agenda today in that direction, we should be looking at more of an educational focus for the youth of Connecticut cities?
I think culturally responsive and sustaining educational experiences.
What does that mean?
So that means.
One second, Mr. Goodrich. Representative Dubisky, I'm going to let you go down this line a little bit, but it is getting away from his testimony on the bill. I recognize he might have an opinion that has something to do with what we're talking about, but it's not about the bill. So I'm just letting you know that.
Okay, I won't go very far. If you wouldn't mind, Mr. Goodrich, what do you mean by that?
So when I think about culturally responsive and sustainable practices, that means that one, power has to be shifted away from administrators and educators and bureaucrats and given back to parents and students and educators in classrooms so that they can clearly define the objectives of what education should serve and the outcomes that come from that. So that means, one, that the first step is restoring the power to parents and students about what types of education that they receive and who educates them.
So as opposed to the bills that are on our agenda today, are there any bills in any other committee that you're supporting that you think would be better than what's on our agenda today?
I'm unclear how this is.
I'm just trying to wrap this up, Mr. Chairman. He's discussing a way that he thinks is better than the police enhancement bills that are on our agenda today. So I'm just trying to wrap it up to see if there's some proposed legislation that he thinks is better than what we've got on here. Or if, and my next question, or my last question would be, is there any way that we could amend the bills that he's opposing today on our agenda to make them more in line with what he thinks would be effective in his community?
So while I have issue with going down this path because I think we're too far off the book, I'm going to let you ask that question, but I'm not going to let you go further.
That was my last question.
So one, we need to have a piece of legislation that accelerates ECS funding, but not about equal funding, but equitable funding. Okay, we need to accelerate that so that school districts are fully funded by the state immediately this year. The second answer to your second question is yes, I will meet with you and with coalition members to talk about the detailed analysis that we have on every piece of legislation that we've identified in our testimony. We have multiple recommendations, and we're credible community messengers. I'm a former educator, okay? I also run an organization in Waterbury. So we can spend some time with you if you want to work to amend the language.
Did you submit any written testimony that might incorporate some of those proposed changes?
No, we did. No, we think that a lot of the revisions that we make would completely redact and remove the increased policing efforts in the bills. But there are other specific ones, like around SB 387, that we can alter to make that much more better.
Okay. Well, I appreciate it, and if you are able to make any proposals on SB 387 or any others, any proposed textual amendments, I'd be glad to read them. Thank you very much. Thank you, Mr. Chairman.
Thank you, Representative Dubisky. Comment or question from other members of the committee? Comment or question from other members of the committee? Seeing none, thank you very much, Mr. Goodrich, for joining us. We'll next hear from Warren Stevens, followed by Ray Bevis, and then Luigi Ceci. Warren Stevens, you may testify.
Dear Judiciary Committee, I'm Warren Stevens of Southington, Connecticut, DCDL member and a spokesperson for the Southington Sportsmen Association and Bell City Rifle Club, representing several thousand voters, and we are single-issue voters on the Second Amendment. Gun control laws do not stop crime. We are adamantly opposed to SB 16 and AB 5416. Placing restrictions on law-abiding citizens does not stop criminals. Gun control itself is a failure. If it worked, we'd not be here every year discussing more laws. The fact that we are is an admission that laws up till now have not worked. Per the Connecticut Department of Public Safety website, over 70% of gun charges in this state do not result in a conviction. But when liberal policies fail, Connecticut diverts away from those failures and attacks the Second Amendment. Further, there is no such thing as gun violence. We have a criminal violence problem. Instead of attacking law-abiding citizens, we should be attacking crime and criminals. According to Forbes, the top 10 most dangerous cities in America are all Democrat-led, with soft on-crime policies and extreme gun control. These policies are killing Americans. Limiting carrying in public places puts people at risk, as they will not be able to defend themselves. Gun-free zones have claimed more lives than it was intended to save. According to the Crime Prevention Center, gun-free zones have been the target of more than 94% of mass shootings. They're described as soft targets, unprotected, and vulnerable. According to the Crime Prevention Center, since 1950, only 1% of public shootings have occurred where citizens are armed. Allowing police to detain citizens and ask for their permit with no evidence of being crime committed is unlawful and, quite frankly, scary. Show me your papers was a tactic used by the Nazi Party in Germany under Adolf Hitler, and it has no place in Connecticut. Preventing bulk purchases of firearms is laughable, as criminals do not follow laws. This would affect legal gun owners from buying and transferring collections and other legal family purchases. Straw purchases are already illegal, so it's still a crime. We support SB 388, HB 5415, and HB 5412. For years, we've heard Democrats state, I support the Second Amendment, but you don't. For years, we've had Democrats say, you're not coming for our guns. You are. There's a struggle going on in this country and state right now to preserve liberty, freedom, Constitution, and Bill of Rights. That struggle is not between Republicans and Democrats, it's between Americans and liberal policies. This is an election year, and anyone who votes in favor of further gun restrictions on us law-abiding citizens will feel the full impact of our efforts to vote you out of office. Thank you.
That's pretty good.
Representative Trubisky. Thank you, Mr. Chairman, and thank you, Mr. Stevens, for coming in. I think you represented your position very well, and I got in under the time. I don't have any questions for you because you did such a good job. But thank you for coming in. Thank you, Mr. Chairman.
Thank you. Seeing no further questions, thank you for being with us, Mr. Stevens. Next will be Ray Beavis. Hello, my name's Ray Beavis. I'm the legislative coordinator with Connecticut Citizens Defense League. I'm here speaking on Senate Bill, in support of Senate Bill 388, House Bill 5412, House Bill 5415, and I'm in opposition to Senate Bill 16 and Senate Bill 5416. I'm really would like, you've heard a lot of testimony today, so I'm just going to try to keep it as short as possible for you. But I want to refer to Section 4 of Senate Bill 16, which ultimately bans a type of firearm that is in very common use for personal protection here in Connecticut. Section 4 bans a class of firearms that we commonly known as others. And currently in Connecticut, there are over 75,000 others in the Connecticut database. In 2021, approximately 1,900 others were sold every month. They are just a commonly owned type firearm that we're banning that does not show any increase in crime or haven't been used in a crime. It's just solely a target on gun owners, and every year we seem to come back with more weapons bans in Connecticut that attack the common type firearms. I'd also like to address lines 292 and 293 of Senate Bill 16 by removing the reasonable suspicion of a crime. Really gives law enforcement the green light to profile not just gun owners, but basically racially profile the largest growing demographic of new pistol permit holders. In 2021, we saw Black and minority communities, especially women of color, their numbers doubled in new pistol permit holders in the state of Connecticut. In regards to HB 5416, and that concerning the purchase of firearms, I think limiting a right by placing purchase limits, especially a right that is in the Bill of Rights as inalienable rights, is just wrong. Definitely a road I do not want to see this Connecticut legislation go down. Definitely start a slippery slope. And I'm in support of Senate Bill 388, and I'm also in support of 5412, removing the duty to retreat in house worship, and I'm in support of HB 5415. So thank you. If there's any questions, I'll be happy to take questions.
Questions from the committee? Representative Trubisky.
Thank you, Mr. Chairman. Thank you, Mr. Beavis, for coming in. Very much appreciate your testimony. With regard to Senate Bill 16, you briefly said at lines 292 to 293 the removal of reasonable suspicion of a crime. That sentence, those words encompass a lot. And could you just tell me what removal of those, was it 6 words, 7 words from the statute, what effect that would have on the law-abiding gun owners of the state?
Right. So, so lines 292 and 293, they remove the reasonable suspicion of a crime, which is a fairly low threshold for law enforcement. But it just gives will allow law enforcement, if they see a firearm visible, whether it be printing or the outline of in their clothing, it's just simply approach the firearms or the permit holders. And the law also says that the permit holder must produce their permit. So it doesn't say that they have to produce an ID, but it just says the permit holder has to produce a permit. And what that means for gun owners is that they will ultimately be stopped because they're carrying their firearm. And in Connecticut, it's both an open and concealed carry state. I also just want to, on its face, it seems like people are just make the comment, we'll just show your permit. But I think in practicality and in the way it will work on the streets is the police officers, when they do see it, they identify you, and then they don't know if that permit is valid or not. So they want to go and run your name through the database to confirm that that permit is valid. And they might even want to run your firearm, which an incident similar to that happened to me years ago. They'll want to run that firearm through the database to make sure the firearm is not stolen. So that simple interaction now has turned into a 20 or 30-minute interaction.
And during that interaction, I'm assuming the person is not free to leave.
Right, and I would go into the assumption the second the police officer takes my identification, especially if it's a pistol permit, because I'm not allowed to carry without the permit in my possession. So anytime a police officer takes your identification, I feel you're not free to leave. It's a form of detention, whether it be mild detention or it's a form of detention in my eyes.
Now, where do the members of CCDL live?
So that's a great question. We have 43,000 members across the state. We do have many members among the urban areas. We have members in Goshen, Connecticut, and we have members in New Haven, Connecticut. And I really do think that interaction will be totally different. If this passes, the interaction will be totally different from our members in Goshen, Connecticut versus New Haven, Connecticut.
how do you think what do you think that difference would be if the language in lines 292 and 293 is removed? What do you think? How do you think that's going to affect the people in New Haven and Bridgeport and Hartford and Waterbury and the other urbanized areas?
Yeah, unfortunately, it's sad for me to have to say this, but I think it's reality that there is, I believe, a police response to a white man with a firearm will be totally different than a minority or a Latino or a person of color with a firearm. And I think our members, and we have, recently we've had a lot of our new members, are members of the minority communities, Latino and the Black community. So I think their interaction is not going to be the same in New Haven, Bridgeport, Hartford, as someone that lives in the more suburbia area of Connecticut, or even the rural areas of Connecticut. I think it's going to be a different interaction. I think it's going to be a negative interaction, and I don't think it will go as smoothly. I believe if someone calls, or if someone sees a white man with a gun, that interaction is totally different than a black man with a gun. And it's sad to say, but I think that's reality in our state.
I appreciate that. I share your fears in that respect. I did want to touch base with you real quickly about HB 5415. The language of that bill would. Why don't you tell me what your position is on that bill, and why you take that position?
Right. So I'm in support of 5415, which would allow the transfers of assault weapons, what the state defines as assault weapons, that have a certificate of possession, or large capacity magazines that are declared. This is a lateral move. It's not introducing new numbers into our states. It's allowing the commerce and sales between those. And I do have to say, of someone that has declared magazines, I can tell you that finding replacement large capacity magazines is obviously I cannot do because that's against the law, but even finding replacement magazines with the 10 magazine limit is very hard for some of the firearms I own.
So for example, if you were like a competitive shooter, let's say you participated in 3-gun competition, which utilizes firearms that typically have large capacity magazines under these definitions. And let's say you're a competitive shooter and live in Connecticut, and you break a magazine. What are your options currently?
So my options currently, if I have what the state defines as a large capacity magazine that breaks, and I would have to try to find a replacement, but I cannot bring that replacement in the state of Connecticut. So I would only be able to keep that magazine outside the state, and that would inhibit me from competing in these competitions. So it's, but if this was to pass, I would be able to replace the magazine that broke by purchasing another used one that was already declared.
So you wouldn't actually go to a gun store and buy a new magazine. Nobody would be stocking these things. It would just be you'd find a person who had already declared one, who owned one, and it would be a lateral transfer through a federal firearms licensee, right?
Correct. So I would have to find a used one, and it would be a lateral transfer from someone that also declared them to someone that has declared them. And it's not like I said, it's not introducing any new magazines into the state or new state-defined assault weapons. It's just allowing the legal gun owners to transfer these amongst each other.
Thank you very much. Was there anything you want to say about any of the other bills?
No, I really appreciate your time, and I think I've covered everything that I wanted to.
Great. Well, thank you very much. Appreciate it. Thank you, Mr. Chairman.
Luigi Ceci, Jordan Wilson,
Representative Stavstrom, and members of the Judiciary Committee. My name is Jordan Wilson. I'm the Community Connections Associate with the Connecticut Justice Alliance, and I'm here to communicate my strong opposition for Senate Bill 365, and I'm concerning juvenile criminal justice. CCJA is a youth adult partnership model working to end the criminalization of youth. I submitted written testimony on this bill. Our organization submitted written testimony on a few more of the bills on the agenda, and you'll hear from our staff, allies, and JAs throughout the day today. I'd really like to emphasize my strong opposition for Senate Bill 365, specifically the automatic transfer of kids 14 and up to the adult court. The adult court is not designed to meet the needs of our young people. It is ineffective, inhumane, costly, flat out racist, and wrong. And we instead should be talking about what we should be doing because we know incarceration doesn't work. I don't have to tell you that. And we have a bunch of studies that we can share that proves this. It relatively costs $1,400 a day to incarcerate a child. With that kind of money on a daily basis, we can provide specific community-based services to our young people, as it has been found that young people are more likely to attend school, go to work, be model citizens, and reduce offending than those who are incarcerated and do not receive these services. Of the kids that do enter the adult system, 30% are more likely to be rearrested after returning to their community compared to young people who stayed in the juvenile system, meaning transferring them to the adult court does nothing but say we have punitive measures and are tough on crime. We should be looking to identify and develop a true community-based program of care for youth with high levels of needs. And for those who are identified to need out-of-home treatment, that treatment should be done in small therapeutic facilities that are developmentally appropriate. Marisa touched on this, not the Department of Corrections, not Manson, not adult prisons. In my written testimony, I talk about the Department of Justice findings and the Manson Youth Institute and want to verbally acknowledge that we're doing something wrong. As mentioned at the start of my testimony, CTJA is a youth adult partnership working to end the criminalization of youth, and we do that by working with and talking to young people directly impacted by the system. I urge this committee to listen to our young people. We can help facilitate this if needed, but I promise you that they are asking for support services and community investment, not incarceration. Thank you for your time and listening to me speak today.
thank you. Questions from the committee? Representative Dubinsky again.
Thank you, Mr. Chairman. Thank you, Ms. Wilson, for coming in. Very much appreciate it. Earlier, a gentleman testified, and he said that crime was the result of cultural conditions people are forced to endure. Would you agree with that?
Crime is a result of what?
Cultural conditions people are forced to endure.
I think so.
Representative, that was not her testimony. Let's focus on her testimony and focus on the bills, please.
I'm sorry, I didn't hear you, Mr. Chairman.
I said focus on her testimony and on the bills she's testifying on.
Will do. Thank you. I'm sorry, I didn't catch your answer to my previous question.
Yeah, I would say yes.
Yes, okay, thank you. That was all I wanted to find out. I very much appreciate you coming in and appreciate your testimony. Thank you, Mr. Chairman.
Christina Quaranta. Ileana Poulos. Laura Devlin. Jared Harrow. Jared Harrow with us. Joshua Fritz.
Representative Stavstrom, Christina Coranda was here, but no one had promoted her to a panelist.
Okay, let's go back to Christina.
As well as Ileana.
Here's Christina.
He was promoted to panelist. They both were.
All right.
Carol's in there right now. He's just not speaking.
Chris, we got Christina Quaranta. Let's go with that. You're on mute, ma'am.
Thank you, Representative Staffstrom. Chair Senator Winfield, Rep. Staffstrom, and members of the Judiciary Committee. My name is Christina Quaranta, and I'm the Executive Director of the Connecticut Justice Alliance. We're a statewide youth adult partnership. We work to end the criminalization of youth. I'm here today to talk to you about a few bills. Two that we are in support of, SB 387, SB 392, and a few that we are in strong opposition to, which are SB 365, 386, and 16, and House Bills 5418 and 5417. Connecticut has made many strides in the life or death race to improve the landscape of youth justice. In 2022, just 2 years following massive Black Lives Matter protests, and many people around the country pledging to do better by Black and brown people, there are numerous dangerous bills that have come out of the Judiciary Committee that have bipartisan support, and we've been hearing about today. This is an emergency. Despite research telling us that locking up young people in adult prison, making it easier to transfer youth under 18 to the adult legal system, and surveilling young people does not improve public safety, this is the goal of these bills, along with many other disgraceful things against youth. The narrative for the past few years, coinciding with the beginning of the COVID-19 pandemic, has been that Connecticut is experiencing tremendously high rates of crime being committed by youth. This is not supported by data and is a shameful political tactic to win votes on election day and to stoke the fear in communities across Connecticut. Along with these mistruths being spoken about young people and their families, the folks that are proposing this legislation are not proposing things that will actually address the roots and help young people be successful in life, and this is not okay. Youth justice policies must be based on data and research about youth development and delinquency to prevent reoffending and to promote improved outcomes for youth. Legislation that would make it easier to send a young person, as young as 13 years old, to the adult criminal legal system is wrong. It would increase the number of young people in that system, even as one of the prisons that incarcerates young people as adults and in youth, is just found to violate the civil rights, the 8th and 14th Amendments of young people by the United States Department of Justice, where they found that their rights are being violated for the Individuals with Disabilities and Education Act. There's inadequate mental health services, and the amount of isolation and solitary practices that are committed against youth is harmful. A couple other things to mention, and I submitted written testimony so you can follow and read through there to see the other pieces where we opposed. Go along with calls to review Connecticut's youth legal system to see what's working and what's not. We currently have the Juvenile Justice Policy and Oversight Committee. We've had that committee since 2014. It's done great work. We do believe that government systems should be held accountable to monitor youth outcomes. The JJPOC was created to do just that. And I will stop there. I have a couple more points, but I'll take any questions. Thank you.
Thank you. And certainly we do have your written testimony. So, Representative O'Day.
Thank you very much, Mr. Chair. Just briefly, ma'am, thank you so much for your testimony. I was one of the ones citing some statistics in my town, and it wasn't for political reasons. I assure you, in New Canaan, we had an increase, a dramatic increase over the last 4 or 5 years, and even a big increase from 27 to 39 car thefts in last year. And I assure you, it wasn't for political purposes. I guess our chief says it's youthful offenders that are doing it, the majority of it from out of town, and I'm wondering if you think that the chief is wrong or we're wrong.
So thank you, Rep. O'Day. I'm looking at you about CET auto theft. Got data about going back to 85. So I see an uptick between 2020 and 21 by 12 car thefts. I think the biggest point to highlight, no matter what town we're talking about, 2 points. One is we can't definitively say who is actually stealing the cars unless we arrest them. And we have a low clearance rate in Connecticut, which the Alliance has gone around and been transparent and talked with police chiefs about that and what that means. So if we can't actually see the person and hold them, we don't know who's actually stealing the cars. And number 2, I think it's important, and a colleague of mine, Ken Barone, will point you in the direction of the great data presentations he uses to show that car thefts are moving around the state. It's not necessarily that they're increasing as a whole, but they're shifting in where they were happening a couple of years ago to where they are happening now or last year. And that's something just important to think about when we talk about car thefts how to properly intervene, and what should be done for young people, which happy to have a further conversation with you offline about that and share the data that we have and some interventions that we know to work in Connecticut and then nationally.
Great, thank you. So just to be clear, then you're not claiming I'm making anything up for political. You saw in your own data we had a pretty big increase, right? I mean,
the issue is that folks, and there's no personal attack on you. I think the rhetoric as a whole and what I've seen in the media, conversations I've had with all different kinds of people has been, oh no, youth crime is up. Kids are stealing cars. You better stay in our house. There's going to be mass murder. There's going to be all of these problems. When that's not necessarily the truth, because we don't have the numbers on how many kids are actually stealing cars, right? So I think if we talk about who is it, I have some information. So if we had, in the year 2020, there's a 7.9% clearance rate in motor vehicle theft out of 8,400 motor vehicle thefts, right? So they were able to arrest 671 people, and only 247 of those people were under the age of 18. So that leaves 37% of car arrests in the state of Connecticut were young people under 18, and the rest, 63%, were adults. So I think another talking point when I go around with my organization talking about this issue and how we can best address it, and I talk to folks nationally too, because it's not just a Connecticut issue, is what are we doing for young people and adults? Because we find it disturbing that all of the attention is focused on young people in motor vehicle theft, when that can't even necessarily be proven, and not enough attention being focused on the adult side and what is being done intervention-wise to help them. Because eventually, if you think about it, kids are going to grow up to be adults, right? So we need to make sure we are giving them the services that they need from the beginning. And incarceration and the things that are proposed in the bills in front of me today and the agenda are not going to get at the root, and we're going to be back here in 2023 with the same discussion.
thank you very much. Thank you, Mr. Chair. Thank you, ma'am.
Thank you. And Christina, always good seeing you. You know, we have talked about districts a little bit, and I think your point is well taken that we have seen increases in some districts and decreases in others. And obviously your organization happens to be based in my district, where we have seen a precipitous drop in property crime over the last 10 years in particular. So thank you for being with us today.
Thank you very much.
Ileana Poulos.
Hello. My name is Ileana Poulos, and I am the Policy Director of the Connecticut Justice Alliance. I'm writing this testimony to communicate my strong support for Section 3 of SB 387 and my strong opposition of SB 386 and Section 10 of HB 5418. I've been a part of the Connecticut Justice Alliance since the inception of their Youth Adult Partnership, the Justice Advisors, which means I've been heavily involved in the work of the JJPOC, Juvenile Justice Policy Oversight Committee, since 2018. I support the entirety of SB 387, but I wanted to highlight the importance of Section 3 as it ties into the reasons why I'm opposing the other two bills. Section 3 calls for the expansion of the JJPOC membership by 4 members, 2 directly impacted young people under the age of 26, and 2 directly impacted community members, hopefully parents. Directly impacted meaning they feel the impact of the policies passed specific to youth justice. They are the people we are having these conversations about. Since being at the JJPOC, I've watched this table transform and try its best to work alongside those impacted, something that not many legislative mandated bodies do. SB 386 and Section 10 of HB 5418 work against everything the JJPOC has done to work with communities to fill the gaps in our youth justice system. Both bad bills recommend either creating a new group to take on the task that the JJPOC already does or has the capacity to do, and insults the collaboration efforts on the JJPOC as it aims to create a small, non-impacted, non-inclusive group of decision makers. As co-chair of the JJPOC's community expertise work group and someone who has been in the youth legal system themselves, it's truly a spit in the face to see that there is effort being made to eliminate the JJPOC, undermine the effort we put in annually, and ultimately keep directly impacted young people away from the decision-making conversations. We have to do better. There's no expertise that can compare to actually being the person in the system, or the mother of the child in jail, or the sister of the brother on house arrest, or the spouse of someone who's been confined 23 hours a day at the age of 18. Everyone wants to know why kids do what they do, but nobody asks them. The JJPOC has taken these baby steps to do just that. In 2021, we proposed the same recommendation. It wasn't passed and nobody knew why. It would be truly shameful if we did not see it pass again. If you remember anything I said today, let it be this. I can go on and on about why we deserve the voting seats, but if you've been there, you know why. The JJPOC has 43 voting members, only one directly impacted community member. Opinions and experiences from all areas, Republican, Democrat, on the ground, in the agencies, are all currently invited and voting members of the JJPOC. The only voting seats that are missing are those who are directly impacted. And the only recommendation we should be chasing when talking about creating groups to address or analyze youth crime is Section 3 of SB 387. We ask a lot of questions about hypotheticals, but you can't do that unless you know what it's like to be in the shoes of these kids and families, to be excluded or siloed because you're not white, to be 17 times more likely to be arrested in schools with police because you're Black, not a criminal, to make up less than 35% of the state's population, but 83% of the state's incarcerated population. That's not a coincidence. If you know, you know. Thank you for allowing me to speak today, and feel free to reach out to me to learn more about the Community Expertise Work Group. And there's my timer.
Well done. Appreciate that. Questions or comments from the committee? Representative Fishbein.
Thank you, Mr. Chairman. Good afternoon, Ileana. Ileana, we heard earlier from someone who just doesn't want any children to go to jail. Is that your position as well?
I do believe that young people don't belong in prison, yes.
Okay. So
or jail or detention.
So no matter the crime, they should not be detained or go to jail.
I think back to Maurice's testimony, case by case, we could analyze whether or not a kid should be in a locked setting. I don't think it needs to look like a prison, jail, or detention center.
Okay, so if we paint the walls pink and have flowers and all that on the walls, that would make it different.
If we remove, I got you. If we remove the locked cells, the environment, the ways that the staff treat the kids that are incarcerated, and the bad policies and the practices and the use of solitary confinement and pepper spray, and implement some services and programming that the kids would like, and also implement some credible messengers, I would love it. But without that, I think there's a lot of improvement. And also being mindful of not violating any civil rights.
Sure, well, I'm all about civil rights, or victims' rights too. So with a 13-year-old that's arrested for murder, they should not be detained. They should not be incarcerated.
I think that a 13-year-old that is arrested for murder, and this goes, a lot of people said very similar things that I would say, so I won't go too far. I think that we should be analyzing that kid, what led them to commit the murder. I do think that, again, we can have conversations about what a secure facility or placement looks like for kids that young who need to be away from the community and somewhere where they're able to focus on themselves. But I don't think that the current jails, prisons, or detention centers that exist incorporate anything that would help that 13-year-old who committed murder.
Okay. I understand your perspective, and it's very helpful. Thank you, Mr. Chairman.
Thank you.
Further questions or comments? Seeing none, appreciate being with us and appreciate working with us.
Thank you.
Next up is Laura Devlin.
Thank you, Mr. Chair. And thank you to the committee for the opportunity to speak with you today. I've been watching your hearing and applaud all of you for the amount of work that you are doing. But I'm here to talk in support of 5418. I don't want to speak specifically about the bill, but I do want to provide some context about why I'm before you today. First and foremost, I am here because the people in my community certainly do not feel safe. And I've heard extensively from our local police, from our prosecutors, and also from our public defenders. What we're seeing is, not only an increase in stolen cars, but it's not just about the property. It is to some extent, but those vehicles then are used in other incidents of much higher violence. So we're seeing increasing brazenness and also violence, whether it's a car stolen with a kid in front of an ice cream shop on our downtown main road, 2 teachers at 7:30 in the morning confronted at gunpoint in front of their schools. Just the other day in Westport, our neighboring town, a Uber Eats driver who now has traumatic brain syndrome because of a carjacking of their car. The key, I think, is addressing this issue of repeat juvenile offenders. And if I could, I hope it doesn't take too much of my time, I'd just like to share some numbers with you that were shared with me from the prosecutor's office. So if you look at, there were 48 youths, right, that were repeat stolen car offenders. And I can't tell you for sure right now if these numbers were 2020. I think they might have been 2020 numbers. 36 of those individuals went to community programs. That's about 75%. But there were another 12 that were basically unreachable. So 25% that didn't. Of those 12, right, the average age was 15. The average arrest between 2017 and 2020 was 8 times per individual. All of them had a gun. Regrettably, one of them died. 11 had 55 or more disciplinary incidents in school. They were responsible for 84 stolen cars in 2020, and the police were called an average of 30 times for each kid. And what I hear from our police, again, from the prosecutors and the public defender, are that, they're really about the kids and taking care of the kids, but there's sort of 3 buckets. There's the bucket up front where some individuals do go into diversionary programs and there's success. There is another group at the far end that you could say go over the line and they end up in being adult criminals and ultimately being convicts. I would count these 12 as sort of being in the middle. And this is what we want to prevent. We want to stop these kids from, moving into that third bucket. I'm all about programs. I do believe we need consequences, and I don't see that we have those. But I have been asking since November.
Representative, you're at your 3 minutes, and I want to ask, because in the Judiciary Committee, we really don't do subject matter public hearings. We do public hearings on the bills. So I understand you want to talk about some incidents in your district, and I'm certainly familiar with those being from a neighboring town. But what specifically about the bills in front of us today do you believe would have prevented those incidents from occurring?
So I think one of the things that's really important and that I do support in the bill is that if a juvenile, there's several different things. First of all, if a juvenile commits murder, or if a juvenile is caught with a gun, right? We have some of the most strictest gun laws, and I've been listening to your debate most of today about gun violence. But if a 14-year-old is caught with a gun, it doesn't seem to be a big deal. So I do believe that transferring certain cases of extreme violence and sexual assault, for sure, and crimes involving a firearm to adult court are important.
So you were in the legislature in 2015, and you voted.
That was my first year in the legislature.
And you voted for Public Act 15-143 that actually set up the current system by which we decide what cases are tried in adult court versus what cases are tried in juvenile court. And under that bill, the Public Act we all voted for, under that bill, a B felony could be transferred to adult court by an application of a prosecutor. Is that right?
I will take your word for that, Representative Stavstrom.
So you voted for the bill. But
okay, I don't have it in front of me, and it's 2022, so I can't share the details right now of that legislation. I'd be happy to look it up and get back to you, and we can discuss it.
Okay. Well, yeah, we can certainly do that. I guess what I'm trying to figure out is, I keep hearing this narrative today. I'm sorry to take out this frustration on you, but that somehow something has changed from the bipartisanship we all had in 2007, and then 2015, and then 2016, and again in 2017, 18, and 19. We passed juvenile justice reforms in each of those years with broad bipartisan support, near unanimous support. And now I'm hearing that, no, what we need to do is automatically transfer more cases to adult court. And so I'm trying to figure out, sort of based on the scenarios you gave, right, why automatically, as opposed to just giving a discretion to transfer a case to adult court, would somehow solve the problem you're trying to. Because I'll be frank, I'll put my cards on the table. To me, it seems that investing in community services, support, housing, education access, after-school programs, etc., for a lot of the folks I represent, is a better investment than $1,400 a day to detain a kid in prison. And so I am just drill down for me, if you will, on this proposal of why the issues, the incidents you cite in your community, which I share your concern on, don't get me wrong, how the language of the bill before us solves that problem.
So currently, there are no consequences for that type of juvenile offense, or there are no consequences being imposed. And to answer your question related to, all of the money that we're spending on services and programs, I'm all about services and programs, right? But we don't know. The Judicial Department has told your committee, I believe, that we, in our state of Connecticut, have more programs on recidivism than any other state in the nation. Yet, we have been unable to get any information about what they are, how they're administered, how much money is spent, importantly, what are their outcomes, and how many individuals are involved in those. I think that information is essential. Representative or Chairman Safstrom, I would like nothing more than to never send a child to school, or to jail. But at what point, and hopefully going in adult court, perhaps they're not automatically sent to adult prison, right? There's no sort of intermediate step between the diversionary program, and if they don't repeat, great.
Guns in polling places. Do you think people should be allowed to bring a gun into a polling place?
Well, that's a good question, and one that I haven't thought of before, but if someone has a permit to carry a gun, are they currently restricted from bringing it to certain venues?
All right. Representative Fishbein, any questions?
Thank you, Mr. Chairman. Mr. Chairman, well, perhaps the good representative knows, you were given the impression that a transfer as a result of the legislation passed in 2015, a transfer from juvenile court to adult court was discretionary just based upon an application by the prosecutor. Do you know that to be the fact? Or,
I don't know that to be the fact.
Because I believe there are certain criteria even after that application is made. And, while I wasn't in the legislature in 2015, my understanding is that there was a representation this would make the process better. So it was trust but verify. The legislators voted for this language. And as part of the 2015 changes, B felonies, which were previously automatic transfers, became discretionary transfers based upon the court permitting the transfer. And are you aware of how many times since 2015 those discretionary transfers have been granted by our courts?
I do not, Representative Fishbein, but I'm going to guess you can tell me.
Well, I think it can be counted on two hands, and that's it. In almost 6 years since that legislation has been into place. So on discretionary transfers. questions. I thank you for coming here today and representing our caucus in support of 5418, which is our caucus bill. Thank you, Mr. Chairman, for the ability to answer the representative questions.
Thank you. Representative O'Day.
Thank you, Mr. Chair. I just want to say thank you. I am very glad that we let legislators testify in various bills as somebody who has in the past. And I do appreciate you taking the time out. And I agree with you, we've got to do something because right now we've got a huge problem, and particularly in my district. Now, I can't speak to the good chairs district and what's going on in Bridgeport, but I can tell you in Fairfield and New Canaan, we got a problem we need to address it, so I appreciate it.
Could I say one thing?
Yes.
We hear frequently, oh, they, usually meaning Republicans, just want to lock up these kids and throw away the key. I have never heard anybody state that, and I don't know anybody who has that point of view. What I have heard repeatedly, and particularly what I was shocked about in speaking with the prosecutors and the public defenders, was the amount of compassion that they have for these kids. And what I hope for, Mr. Chairman, and your speak of bipartisanship, that we can all work together to come up with some solutions that help these kids caught in that middle bucket that are going down a path that is no good for them, no good for their families, and no good for public safety. So thank you.
Representative, not to step on Representative O'Day's toes, but I think folks know me well enough, I hope, to know that that is always my goal, is to get to bipartisanship on this. I do not support stripping discretion away from our judges and sending more kids to adult court, where I think they have less services and less support than they do in the adult system. But yes, there are other provisions of some of these bills that we can certainly work off of.
Well, thank you, Mr. Chair, and thank you, Representative, for your testimony.
Thank you.
Seeing no further questions, good seeing you as always, Representative Devlin. Jared Perro will be next. Jared Perro with us?
Hello?
Yes, hello, sir.
So I'm actually on the road right now. This kind of brought on longer than I initially anticipated. Would it be possible to testify in about 20, 30 minutes or so?
Yeah, we can put you towards the end.
Okay.
All right. So we'll skip you.
Sounds good. Thank you.
Joshua Fritz. Joshua Fritz with us. How about Matthew Malacott? Matthew Malacott. Madam Clerk, slow me down if we're trying to get folks in electronically with technology.
You're good so far.
Annie Dance. Brendan Malone.
He's joining right now.
Okay. Mr. Malone.
Hello. I'm on. Can everybody hear me?
We can.
Thank you so much. Thank you all for your time today. My name is Brendan Malone. I'm a resident of Suffield, Connecticut, and I am here to speak about in opposition of SB 16, particularly regarding the portion expanding the definition of ghost guns to include those manufactured prior to 1968. Several years ago, I testified when it was called HB 7219, an act concerning ghost guns, and prior to that, it was HB 5540. My biggest problem is that, in my opinion, it really doesn't do anything to stop crime or slow crime. In many cases, when a criminal uses a firearm, while perpetrating an illegal act, they've taken the time to obliterate or destroy the identification numbers on that firearm. So, should this be implemented, the thought that a criminal would leave these identification numbers required by the state intact, it just doesn't make sense. And furthermore, I think there's a misconception that I wanted to address regarding when these firearms change ownership. I think that there's a thought that they're untraceable, but when these are legally purchased, I can tell you from personal experience, you fill out a DPS-3 form just like any other firearm transfer. The local police and the state police still receive, those forms for the transfer. The make and the model, everything is still listed on the transfer forms, and it's obviously all the information is still disclosed, and they recognize the legal transfer of ownership. So I know you got a lot of people today, so I just wanted to make it quick. Like I said, I've testified on this before, so I wanted to thank everybody, and please join me in opposition of SB 16.
Thank you, sir, and thanks for keeping it brief. Obviously, we are getting long here. We do have folks written testimony, so we appreciate the summarization there. Representative Trubisky, do you have a question?
Thank you, Mr. Chairman, and thank you, Mr. Malone, for coming in. So, with regard to this, the bill to mandate that all unserialized guns get a serial number, what kind of firearms would that affect?
Well, I would assume mostly in 1968, the federal government passed what was called I believe it was the National Gun Control Act, in which they made a requirement for all firearms to be serialized. Prior to that, it was, I know that the experience that I have with those firearms, they're mostly youth guns. They're single shot, usually calibered is .22 long rifle, or what's commonly referred to as rimfire. I don't know of any that have really been used in a crime. I may be wrong about that, but typically, regarding the firearms that I personally own, they're firearms that are used in things like 4-H Club, the Boy Scouts of America use them for summer camp when their kids get their marksmanship merit badges, or when they're teaching, firearm safety. These are really popular with that because they're so simplistic. Most of them are single shot .22. I guess that's, to the best of my knowledge. I certainly, I'm a firearms owner, and I don't own anything of what I'll describe as a larger caliber that doesn't have a serial number on it. So, and those are firearms that were produced prior to 1968. So, I hope that helps answer your question.
It does. Thank you very much. Thank you, Mr. Chairman. Thank you for your time, Mr. Malone.
Thank you. Thank you, Mr. Malone. Next will be Peter Estrada.
How you doing? Good afternoon. Good afternoon to the members of the Judiciary Committee, Chairman Stastrom, Chairman Winfield. My name is Peter Estrada. I'm the Urban Engagement Coordinator with the CCDL. I am also a resident of Hampton, Connecticut. Today I'm here to ask everyone to oppose SB 16, an act addressing gun violence and juvenile crime. Just so you know, I have spent many hours trying to take the time to try to understand what's being proposed in the bill. I was speechless to what I have found. Majority of what is in this bill, I believe, is an attack to the people in my community. I cannot see how, in order to reduce gun violence and juvenile crime, the answer is to open up the floodgates and allow law enforcement officers to stop and detain people of color for no probable cause. Why would anyone want to legalize a tactic that police officers have a long history of abusing? And I don't know of anyone that would want to be subjected to that type of treatment. I ask, who will be impacted by this type of law? Will be people in my community, people of color, Black, Latino. How, in order to reduce gun violence and juvenile crime, the proposal is not to allow legally permitted firearm owners to ride the public transit. How does that reduce any crime whatsoever? And who is this going to impact the most, affect them the most? Will be people from my community that depend on taking transit, taking the bus. A lot of our people in our community cannot just afford a car. We don't just have that luxury. I do. I'm not speaking for me. I'm speaking for those that can't afford a vehicle and they have to ride public transit. So I gotta ask, in order to reduce gun violence and juvenile crime, how is it that having and banning people that are legally carrying a firearm within 250 feet of a protest, sitting in march, or gathering, just because 15 people or more are together, how does any of that reduce crime? So I started to ask myself, why is this? Why now? Why is this happening? Why these type of bills are coming before us? And then I started doing some research. What happened recently within Connecticut? And what I found and I remembered was a year ago, I believe it was 2021 to 2020, a group of Black and Latinos decided to march for Second Amendment rights in the city of Hartford. And I wonder, is that the reason why they don't want people to carry legally in a group setting? So today I'm here to ask every member of the Judiciary Committee to please vote no because of the impact that it could have on the members of my community.
Thank you. Representative Witzkin.
Thank you, Mr. Chairman. And thank you, Mr. Estrada, for coming in and testifying today. A couple of areas of SB 16 I wanted to ask you about. You mentioned how you thought you asked sort of rhetorically how banning the carrying of firearms on a bus or a train would affect the people of your community. And rather than have you ask rhetorically, I'd like you to tell me, how would this affect people in your community that can't afford a car or choose not to have a car, and their right to protect themselves in their communities? You're muted, Mr. Estrada.
I was muted. I apologize. Thank you, Representative Tabisky. Past few days, I've been having a conversation with friends and family in regards to what's happening in this bill. And I read the bill. It's a little bit complicated trying to learn all the language, but what my takeaway was just pretty much what I spoke on. And the impact is, it's not more of when you're on the bus, the walking to the bus, maybe you don't live in an area that is, more affluent, where you don't have to worry about crime. But for those individuals that live in those towns, that have to get to the bus, maybe there is a spike in crime. What do? They have to stay home, So how do they travel if there's a spike in crime? How do they protect themselves? And I don't understand. I remember early on, I've been watching since the beginning when they were asking the commissioner. I'm not sure if I remember it was you, but I don't know of any crimes being committed on public transit. I haven't heard of it. And I'm sure if there was these type of crimes that being committed, it would be all over the news, and I just haven't seen it. So why is it that these type of bills are impacting the minority community? First we're going with delays in the urban cities in processing these fees just to submit applications to even get a permit is outrageous. To have to spend $220 to exercise a constitutional right. Everyone claims to support the, to say, everyone loves to say, I'm a supporter of the Second Amendment, but we should have restrictions. But I don't think the restrictions should come with a fee. If I'm going to get a permit, then give it to me for free. Are we going to start charging fees for the right to vote, to get a voter ID? This is just the type of things where I think, I don't want to say members of this legislator really want to discriminate directly, but it's just, you got to ask the question, why is this happening now? We have had, I believe last year, over 6,000 Black people get a pistol permit. Thousands of Latinos last year got pistol permits. And as a result, what happened? Delays. City of New Haven, to submit a pistol permit application, you have to wait a year almost just to hand in an application. How is that fair? A city that has how many Black and Latinos that live in that city? Waterbury, Bridgeport, Hartford, urban areas, all delaying people in the minority community. Why? I don't gotta ask that question. Why is that happening? And no one's speaking up. I've been trying to contact my legislators to bring them, to make them aware of what's happening, but no one responds. No one responds. The only one that responded is my organization, Connecticut Citizens Defense League. Had to take them to federal court with a civil rights lawsuit to get them to do their job. I'm sorry, I apologize. Someone did respond. The mayor of New Haven, who then was upset that the police department was being sued to do their job. That's outrageous. Wasn't upset that they have delays, upset that they're being sued to do their jobs because the people in the community can't get a pistol permit. They have to wait over a year.
Okay, there's another provision that I'd like to ask you about. I assume because you're in the car, you don't have the bill in front of you, but in lines 292 and 293 of SB 16, the proposal is to remove the requirement that a police officer has a reasonable suspicion of a crime, a reasonable suspicion that a individual has committed a crime before they can stop them and demand to see a pistol permit. How do you think that will affect your communities?
Well, how has it affected our communities over the years since the 90s? I grew up in New York. It was common practice for law enforcement just to grab Hispanic and Black kids and throw them against the wall just to search them. It was common practice. That's that's the environment I grew up in. For doing nothing except walking from work, coming out the train station to the project building I live in, to have the police officers just to run up on you, stop you, and say, "Hey, any guns or drugs on you?" You know, what is it? And that's not even with probable cause. That's not even me carrying a gun. That's just because they wanted to do it. Now, amplify that with having a firearm. Now, people like to say, just show them the permit. What's the big deal? Look at what happened with Philando Castillo a few years ago with his girlfriend that live streamed the event after the fact. He got pulled over, right? It looked like a legit stop. The car light, brake light was out. Police officer, no problem. You know, hey, you got pulled over for the light. He did the right thing, like everyone would like us to do. Hey, you know what, officer? I have a permit. I'm legally carrying. I do have my firearm on me. That's what he tells the officer. Officer says, hey, don't worry, don't touch it. No problem, I won't. How is it about 3 seconds later, the officer's putting 7 bullets into him? And the last words out of his dying mouth was, oh, I wasn't reaching for my gun. I can't imagine that happening here. Well, actually, I could imagine because it has happened, but this is insane. Why would you want to remove probable cause to stop and detain people? I don't understand what people are thinking. That makes absolutely no sense. Do we not have rights? Why would I want to give away my rights? That makes no sense to me.
And the other one that I wanted to ask you about was we already talked about public transportation. How would it affect the minority communities in this state to ban possession of a firearm at a demonstration, march, rally, vigil, sit-in, protest, picketing, or similar public assembly?
And who's to define what's a similar public assembly? So if I'm around with 50 of my friends, if the muzzle of my pistol happens to peek out, or the officer just can say, hey, I saw his gun. Let me stop and detain these people. Let me arrest this person. To me, all I see this is as loopholes to arrest us. It's not, it just has nothing to do with reducing gun crime. If it was, I want to hear it. I want to be a part of the solution. But how does arresting someone for having a gun legally, after you obtain a permit, purchased it, went through the whole background check, and then to be able to then arrest them? To me, all I see is a bunch of loopholes to actually put people in jail. I'm sorry, I thought the past couple of years we were working on not putting people in jail, trying to find out solutions to the people in my community. But then when it comes to firearms, you know what? Let's put them in jail. That makes absolutely no sense to me.
Well, I very much appreciate you coming in. Your testimony is certainly well taken, and I appreciate it. Thank you, Mr. Chairman.
Further questions or comments? If not, we'll next hear from Stephen Megira. Christopher Dukes.
Good afternoon, all. Please pardon my brief greetings to all of you. I appreciate you being here. I've been here since 10 o'clock as well. My name is Christopher Dukes. I'm a former liaison to the State Attorney's Office in New Britain and various law enforcement agencies inside and outside of Connecticut. I'm a consultant, private investigator, and I'm a community activist. I'm a legal gun owner for more than 20 years now, and I'm a holder of a Connecticut concealed carry permit as well as for the state of Utah. I believe I'm checking a lot of boxes here with my testimony, being that I'm the first African-American male to testify throughout this hearing. And I've heard a lot of questions about how we are affected, and I'm hoping that I can receive and respond on behalf of myself and the community to those of you who I know are actively listening. I'm here to provide my support and my opposition for a couple of bills. First off, I'm in support of HB 5415, HB 5412, and SB 388. I also failed to mention I am a member of multiple gun clubs, including the CCDL. So if you want another perspective, I think Brother Estrada just did a fantastic job. I'm willing to piggyback on that one. I am in opposition of HB 5416, specifically because of bulk purchases. The first time I ever purchased was on 9/11/01. Nobody knew what was going to happen on 9/12. I would have hated to want to protect my home with a pistol and a shotgun, and I couldn't because some law was in place that stopped me from helping defend myself and family members. And I'm in opposition of SB 16 for all the reasons that other folks have mentioned. Here's my concern. I believe that the bill is unnecessary for, even Commissioner Ravella has stated earlier, Connecticut is safe, and most violent crimes are involving illegal guns, not our legal guns. Criminals don't abide by boundaries or existing laws. I've heard some conversation about exposed, mean open carry or concealed carry. There's no way it can be intimidating to carry a concealed weapon when nobody knows that you're carrying. Therefore, there's no need to infringe upon that particular right. I'm going to end in closing by telling you some of the impacts that I don't believe you may be aware of. SB 16 would make a crime for activists and allies who continue to enjoy exercising their First Amendment right while protecting themselves using their Second Amendment right. Activists have faced hate crimes. Motor vehicles have attempted to hit them, and in some have hit them. Some of us have survived drive-by shootings intended to silence us. We must retain the ability to protect ourselves as intended by our country's Constitution. Some of us rely on public transportation as well. And we are most vulnerable when leaving demonstrations. When people don't see us united with a group, we become soft targets and people can take us out if they're opposing to us. And because Peter Estrada already mentioned Philando Castile, that was someone who I wanted to mention to you as well. So I'm done. Thank you. I'm at the 3 minute. Thank you. If you have any questions, I'll be happy to answer them.
Yeah, Representative Dubinsky.
Thank you, Mr. Chairman, and thank you very much for coming in, Mr. Dukes. I very much appreciate it. You had said you had something to add in addition to what Mr. Estrada said with regard to SB 16. And I asked him specifically about the provision about banning firearms on public transportation, and with regard to banning any demonstration, and also with regard to reasonable suspicion. Perhaps we could take those one at a time. If you could, if you had something additional with regard to how the ban on carrying a firearm on any bus, train, or ferry operated by a governmental entity, how that would affect people in your community.
I would say for the same reasons that Brother Estrada had hit, walking to and from and waiting at a bus stop can be dangerous. I mean, I don't think it's less dangerous or any more dangerous than anyway else. People need to be able to protect themselves. You just never know. You could be mowing your lawn and all of a sudden shots just ring out and you don't know what's going on. So people don't use guns. I don't believe responsible gun owners, and you've heard a lot of them today, I don't believe that any of us carry so we can feel big and bad. All right. I think that the whole point is being able to protect ourselves legally when we are pursuing, life, liberty, and happiness. I have personally used public transportation quite a few times, and when I did legally carry at those times. One time I couldn't drive; I had shoulder surgery, so I was able to carry, but I was still able to use one hand. So I felt comfortable that I was going to be in this space. So, but again, I do know others who do not have a vehicle, and they like to come out and support and be a part of a vigil. Or actually, I'm getting into what I think your next question is, so I'll stop there.
That's okay. You can segue in if you'd like. But I did want to ask you about, I didn't ask Mr. Estrada about it, but there's also in SB 16 a provision banning the carrying of any firearms in any municipal or state building. In the cities, there are more municipal and state buildings than there are in the rural areas. My town, we have very few. We have no state buildings, and we have very few municipal buildings. But I know that in the cities there are quite a few more. How would that a ban on carrying a firearm in any municipal or state building affect you and the members of your community?
I believe it affects every community, to be honest, not just the black or brown. It affects everyone. We have legal gun ownership. As I stated, I've owned firearms since 2001. I have no criminal record. My firearms have never been abused in any way. Being able to come and go and respectful of the laws, it's the gun owners who I believe are going to be far more respectful than the criminals. I would like to have the ability to be able to carry in such buildings, because if a bad person comes in, who again, as Ravella stated earlier, has no boundaries, they don't care about the existing laws. I'd like to be able to protect myself and perhaps others if something of a dangerous situation did come about. An active shooter can just come anywhere. You just never know, which is why you train. And some of us train as much as law enforcement agencies to make sure that we are thorough. We don't have any accidental discharges or any unintended recipients of any rounds whatsoever. So that's how I feel about the buildings in itself. I hope that your next question will be about demonstrations.
It certainly is. Go right ahead.
Thank you, because that is what I feel the strongest about. I've had a raw deal that have made me a community activist, and I am out there very frequently. Some of you have seen me at the Capitol. Some of you have seen me here. I'm there. I'm at various places, New London, all over our state where we go, wherever there's a problem. And basically, we are addressing corruption, and we are speaking out against it. Racism was declared a public health crisis. We want to make sure that we are out there speaking to advance and help you all make laws that are safer for the entire community. It would be devastating, because we don't have police who are able to be with us all the time. It would be devastating if we are not able to protect ourselves in or outside of our homes when we're at these demonstrations. We've had demonstrations or vigils on a corner where someone's been deceased, or whether it be a DUI or a shooting or so forth. We are vulnerable when we're out there showing support for the life that was lost. There are people sometimes who will come out and target those crowds. I can tell you, myself, I am a survivor of a drive-by shooting. That's what I mentioned earlier. There was someone who we believe opposed my opposition to corruption within Hartford Police Department and the State Attorney's Office, who on Martin Luther King Day last year, the case number is 21-1650, if anyone wants to look further into it. This person followed me down my street, waited till I was in my driveway, fired 3 bullets in my car. I'm a deacon of a church, although I'm not involved in any criminal activity. That's why all of us believe this was a target. They wanted to take you out like they took out Medgar Evers in the driveway. It's dangerous out there. So again, had I, at that point in time, been able to, I've never had a chance to defend myself because cars sped off so fast. But the point is, there are people who are opposing us, and it is dangerous for us. So luckily now I am able to carry to and from home to demonstrations I never brandished weapons. None of us have. There has been no shootings in any of the demonstrations that I can think of throughout the state. So I'm not sure why we need to start protecting for a problem that does not exist here in Connecticut. Thank you for your question, sir.
Well, thank you for that. I appreciate your personal knowledge on that situation. One last area I'd like to ask you about. In the bill, the provision requiring police have reasonable suspicion of a crime prior to demanding to see a permit is removed. And if you could just talk to me from your perspective about how that would affect you and people in your community.
Thank you. And again, Peter Estrada said it best so far. It does put us in a dangerous sense. Philando Castile did the right thing. I'm reminded of Eric Gardner. Eric Gardner wasn't even armed, and he got choked out and was killed when he was approached by police. It can be a dangerous encounter. I stated earlier, I've been in my past employment a liaison in the police department. I never had a problem with police until about 2018. And then during that time, I was asked by a police officer, "Are you carrying a firearm?" And my response was in the affirmative, yes. Well, that whole story got twisted into he's having an armed standoff. Here I am described as a big black bearded bald guy, and he has legal firearms, but I was demonized. So that's all we take care of in other arenas right now. I believe that it is, and I never had, well, I did have, again, I've been an African-American male for about 50 years now. And even though I've never had problems with law enforcement before, it is a concern when you're approached. I have been diagnosed with PTSD since then. I do have a problem. I'm working on that, but I've always been respectful of law enforcement and police. So when we are approached, I believe the man named earlier, his last name might have been Beavis, I believe, he had stated, these are negative encounters. They can be. There are people like, for example, Representative Howard, who I believe in doing his job, I'm not accusing you. He almost got whiplash and turn around now. Who I believe would have been a respectful officer out in the field. And, I've never had a problem with folks who did their job well. But it is dangerous when people automatically are scared themselves. I've had a lot of personal friends who are law enforcement officers. They're afraid. It's crazy out there. It can be crazy out there. But not everybody's crazy. And not every gun owner is a demon. So I applaud everybody for what they do, but I think approaching us and asking us for anything can be intimidating because we have to find out, are we the next Eric Gardner? Are we the next Alton Sterling, Philando Castile, Michael Brown, Trayvon Martin? Are we those individuals who this encounter is going to turn from an innocent talk to you about this to where I'm in the ground somewhere? That's a reality for me. Others.
I appreciate that, and my concern is that if this bill were to pass, it would prevent you from just walking away, which is what you have a legal right to do. You should not be compelled to talk to the police. You have no obligation, no constitutional obligation to say anything to a police officer, and if this bill were to pass, that would change. And that's why I have grave concerns about it. I very much thank you for your time and for your answers. And thank you, Mr. Chairman.
Thank you.
Porter.
Thank you. Thank you for your testimony. I hate that I wasn't able to get to my unmute button before Mr. Estrada left us, because he too did a very good job and explaining himself around what the concerns are, especially in communities of color. And you answered my question because Representative Bisky asked it in his round of questioning. But I just wanted to take this opportunity to really thank you for bringing it home. I mean, I listen to you and it resonates. It concerns me that reasonable suspicion of a crime is removed because some people's eyes, just being black is a crime. So the fact that you're talking about taking away a reasonable suspicion of a crime opens the floodgates, and they're already open. We've seen it. You've talked about instances where we have been subjected to it and continue to be subjected to it. My son was robbed twice at a bus stop in New Haven when he was a teenager. So, I mean, everything you're saying, I can validate through lived experience. Myself and my children have been impacted by gun violence, and I think it is everyone's right. If it's a Second Amendment right for all citizens of the United States, it is your right to carry. And I don't think that should change now because we have more Black and brown people getting armed. You know, it is a right. So thank you again, and thank you, Mr. Chair.
Other questions or comments? If not, thanks for being with us, sir. Next up will be Michael.
No.
Mike, sorry, we good?
I think Representative Howard had a question. He had a hand up.
Oh, sorry, I was looking down to read the sheet. Representative Howard?
Yeah. I'm sorry, Mr. Chairman, and I just want to say thank you to Mr. Dukes for his kind words. I didn't want him to leave without that. I appreciate it, and I think that there are a lot of people in Connecticut watching this, and I think that what you did was that you displayed what we should all be displaying, and that was that you express your position. You know what I do. You know my positions on things. And you and I have had great conversations. And I think that the relationship that we have and the conversations we have should be an example for everybody that we can work together. And I just want to thank you for that.
Thank you.
Further questions or comments? Seeing none, thanks for being with us. Michael Navaroli. Michael Navaroli. Jasu Tristanis. Jason Levy. Go ahead, sir, if you can unmute.
Got it. Thank you guys for allowing me to testify today. I do want to start by saying I'm a little dismayed because several individuals I know do not feel comfortable testifying or even submitting written testimony because of actions taken by supporters of members of this committee that they have been doxxed, harassed, intimidated, and slandered, myself included. My personal information exists on Facebook on a representative's page that I asked to be removed years ago and has not by a supporter. And that's very upsetting to me that we can't even have a discourse without being attacked. There is so much wrong with SB 16. It's hard to know where to begin. You guys are going to hear a lot of it. What concerns me most is the clause that would allow law enforcement to detain and demand papers from anyone they suspect of carrying a firearm. This kind of sums up the tone of the legislature's attitude towards legal gun owners in this state. It seems that many of you wish to demonize and vilify us. We are simply law-abiding people who want to keep our families and ourselves safe. The fact that this is again being proposed after being shot down by pretty much every advocacy group in the state is really a dismay to me. The idea that you want to create more gun-free zones, saying that we are not allowed to carry our firearms, that we have gone through one of the most arduous processes in the country to be able to exercise that right, is extremely concerning. Something like 98% of mass shootings occur in gun-free zones. So, I mean, is this proposal to literally create more areas for criminals to target? That's what it seems like to me. As far as buying more than one gun a month, when I got my permit, I was pretty excited. I went and bought 2 handguns. One for practice was a small 22 because ammo is cheaper. I bought one to carry. I wouldn't be able to do that if this passes. The other provisions that are disturbing are you want to license FFL dealers, again, at the state level. The state, quite frankly, can't even manage the permit process right now. I'm up for renewal next month. I sent my paperwork in 90 days out, which is as far out as I'm allowed to, and I fully expect my permit to expire before my renewal gets sent back to me, which means I can't purchase firearms or ammunition. I've gone through the arduous process in this state, and my rights are going to be suspended because the state can't even handle some simple paperwork, and you want to give them more paperwork and tools to harass firearms owners. The only good thing in this bill, as far as I'm concerned, is the funding of the Firearms Trafficking Task Force, which was funded immediately after Sandy Hook was created. They did a phenomenal job. They reduced gun violence in this state by an enormous percent. And
so we're at the 3-minute mark, sir.
Okay, thank you.
Appreciate your testimony.
Are there any questions?
Yeah. Representative Jablonski.
Thank you, Mr. Chairman, and thank you, Mr. Levy, for coming in. I just wanted to thank you for your testimony. You mentioned some adverse publicity, doxing, you said, that you and others have received by members of this committee.
Not members, they're supporters.
Supporters of who?
A representative that sits on this committee.
Okay. Do you have any information that any member of this committee?
Representative Jablonski, let's take this offline. I share your concern.
Okay.
I'm not sure it's something we necessarily want to get into publicly. So let's have a conversation offline. It's also not directly related to this bill.
I would ask Mr. Chairman if we have Mr. Levy's contact information that we could get in touch with him. And
yes, yeah, I submitted a written testimony as well. So you can have my email.
All right, perfect.
Great. We will get in touch with you and we will discuss your accusations about anybody that might be connected to this committee.
I appreciate that.
Thank you very much. Thank you, Mr. Chairman. And thank you, Mr. Chairman, for coming in.
Next up will be Liberty Moyer.
Representative Staffstrom, I think Mr. Navaroli has turned on his.
Okay, Mr. Navaroli, we've got his camera on now. We will go to Michael Navaroli.
He's muted. I've asked him to unmute.
There we go. Mr. Navaroli, can you hear us? We still can't hear you. All right. We're going to come back to Mr. Navaroli after we get his audio issues figured out. Jason Levy, Liberty Moyer.
Hi, yes.
Go ahead, ma'am.
Thank you. Thank you, Chairman and members of the committee. I'm here to speak on SB 16, to which I am strongly opposed. I have two primary concerns with this proposed legislation. The first is that I do not feel that it treats citizens of Connecticut equally under the law. And the second is that I believe its provisions are largely ineffective against criminals while punishing law-abiding citizens. Regarding the gun-free zones on public transit, as has been discussed, the primary users of public transportation are primarily lower-income groups and minorities, for the sole reason that they cannot afford to take private transportation or have chosen not to do so. These citizens who are licensed to carry a firearm by the state of Connecticut would be denied the same rights as others. Further, criminals can simply continue to carry concealed weapons on public transportation, and this law is unenforceable. Lastly, I'm not able to find any records of shootings on public transportation in Connecticut, so this law limits the rights of lawful citizens to defend themselves while attempting to solve a problem that does not exist. SB 16 also allows police to request the proof of a carry permit if a carried handgun is observed. I think, as we've discussed here a few times, this strips lawful citizens of their Fourth Amendment rights without having any effectivity on criminals who historically and statistically keep their weapons concealed and can continue to do so. It also fails to define visible, so having your shirt come up while carrying concealed or imprinting could be potentially included as well. It also revises the assault weapons ban to include weapons commonly known as others, which are often similar in appearance to a rifle. Weapons defined as others are responsible for less than 1% of firearm homicide nationwide, and thus less than 1/16 of homicides carried out with a knife or other cutting object. If you were to remove all rifles from existence, and not just those defined by various laws as assault weapons, gun homicides would be reduced by only about 4% per year. Rifles as a whole are responsible for fewer deaths than knives, fewer than blunt objects, and fewer than hands and feet. In 2020, there was an over 33% increase in gun sales in Connecticut, and in 2021, they increased another 64%, which is a 5-year high. 30% of these purchases were first-time gun buyers, and 33% were women. Retailers seeing an increase in purchases by minority groups were reported at 44% for African Americans, 40% for Hispanics, 27% for Asians, and 18% for Native Americans. It's evident that this bill is not reflective of the growing positive public sentiment towards firearms in this state. Instead, it limits the rights of women, minorities, and all law-abiding gun owners while making an ineffective attempt to address what are not even meaningful sources of crime. Citizens of Connecticut elect our legislators to represent the will of the people, as well as to enact laws that are logical and supported by fact. SB 16 does neither of these, and I would strongly urge you to stand in opposition to this bill. Thank you for your time.
Thank you. Representative Fishman.
Yes, thank you. Liberty, thank you for coming here today. Nice first name, considering that we're talking about Liberty here today. I just want to mention to you that SB 16 was submitted by your governor. And I would hope that you would share with your colleagues, friends, and family how your governor feels about gun ownership in the state. So that's all I had. So thank you. Have a good day.
Thank you very much, you as well.
Representative Javitsky.
Thank you, Mr. Chairman. Thank you, Ms. Moyer, for coming in. I think you did an excellent job. I don't have any questions for you because you did such a good job and you hit all your points very well, right in the time as well. So, I certainly appreciate your coming in and talking about how this bill, SB 16, would affect you and your and the community in which you live. So thank you very much. Thank you for your time. Thank you for coming in. Thank you, Mr. Chairman.
All right, next up will be Evalis Correa.
Evilise, hello.
Sorry about that.
No, that's okay. People get it wrong all the time. Okay. My name is Evilise Correa, and I'm giving testimony on behalf of Black Lives Matter 860 and city residents we polled from the communities that are most affected by gun crimes about why SB 16 must die in the committee. I also wanted to log support for HB 5416 and opposition to SB 365. SB 16, while good intentioned, places the lives of activists in danger. I am one of several racial justice activists testifying against the bill, and we know this bill places Black and brown lives in danger. Our Second Amendment rights are currently under attack, and racial justice groups do fear for their lives. We hire security and have great relationships with local gun clubs, and police are not welcome at our events. There is currently an open internal affairs investigation where Hartford police made comments about discharging their weapons to disperse the crowd back in November. But they claimed they didn't have their cameras on during public-facing interactions. We have been attacked by police in West Haven, Connecticut, which led to an officer breaking someone's spine, and I myself have been attacked on the news by an armed man that left bruises on my body. Also, removing reasonable...
Ma'am, we can't hear you.
Yeah, I lost volume too.
Ms. Correa? Ms. Correa, we can't hear you. I don't know what happened there.
Wait, can you hear me?
Now we can, yep.
Okay. So where did I leave off, according to the audio?
I think it was really just the last 15 seconds or so we didn't get.
Okay. So we have been attacked by police in West Haven, Connecticut, which led to an officer breaking someone's spine, and I myself have been attacked by an armed man that left bruises on my body on the news. Removing reasonable suspicion in SB 16 again is another a failed stop and frisk policy like the previous law in New York that attacks our Fourth Amendment rights. Also banning weapons on public transportation will once again put Black and brown lives at risk. As for polling places, Connecticut is segregated due to housing laws, which push pushed us into Hartford and Bridgeport, which is why we didn't need Jim Crow. If you really want to protect voting rights, enact early voting so we don't have to wait 2 hours during midterm elections. Not everyone in Hartford owns guns illegally. The Constitution has been standing since 1776. This moral panic for the children must stop. The last officer that died in the line of duty, if I'm not mistaken, was Brian Asselton, who died during a home invasion in my freshman year of high school in 1999. So that is it. Oh, wait, I'm sorry. And HB 5416 would have prevented cases like Norman Classic from Enfield, Connecticut, who is currently serving 46 months for being the strawman purchaser of 47 guns, despite 3 people having died in shootings with the guns by the time he was sentenced. While he serves 1 month per gun, those caught with the guns will be disproportionately black and brown, and they will be treated much different than Mr. Classic, just like the people targeted in SB 16.
Thank you. Thank you.
Yeah, sorry I got cut off. But,
That's okay. We understand. All right. Questions or comments? Representative Dubetsky.
Thank you, Mr. Chairman. Thank you, Ms. Correa, for coming in. I appreciate your testimony. Did I get it right that you are a representative of Black Lives Matter?
BLM 860, we're the Hartford-based group. I'm also a friend of Chris Dukes.
Okay. So
something he didn't mention to you is that when the person went and shot at him, they actually hit the metal piece in the headrest. It would have gone right through his head if it was just a couple inches up.
Okay, so are you speaking on behalf of BLM?
Yep. Okay.
All right. Well, thank you very much. I appreciate your testimony. Were there any of the other bills you mentioned? The SB 16.
Yes, SB 16 we are opposed to. So we took a vote with the board, and we pulled quite a few people and our security. So this would basically criminalize every protest. I know Corinne Prescott's after me, and she also hires private security. We share security, so it would criminalize her protests. And I mean, this woman just runs a food pantry. So basically, this law would criminalize Black Lives Matter protests in the state of Connecticut without exception.
Well, thank you very much for coming in. I appreciate it. Now, just one thing, you mentioned Fourth Amendment. Do I understand?
Reasonable suspicions, search people.
Okay, so that's you're talking about ones 292 and 293, the removal of reasonable suspicion requirement.
Correct. So that would allow law enforcement. And mind you, there's a pending internal affairs investigation right now in Hartford. So this would basically remove reasonable suspicion and would allow law enforcement to stop our security as well as armed people. So we work very closely with the Self-Defense Brigade, the Huey P. Newton Gun Club, the John Brown Gun Club. They've made statements publicly supporting us and letting people know they are our security. And it would put all of us at risk and allow law enforcement basically to break up all our events. So that includes our toy drive.
We lost your audio again. We lost your audio.
Well, I think we've lost your audio again, but I do believe we're getting beyond the four corners of the bill. And
hold on 1 second.
Hold on. Okay. Ma'am, if we have your audio back.
Thank you. I'm lagging during Senate testimony because you can't get off Roblox. Okay, hello?
Okay, ma'am. Before you go, I think we're getting well off the four corners of the bill. We are now 8+ hours into this public hearing. There is still over 150 people who are signed up to testify, 175 people. At the rate we are going, it will be 27 hours before we are finished. Okay? This hearing will not go out. I will not do that to the staff. We will end this public hearing at some point because it is is not fair to the staff to do that. And it's also not fair to all the people who are sitting here waiting to testify. So, Representative Trubisky, if you have questions for witnesses on areas that we have not covered, that we have not exhausted yet, you can ask those.
I believe that
ma'am, I am, and it's not just to Representative Trubisky, it's to all the members of the committee. I am very concerned that we are not going to get to the folks who want to testify on this bill. It's their opportunity as the public to be able to testify. So let's try to be very, very succinct with our questions and with our comments, and try to get through as many people as we can before we need to let the staff go home for the night. Okay. Representative Trubisky, do you have additional questions that have on topics that have not been covered for this witness?
Not been covered. I will stop with this witness, Mr. Chairman, but for the record, my question was specifically on lines 292 and 293. I think that's part of the bill. So I think that's fair game for any question, but I will stop with this witness right now. And I thank you, Ms. Correa, for coming in and talking to us. Thank you, Mr. Chairman.
All right, we will move on to Karen Prescott.
Woo!
Yes, Karen Prescott is here.
Go ahead, ma'am.
Hello, Senator Winfield, Representative Stavstrom, and members of the Judiciary Committee. My name is Karen Prescott, and I am the founder and CEO of Power of CT. I strongly oppose SB 16, SB 365, and HB 5418. I do support SB 387 and SB 388. I'm very nervous. I want to start off by saying I'm very nervous and upset that SB 16 has juvenile crime and gun violence wrapped into one bill. 3 minutes is not long enough to speak on behalf of both of these bills. SB 16 was designed intentionally to discriminate, demonize, and vilify Black and brown activists who exercise their First and Second Amendment rights. My organization, along with other organizations, organized marches to advocate for Black and brown communities to legally obtain and register weapons. We organized rallies with legal gun owners to protest the nooses found at the Amazon worksite this past summer. These bills are to further support mass incarceration. Black and brown youth and adults from underfunded communities are affected the most by these types of bills. These bills do not address the problems many marginalized communities are facing daily. They are addressing the symptoms. If we address food insecurity, underfunded schools, affordable housing, affordable and accessible mental health programs, increase in wages, affordable childcare, to name a few, we would see a significant decrease in crime. Have we ever tried to equitably fund the marginalized communities that are severely underfunded? Have we ever tried to equitably fund the severely underfunded schools in places like Hartford, New Britain, Waterbury, New Haven, and Bridgeport? If not, perhaps that is where we should start, and not with these bills. Thank you.
Thank you, ma'am. There's certainly no opposition for me to funding Bridgeport schools. Representative Goodson.
Thank you. Thank you, Mr. Prescott, for coming in. I know you were nervous, but you did a great job, and I very much appreciate your testimony. And we're not gonna bite you. So you did a great job. You need not be nervous before us. I assure you. Thank you very much for your testimony, and thank you for coming in. Thank you, Mr. Chairman.
Representative Porter.
Karine, I just want to say thank you. I know what it took for you to do what you just did. I know all that you've been through. You do speak from a wealth of experience, knowledge. And I just want to thank you for showing up and making the time to be here and to testify today. And just know my strength and my prayers continue to be with you. Thank you, Mr.
Thank you.
All right, Maya Shepherd will be next.
Hello, can everybody hear me?
Okay.
Good evening, Senator Winfield, Representative Stavstrom, and members of the Judiciary Committee. My name is Maya Shepherd. I am an organizing leader for Hearing Youth Voices, and we are members of the Community First Coalition, which is convened by the CT Black and Brown Student Union. Our coalition consists of dozens of grassroots and youth-led organizations fighting to reimagine public safety in our communities. Today, we submit testimony on multiple bills. Our research has shown us the widely adapted idea of public safety is not constructed in a way that protects Black and brown young people in poor communities. In fact, the very language of multiple bills being raised today puts the lives of those exact children in danger of being surveilled, criminalized, and incarcerated. This is robbing them the ability and opportunity to even begin building full lives for themselves, their families, and their communities. And as a Black woman, mother, community organizer, and servant, this goes against everything that we are fighting for every day. We are also recommending that the Judiciary Committee members and co-chairs request a racial and ethnic impact statement. Be prepared for bills HB 5417, 5418, SB number 16, SB 365, and other amendments. I would like to assert my support for SB 387, Section 5. Specifically, we endorse the collection and reporting of data that reflects specific information such as date, time, location of when a police officer engages any person in a traffic stop. And this is important to us because we urge the committees to strengthen the language that includes police interventions in schools. We know that dozens, if not thousands, go unreported every year. The Juvenile Justice Policy Oversight Committee has laid out recommendations that would lead to increased community ownership of school-based 911 data so that students, parents, and credible community messengers can be fully aware of the reasons, frequency, and for whom police are being called to schools. We urge the committee to adapt those recommendations and promote further covering for people in our communities and schools. I'd now like to speak on the opposition to any legislation that increases the likelihood that youth are transferred into adult criminal justice systems or proceedings. Child school-based arrests continue to be in the thousands year to year. Is this because we honestly believe the youth across our state are dangerous and criminal? Let's talk about child development for a minute. At the age of 12, abstract thinking, problem solving, and logic are becoming easier, but prefrontal cortex, which plays a role in impulse control and organizational skills, is still immature. At age 14, brain development shows a child's increased ability to understand his or her environment and therefore their actions. As children grow and develop, they will learn more new skills and begin to solve in their daily life, but it is just the beginning. We are talking about children. The conditions of adult court are not designed for young children. This feels like a campaign to further criminalize Black and brown youth by making it more likely they are treated as adults, and that is the way the school-to-prison pipeline operates. These types of recommendations disregard the science of child and brain development, and we should instead be looking at the root causes of what's dubbed as crime and take a more holistic approach towards promoting safety, wellness, and rehabilitation.
Thank you, ma'am. We're at the 3-minute mark.
Okay.
Certainly appreciate it. Questions or comments from the committee? If not, we appreciate you being with us. All right. Did we get Michael Navaroli's audio fixed? Mr. Navaroli, can you speak? Mr. Navaroli? All right. And we're going to go to Don Basil.
Co-Chair Winfield, Co-Chair Staffstrom, Vice Chair Flexer, Vice Chair Blumenthal, Ranking Member Kissel, Ranking Member Fishbein, and all members of the Judiciary Committee respectfully request that you oppose SB 16, an act addressing gun violence and juvenile crime. Juvenile crime is a rapidly growing problem. Coupled with recidivism, these individuals can become career criminals. While I have long favored the reimplementation of the gun trafficking task force, I am suspect as to how well they will be utilized. In my opinion, the most effective way would be to crack down on street gangs. These are the entities that are notorious for possessing illegal guns and for preying upon the populace. They actively recruit juveniles to commit crime, and they are the conduit used for distributing narcotics on our streets, which are the crux of our crime problem. I also have difference with the term gun violence, as there isn't any such thing. What we have is a criminal violence problem. I have very little confidence in this bill's ability to offer solutions if it fails to even correctly identify rectify the problem. Further, continued that are clearly in common use is a direct violation of the United States Supreme Court's Heller decision and would spur a court case by local and national organizations that believe in the Constitution. I respectfully request that you support SB 388, an act concerning defense of a person or her dwelling, place of work, or motor vehicle. Any prudent person would respect someone's right to exercise reasonable force to protect themselves in the three places that they are most likely to get accosted. I respectfully request that you support HB 54, an act concerning the duty to retreat in a religious house of worship. I carry a gun because it is my duty as a good citizen and as a good Christian to be able to come to the aid of my fellow man. It goes against the grain of my religious beliefs and my moral compass to be legally hampered from helping a fellow Christian who's in harm's way. I respectfully request that you support HB 5415, an act concerning the transfer of assault weapons and large capacity magazines. There isn't any rational reason for people that are fully vetted to not possess the same registered and declared item they are already in lawful possession of. I respectfully request that you oppose HB 5416, an act concerning bulk purchase of pistols and revolvers. The purchasing, inheriting, or gifting small protections is a law ready is implemented for multiple gun acquisitions with the submission to the state of additional forms and the issuance of multiple authorization numbers by the Special Licensing and Firearms Unit to not warrant any concerns that someone may have.
Thank you, sir. You know, we're you're at the 3-minute mark. I think we got the bulk of that. So
no, that was it. 3 minutes.
Okay, great. Representative Dubinsky.
Thank you, Mr. Chairman. And thank you, Mr. Basil, for coming in. I think I missed your audio was breaking up a little bit, so I think I missed the part where you were talking about the HB 5416, an act concerning bulk purchases of pistols and revolvers. I didn't hear what you were saying on that issue because your audio was breaking up. If you wouldn't mind reiterating that, I'd appreciate it.
Not at all, Representative. Can you hear me right now?
I can, yes.
Okay, sir. I read the purchasing, inheriting, or gifting of small private collections is a long-standing tradition. There are already checks and balances for multiple gun acquisitions with the submission to the state of additional forms and the issuance of multiple authorization numbers given by the Special Licensing and Firearms Unit to not warrant any concerns that someone may have.
Okay. You care to expound on that a little, or is that the testimony pretty good as is?
No, that's pretty much self-explanatory. Whenever someone purchases multiple gun sales, this SLFU are well aware of it through additional forms, and they have to issue the authorization number. So they're well aware that a certain individual is acquiring more than one gun at a given time.
Well, thank you very much, Mr. Basil. I appreciate it, and I want to invest in a better Wi-Fi system. So breaking up a little bit.
It happens. Plus and minuses of remote hearings, right? So, all right. Thank you, sir, for being with us. I am going to turn over to Vice Chairman Blumenthal.
Thank you, Mr. Chair. Next up is Marissa Boos, followed by Giona Heckmer. Apologies if I mispronounced either of your names. Is Ms. Boos available? I do not. Oh, there she is. Ms. Boos, you have 3 minutes. Just make sure to unmute yourself. Ms. Boos, you're on mute. You're still on mute. There you go.
Can you hear me now?
Yep, you're good. Go ahead.
Okay. Yes, I'll try. I had a long. I'm gonna try to breeze through this. So, my name is Marissa Booz. I'm the mother of Zanaya Wright. I support bills 54-17 and 5418. I support these bills because the current law of 30 months max is not sufficient. A 13-year-old knows right from wrong. A 13-year-old knows there's no coming back from death. I still can't believe that a group of people would let the previous law pass without thinking about it being a blanket statute, as far as not considering the child's criminal history, the victim and impact on the victim's family, severity of the crime, which is the major thing. My daughter was left in the house with a friend of mine of 18 years. I came back to get her. She was gone. The individual, I'm not even going to, the point is, at the end of the day, he knew what he was doing. He knew right from wrong, okay? And at the end of the day, 30 months max, it's just not enough. A life is gone. My daughter's never coming back. She's not coming back. Everything that was done to her in that basement, her being sexually assaulted. I'm gonna shorten this up. So basically, the person is charged with 4 felony crimes that he committed against my 13-year-old daughter: illegal sexual contact, first-degree sexual assault, first-degree strangulation, and felony murder. And yet this individual may just walk away with 2.5 years, nothing else. So this is why I support this bill. At least there is some, at least he will have more time. I'm sorry, I'm trying to.
So, Ms. Booth, do you have any more testimony? It looks like there are some questions for you.
Yeah, I guess just the questions. I'm sorry. I tried to shorten it up because I had a long one. I tried to shorten it up because I know we're running behind. But long story short, my daughter didn't get justice, and all these type of things need to be put into play. These kids, they're stealing cars. You know, everyone's talking about rehabilitation. Rehabilitation works for some kids, and some kids it doesn't. But at the end of the day, what about the victim? What about my daughter? She's 30 months when this person gets out. She's going to be gone. She's not going to go to the high school. She's not going to go to prom. And then for the stuff, what she endured when she got raped and strangled and everything, and then it's just, I mean, how did a group of people not think about all of this, about just putting a blanket, like, oh, a car thief, someone stealing candy, like I don't remember the representative's name. I think it was Howard. Like, it's not one and the same. People, just like adults, kids need to be treated differently. Like, all of this babying them, like, you took a life. Like, my daughter's not coming back, you know? And that's the thing about it. She's not coming back. And then he just gets to 30 months. He's going to get to do 30 months and then go on about his business with no record and may even reoffend to the next person. I would pray he doesn't, because I wouldn't want a family to go through what I'm going through in a daily hell. So I just, I wrote something down, but I just said I'll just freestyle with it and try to make it fast.
Well, Ms. Booth, thank you for being here today to share your story and your daughter's story. I'm certainly so sorry about what happened to your family and to your daughter. It looks like there are some questions, and the first will be from Representative Doucette. You have the floor, sir.
Thank you, Representative, and thank you, Marissa, for coming forward. And again, we've talked a number of times, but I offer my condolences to you, and I think you're going to hear that from most of the committee. There's no words that can, that I can offer to you. As you know, I'm a parent myself. My son and Zanaya went to school together, 7th grade at Ealing Middle School in Manchester. I want to recognize your courage in coming forward, because not everybody can do that. And as you told me, this is not something that, you ever thought you'd be doing. But it's so important for us to hear you. It's so important for everyone to hear this story and, hear who Zanaya was and how this happened. We've had a number of conversations, and your perspective is so important to hear on this, because we talk about these things, and it's a topic which is under discussion in a lot of different communities for a lot of different reasons. But to hear your story, which just happened last June. I remember after the last day of school, 7th grade ended for Zanaya and my son Charlie, and this happened the next day, and for her to not make it through the summer back for 8th grade, it's unconscionable. So, again, we hear that there are these stories, but we don't often get to hear this kind of firsthand testimony. So I appreciate you coming forward. We've talked about the penalties for these kinds of offenses, and that there are different approaches on this committee. There are 2 bills, and we've talked through it, and we're going to continue to talk through it on this committee. And I would just ask my fellow members of this committee to keep an open mind, and to remember this testimony, because I sure know I won't for the rest of my life. So thank you again, Marissa. It takes tremendous courage. I know there's others who have questions. Go ahead. Anything else?
One more thing I just want to say is, I'm just off the top of the mind. And another thing about it is that, this is my first time being on any type of, politic meeting or political meetings, what have you. I'm not really into politics, and I noticed that everything is about suburban, urban, or things of that sort. But I feel like with someone losing a loved one, even if it wasn't a child, when losing a loved one, that's the first devastation, right? And it's my child at that. And then the second is to put salt on the wound by because he's 13, but he did 4 felony charges. What is even the point of giving a 13-year-old, or anybody for that matter, what is the point of even giving 4 felony charges, and you're only going to do 2.5 years? It doesn't even make any sense. It makes no sense. And this isn't even about a black thing or a white thing. This could happen in any community. So it's almost like right now the law that's in place, so a 13-year-old could go and I don't even like to bring in Sandy Hook, but say a 13-year-old could go into a school right now and shoot up 100 people. So he's going to get 2.5, the person's going to max 2.5 months. That's basically what the law is. And it's crazy. It's just crazy.
And you brought that up when we talked about repeat offenders, and that's something else we've heard about today, because the system did not serve that young man, certainly for 4 prior offenses. The system did not serve him, or else we would not be here today, right? So that's so important to hear too. So again, thank you for your courage coming forward. Appreciate it, and we'll continue to talk. This is not the end. Thank you for your advocacy.
Thank you for letting me have this platform to say what I have to say.
Thank you, Mr. Vice Chair.
Thank you, Representative. Next up will be Representative Fishbein. Questions or comments?
Thank you. Marissa, very sad to hear your story. Unfortunately, I've heard stories like yours over the last few years, and I share your situation. I know it takes a lot to come before us here today. I know you're not doing it necessarily for you. You're doing it for other families that hopefully don't have to suffer what you have. And just to put into context, because you sort of jumped into the 30-month situation, presently under our law, passed about 5 years ago, a juvenile, any matter actually that's adjudicated in juvenile court, there could be 10 murders, 20 murders. The maximum penalty is 30 months supervised probation. And at the age of 22, those 10, 20 murders are going to be erased off of that individual's record. And I've been going across this state for the last 6 months speaking out for victims. So, you know, I really wish I could bottle your message here today and shoot it out by a megaphone, because, you know, it's all about that. We've got to do something with this. So, you know, I have no questions for you, but I really share your pain. And hopefully we can get these things changed. I mean, it was probably hurtful. We may have heard today, you know, from some of the advocates saying that no children should go to jail ever. And, you know, that's tough to deal with, I know, as a parent. So thank you for coming here today. I know it takes a lot of strength, and I see you've got, you know, somebody right next to you. I'm sure he's a better out for you. But I thank you for coming here. So thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Next up will be Representative Porter. You have the floor.
Thank you, Mr. Chair. Ms. Booth, I have no questions for you. I just really wanted to thank you for sharing your story, to express my condolences to you and your family for what happened to your daughter, and just know that we are listening. We do hear you, and there will be some ramifications around how we come about what we're going to pass out of this committee. But thank you for having the courage to sit there and go through what you just went through. I can't imagine, but you and your family are definitely in my prayers, and you will be in my thoughts, because this is something that you don't forget. You don't forget a story like that. And it is true. We hear way too many stories like this. So just thank you. I know that you are in my thoughts and prayers.
Thank you. Thank you for that.
Thank you, Representative Porter. Representative Sims, you have the floor.
Thank you, Mr. Chair. Ms. Booth, I also want to share some of the comments of my colleagues here. And I want to send my condolences to you and your family. I'm a father of four girls, and I couldn't fathom something like that ever happening to my child or my children. And I just thank you for your bravery, for your courage, for your strength that you are displaying today. I know it takes a lot to come up here and share that story and even talk about your child in this public setting. So I just want to really share my heartfelt condolences with you and your family. And as it's been said by a few of my colleagues here, we would certainly be taking a look at a lot of the laws and policies that we put forth out of this committee, and look forward to addressing and moving the state in the right direction. So thank you for coming forward and sharing your testimony with us. Thank you, Mr. Chair.
Thank you for that.
Thank you, Representative Sims. Senator Champagne, you have the floor.
Thank you. Mrs. Boyce, I don't even know what to say. I am so sorry for your loss. I remember when this happened. I remember saying a prayer for your young daughter and the family. And when a victim of a crime finds out that they're victimized a second time by the justice system, it's shocking. It's shocking to the system. And I've been fighting for victims for a couple years now, and I'm going to continue fighting for them, because here you are, you're speaking out as a victim, and I hope everybody in this committee is listening, because this can happen, and the fact that you brought up a tragic incident that happened in Connecticut, and if it was somebody young, the same results would have happened, and that's just unfathomable. And my prayers are still with you, your family.
Thank you.
And I'll continue the fight. Thank you.
Thank you for that.
Thank you, Senator Champagne. It does not appear that there are any further questions, but before we move on to the next person, I do just want to say again, thank you for being here and sharing your story. It takes tremendous strength and courage. And so, I hope you know that you have my, and I think this whole committee's deepest condolences. Thank you for being here to honor Sanaya's life.
Thank you for that.
Next up, we have Morris Armstrong. Is Morris Armstrong with us? I do not see Morris Armstrong. If he is not, Rich D'Angelo, you are next. Mr. D'Angelo? Not see Mr. D'Angelo either. So after that, we have Jordan Levine or David Hertz.
I'm here. Can you hear me?
Hi. Oh, hello.
Oh, Jordan's there. Jordan.
It's okay, David. Okay, we have a traffic jam now. So why don't we go?
I'll mute myself. That's fine.
Jordan Levine first, then I see Tiana Heckner is with us. She'll go next, and then Mr. Hertz after Ms. Heckner. Thank you, Jordan. Go ahead. You have the floor.
Thank you, Representative Blumenthal. Ladies and gentlemen of the Judiciary Committee, my name is Jordan Levine. I'm the owner of A Better Way 2A, and I'm a resident of Seymour. I oppose SB 16 and HB 5416, and I support SB 388, HB 5415, and HB 5412. I was going to spend my 3 minutes talking about SB 16, but as I was writing, I couldn't ignore the immense disappointment and frustration that I, as well as it seems many others, felt reading this bill. The biggest issue we face right now is not gun violence, it's partisanship. Due to an ever-increasing gap between the left and the right, and the contempt for the opposing side, and ignorance continues to fester that manifests across this country in good-intentioned bills written by people who remain ignorant to the effect that they actually have. Bills people mean to protect our school children will end up harming our LGBTQ youth. Bills people mean to save babies will force women into dangerous situations, and bills people mean to reduce gun violence will strip our vulnerable communities of protection, chip away at our right to feel secure, and fail on almost every front to address the legitimate concern of gun violence that all of us have. Governor Lamont has commented on the increasing gun ownership in Connecticut, even if he doesn't differentiate between legal and illegal guns. In 2020, with the murder of George Floyd and the safety concerns surrounding the ensuing protests and distrust or unreliability of police during those events, 4 million Americans became new gun owners, with 170,000 gun purchases in Connecticut alone. People from all across the political spectrum and all walks of life bought their first gun over the last few years. Members of the LGBTQ community, African American community, and other marginalized groups have armed themselves in record numbers. Black women are the fastest growing percentage of gun owners in this country. The last 2 years have shown us all the utility in owning a firearm for self-defense, and the numbers show this. So the fact that after everything that's happened, a bill like SB 16 is even before us today shows just how disconnected the governor is with the residents of Connecticut and the American people. In a time where bus driver unions have been begging the state to protect their drivers better, people want to ban firearms on public transport. Just a small part of this bill is our governor telling each passenger who relies on a gun for protection on the way to work or to get food that they should just buy a car if they want to stay safe. I'm big on giving the benefit of the doubt. So when I read things like that, I assume it's the best intentions. Even if at face value, it seems like a blatant attack on poor people. To our representatives who question why someone would ever want or need to carry a gun on the bus ride to work, I urge you to ask the people who do. I assume this bill is written with good intent, but due to the inability of our politicians and us to work with one another, we end up with language that at best will fail to curb gun violence because none of it actually addresses the cause of gun violence, and at worst will actively take part in harming the people it's supposed to protect. Support for more gun control is at an all-time low across the country. We need to work together to create effective laws to protect our communities without chipping away at the individual and collective liberties of Connecticut residents. You all need to work together.
I'm sorry to interrupt, but your 3 minutes have elapsed. Please summarize in a sentence or so, and then I believe you'll have at least one question.
Perfect. I'm on my last sentence.
Great.
You all need to work together for the future of our state. I would love an opportunity to speak with you on this issue further, and I would gladly accept any questions you might have.
Thank you, Mr. Levine. And it looks like Representative Dubitsky has a question for you. Representative Dubitsky, you have the floor.
Thank you, Mr. Chairman. Thank you, Mr. Levine, for coming in. One thing you said that resonated with me was that that SB 16 essentially says if you want to stay safe, buy a car. I would think that after some of the hearings that I've sat through in the last couple of weeks, it's if you want to stay safe, buy an electric car, but buy a car. And there are many people in our state, in our cities, that either cannot afford a car or their circumstances don't allow for it. Many people in apartment buildings have no place to put a car. You can't park it on the street. They have no parking. Cars are very often an impediment if you live in the city. So, if you want to stay safe, buy a car. Only works for somebody who can logistically maintain a car. And for far too many people in the state, that's just not an option. But I thank you very much for your testimony. You raised some very important issues, and hopefully those pushing this SB 16, including the governor, will take heed of what you just said. Appreciate it. Thank you,
Representative. Thank you, Representative. Seeing no further questions, thank you, Mr. Levine, for your testimony. Ms. Heckner, you are up now.
Thank you. Good evening. Thank you to the chairs and all the members of the Judiciary Committee for letting me speak today in support of SB 392. My name is Tione Hoekner, and I'm currently 18 years old and a first year at Yale. I'm highlighting my age because that is what this bill is focused on. Under Connecticut law, just last year, I would not have been criminally responsible, which means that I could not be automatically subjected to an adult court jurisdiction. And yet, while I would be protected from automatically being treated as an adult in court, I would not have been required to have a parent or guardian present when making a statement to a law enforcement officer. Thus, I would have been treated as both an adult and a child in the same criminal justice system. Recent neurological research shows that the brain does not fully develop until age 25. Adolescents' actions are guided by the amygdala, the part of the brain that is more emotional and reactive, while the prefrontal cortex, or the part of the brain responsible for logical reasoning, is not yet fully developed. This is relevant because according to a study from the Prison Policy Initiative, out of 340 exonerees, 42% of juveniles falsely confessed, while only 13% of adults falsely confessed. Furthermore, another study, also from the Prison Policy Initiative, found that a majority of youth participants complied to sign a false confession without a single word of protest. The data on this issue is thus clear. Juveniles are more likely to falsely confess because their brains are not fully developed, and they are more susceptible to social pressures and impulsive decision-making without fully understanding the consequences of their actions. That is why it is essential that a parent or guardian be present when a juvenile defendant makes a statement, so that they may intervene on their child's behalf if their child makes a false confession. Parents and guardians are also more likely to understand their child's rights and interpret the written law, which the juvenile defendant themselves might not understand. The change from 16 to 18 years old is crucial because the brain is not fully developed until 25, let alone 18. In addition, Connecticut raised the age of criminal responsibility to 18 over 10 years ago. Our state recognizes 18 as the age where individuals can start making their own decisions, including voting and joining the military. So it is imperative that 18 is held as a standard for all adult decisions, and making statements to law enforcement officials is one of those decisions. I recognize that some people do not see a difference between 16 and 18, but as someone who is currently 18, I can say that there is a big difference. 16 and 17-year-olds are still in high school, and most are dependent on their parents for everything. A 16 or 17-year-old cannot sign their own paperwork to go to a school activity, such as canoeing or axe throwing. So by that standard, they should also be required to have their parents' protection when giving statements. I urge you to favorably vote SB 392 out of the Judiciary Committee so that parents and guardians and the law can both protect one of the most vulnerable groups from making choices that could negatively impact the rest of their lives. Thank you for your time.
Thank you, Ms. Hoekner, and apologies for mispronouncing your name. Seeing no questions, David Hertz, you have the floor, followed by Alex Villamil.
Can you hear me?
Yep.
Okay, David Hertz here. I'm an attorney out of Bridgeport, where I've been for the last 2 years. I have a couple of, just want to put a slightly more human face on this. One of those things is I belong to a gun range here in Bridgeport. It is the most multiracial but non-racial place I have ever been. My wife loves going there because you have people from all different walks of life who respect the guns that they have. They know the death that they carry, and they know that they would only use it in the direst of situations. But anyway, that's not really what I wanted to talk about. I want to talk about two other things. One is I was at the shop last week. I asked my mechanic who deals with a lot of cash. If they carry, he's like, yeah, we carry. Most of us carry. He also owns a tow truck. Well, if his tow truck would drive into, I don't know, your office building, the parking lot of your office building, he now becomes a criminal. Just because he's carrying and doing his job. Or if a teacher, invites him onto, according to the regulations that I've seen, or the some of the law that's proposed. I bought a collection of guns from an elderly gentleman who was just about ready to go to an old age home about a year ago. It would have been ridiculous to try to have to stretch that out over 4 months. There are people who are aging out. By the way, his guns, he had oversized clips, so he was also a Class D felon until we modified the clips so that wasn't an issue. So you're making people criminals for no reason. I guess the thing I have to say is this. My impression is that when your only tool is a hammer, everything looks like a nail. I think as legislators, sometimes we want to just write another law, or you want to write another law to make things happen. Sometimes that's just not what's right. We have a public health crisis. That's the last point. I know I'm running out of time here. I think it's ridiculous to call this a public health crisis. We could call car driving a public health crisis. We could call, by that standard, we can call anything a public health crisis. The next side of that is that I become sick for wanting to have a gun. And it seems to me that, unfortunately, as the prior gentleman just said, and I don't remember who that was, we seem to come from different sides. I think there's a lot of ill will here. The people who look at gun owners as crazy gun owners, people who shouldn't. If we would just let the police do their job and put our guns down, that the world would be better. I invite those of us who disagree to take a look otherwise and see. Let's try to see the world through each other's eyes. That's it. Thank you.
Thank you, Attorney Hurst, and it's perfect timing. You're right at the time limit, but you have a question from Representative Dubitsky. Representative Dubitsky, you have the floor.
Thank you, Mr. Speaker. Thank you, Mr. Speaker, and thank you, Mr. Hurst, Attorney Hurst, for coming in. I'm glad that you were testifying today and that you acknowledge you're an attorney. I was wondering if you might be able to comment on SB 16 lines 292 and 293, where the proposal is to remove the requirement that a law enforcement officer has reasonable suspicion of a crime prior to demanding.
With regard to the permit issue,
prior permit to an officer who asks.
Well, essentially what it's doing, in my mind, I'm not a criminal lawyer nor a constitutional lawyer, but you're presuming that a person is a criminal for actually carrying a gun or for having a bulge that looks like a gun. And it seems to me that we have a presumption of innocence in this country. And by giving a police officer the right to walk up to anyone who seems to be carrying, it blows the mind.
Thank you very much. I appreciate your time. I appreciate your coming in and spending the time with us to testify. Thank you very much. Thank you, Mr. Chairman.
Thank you, Representative, and thank you, Mr. Hertz, or Attorney Hertz. Seeing no further questions, we will next move to Alex Villamil. You have the floor, sir. And Alex will be followed by James Curry and Christopher Batten. Mr. Villamil, go right ahead.
Thank you, Mr. Blumenthal. I have prepared a written statement. Senator Winfield, Representative Staffstrom, ranking members Cassell and Fishbein, and distinguished members of the Judiciary Committee. My name is Alex Villamil. I'm from Sandy Hook, Connecticut. I'm a volunteer in Connecticut Against Gun Violence and a leader of Action Together Connecticut. and testify in support of the provisions in SB 16 that directs the Office of Injury Prevention within the Department of Public Health to create a gun violence intervention and prevention program. As a gun violence survivor, and because of the tragic history of the town that I live in, I've testified in front of this committee in the past. I believe that gun violence is an epidemic and that ignoring it is tantamount to proceeding at our peril. Every year we hear that there are more guns out there, more killings in our state than in our country. We are sadly at one point where frequent mass school shootings no longer shock or even surprise us. More needs to be done by our legislature to counter these trends. While I commend the governor for directing DPH to establish a gun violence prevention and intervention program, and for allocating $3.6 million from the American Rescue Plan to fund the program, I strongly urge the legislature to do that. A dedicated staff in DPH ought to be created to address community gun violence and commit to a more substantial level of grant funding measures, both proposed in HB 5397 and Act Declaring Gun Violence a Public Health Crisis and establishing the Office of Gun Violence Prevention. I also support other provisions in SB 16, including establishing a gun tracking task force to stop the flow of illegal guns, requiring registration of all ghost guns, creating a state license for gun dealers to ensure compliance with state laws, tightening regulations for carrying guns in public, and making domestic violence convictions an automatic disqualifier for carrying guns in public. I support HB 5416 to crack down on straw purchasing by limiting firearm purchases to one per month. I oppose SB 388 and HB 5412, which would also allow us use of deadly force in vehicles in places of worship regardless of whether someone is at risk of harm. I oppose HB 5392, which would allow off-duty police officers to carry guns in schools, contrary to existing state and federal law. I oppose HB 5415, which would allow banned assault weapons and large-capacity magazines to be sold. Regarding the juvenile justice aspect of this form, I do not believe that the correct approach is to lower the age for a child to be held accountable and judged in the adult court. The history of the problem needs to be better studied, as well as better related to the community at large. There needs to be a better effort put forth by our legislators than to simply rely on the simplistic solution of incarcerating children. The problem is multifaceted in nature. Therefore, this calls for multi-pronged solutions and an all-out effort from the community. These solutions need to come from the community and from legislative and judicial entities, all working together. Failing to do so takes away the possibility of rehabilitation and places an overwhelming and unjust reliance on retribution. If we take the time to understand the problem, we act as a civilized and conscientious society ought to act. I'd like to thank this committee for the work that you do and for taking the time to listen to my testimony. Thank you for taking on this important task. The impact of your decisions is the difference between life and death.
Thank you, Mr. Villanelle. It looks like you got questions. Representative Fishbein, you have the floor.
Thank you, Mr. Chairman. Sir, thank you for coming and testifying today. I just want to focus on, you testified that you were in support of the domestic violence provisions of SB 16. Can you tell me specifically what portion?
Specifically, I don't have it. I don't have it in front of me. I wrote this while I was looking at.
Can you read again the portion from what you
read
to us? Yeah, about the domestic violence crimes.
So I also support our other provisions in SB 16, including, the last part, making domestic violence convictions an automatic disqualifier for carrying guns in public.
Okay.
So if in my opinion, someone who's dealing with domestic violence.
No, I'm trying to stay within the four corners of this bill. So what portion of this language prevents a domestic violence conviction carrying in public?
I don't have it in front of me right now, unfortunately. I would probably refer you to Jeremy Stein, who could probably answer this much better than I can. Unfortunately, I didn't put the bill in front of me.
Well, I'm looking at section 25, and that adds the clause. I'm just trying to refresh your recollection as to what you reviewed in preparation for today. It has a list of things that are disqualifiers, and it says, or a felony or misdemeanor domestic violence, family violence crime. But wouldn't a felon already be prohibited?
Well, I'm not sure about the technicalities of it. I think, like I said, I think Jeremy would probably be the better person to ask on the technicalities. I'm reading it as a layperson.
Okay, I understand. I don't want to box you in. I just trying to.
Right. My understanding based on the language, as a layperson, that's kind of the interpretation that I'm getting from it.
Okay, because I'm looking at line 1213, where it already says that you've been convicted of a felony, you can't get a permit. So why would we need a felony of domestic violence? Because that's still a felony. So anyway, I understand you're a layperson and
exactly
the governor's bill. So
I would have to pass it on to somebody with a little more experience on that.
No problem. Thank you, Mr. Chairman.
Thank you, Representative. Representative Palm, you have the floor.
Thank you, Mr. Chair. Good evening, Mr. Villamil. Thank you very much for being here. I hate to make you relive any of the agony of the Sandy Hook massacre, but I really feel that your voice is a very, very important one because of what your community has experienced. And I'm wondering if, I don't know how well you've been able to go through SB 16, but I'm wondering if you believe that any parts of that bill might have prevented what happened in Sandy Hook. And if not, do you have any recommendations of how we might strengthen it? I'm thinking specifically of the part about an assault, an AR-15 assault weapon, because of the loophole currently that defines a gun that sits on your shoulder as a rifle. I'm just wondering if you have any opinion on that, because throughout the day we have heard from gun advocates, from Second Amendment advocates, referring to assault weapons in quotes, like as if an assault weapon isn't really used for an assault. Having lived through the assault, do you have any comments on this bill and any ways to strengthen it?
Well, I mean, personally, I don't believe in weapons, whether assault or not. I think anything that, any kind of weapon that is not properly stored should not be left, in the case of Sandy Hook, out in the open for anyone to use. In this case, there was a child who was mentally incapacitated, obviously had issues. Therefore, he had full access to these weapons. I think more control over such, in my opinion, all weapons, but especially assault weapons, because they can do a lot more damage than normal weapons. But overall storage and keeping away from people that should not be having weapons, mentally ill, children, any kind of access like that, I think should be regulated a lot better. And also, it was a tragedy that occurred here in Sandy Hook, but I think it could have been prevented had those laws been in place at the time.
Thank you for that. And at the risk of Bob, do you mind telling us how old were you when that happened?
Oh, I was when that happened, I must have been in my fifth grade. I was in my early 40s at the time, and I had children in school. First when it happened, I thought it happened at the high school. I was picturing something that was Columbine. So my first thought was my high school kids are in the threat. Two of them were in high school at the time. But unfortunately, it was the elementary school. And, my daughter would have been in Sandy Hook had she not been homeschooled. So that was a traumatic experience that I could not even imagine. My neighbors, my friends, parents.
Well, I think I dare say that you're a lot closer to it than most of us. I had a friend whose daughter was killed in Sandy Hook, a colleague of mine, teaching colleague. But I am grateful very much for you for your bravery in coming. I'm sure that it must be tempting just to walk away and never think about it again. And I don't mean to make you relive any moment of it, but I think your voice is a very, very important one to hear, and I appreciate deeply your being here. Thank you.
Thank you.
Thank you, Representative. Representative Dubitsky, you have the floor.
Thank you, Mr. Chairman, and thank you for coming in. I appreciate it. You mentioned assault weapons and regular weapons, and what's the difference?
To me, assault weapons are like rapid fire weapons. Regular weapons are pistols, perhaps. Yeah, I'm not a gun person. Due to personal experience, I don't like guns. So, if it were up to me, I would just ban everything that would harm another individual.
Gotcha. Okay. So you don't really know if there is a difference between a assault weapon and a regular weapon. Do they both shoot the same bullets?
No, I don't think so. I think there is definitely a difference. But again, not to do injustice to the argument, I would probably refer it to more of an expert.
Okay. Okay. All right. Well, I appreciate it. I appreciate your acknowledging that you're not an expert and don't know.
Well, I am a lay person. Therefore, I take certain things that from my personal experience in my opinions, and especially what I voiced over here. But when it comes to technicalities and things like that, I think I'd rather have the argument pushed forward by somebody who deals with this. So, for instance, Jeremy Stein, I would refer these questions to him, who is much more involved in the technicalities and the minutiae of this topic.
Okay. Well, would it surprise you if I said that the so-called assault weapons that are being banned in the bills that are on the agenda today are functionally exactly the same as every semi-automatic pistol that exists in the world?
Well, again, I would probably, unless they're regulated, and say, for instance, that not to go off the subject, but to me, a vehicle is something you regulate. It could be considered a weapon. The weaponized a vehicle, that we go through the process of getting proper licensing and give people proper instruction as to how to deal with this thing. Nevertheless, it is regulated by our state. But whatever an assault weapon is or not, in my opinion, any kind of weapon, anything that can injure another person, if it's not properly taken care of, or people being given the proper instructions on how to deal with it, how to store it, and when to use it, if they're even allowed to use it, that should be something that the state should take into consideration before allowing just anybody to have these weapons, whatever type of weapon they may be.
All right. Thank you very much for your testimony. Appreciate it.
Yeah.
Thank you, Mr. Chairman.
Thank you, Representative. Representative Howard, you have the floor. Representative Howard, you're still on mute.
Probably better because the dog's barking. I'm sorry. Hi, Alex. You're the first person today that I've heard of. I've been here all day that testified in opposition to 5392, which is the police officer carrying on school grounds. Can you just say why you're against that briefly, because it's been a long day?
As far as I'm sorry, could you repeat the question?
Yes, I believe you said that you're in opposition to 5392. Can you just briefly say why you're in opposition to that particular bill?
Well, right now we have laws in our schools that prevent anyone, unless they're, I guess, my experience at the high school here in Newtown, that prevents anyone to carry a weapon inside the building, unless they work for the building or for the municipality. Right now, not anybody should be allowed to walk into a public building, especially one that's well, in my case over here, that's been through the trauma of Sandy Hook. Don't believe that unless you have any business in the building, if you don't work for the city or if you are not part of the building, as far as safety measures are concerned, you should not be walking in there with a weapon. You can always leave it in a car. You can always pack it up. There's no reason why you should bring it into the school, because who knows what can happen. I think weapons lead to problems. I think you can use it in self-defense, but if you bring it into a public building, I think you're just personally asking for trouble. Let the people who are working there and let them carry the weapons. That's all.
Right. So I didn't. So would you say that no police officer should carry in a school building?
While they're on duty or off duty?
Well, what the bill would allow them to carry on or off duty, but based on what you said just now, it sounds like even on duty you wouldn't want them doing that. That's what I'm asking.
No, let me clarify that. If they're on duty, they've been called in. Obviously, they're police officers. They would be, but if they're off duty, there's no reason for them to carry weapons in. If they're picking up the children or something, which I have friends that have children in the school system. There's no reason for them to carry that weapon inside the school system. On duty, if they're working and they've been called in by whomever in the school, that's a different story. They're on duty. To me, that's the distinction.
So if a police officer is attending, say, a high school game at a high school basketball game, say, and he has a statutory responsibility to respond to an incident, you don't feel that he should be equipped appropriately to respond?
Right now, if we have a statute, I believe we have a statutory. We have a statute in place that prevents people from walking into public places while they have guns. So that would, if that makes it to the individual, just a police officer going into to see a game, if he's just there as a civilian, I guess. No, I would say leave it in the car. We're not, I'm sure we have people protecting the game already on duty.
Okay, thanks. I just, I feel like we hold our officers responsible to respond to things and don't equip them. It's, we're basically just saying that, just do the best that you can and do it. But, all right, well, thanks for your testimony.
To me, the less guns, the better. Because otherwise, if we're all carrying guns, it sort of turns into a Wild West scenario over here where everybody's just answering to whatever, just, by bringing a gun into it and using it. The more apt to use it, if you're carrying it, than if you leave it in a car. If there's something that arises and the need arises, you can always go back to the car. Meanwhile, there's already protection inside, in this case, the stadium. That's my logic.
So state police are standing by at every high school basketball game in the state, as far as you know?
As far as I know, there's always a police presence. I don't know state or local, but those are somebody guarding.
That's I didn't know that. That's news to me. Thank you very much for that. Appreciate it. Thank you, Mr. Vice Chair.
Thank you, Representative. Representative Fishbein, you have the floor.
Thank you, Mr. Chairman. Mr. Chair, I find it a little ironic. Sandy Hook was a tragedy, and I firmly believe that if someone in that building on that day had a firearm, they would have been able to prevent a tragedy. So, a police officer picking up their child from school, entering the school, on duty or off, could have prevented a tragedy. And I find the testimony here today shocking that we would prevent man, woman in blue from entering a school with their service firearm. We know that the law didn't prevent what happened on that day. people were innocent, and they were victims. And for one to believe that the sign, the law saying gun-free zone prevents these activities, I find the testimony shocking. So thank you, Mr. Chairman.
Can I respond to that?
Very briefly, please.
Yeah.
I'm getting a little, it's not an issue with you necessarily, it's just we're getting a little far afield from the language of the bill. So if you could respond briefly in a sentence or two, and we appreciate it.
It's just, to me, that's a conjecture. That's not really based. You don't know what could happen, what might have happened. You know, that's not based on what really did happen. So I think if we are already employing people to protect people in our public buildings, let them do their job. We'll do it.
Thank you, Mr. Villamil, for being with us and sharing your testimony and your experience. Seeing no further questions, next up is James Curry, followed by Christopher Batten.
Representative Blumenthal and distinguished members of the Judiciary Committee. I want to thank you for this opportunity to speak, especially in the difficult work you have of so many people testifying today. My name is James Curry. I'm a bishop in the Episcopal Church. I'm a resident of New Haven, and I am co-founder and chief blacksmith of Swords to Plowshares Northeast, a 501c3 organization that works with towns and cities to organize gun buybacks and then transform the guns, instruments of potential harm from suicide, accidents, and crimes, into instruments of hope and nurture. We give these tools away to community gardens, schools, faith organizations, and youth violence interruption programs. I'm testifying today in support of Section 33 of SB 16 and the $3,600,000 included in the governor's budget adjustment bill for the Department of Public Health to fund community-focused gun violence prevention programs. At Swords to Plowshares Northeast, we encourage people voluntarily to give up the guns that are a danger in their homes. We also encourage people to invite us to bring the forge to their community and to participate in the repurposing of guns. We are mobile, and we can augment almost any other approach to gun violence prevention. I'm here today to speak to a multi-pronged, collaborative, and experiential approach to gun violence prevention. I want to underscore the need for coordination, research, and support at the state level. The work and outreach of volunteer organizations like ours will be greatly enhanced by a staffed program through the Department of Public Health. We are an educational outreach program that engages people across the boundaries of our cities and towns. The guns that are transformed into garden tools become evidence that we need not stay bound to the violence of guns in our society. The process of transformation not only creates tools, it gives power and hope to people who have been harmed greatly by guns in their communities. We believe that starting with this funding, the Department of Public Health can be an information clearinghouse and source of coordination and support for nimble and innovative community-centered anti-violence programs. This funding will help explore new strategies to invite people to in our communities, urban, suburban, and rural, to turn away from gun violence and to change the very nature of our neighborhoods. I commend our governor for proposing funding for community gun violence prevention programs. I also urge you, the legislature, to do more. Now's the time to create an Office of Gun Violence Prevention in the Department of Public Health and to commit the state to more substantial levels of funding to build on and support the work already being done here in Connecticut. Thank you for listening to me.
Oh, sorry. I was just about to tell you to try to wrap up and summarize, but you anticipated me. All right. Thank you, Bishop Curry, for your testimony. It looks like we have a question from Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Bishop Curry, for coming in. Very much appreciated. So you're speaking in favor of support of Section 33 of SB 16. Is that correct?
That's correct.
Okay. And is it your feeling that your organization will receive some of the funding?
I don't know.
Is it your hope?
That's not my point. My point is that there are a number of community-focused groups that need coordination and help, and that a state organization, an office, will help us coordinate across the state. I now work in Hartford, Bridgeport, New Haven, Norwalk, Guilford, New London, and we are able to bring the idea of swords to plowshares, guns to garden tools, and we do that with our own funding. We're not looking for funding at this point. What I think needs funding is research and coordination and clearinghouse of help for community-based groups to feel supported. And I think also we need to really continue to focus on evidence-based choosing programs. If you talk to, in this state right now, if you talk to the media, they'll say that gun buybacks are really wonderful. I have great interviews with TV stations across the state, but we don't have enough evidence-based information to say that this is the way for us to really be going as a community in the future. That's true for almost all grassroots groups that are trying to face the issue of violence in our society.
Okay. Do you think that any such research should be non-partisan?
Absolutely.
Okay. So when a group is put together under, or should a group be put together under Section 33, should that include people who are opposed to firearms and people who are supportive of firearms?
Yeah, I can tell you in Swords to Plowshares, we have gun owners who are very much a part of our organization. And one of the things we do as we help coordinate gun buybacks in our cities and towns is also to offer gun safes, either free or with a discounted cost, and gun locks so that people can safely store the guns that they want to keep in their households.
Do you provide any gun safety training, like for gun owners? Like how to safely handle firearms?
That's beyond our expertise. And it's available. It's available through a number of the people that you've talked to today.
All right. Well, thank you for your time. I very much appreciate it.
You're welcome.
Thank you, Mr. Chairman.
Thank you, Representative. Representative Palm, you have the floor.
Thank you, Mr. Chair. Good evening, Bishop. Thank you so much for your wonderful work. I admire it tremendously. I'm sure Isaiah would be very pleased.
Thank you.
My question, and I would love to garden and till the soil with one of your instruments. When you said you were very much in favor of Section 33 of SB 16, does that mean you are not in favor of other parts, or that was your favorite part. And I'm not trying to put words in your mouth, and nor am I expecting you to have parsed this entire bill. It's very, very dense.
Yeah,
but you singled out that one section.
I'm focusing on that one section because that's where I work. I work in community anti-violence coordination and innovation. That's what I know. And that's why I spoke to that part of the bill.
Okay, I just wanted to make sure that I understood that you weren't saying that the other parts you didn't approve of, or that, okay, just checking. Thank you. Thank you very much for being here, and I appreciate, again, your work and your testimony very much.
Thank you, Representative. And seeing no further questions or comments from the committee, I'll say thank you very much for being with us today, Bishop Curry, and for your work in the community as well. Next up is Christopher Batten, followed by Reverend Josh Pavla.
Okay, can you hear me okay?
Good to go.
Okay, it's Christopher Batten. Don't feel bad, everybody mispronounces it. To the Judiciary Committee, thank you for the opportunity. I wish to voice my opposition on SB 16, an act addressing gun violence and juvenile crime. I believe this bill has been misnamed, as it is only the people who seem to be penalized in this proposal are the law-abiding firearms owners in our state. I'm a Connecticut resident and a Second Amendment supporter. I've complied with every law that I know. I've followed every ordinance in the state concerning the purchase, the storage, and the use of firearms and related equipment and accessories. Yet the governor seems intent on blaming me for illegal gun violence, and his solution is to make it more of a hardship for me to exercise my Second Amendment rights. I don't believe the contents of the governor's bill addresses the heart of the gun violence problem in Connecticut. As a minority living in Manchester, I am gravely concerned that there are more like me who in recent times I have witnessed legally obtaining permits, going to classes, and joining ranges and clubs in Connecticut. The fastest growing segment of the firearms owners group are women and African Americans. Part of the governor's legislation will empower law enforcement to ask citizens for permits in instances of open carry, which can be loosely interpreted, and from my perspective, may become a slippery slope to racial profiling. I am asking you to oppose this bill by stopping this legislation from leaving the Judiciary Committee. I'd also like to express my opposition to HB 5416, an act concerning bulk purchases of pistols and revolvers. The bill makes it sound like Connecticut citizens are going through all the hassles of submitting themselves to federal and state background checks, plus all of the state required paperwork in order to purchase multiple firearms for illegal purposes. That line of thinking doesn't make much sense. Therefore, limiting purchases to one pistol or revolver a month will likely do nothing to address gun violence. Firearms purchases are still legal purchases, and the government should not dictate how much of anything we can purchase. With my remaining time, I'd like to express my support for HB 5412, an act concerning the duty to retreat in a religious house of worship. People who attend houses of worship should feel safe and peaceful, but unfortunately in recent times, they have been the targets of violence and for disturbed people. Last Friday evening, for example, a synagogue and a church in New Britain were targeted by an arsonist. Arson, shootings, and machete attacks in the church were once unthinkable, but unfortunately, it's now happening across our country. Religious leaders should be able to make choices concerning the safety of their congregation. That safety may include employing properly trained security teams and to ensure their auditoriums don't become soft targets and the center of a violent act. HB 5412 is a tool that can help them do this and know that they have the support of our state. Thank you so much for your time and consideration.
Thank you, Mr. Baten, and apologies on your name.
No problem.
Looks like Representative Palm has her hand raised. Representative Palm? Looks like maybe that's left over from the last round. Representative Dubitsky, you have the floor.
Thank you, Mr. Chairman. Thank you, Mr. Baten, for coming in. very much appreciate it. You've echoed what a number of the people coming to testify have said. The one bill that you've mentioned that many others haven't is 5412. And, I certainly, what we hear in the news every day with regard to attacks in churches, as you said, this is something that we would never hear about in years past. Brings us back to, to the days of the old, Mississippi church burnings. And, we want to make sure that the people who are attending church and synagogue and mosque services have the ability to protect themselves just like anyone else. And very much appreciate your coming in. Do you have any personal experience with any of these church groups that have organized to protect themselves?
Well, I am an active member of my church here in Manchester, and I at one time was also employed by the church. So matters of people's safety and security is always something that stays in my mind. And I'm not saying that everybody should carry in their churches. I don't think everybody is necessarily responsible enough to do that. But I think that with proper training, and that you have groups of people who are designated as a security team, just as you would have it, private security for any other type of organization or business. I think that's smart. I don't think everybody should just have a firearm and just do it. But I think that proper training can help prevent tragedies, or at least, for example, that shooting in Texas, where the security team was the ones who stopped that gentleman, and it could have been a lot worse. So I just like the thing that I really like about this bill is that it gives your houses of worship an option. And I think they should be able to know that they're supported by their state if this is the route that they want to take. I know some churches would not agree with that at all, and that's fine. And then I know others that are okay with their people, certain people carrying concealed. It's, whatever comfort level that leader is, he or she has to make those decisions and see what's best for their church and that, or synagogue or mosque or anything else. And I have no problem with that.
Well, I very much appreciate your testimony, and thank you for coming in and sharing it with us. Thank you, Mr. Chairman.
Thank you, Representative Dubetsky. Seeing no further questions or comments from the committee, I thank you for being with us today, Mr. Bateman, and for your testimony. Next up will be Reverend Josh Pavlik, followed by Corey Mackey. Reverend.
Thank you, Representative Blumenthal and distinguished members of the Judiciary Committee. Thank you for this opportunity to speak in support of SB 387 regarding recommendations from the Juvenile Justice Policy and Oversight Committee, and in opposition to the various policing enhancement bills that are on your agenda today. I am the Minister of the Unitarian Universalist Society East in Manchester and a leader with the Greater Hartford Interfaith Action Alliance, which is a regional coalition of nearly 50 congregations who are committed right now to countering the blatant fear-mongering and misinformation campaign from the so-called Safe Streets movement. I am proud of Connecticut for the progress it has made on reforming its juvenile justice system over the last decade. We incarcerate fewer youth than almost any other state. Recidivism has declined moderately in every category over the last 10 years. Youth who commit crimes are more quickly diverted to community mental health resources. We don't try youth as adults. These outcomes improve the life prospects for many youth who historically were caught in the school to prison pipeline. Is the system perfect? No. But this is why the work of JJ Pak matters. This is why I support SB 387, and I want to give a shout out especially to the child advocates on that committee. The policing enhancement bills on your agenda would move us in the wrong direction, exposing more youth to the criminal justice system These bills align with the Safe Streets campaign, which I think willfully distorts the data on youth crime and promotes a fear-based, racially coded message in white suburban communities that an out-of-control youth crime wave is making all of us unsafe. This campaign blames this manufactured crime wave on our juvenile justice reforms and then suggests that going back to the days of higher levels of youth incarceration and reopening the juvenile training school will make us safer. I say passing these bills would make no one safer, but they would make life much less safe for youth of color who face both conscious and unconscious racial profiling throughout all the institutions involved in the juvenile justice system. Youth of color with disabilities, language barriers, and GBLTQ identities would be even less safe given the layered nature of the profiling and vulnerabilities they face in relation to the criminal justice system. Legislators from both parties have spoken passionately all session about the need to address youth mental and behavioral health issues. We know mental and behavioral health needs have risen markedly during the pandemic, and we know resources are strained. We also know that most of the youth who end up in the criminal justice system live with behavioral or mental health diagnoses and are classified as disabled. Let's not pursue bills that would enmest such children in the criminal justice system further. Rather, I urge you to put every available resource into treating youth mental and behavioral health disabilities, not to mention, as others have pointed out, addressing racialized gaps in affordable housing, public education, job training, healthcare, childcare, and access to healthy food, all of which factor into the reduction of crime. Let's focus on getting youth the resources they need, not punishing them more. Thank you.
Thank you, Reverend. And appreciate your testimony. Thanks for being here with us. I'm not sure I missed it, and you did say it, but could you just state your name, your full name for the record?
Oh, it's Reverend Josh Pollock, and you gave the correct pronunciation in Polish. We say Pollock like a dog licks its paw.
Well, thank you, Reverend Pollock. I'm sorry we're guessing wrong on your pronunciation, and we'll make that mistake again. Thank you for your testimony and for being with us. Next up is Corey Mackey, followed by Bob Margolis. Corey, you have the floor.
Thank you. And to the members of the Judiciary Committee, thanks for this long day. I'm writing in support of Senate Bill number 387 and Senate Bill number 392, and I speak in strong opposition to Senate Bill 365, House Bill 5418, 5417, Senate Bill 386, and Senate Bill number 16.
I'm sorry to interrupt. Ms. Mackey, could you just state your name for the record?
Sure. My name is Corey Mackey Nicewander. I am the director of the Center for Leadership and Justice and lead organizer of the Greater Hartford Interfaith Action Alliance. We have 50 congregations, synagogues, mosques, and churches paying attention with great concern to this legislation. I am also a resident of Newington. For this testimony, however, I speak as a mom. 2 years ago today, March 14th, 2020, I buried my 63-year-old mother who died completely unexpectedly in her sleep. My son was 7 at the time, and his grandmother was his whole world. The night I told him she died, he hugged her sweatshirt and sobbed from the deepest place of grief I have ever seen in a kid. As we were planning her funeral, the state shut down because of COVID. My son didn't have a school to return to or friends to see. In addition to that pain, his parents were in the middle of a divorce. It was one jarring experience of sorrow and disorientation after another. Within a few months, we started to see rage and outbursts that were concerning. Finding a therapist in the beginning of pandemic for a kid was no easy task. We had to settle for telehealth, but at least had insurance, flexible jobs, a computer and internet connection, and the ability to take days off without losing pay. We also had stable housing, money for groceries, transportation, and the ability to seek our own mental health support. My son is now 9, just a few short months from being able to be arrested should he have a fit of rage on the school bus or at school or anywhere else where one might be inclined to call the police on him. However, the fear of adults calling the police on my son because of his behavior is nowhere in my mind. He is a little 9-year-old white boy. His rage will be met with concern in the professionals around him who will want to get to the bottom of it. His anger will be seen as rooted in grief, and he will be given the grace and supports to work through his issue, free from involvement in the juvenile justice system. Statistics show that this would likely not be the outcome for his black and brown peers. He is doing well, but should he take a turn and end up being one of the few white kids incarcerated, slapped with GPS monitoring, or be 14 and transferred to adult prison and experience all of the other harmful policies being considered today, he will experience long-term harm demonstrated in research study after research study. These efforts would completely miss the root cause of his behaviors. This legislation misses the root causes, and it harms children. You know this, I know this, and yet we peddle these policies in some thinly veiled attempt to respond to people who are afraid of their car or other property being stolen. This is because of a dangerous misinformation campaign being waged in the state by Safe Streets Connecticut, which is putting lives at risk, especially the lives of Black and brown youth. With the exception of a small uptick in car thefts in Connecticut during the height of the pandemic, car thefts are 77% lower since 1991. We do not have a crime epidemic. We do not have a car theft epidemic. We have an affordable housing crisis and crises in healthcare, education, food security. And yet, despite knowing all of this, we are spending time today on policies that will completely fail to address the root cause of the crime and violence we do see. I commend to you the work of the JJPOC, which roots policies and legislation in actual research and data. Thank you.
Thank you, Ms. Mackey, for your testimony. Seeing no comments or questions from the committee, I thank you for being with us and for being so patient today. Bob Margolis will be next, followed by Kurt Frank. Mr. Margolis, you have the floor.
You're in the car. Right. Have we got you?
I'm clear.
Thank you. As a holder of a valid Connecticut pistol permit since 1976, proposed laws that encompass as much gun control as what's being discussed today is an insult to me and should be an insult to every law-abiding pistol permit holder in Connecticut. I'm speaking in strong opposition to SB 16. Laws like these are the equivalent of banning forks and spoons to address obesity, or taking cars away from sober people so that drunk drivers can't hurt them. Gun control through legislation is the misguided statement, we have to do something. Attacking guns is the low-hanging fruit of legislation. Let's all agree that we need to attack the root of the problems, not punish law-abiding gun owners. Our rising crime rate in Connecticut has nothing to do with guns or permit holders. It has everything to do with lax criminal punishment for both juveniles and career criminals. How many times have we heard in the news that someone that committed a violent crime with a gun has had 5, 10, or more arrests for similar crimes? Why are these people still free? When police are legislated not to pursue juveniles that commit crimes, that incentivizes delinquent teenagers to do the same thing without risk of consequence. Permit holders commit less than 25% at the rate of, permit holders commit crimes at less than 25% of the rate of non-permit holders. And this proposal seems to ignore that statistic. In preventing carrying of a firearm on public transportation, this not only severely impacts minorities, but will also negatively impact already very poor utilization of public transportation. With 94% of mass shootings occurring in gun-free zones, why would we want to create more gun-free zones? I'm a lifelong Connecticut resident, business owner, and I hold a federal firearms license. My current business permits and licenses from both my town and the federal government are already highly regulated. And along with the fact that 99.99% of FFLs are already in compliance, we don't need a state license and more oversight than we already have. This would be an additional burden in an already difficult and expensive state to do business in. There's also a provision in the bill for the commissioner to require any other materials from FFL or FFL applicants. We shouldn't create a law that creates confusion or ambiguity. I'm a law-abiding resident and a certified insured professional firearms instructor. There currently...
I'm sorry to interrupt, but your time has expired, so please just summarize your last sentence or two of your testimony. And I believe there will be a question for you.
Thank you. I'll leave it where I'm at.
And I imagine were there any other bills on the agenda that you had mentioned I missed?
No, I didn't mention them, but I did submit written testimony opposing HB 5305 and HB 5460.
5305 is not on our agenda.
I apologize. And supporting SB 388 and SB 5412.
Okay. You indicated that you're a licensed firearms dealer in Connecticut?
Yes, sir.
Okay. Now, over the last year or so, my understanding is that the state has had some significant problems in processing firearm sales. And I ask you that because I want to kind of fold that into how the state would conduct itself were it to be require that each federally licensed firearms dealer also get a state permit. So could you just give us some indication as to how the state handled its responsibilities this past year?
Sir, to characterize how the state has done with firearm authorizations has been nothing but troublesome, disastrous, time-consuming, and has tremendously affected my business, and I assume most federal firearms licensees here in Connecticut. It's sometimes taking hours just to get someone on the phone to get an authorization number. So we go through a lot to make sure that we stay in compliance.
Okay, so when you say that it's taken hours, so I walk into your store and I say, I would like to buy this shotgun. And you and I make a deal on the price. And then how is the state involved in that?
As of last Friday, I'm able to log on a laptop and hopefully get a fairly quick authorization. But prior to last Friday, I had to continuously dial on my cell phone and hope that someone would pick up the phone. Now, on a Tuesday at 9 o'clock in the morning, it's pretty quick. But on a Saturday at noontime or a Friday at 4 o'clock, I might never get through.
So you would need, so in order to sell me that shotgun, you have to contact the state, who then runs a background check on me and the serial number of the firearm, and determines if I am eligible, and then gives you a unique number to put on the paperwork. And so if the state takes hours or days, I have to either stand there in your store for hours, or I have to come back at some point. Is that right? Did I get it right?
Yes, that's correct.
Okay, and do I also have it correct that you're not allowed to even make that phone call unless I'm standing in front of you?
That's also correct.
Okay, so if I come in on a Friday afternoon, you close at 5 o'clock, and we wait 3-4 hours for you to get through. You can't get through. I have to leave and then come back, and then you have to try again, right?
Correct. So the phone lines close weekdays at 7. If we don't make it by 6:45, chances are we're not going to make it at all.
Okay. So based on that, what is your confidence that the state would properly handle a separate licensing scheme for federally licensed firearm dealers?
My confidence is very low, sir.
Okay. All right. Well, I appreciate your coming in and talking to us about this. We will certainly, your testimony is well taken, and we will certainly take it into account. Very much appreciate it. Thank you, Mr. Chairman.
Thank you, Representative Dubinsky. Seeing no further questions or comments from the committee, Mr. Morales, I will thank you for your testimony and for being with us tonight and your patience. Next up is Kurt Frank, followed by Holly Sullivan. Mr. Frank?
Hello, can you hear me?
I'm clear. If you could turn on your video, if possible, that would be appreciated.
How about now?
Good.
Okay. Dear Judiciary Committee, my name is Kurt Frank, and I live in East Windsor, Connecticut. I am a law-abiding citizen who, like many people here today, strongly oppose proposed Bill 16 and 4516. The proposal SB 16 will do nothing to deter or reduce crime in any way. All this proposal will do is affect the ability of law-abiding citizens in protecting themselves from criminals. This is proven by the Public Act 13-3 of 2013. If that gun control act worked, why is there need for additional gun control all these years later? The proposed bill, SB 16 and 4516, are both clear violations of our Second Amendment right. The right of the people to keep and bear arms shall not be infringed. As well as the proposed bill, SB 16 violates our Fourth Amendment right, the right of the people to be secure in their persons, house, papers, effects against unreasonable searches and seizures. I would like to state that I am in support of proposed bill SB 388, 5412, and 5415. Thank you.
Thank you, Mr. Frank. Appreciate you being with us and your patience this evening. Seeing no questions or comments from the committee, I'll thank you for your testimony. Next up is Holly Sullivan, followed by David Iomi. I apologize in advance for butchering your name, I'm sure. Ms. Sullivan, you have the floor.
Thank you so much. Distinguished members of the Judiciary Committee, my name is Holly Sullivan, and I am proud to be the president of the Connecticut Citizens Defense League. I expect that much discussion today has and will be focused on SB 16, so I'd like to take this opportunity to focus on HB 5416, an act concerning bulk purchases of pistols and revolvers. It's important to be clear with this committee that the title is a misnomer, as it does not merely concern the purchase of pistols and revolvers. And taking my CCDL president hat off for a moment, I'd like to share with you the situation that my family found ourselves in when my father tragically passed away in a sudden accident. He had, over his lifetime, owned what would be considered a very small collection to any avid enthusiast. He never earned a proper college degree, but worked tirelessly to provide for his family. His one recreation was his firearms and his marksmanship. When he was suddenly gone, my mother found herself alone and very uncomfortable. Very shortly after he passed, a local newspaper company in Westchester County, New York, ran a story publishing the home addresses of pistol holders in our county, which attracted many readers, as was certainly the intention. Now, my mother was in fear that she, as a single widow, learning to be alone for the first time in her life, would be targeted for a possible home invasion, as it was known to the public what was inside my childhood home. It was essential that I lawfully transferred my father's collection and moved them, along with a large safe and etc., to my own home quickly. In the state of Connecticut, we went through all of the proper means. We called DESTP together and acquired a unique authorization number to lawfully transfer each firearm. Under HB 5416, this would not be possible. You see, this bill does not just say that it limits sales, it restricts all transfers. And I would like you to think of the individual looking to remove firearms from their homes for other safety reasons. If passed, SB 5416 will prohibit law-abiding gun owners from taking action to make their homes and their families safer should firearms need to be in the possession of another. Many of the statistics that you will hear are regarding suicides, which constitutes 2/3 of all firearm-related deaths. If an individual seeking help is unable to pass their firearms to a loved one or other trusted law-abiding resource, SB 5416 will make it more likely that tragedy will occur. This is the antithesis of common sense. I hope you will think about the repercussions on real people who actually live with these concerns and vote in favor of safe decisions. I clearly, obviously oppose SB 16 and support SB 388, HB 5415, and HB 5412. I'm happy to take any questions.
Thank you, Ms. Sullivan, for your testimony. It looks like Representative Dubitsky has raised his hand to ask a question or make a comment.
Thank you, Mr. Chairman, and thank you, Ms. Sullivan, for coming in. I think that you made a comment and raised an issue that has not yet been raised in all the hours that we've been here tonight with regard to the transfer of firearms and how that would be prohibited under HB 4516. Now, the issue of having somebody who perhaps is having some psychological problems and their family may need to move those firearms quickly. It hadn't even occurred to me, frankly, and I've analyzed these bills quite a bit, that what this would do, this bill, would prevent the family from taking that collection and securing it with another person, and in order to keep the firearms away from the person with that's having problems. And you can think back to many different tragedies where the shooter was known to have a mental problem, and if the family was able to remove the firearms from the home, that perhaps some of those tragedies could have been prevented. And under this bill, it appears that it would be a significant impediment to the family doing that. I very much appreciate you raising that issue. Was there anything else on that issue you wanted to say?
Well, I think that's, I think we're underscoring exactly that, is that we talk about how gun owners are tasked with being so responsible, and I'm so proud of my people that they are. I mean, when we talk about permitted gun owners, we know that we are the most law-abiding demographic of people in our society. We do take our responsibility very, very seriously, and I think it is so important that the committee understands that this bill, should it pass, prohibits a family from taking a collection away and lawfully transferring it to a safer family member or somebody who is another trusted resource. There's a lot of different things that we're talking about today, but I went through this, I lived through this, and my mom, who had, really gone from, she got married in the 1970s, she moved in with my dad from her family, she's never been alone before, and then when this newspaper article, which was intended to be sensationalized, was, she's never been alone before, and she called and said, I don't know what to do. Since then, she's moved to Connecticut. She is a resident of Newtown. I'm a resident of Southbury. And it's a relief to know that, as kids get older, as, we have nephews and there's more people in the family, that we have a safe network should we ever find ourselves in a position that we might want to take firearms and remove them from our homes. And I think one of the things that often is overlooked is that there is so much restriction on gun owners that they are sometimes afraid to speak up or ask for help. And the fear of losing their investment or their collection or something like that, that is a very valid fear. And should they turn it over to the police department, they might not know what might become of it. Whereas maybe they just need to say, hey, I'd like to have a little bit of time that they're just not around. Maybe they're going through something, maybe they're going through a divorce. And the responsible thing to do is just to not have them in the home. They need to have the ability to make that choice for themselves and give it to another equally permitted law-abiding person who is safe to store those on their behalf. And should this bill pass, people will not be able to do that. My mother would not have been able to transfer my father's collection to me legally with an authorization number for each and every one without, should this become law.
Well, it's certainly something that I'm sure the committee, the Judiciary Committee, and hopefully everybody will think about that. It's easy to just throw out a bill that says, "Oh, we're going to stop, bulk purchases," but looking at what the unintended consequences of that. It's really important that we have these public hearings and that we have people like yourself who are knowledgeable in this area to come and testify about what those ramifications might be. So I very much appreciate your time, and thank you for your testimony. Thank you.
Thank you very much.
Thank you very much. Comment or question from other members of the committee? Seeing none. Thank you for joining us this evening. Next, we'll hear from Brian Young.
So that was Holly Sullivan, the president of the Citizens Defense League.
Thank you. Thank you, Chairman, and thank you, members of the Judiciary Committee. SB 16 claims to address gun violence and juvenile crime by its...
They're testifying on some Connecticut anti-gun legislation that's being proposed right now from their governor and is now in House committee. 50 items, 34 of which are firearms infringements. This is happening in Connecticut. They're taking testimony today, and tomorrow they have 230 something citizens on board in line to do these Zoom testimonies, and we're live over here watching it. Barbecue is live over here, and we've got quite a few people who are in Connecticut are paying attention to the Connecticut situation. So if you want to join us, we'll be live again when Brooke Cheney goes live here. She's about 3 folks away. She's only 3 away, so we'll be going live here in another moment or two. But we're live on this stream. Barbecue's live on this stream, and then you can watch it live from the Connecticut Judiciary Committee without comments here. And both Barbecue and I both have links to that. I'll probably get links in the video here as well. So if you want to be part of what's happening, observe the actual government happening. We're able to do that now better than C-SPAN because we're participating in it. And when you listen to the summaries of this later, gives you real data to compare those summaries with to help sort out people's point of views. I'll end this one, and we'll start another one here soon with Brooke Cheney.
Dolman?
You got it.
David Iommi.
Thank you. Good evening. My name is David Iommi. I reside in Cheshire, Connecticut, and I'm testifying my opposition to Governor's Bill number 16. I am a retiree and have a Connecticut pistol permit. I legally own several firearms, and I enjoy target shooting with my daughter at our local shooting range. I personally find it reassuring that I have a legal firearm in my home to keep us safe in the event of an armed home invasion. While I choose not to carry a handgun in public, I am thankful that my pistol permit in state law gives me the right to do so. There are 5 specific reasons I oppose the bill. Reason 1, the bill greatly expands the definition of what qualifies as an assault weapon. It adds, for example, the others classified firearm to the ban list. I feel that the others firearm is a common legal firearm and should not be placed on this list. An example of the craziness of the new assault weapon definition in the bill is that even a 22 caliber firearm having a detachable magazine is defined as an illegal assault weapon. And hopefully, let's see, where is it? Why can't I get this here? There you go. That is a 22 caliber cartridge. It is defined as assault weapon ammo under this bill. It's about the length of the width of my thumb. The small cartridge that has been used forever for target shooting by people of all ages. I have to ask, what direction are we going in with this? Is the governor next going to define BB guns as an assault weapon? The reason number two for opposing the bill bans additional firearm accessories that includes pistol braces. Pistol braces do just that, stabilize the firearm, and are particularly useful to those with disabilities. Reason number three, the bill modifies the carry arms laws to show your permit if asked by police. This modification is intended to discourage lawful pistol carriers and will encourage racial profiling, especially in our cities having minorities that legally carry. Reason number four to oppose, the bill creates more gun-free zones. To me, these additional restrictions are intended to prevent legal gun carry everywhere in public. It is unacceptable to me and probably unenforceable. And lastly, reason number five, the bill creates regulations and new licensing requirements for FFLs. These provisions appear to be the start of an attempt to drive FFLs out of business. Gun owners like me need to use FFLs to legally buy and transfer firearms as well as to buy ammunition. In summary, I'd like to say that law-abiding citizens like myself that own legally purchased firearms are not the enemy. It's criminals using illegally acquired firearms that are the enemy. Let's stop enacting laws that will take legal guns away from law-abiding citizens and instead enact stronger laws that go after criminals using illegally obtained guns. Thank you for permitting me to speak on this bill.
Thank you, Mr. Army. Representative Fishbein.
Thank you, Mr. Chairman. Just briefly, David, nice to see you again. And I know you're one of my constituents. We've communicated in the past. I just want to thank you for testifying here today. Thank you, Mr. Chairman.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Seeing none, Ms. Iommi, thank you for joining us and sticking around and provide us with your testimony. Have a great evening. Next, we'll hear from John McCartney. John McCartney. Mr. McCartney will be followed by Brooke Cheney. Is John McCartney in? Brooke Cheney, I see you. You may testify. Good to see you.
Nice to see you too, Senator Winfield. And you should be smiling as you're hugging that adorable child of yours. All right, so if I read this, I'm pretty sure it'll be exactly the 3 minutes. My name is Brooke Cheney, and I am from Harwinton, Connecticut. I am the DC Project State Director, a firearms training counselor, suicide prevention advocate, and competitive shooter. I'm a victim of violence. I was bullied in school starting at 9 years old. I started getting raped by upperclassmen at 13 years old. I know what violence is. I know that the act of violence has little to do with the weapon of choice for the bad actors who do violence. I've had a knife held to my neck and my life threatened more than once. I'm also a mom. So when my kids were 5 and 6 and the Sandy Hook Elementary School was attacked, I wept for all those who lost their lives. I wept for weeks until I decided I needed to find out for myself what really does help prevent violence. The media certainly had a lot to say about what causes violence. It's guns, big, black, scary guns. I'd been a victim of violence and there were no guns involved. Violence is an act, not a weapon. For over a decade, I've been testifying. For over a decade, I have kept coming back with the same hope that maybe this time we will actually use some of the proven research that helps prevent gun violence and crime. Yet here we are again, talking about creating more bureaucracy, banning more guns, and doing very little to actually help. Out of the 35 sections of the 52 pages of the Governor's Bill number 16, only 2 are actually focused on gun violence prevention. How many more have to die in gun-free zones before you look at the studies that the Department of Education and Secret Service have done, stating that the most mass shooters are cowards and look for the highest body count by targeting gun-free zones? When are you going to look at the FBI crime statistics that show that the rifles you are so eager to ban are barely a blip in the statistics of violence? I am not a violent person. The bugs in my home get caught and put outside. All life is precious. According to these bills, the idea that I would buy more than one gun in a month or have a gun that has a certain feature, I should be violent or possibly a threat. Education has been shown to be the way to safety when it comes to guns. In 2006, I had my first child. I realized I needed training so I would not be the person who causes harm by accident. I went from knowing nothing about guns and afraid to touch one to becoming an instructor and a sponsored competitive shooter. As a legislator, you have a difficult job. This is just one of many hearings that you will attend during this session. Even just today, some of you are going from hearing to hearing. You are expected to wade through countless bills and make educated decisions. I ask that you do pay attention to the information that is put forth and avoid the temptation to do something just because you feel it might help. Thank you for your hard work and determination to make Connecticut a better place to live for all, not just people who think the way you do. In closing, I ask that you vote no on the governor's bill as it currently stands. Vote no on Raised Bill 5416. Please consider voting yes on Raised Bill number 388, number 5415, and Raised Bill number 5412. And I thank you for your time and your commitment to making Connecticut a better place.
Thank you very much, Brooke. Again, pretty good with the time as usual. Representative Dubisky has a comment or question.
Thank you, Mr. Chairman, and thank you, Brooke, for coming in. You and I have, I've known your story for a long time, and it still amazes me that after the crime that you have suffered, that you would be able to pull yourself together and become such a strong mother and advocate. And I really appreciate you coming in and talking to us about it. Others during the evening during the day and evening have gone through individual sections of SB 16. But certainly I appreciate you coming in and explaining how these bills would affect you as a crime victim who's overcome. And I very much appreciate you coming in and giving us your testimony today.
You're welcome. And I will say, as a competitive shooter, just so people know, it's like I always will buy 2 guns at once, simply for the fact that I have a practice gun and a competition gun, and it has nothing to do with straw purchases, and I'm not doing anything nefarious because I'm buying more than 1 gun at a time. So, as to the gentleman who said that, I have to plan better if I'm going to do this, that kind of defeats the purpose of what I try to do on a regular basis. So, thank you all for your time, and I appreciate all the hard work you guys do.
I vote to buy a practice gun and a competition gun. The representative that said, sorry. Comment or question from other members of the committee? Comment or question? If not, Brooke, thank you for joining us again. You always offer important perspective and information.
Thank you, Senator Winfield. I look forward to seeing you again in person sometime soon.
I'm sure we will.
All right.
Next, we'll hear from John Westlake.
Good evening, everybody.
Good evening.
So that was Brooke from a Great Start Shooting School.
Good evening, co-chairs Winfield and Stratham, ranking members Kilsey and Fishbein, and distinguished members of the Judiciary Committee. My name is John Westlake from Coventry, Connecticut. Thank you for this opportunity, allowing me to submit testimony in opposition to Senate Bill 16. I hail from a long line of proud Yankees, going back to New London in 1635. Pragmatic and commonsensical. The "you can't get there from here" crew. We're not happy with this most recent attempt at infringement of our God-given right to self-defense, and this is why. This bill is discriminatory, as it targets the law-abiding citizens of the state of Connecticut and provides no new attempt to actually curb violent crime. Here's a fact. The use of a firearm during the commission of a crime is already illegal. How many other ways do we have to dress it up to basically say the same thing? We are missing is an effective deterrent to keep these crimes from continuing to happen. What my rifle looks like, and this is going towards the named illegal assault weapons that are added to Senate Bill 16. What my rifle looks like has no impact on what happens to the bullet once it leaves the barrel. Ask Abraham Lincoln. All right. It fires one bullet at a time with each squeeze of the trigger. No different than Barney Fife's revolver. In fact, the difference is he only carried one bullet in his pocket. But still, only fires one bullet with each squeeze of the trigger. These aren't machine guns. They're semi-automatic by definition, which boils down to one bullet per squeeze. Pistol grips and different types of stocks have no impact once that bullet leaves the muzzle. Military features, such as a bayonet lug. That's a little item at the front of the rifle, allowing you to attach a bayonet. It's illegal and considered one of those evil items that may keep you from owning a particular firearm. In many cases, a historical particular firearm. To my knowledge, nobody's been bayoneted to death in the United States probably since the Revolution. Well, no, I take that back. Since the Civil War. Pistol grips, forward grips, banning these features makes it clear that you're attempting to ban.
Mr. Westlake,
Yes.
your time is elapsed. If you could summarize.
All right, well, I'll tell you what, rather than summarizing, because my statement is written and submitted, what I would like to do is go back and visit a statement made earlier by Robert Goodrich.
Mr. Westlake, your time is elapsed. I can't allow you to.
Fort Hood, Texas is not a gun-free zone.
Mr. Westlake, we'll see if there are comments or questions.
Just want to clear that up. Okay. All right. Subject to your questions, this concludes my testimony.
Thank you very much, Mr. Westlake. Are there any comments or questions for Mr. Westlake? Are there any comments or questions? There aren't. Mr. Westlake, I appreciate you joining us this evening to offer your perspective, and thank you for providing written testimony as well.
Thank you for the opportunity.
Have a great evening.
You too. Thank you.
Next, we'll have Edward Pashal. Edward in. Edward Pachal. Andrew Pachal. Robert Nalawajek. Andrew Nalawajek. Paul Rosinski. Paul Rosinski. Daryl Valenti. Daryl Valenti. Mark Palazzo. Mark Palazzo. I'm going to call Daryl Valenti again because I see Daryl's name.
Hello, can you hear me?
I can hear you.
Okay, great. I'm going to be succinct. I'll probably be under 3 minutes. I wanted to read something about assault weapons from Alcohol, Tobacco, and Firearms. AR-15 style rifles are not assault weapons or assault rifles. An assault rifle is a fully automatic machine gun. Automatic firearms have been severely restricted from civilian ownership since 1934. AR-style rifles look like military rifles, such as an M16, but function like a semi-automatic civilian sports firearm or pistol, firing only one round with each pull of a trigger. Versions and models of sporting rifles like this are legal in all 50 states provided that the purchaser passes mandatory FBI background checks and state requirements. The reason I'm opposed to Bill SB 16 is twofold. One, it doesn't properly characterize the rights of lawful gun owners in the state, and it also does not properly deal with the causes for juvenile violence, juvenile crime. I think the two bills should be separated, and we can focus more on each of the problems. One thing that I've been listening to since 10 o'clock this morning that I was greatly concerned about was lines 290 through 298, which talk about an officer requesting licensee's license permit. And specifically, I think people have been reading this wrong. They've been saying that they wanted to take out the statement about the officer using who has reasonable suspicion of a crime. But if you take that out of that sentence, a holder of a permit would have to present the permit to the request of a law enforcement officer for any reason, for the purpose of verification and validity of the permit and the identification of the holder, provided that the holder is carrying the pistol. So that by taking those lines out, you're actually giving or creating a situation where an officer could do more profiling of gun holders or racial profiling. So I think the whole section has to be restructured. Obviously, a permit holder should be carrying their permit if they have their pistol, but I just think it needs to be reworded. That's really all I have to say. Everybody else has really testified and covered everything else that I'm concerned about, other than the description of what another is and how I'm afraid that this wording, it's definitely not the intended purpose and it needs to be clarified. Thank you for your time.
Thank you, Mr. Valenti. Representative Dubisky.
Thank you, Mr. Chairman, and thank you, Mr. Valenti, for coming in. Could you indicated that the definition that you read at the beginning of your testimony was from ATF. Could you be specific as to what you were reading from?
It's actually on the source of it is the NSSF organization website, and they have the definition of what an assault weapon by ATF is, and that's just a little paragraph that I read versus others and AR-15s.
Okay, and just for the record, ATF is the Federal
Alcohol and Fire, right?
Federal Department of Alcohol, Tobacco, and Firearms.
Correct.
Thank you very much. Appreciate it. Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this evening, Mr. Valenti.
Thanks.
Next up is Mark Palazzo. Mark Palazzo. Frank Rosello. Frank Rosello. Sorry. Mary Bernstein. Mary Bernstein. Dr. Matthew Cucolo.
I'm here.
All right, you may testify.
Thank you, sir. Thank you, everyone, for taking the time to listen to me. I truly encourage all the members to stay up late, listen to every potential speaker. It's already late in the day, so I'll be quick, but I've waited long times to speak on other bills like religious exemptions and things like that. I never got a chance to speak, which is very frustrating as a citizen of Connecticut. I like to think we're all in agreement that we want to keep our community safe. So I believe that's what's in everyone's heart here, and every listener and everybody giving testimony. That's wonderful. I ask anybody who's listening to please oppose Senate Bill 16, HB number 5416, support SB 388, HB 5415, and HB 5412. SB 16, I feel like, we got to start punishing criminals and not legal gun owners. We need to start prosecuting these crimes rather than inventing new crimes. That's just how I feel. I think when there's gun-free zones, it's a big sign for criminals to, or crazy people if they want to get in trouble. Criminals will always be able to find guns. Criminals will always be able to find any weapon, for that matter. I think as citizens, we should be able to arm and protect ourselves, especially with the big push before to defund the police or have less police or less people in our communities. You need to use whatever it takes to protect your family. God forbid that should ever arise. I know as a legal gun carrier, I never want to have to use my firearm ever. But I know I can protect myself, my family, my friends, and other people in the community who may not even want to be anywhere near a firearm. So I want to thank a lot of the representatives giving their great points today, especially State Rep Dubitsky. I met him before, and I think he's really a smart and sharp guy. And I really like this morning, I got to hear a little piece of it as I was in between patients with you trying to just get the definition of homicide and murder and what the real statistics are. Are people defending their lives or people going to use weapons to take people's lives? I like data. I think the more data that we have is always a good thing, and we can analyze things better. Last thing I'll say is, without the Second Amendment, I don't think we'll have the other amendments. It's the one thing our founding fathers bestowed upon us. I get into these debates all the time. People are like, oh, back then they were just muskets. The forefathers would be rolling over in their graves. I agree. They would be rolling in their graves. We don't have enough firepower to combat the government. They could drop a drone or anything they want on you at any time. I think there's such a miscommunication out there, a disconnect between what an assault weapon is and all that. I just think it's gross. I think my time is up, and I just want to thank you again. And I hope we get to listen to everybody all night. So thank you so much.
Thank you, Dr. Piccolo. Comment or question from members of the committee? Comment or question, Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Doctor, for coming in. The one thing that you did mention is that in other committees, even though you were diligent and stayed and tried to testify, that they cut you off, and we certainly appreciate that here in the Judiciary Committee, we don't do that. That if somebody is going to spend their time and effort to wait their turn in line to testify, that we're going to hear them. And I certainly hope that never changes in the Judiciary Committee. And so thank you very much. Very much appreciate your coming in and taking your day and watching and giving us your input. Thank you very much.
Thank you so much. Thank you. Thank you, everyone.
Thank you, Mr. Chairman.
Thank you. Thank you for joining us. Enjoy your evening. Next, we'll hear from John Lucarelli.
Can you hear me okay?
I do.
All right. Thank you. Thank you, Chairman Winfield. Thanks to the Judiciary Committee for hosting these very important hearings on public safety, and especially Representatives Dubitsky, Fiorello, and Fishbein for your insightful questions over so many hours. My name is John Lucarelli, a concerned citizen and lifelong Connecticut Yankee. I applaud this committee in allowing Dr. John Lott's testimony to be on the record and give him ample time to explain his independent research that is recognized not only by many state legislatures, but also the U.S. Department of Justice. And I am pleased we are finally having a much needed debate, not only on SB 16 and the other laws tonight, but a public referendum almost 10 years later on the Gun Provisions in Public Act, ratified in 2013 after Sandy Hook. Many of us sat in these same type of hearings back then and witnessed the legislature act in haste, no matter how well-intentioned, but succumbing to pressure to act prematurely when emotions were extreme on both sides of the aisle. Today, I view our situation as your situation as lawmakers, is you have a social contract with your constituencies to provide the best means for adequate public safety. But I ask, who's going to provide this service? As evidenced by Attorney Jeremy Stein earlier today, violent crime has spiraled out of control over the past few years since the 2013 law was ratified, which was a law severely curtailing citizens' ability to defend themselves. SB 16, as Dr. Lott stated, enacts some of the same rights confiscation language that will also have unintended violent consequences going forward. And then last year, this legislature sealed our fate by passing the 2021 Connecticut Reform Law, Connecticut Police Reform Law, one of the strongest anti-police laws in the country. And this police, quote-unquote, defunding law diminished state and local police departments' ability to provide adequate public safety by cutting needed funding for more training, essential manpower, and even put more pressure, diminishing our already embarrassingly low average response times of 7 to 10 minutes for call-outs, according to the state police. So I asked this joint committee again, who is responsible for public safety? This decision lands squarely in each of this committee's 37 members' laps. You are the ones that will present this bill to the Connecticut General Assembly, and you will be responsible for the future victims who, as it stands, will have a more diminished ability than ever before to defend themselves if SB 16 is enacted into law. I truly hope this committee will have the courage and strength to defeat Governor Lamont's new bill and give serious consideration to hiring Dr. John Lott to independently review and assess the efficacy of the 2013 Act. Thank you for your time, and thank you for all the hours you guys all have given. I'm open to questions if you have any.
Thank you very much, Mr. Ugarelli. Comment or question from members of the committee? Comment or question? So now, thank you very much for holding on and testifying before us today.
Speechless, huh? Take care.
Next, we'll hear from Kate Rivera. Is Kate here? Kate Rivera.
I've been trying to get on. Mary Bernstein, number 76, for some reason.
Right before that, go ahead, Ms. Bernstein.
Good evening, distinguished committee members. My name is Mary Bernstein. I am from West Hartford. I'm a board member of Connecticut Against Gun Violence, and I'm testifying in opposition to HB 5412 and SB 3388. 5412 is an act concerning the duty to retreat in a house of religious worship. This proposed law is a stand your ground law that can be used to insulate people from having to justify why they shot and possibly killed someone. Currently, and in contrast to what proponents of the law claim, people already have the right to use deadly force if it is the only way to prevent the imminent commission of a forcible felony. Otherwise, a person has a duty to retreat. Self-defense is already an affirmative defense that can be adjudicated at trial. If a defendant makes a prima facie case that he or she had acted in self-defense, the burden switches to the state to prove beyond a reasonable doubt that he or she had not been, that they have the legal advantage, which then goes to the person claiming self-defense. According to current law, the duty to retreat provision is not particularly demanding, as it only requires retreat if the person, quote, knows that he or she can avoid the necessity of using such force with complete safety. The proposed law removes the duty to retreat and allows the use of deadly force, even if the assailant were retreating and thus no longer posing a threat. I would urge you to take into account the implicit bias literature, which shows that people harbor prejudice that they may not be aware of, and that it causes them to interpret the exact same behavior as violent or nonviolent based solely on whether the person is Black or white. There is already evidence that stand your ground laws produce racially disparate results. Several people have testified against allowing police officers power to ask gun carriers to present their permit, and they've noted the possibility that police might use that bill as an opportunity to target Black and brown people. That testimony acknowledges the existence of racial bias. We only have to look at the high-profile cases of Philando Castile and others to know that this can happen. A defense based on the Stand Your Ground bill would rest on the claim that the shooter was afraid, which is subjective. What this translates to, based on how these laws are implemented in other states, is that all the shooter would need to do would be to say that he or she believed that they were in danger and that this fear is both subjective and reasonable, and that rather than retreat, the person used lethal force against their attacker. Now, data supports that these laws are used in racially biased ways. One study in Florida of 200 standard ground cases found that 73% of individuals who killed a Black person faced no penalty. 59% of individuals who killed a white person faced no penalty. With standard ground, if people have probable cause to believe the perpetrator acted in, if the police have probable cause to believe the perpetrator acted in self-defense, then they can't arrest them at the scene. Therefore, they can't question, search, and gather critical evidence. A judge at a pre-trial hearing can decide the case need not go to trial, so no examination of all the evidence ever happens, and that should be something that's decided by a jury. It is reasonable for the state to do what it can do to prevent the case. Yeah.
Your time has elapsed. If you could summarize, please.
Sure. Basically, the law that already exists is sufficient. If their life is a danger, they already can use lethal force. But then they just need to justify that that was the case. Removing it is going to open up to shoot just because you say you were afraid, and we know that because of racial bias, we know who people are going to say they were afraid of.
Thank you. Representative Dubinsky.
Thank you, Mr. Chairman. And thank you, Ms. Bernstein, for coming in. If an active shooter walks into a church and a parishioner has a firearm, but is at the other side of the room and is able to get out of the room, but everybody else in the church is not able to get out of the room. Currently, that armed parishioner is required to leave, isn't it?
No, because they would be preventing a forcible felony from happening, because they would be protecting other people from being shot. And that's clearly something that they could defend, and that a jury, if the evidence was there, would believe.
That's not self-defense, is it?
It fits within the current law. It's self-defense, or you can protect others from being victim of a forcible felony.
Okay. So you're saying that you already don't have a duty to retreat?
If it's about protecting other people. If the parishioner were alone in the church with the shooter, and that person could get out safely, then that person, and nobody else was there, that person would have the obligation.
So how would this law change what already exists?
It would remove the duty to retreat. So, for example, you can take, for example, let's see. Usually the way that this defense is used is somebody is able to claim that I was afraid and therefore I shot and killed that person. And what this does is it basically gives the presumption to that person without anybody ever examining the evidence as to whether that case is justified. So what I'm doing really is talking about the research and talking about how these laws are implemented.
Okay, there's nothing in the bill that says that the evidence is not going to be examined.
But that's the way it's been implemented in other states. There are law review articles that I have referenced in my testimony. And so, in fact, that is actually what happened. I mean, you can look at what happened in the Ahmaud Arbery case, right, where the men who killed Ahmaud Arbery basically said, "We fear for our life." And they said, "Oh, yes, you must have feared for your life." And so then nothing happened for months and months and months. There was no examination. There was simply a presumption that because you said you were afraid, you must have been afraid for your life.
I think you picked a bad example, because each of those men were convicted of murder, and my understanding is that that they may face the death penalty.
Because the video surfaced. Had that video not surfaced, then they went for months and months and months, and nothing was examined. Nothing was examined when it happened. The men weren't taken in. Nobody was questioned right after the murder. If there were no video, there would be no conviction. I mean, I'm sorry, if there were no video, right? All they would have done is said, "Oh, you were afraid." You were afraid of a black man who was running through the neighborhood. Of course you were scared. Of course you shot him. And that was the presumption for months and months and months in that case.
I've never heard of any shooting case that has been found justified just because somebody's afraid. There has to be a reasonable, a reasonably articulable situation where a person has is in fear of immediate and otherwise unavoidable danger of death or grave bodily injury. You can't just say, "Oh, a black man walked in, so I was afraid, so I shot him." I've never seen any jurisdiction that be justified. You're saying that is?
I'm saying that if you look at the Philando Castile case, right, and that was a police officer, and he was a permanent gun owner who told the officer, we have this on video, who told the officer that I'm going to show you my permit, I am carrying, I'm a legal gun owner, and the officer shot him multiple times.
That was not a stand your ground case.
No, that was not. For their permit, right, that could be subject to racial bias. And what I'm arguing is that stand your ground, and the way that these have been implemented in other states demonstrates that these are used in a racially biased way. And it's because of implicit bias. It's because of who in our society we are taught to be afraid of and who we are taught not to be afraid of.
Well, I think there's probably few, if any, people in this legislature who want to make sure our laws don't invoke overt or implicit bias, but I don't think that this is one of the cases that is susceptible to that analysis. But I appreciate your testimony, and thank you, Mr. Chairman.
Thank you, Representative. Senator Champagne.
Thank you. Ms. Bernstein, something you said about the church example that Representative Dubinsky said kind of bothered me. And I want to go back to it. So you have a parishioner in the church, on the other side of the church, a gunman comes in, and you said that our current laws, that if the gunman interceded, he would be found not guilty by a jury.
I believe that, yes, if the evidence showed, if there were if somebody had a gun and they were aiming it at people or started to shoot, hopefully that would not. We know it has happened, sadly, and somebody took the shooter out, then they could certainly defend that action as defending, somebody who, defending a lot of people, presumably.
So,
Ms. Bernstein, just when the senator is asking a question, let him finish the question.
I apologize.
Yeah, proceed, Senator Champagne.
Thank you. The second part of my question was that means that in order to be found not guilty by a jury, that this person would be arrested, handcuffed. Basically, the media would go after him. And all he's doing is defending a church. So if the case that happened in Texas, where the retired FBI agent basically shot and stopped the gunman inside the church, given the logic that you just said, he would have had to have been arrested and gone before a jury. Don't you think if somebody's going to step up and protect the lives of others, that they shouldn't have to be arrested and have to go before a jury?
Are you finished?
Yes.
I think that if you take the life of another person, that your word should not be enough. I do believe that, in fact, that the evidence should be examined, and because you can think of other examples where somebody walks in and a person thinks that they're suspicious and they've got their hand in their pocket and maybe they're getting out their cell phone, and somebody thinks that they're a shooter because they don't recognize that person and they shoot them, then I wouldn't want to take that person's, would we take that person's word? Well, I would want somebody and a group of people charged, like a jury, to actually look at that evidence.
Okay, that wasn't the example that was given, but I just want to make sure that, if a citizen's going to step up to protect the lives of others, that he's not facing having to go to court, defend himself. If you're going to defend, and basically, if you're given the state laws, most likely you wouldn't be arrested because that would be a credible self-defense of a third person. But, to have the idea that if somebody steps up to defend a whole church full of people, that they should have to go before a jury is kind of, I don't know. I guess we're not thinking the same here, because I definitely, if somebody's shooting at people in a church, I'm praying that that person that's armed would step up and help them and not be arrested, because he's probably going to save countless lives like that FBI agent did in Texas. All right, thank you.
Thank you, Senator. Comments or questions from members of the committee? Comments and questions? Seeing none, Ms. Bernstein, thank you. Sorry, Representative Fishbone.
Yeah, Mr. Chairman, just briefly, I'm just trying to put it in perspective because I'm sorry. I'm just trying to put it in perspective because we've heard a lot about the law that I totally disagree with. And Ms. Bernstein, are you an attorney?
No, I'm not.
Okay, so the acumen by which you testify here today about what the law is presently is based upon what?
It's based upon my reading of law review articles on Stand Your Ground that examine how they've been implemented over the years in states that already have them.
Are any of those law review articles written in Connecticut based upon Connecticut law?
But we don't have Stand Your Ground in Connecticut at this point.
I understand, but you're here testifying about these bills telling us, given the scenarios under Connecticut law, and I'm just trying to figure out where this is coming from. So, are any of those law review articles that you're referencing, and you're talking about, scenarios inside the church and all of that, and requirement, duty to retreat, is any of what you've written based upon Connecticut law?
Studies that I am discussing.
That's a yes or no.
Representative Fishbone, I understand how you would like the question answered, but I'd ask you to let her answer the question.
Sure.
Yeah. The studies that I've examined look at how Stand Your Ground laws have been implemented, and so they can't be any about Connecticut because we don't have Stand Your Ground laws.
Okay, so I take it that the answer is no, none of this is based upon Connecticut laws. So you said in response to Representative Davitsky's scenario, the duty to retreat from a church, that one does not have a duty to retreat from a church. That was your testimony, and I'm just trying to figure out where that comes from.
That comes from my reading of the literature on how Stand Your Ground has been implemented, and my understanding of that in the state of Connecticut. And please correct me if I'm wrong. In Connecticut right now, if somebody stepped in to defend somebody who was being attacked, and in defending that person, they killed them, right? That act would be defensible if the facts were on their side, that they indeed stepped in to prevent some kind of forcible felony. That's my understanding in Connecticut, and correct me if that's not right.
There was a lot of conflicting elements there, but I just want to bring your attention to Connecticut General Statute 53A-19, which has to do with the duty to retreat. And the only place you do not have a duty to retreat is in your home place of business. That is it. So I understand where you're coming from and your perspective, and I thought I missed something here. So thank you, and thank you, Mr. Chairman.
Thank you, Representative. Comment or question from members of the committee? Comment or question? Seeing none, Ms. Bernstein, thank you for joining us this evening.
Thank you.
Kate Rivera is next. Kate Rivera.
Good evening.
Good evening. You may testify.
Okay. My name is Kate Rivera. I'm a racial justice advocate, organizer, and educator, and I'm the mother of a victim of gun violence who was juvenile justice involved.
Kate, one second.
Additionally,
Just so you know,
Sure.
I'm not sure you know your camera's not on. If you can turn it on, please do.
sure. Can I continue?
Yes, you may.
Additionally, I have organized multiple Black Lives Matter events, and SB 16 violates the First Amendment rights of us freedom fighters for civil rights. Police enhancement bills are a bizarre way of saying new ways to incarcerate Black and brown youth. Police do not stop crime. They are the cleanup crew after the fact. Stopping poverty is how you stop crime. Fully fund schools, offer pro-social activities, affordable housing and childcare, and jobs that pay a living wage. 365, 386, 5418, and SB 16 are racist, ableist, classist, and do not serve to make our community safer. They only ensure the continuation of mass incarceration. It is imperative that we treat our youth like the young people they are. Science tells us that the prefrontal cortex is not fully developed until 25. Why are our laws ignoring scientific facts? Children cannot make statements to law enforcement alone and should not be incarcerated, period. The DOJ determined the civil and disability rights are being violated in NYI. The same is happening in detention and Regions facilities. My son was abused at Regions at Boys and Girls Village, and only after I advocated were staff fired. Last year, a child at Bridgeport Detention had his clavicle broken by staff. Think about the abusive environments you are sending our kids into. Please know there is no therapy for kids in detention while they await adjudication, which takes the better part of a year. Instead of my son was born with disabilities that affect his executive functioning and impulse control. Connecticut is severely lacking in effective, appropriate, and safe mental health services for youth. I know this because I spent the last 16 years of my life searching for the best help for my boy. At age 14, my son was robbed and shot in the head and stomach, and later he became involved in our woefully inadequate juvenile justice system. Instead of paying $1,400 per day to incarcerate youth, imagine if we provide the services kids need to thrive, like community-based service providers, safe houses, and Section 8 vouchers to move families that are targets of gun violence out of harm's way. Flex funds need to be used liberally to support justice-involved youth and their families. If you plan on actually using the valuable recommendations of the JJPOC, I can volunteer my time as the voice of parents is missing. And I am open to questions.
Perfect. Let's see. Are there comments or questions from members of the committee? Comments or questions? Seeing none, Kate, thank you for joining us and your continued work. Enjoy your evening.
There are children waiting to testify. Their numbers 200, 201, and 202. And they're really the experts on this matter. So if we can get the children to testify, that would be great. Thank you.
Kate, I'm trying to get us through. So
Thank you.
Next we'll hear Marie Jurgens. Marie.
Yes.
All right, you may testify.
Senator Winfield and members of the Judiciary Committee, thank you for letting me speak. My name is Marie Jurgens. I'm an East Hartford resident, and I am an activist in Connecticut, Power Up Manchester, and Power Up East Hartford. I am writing, along with, I agree with the Connecticut Justice Alliance in support of SB 387 and SB 392. And I'm writing and speaking in strong opposition of SB 365, SB 388, HB 5418, HB 5417, SB 386, and SB 16. I am testifying in opposition to these bills I listed because they are rooted in the false claims that Connecticut is experiencing tremendously high rates of crime being committed by youth. This is simply not supported by data. This crime rhetoric is being used by some legislators and groups such as Safe Streets to push fear and push for reforms that in the end will result in more Black and brown youth and low-income white youth being involved in the juvenile justice system. Organizations such as Safe Streets only promote racist dog whistles and white supremacy. They have not provided any real solution for issues related to crime in our state. This issue is important to me because in working with Corinne Prescott, CEO of Power Up Manchester, I have seen firsthand the difference made when adults invest their time and energy into improving the lives of children. Organizations like Power Up create real opportunities for children and teens to thrive on a limited budget reliant on donations. Corinne Prescott identified that children in Manchester needed not only safe spaces, but also mentoring and engagement that boosts them physically and mentally. Legislators should take note of the success that Corinne Prescott has already had in 1 year with her Empower You program through Power Up and ask themselves, 1, how can I assist her in getting more financial support? And 2, how can we create, support, and sustain programs like this across the state? We should be looking at ways to prevent crime, not incarcerate children. Preventing juvenile crime starts with investing in the needs of our youth. I urge you to support SB 392 and 387 with the recommendations submitted by the Connecticut Justice Alliance. And thank you for the opportunity to testify today.
Thank you. Comment or question from members of the committee? Comment or question? Seeing none, thank you very much for joining us this evening.
Thank you.
We'll next hear from Mark Chimbolo. Mark Chimbolo, followed by Steve Jagodzinski. Steve Jagodzinski.
Yes, I'm here.
I hope I didn't butcher your name.
It's close enough. Thank you.
You may testify.
All right, thank you, Mr. Chairman, members of the committee. Appreciate you allowing me to participate today. My name is Steve Jagodzinski, and I only wish to make a brief statement today. I'd like to have my voice heard, and it's certainly nothing new that you haven't heard already in this long session. I will be speaking in opposition of SB 16. I currently live in Stamford, and I am a law-abiding, lifelong Connecticut resident, and I absolutely oppose SB 16. This bill is broadly written to punish law-abiding citizens and sportsmen and does nothing meaningful in its goal to prevent crime and violence perpetrated by those who violate our existing laws. It's a person that is responsible for committing crimes, not an inanimate object. Again, something that has been touched upon by many people throughout this testimony today. I oppose revising the assault weapons ban to include pre-1994 rifles with certain features and firearms classified as others. This does nothing more than create hardships for potentially tens of thousands of law-abiding Connecticut gun owners and possibly turning them into felons simply by not registering their firearms in time. I also oppose the creation of gun-free zones on public transportation. This is incredibly discriminatory to low-income residents. And it's actually quite shocking that this has been presented. Those who cannot afford their own car and rely on it for basic transport are effectively being classed out of the ability to carry when they like. That's all I had to say. Thank you for your time.
Thank you, Mr. Jagodzinski. Representative O'Day.
Thank you, Mr. Chair. Just real quick, thank you, sir, very much for your testimony here late as the newest Stamford rep coming up. I just want to thank you for gutting it out. Thank you. Thank you, Mr. Chair.
Thank you.
Thank you, Representative. Comment or question from other members of the committee? Comments or questions? Seeing none, thank you very much for joining us this evening. Next, we have Dimitri Golobayan. Dimitri Golobayan. Cindy Prisio. Good evening. You may testify.
Hi, good evening, Senator Winfield, Rep. Staffstrom, and all esteemed members. My name is Cindy Prisio, and I'm Executive Director of One Standard of Justice, an organization that stands up for fair and equitable treatment of those in our community burdened with great stigma and injustice. We support people, not crime. One of the things I just need to say quickly is I had a visceral effect here today by hearing so many people use labels rather than person-first language. If not for valuing all human beings for no other reason, why do we call someone what we don't want them to be? I'm here to show very strong support. SB number 387, an act concerning the recommendations of the JJPOC, and SB 392, an act concerning statements made by juveniles. We oppose all other bills. I'm also here to support the work of the Connecticut Justice Alliance and the JJPOC. While I oppose SB 16, the only redeeming factor, which Jeremy Stein shared earlier, is Section 33, Gun Reduction Strategies, Prevention, Intervention. And here I'd strongly suggest restorative justice as a solution for harm reduction, real accountability, changed behavior, and healing for individuals, families, and communities. I personally am appalled at the thought of incarcerating any of our children or adolescents. So oppose transferring anyone under 21 to adult courts, let alone a 13-year-old. Unlike what was shared by Representative Devlin, it is most definitely unnecessary to auto-transfer certain offenses, including sexual assault, to adult court. Two things: neurological research states impulse control and decision-making controlled by the brain doesn't mature until 25 for a person with quote-unquote average trauma. For adolescents with much harm and trauma in their early lives, that age can easily go up to 30. We should be asking our young people not what you did, but what happened to you. Youth crime, this is number 2, follows the age-old trajectory called the age crime curve. You probably know it better than I. The majority of adolescents will naturally age out of criminal behavior or desist. There are things that can promote aging out or halt it so the behavior continues into adulthood. Of course, we're all responsible for elongating that curve. And arrest or incarceration creates more anger, shame, resentment, especially when the youth feels the systemic biases and injustice, especially our children of color. Arrest or incarceration exposes our youth to others with deviant behavior, lack of resources, so individuals don't get what they need. And it triggers mental health issues, including stress, anxiety, and depression, or exacerbates existing undiagnosed mental health issues.
Time has elapsed, if you can summarize.
Okay, I'm saying in short order that the JJPOC's recommendations of last year were over the top good. I say bring them back. Instead, we whittled them down. And we must stay the course when it comes to juvenile justice reform. Follow our hearts and the data to a better Connecticut. Thank you.
Thank you. Comment or question from members of the committee? Comment or question? If not, Representative O'Day.
Just real quick. Hi, Cindy. As always, feel free to reach out. I appreciate your testimony. Thank you, sir.
Well, coincidentally, Representative O'Day, I do need to talk to you, so I will be reaching out tomorrow. Thank you so much.
I'm not sure we're gonna be done tomorrow, but we'll see. Thanks.
Yeah, or the next day. Okay. Good luck to all. It's great that everyone's hanging in. Thank you.
Thank you for joining us again, Ms. Prizio. Enjoy the rest of your evening.
Thank you.
Next, we'll hear from Robert Izzy.
Yes, Easy.
Easy. Yes, sir. You may proceed.
Good evening, distinguished members of the Judiciary Committee. My name is Rob D.C. Jr. I'm the president and founder of Central Connecticut Arms in Portland, Connecticut. I'm also a U.S. Army veteran, husband of 27 years, and father of 4. I've held a pistol permit for over 38 years. I'm also a federally firearms license holder. I'm here tonight to strongly oppose SB 16, also HB 5416, and I'm here to support SB 388, HB 5415, and HB 5412. 46 pages of this 54 bill. Let me back that up. We're going to go back to the first one, which is SB 16. 46 pages of this bill. 88% of it calls for gun control, gun bans, gun registration, more gun-free zones, and limits on how we and where we can carry our firearms. Law-abiding citizens of Connecticut Gun owners are not the problem nor root cause of violent crimes in the state. As a Connecticut business owner who employs 8 people and whose families are supported by their employment, this bill will have direct loss of revenue for my business, which in turn will result in layoffs due to the loss of revenue. It will also cause people to not be able to defend themselves, adding additional gun-free zones, which, as testified today, have been proven to be ineffective. I am in the process of building a 54,000 square foot all-inclusive destination-style facility in Portland that would not only employ approximately 20 people, but draw in customers from the tri-state area with the archery, axe throwing, and restaurant, in addition to the firearms training and retail and range operations. The additional yearly sales tax revenue would be over $500,000 to the state of Connecticut. So I question you, why would I want to continue to invest almost $7 million of my money into a project in Connecticut to be legislated out of business due to ineffective, unconstitutional gun laws that have little to no bearing on crime? These proposed laws would not only affect the rights of the citizens who have taken the time to legally own common firearms listed on this bill, including a criminal background check and state mandated training. The claim that homicide is at a 25-year high means that over the last 30 years, gun control didn't address the issue of crime. Maybe that has to do with the fact that our criminals do not obey the gun control laws, and criminals are not being prosecuted to the fullest extent of the law. Criminals are criminals because they do not follow the law. It's really quite simple. Enforce the laws that are on the books, prosecute criminals who commit gun crimes to the full extent of the law. Thank you for your time. Appreciate it.
Thank you, Mr. Peasy. Comment or question from members of the committee. Representative Kubitsky.
Thank you, Mr. Chairman, and thank you, Mr. Pizzi, for coming in. There's section 10 of SB 16 has rarely been discussed today, and I just wanted to get your views on it. That's the section that imposes a new state license on federally licensed firearm dealers. If you could tell me what that would mean to you and your business, appreciate that.
Well, being that we're already regulated by the federal government, and as has been testified earlier, we have to have a state permit to sell pistols and revolvers at retail, which is issued through our town. The additional need for oversight from the state police, which is severely underfunded as it is, can barely keep up with the permit applications, authorizations, and things like that. I'm afraid that would just have more of a negative impact in business. They wouldn't be able to oversight. Well, what would they do?
So it would be a third level of regulation.
Correct.
Do you see any gap in regulation between the federal authorities and local authorities that needs plugging?
No, not really. I mean, we follow all the federal laws that are laid out. Connecticut already has some of the strictest gun laws in the country, which all FFLs adhere to. Our number one duty as a store owner like myself is to make sure that firearms don't go into the hands of the wrong people. I take that obligation very serious, and we follow all laws, and we really keep an eye on that stuff.
And you're already you already need to follow state law with through the special licensing and firearms unit, right?
That's correct. Yes, we follow all the laws from the STFLU.
SLFU.
There you go.
I always get it backwards too.
There you go. Okay. But yeah, we do follow their laws and their guidance. We operate within those parameters. We conduct the background checks as required and all.
Has anybody from the state, whether it's the state police, SLFU, or anyone else, indicated to you what the purpose of this new state licensing scheme is?
No, I have not heard anything directly in regards to that.
Okay, nor have I. It would seem to me that 2 levels of regulation plus already involvement with the state on every purchase is more than enough for any business, and I just can't imagine what another layer of licensing would do to enhance public safety. But I very much appreciate your responses, and thank you for your testimony.
Thank you.
Thank you, Mr. Chairman.
Thank you, Representative. Comment or question from other members of the committee? Comment or question? Seeing none, thank you very much for joining us this evening and offering this testimony. Douglas Phillips.
Good evening, Chairman, Senators of the committee. My name is Douglas Phillips. I have a degree in countering anti-terrorism and national security from Trinity University. I have also assisted in being a volunteer for the armed security team of my church. I'm calling in today's testimony to be strongly opposed of SB 16. I do support SB 388, and I also oppose SB 5397. Gun control is not a public health crisis. It is something that responsible gun owners have been dealing with for quite some time in the state of Connecticut. It's no more saying that McDonald's French fries are a public health crisis because they cause high blood pressure. We're not going to get rid of any French fries in the state of Connecticut anytime soon. So why put restrictions on responsible gun owners who basically sometimes, as someone stated earlier, some of these lawful gun owners actually do competition for a living. So putting a ban on another firearm that's considered the other AR would restrict that person's lifestyle. Also, you need to impose stricter gun laws for criminals who are caught with these illegal firearms. You'll give someone who's dealing drugs life in jail, yet you'll give someone who's caught with a firearm that's not theirs roughly 5 to 10 years, contingent upon what the crime is. It's unconstitutional. I'm also not comfortable with being profiled, if you will, because I'm a licensed gun holder and I happen to drive by a police officer, and just because my vehicle happens to be a blacked out vehicle with factory tint, I may get pulled over and be asked for my gun permit at any given time, which I will lawfully hand over. But it's more on the lines of you're getting ready to profile the minorities in our great state of Connecticut. I am very aware of the situations that go around in the state of Connecticut. Someone earlier stated if someone were to, God forbid, walk into a public area and open fire, now we're going to be restricted on carrying in public places, where it takes statistically 911 anywhere between 3 to 15 minutes just to get to a specific location, depending on where you're at. So I just wanted to state that again. I strongly oppose SB 16. I do support SB 388, and I also oppose SB 5397. Thank you for your time, and I'm open for any questions that anybody has.
Thank you very much, Mr. Phillips. Comment or question from members of the committee? Comment or question? So now, thank you for spending your time with us this afternoon and evening. Enjoy the rest of your evening.
Thank you very much.
Next, we'll hear from Amber Belengus, followed by Elizabeth Drysdale. Amber Belengus.
Hi, can you hear me?
Okay, you may testify.
Okay, wonderful. Senator Winfield, Representative Stastrom, Senator Kissel, Representative Fishbein, and distinguished members of the Judiciary Committee. My name is Amber Belengus, and I'm a resident of Sherman, Connecticut, and a volunteer with the Restorative Action Alliance. We're a regional advocacy group made up of anti-carceral crime survivors, individuals who've been impacted by the criminal legal system, and restorative advocates and justice practitioners. I'm here today to testify in support of SB number 387, SB 392, and in strong opposition to SB 16, SB 365, SB 386, HB 5418, and HB 5417. While these bills purport to advance public safety, the ones that we are opposing, many of their proposed solutions have been proven to have the opposite effect. For example, the Center for Disease Control and Prevention has determined that a transfer to adult criminal justice system typically increases rather than decreases the rate of violence among transferred youth. And the U.S. Department of Justice concluded in 2010 that transferring juveniles to adult court for trial and sentencing has produced increased recidivism. I think we've heard these themes throughout the day, so I don't want to really beat it too much. But I just wanted to go on record that our organization believes that all people, particularly children, have value. We know that a safe society includes the opportunity for every person to be treated fairly and equitably, to be able to meet their basic needs and have access to the tools that will allow them to thrive. This includes investments in education, affordable housing, equitable employment opportunities, healthcare, and the like. We join the Connecticut Justice Alliance in emphasizing that youth justice policies must be based on data and research about youth development and delinquency to promote improved outcomes for youth, communities, and families. We must ask Connecticut legislators to enact solutions that put actual long-term safety of all of those living in our state over proposals designed to calm unfounded public fears caused by media sensationalism and politically motivated misinformation campaigns. We encourage members of this committee to take a look at the helpful facts and figures, as well as proposed solutions published by the CTGA. We ask this committee to report SB 387 and 392 favorably. We support the JJPOC, and we urge the committee to oppose all the other bills listed above and that I spoke about in my testimony for the reasons that we previously stated. Thank you so much for the opportunity, and I really want to thank all the legislators here tonight because I know it's been a really, really long day, and we are so appreciative of everyone who's taken the time to listen to members of the public about things that are important to them.
Thank you. Comment or question from members of the committee? Comment or question? So now, Ms. Melendez, thank you for joining us again. I'm sure we'll see you in the future.
Thank you very much.
For the rest of the evening. Elizabeth Drysdale.
Thank you. Thank you, members of the Judiciary Committee. I just want to throw my support behind. I'm sorry. My name is Elizabeth Drysdale. I'm the secretary of CCDL. I am also a firearms instructor, a single mom, and I reside in Cheshire, Connecticut. I support SB 388, House Bill 5415, 5412. I oppose SB 16 and House Bill 5416, and it's that last bill that I want to talk to you about. At the end of January, my father came home from the hospital with hospice. He has a rather large firearms collection, including some heirloom guns. And this bill will make it the lawful transfer of his firearms to me, his only child with a permit, after he passes is nearly impossible. I would have to find an FFL that is willing to store the guns until such time as I can transfer them one at a time. This would cost me hundreds of dollars monthly because there would be a monthly fee just like you would at a storage unit, and then it would amount to thousands of dollars a year. This bill has actually encouraged me to seek to transfer those ahead of time if possible. But I know that he was upset when I told him about this law and the fact that especially some heirloom guns could possibly have to be sold without any recourse, because if we cannot find an FFL that is willing to store them, which is a burden to them and to their business, we might lose them. I also wanted to share with you that a couple of years ago, I had the opportunity to purchase 3 consecutively numbered serialized revolvers. And I did this so that I would be matchy-matchy with my 2 daughters. We each have one of the firearms, the youngest will when she's eligible to own them. But it was a fun opportunity, and this bill will make that go away. This bill will also make it impossible for collectors in our state to have the opportunity to purchase things that only come as a collection, such as derringers, such as commemorative firearms where they're issued as a 45 and a 9mm set. And there is absolutely no benefit, no legal benefit to anyone having to wait to purchase a firearm for a month and only being able to do it one at a time. I'm really pretty upset about this because of the situation with my father. And
Ms. Drysdale,
yes,
your time has elapsed. If you could summarize, please.
thank you.
Thank you. Comment or question from members of the committee. Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Ms. Drysdale, for coming in. Each time somebody speaks about one of these bills, they seem to come up with a new reason why why this particular bill is misguided. And you've just nailed it with regard to box sets and consecutive serial numbers and things like that. Collectors thrive on that type of thing, on the box set with perhaps a rifle and a pistol together, with consecutive serial numbers and engraved, and some of those sets sell for tens of thousands of dollars to collectors, and I think you nailed it with that issue, and I appreciate your coming in and giving your testimony.
Thank you.
Thank you, Mr. Chairman. Senator Chicarella.
Thank you. And briefly, I just wanted to thank you, as Rep. Dubinsky stated. These hearings are so important so we could hear these reasons why sometimes legislation is good and bad, and the pros and cons and the unintended consequences. So I do want to thank you for waiting so long to share your story, and I hope your father is doing well. Thank you for taking the time.
Thank you very much.
Thank you, Senator. Comments or questions from members of the committee? Comments or questions? If not, Ms. Drysdale, thank you for waiting so long and providing us with your testimony. Please enjoy the evening. Next, we have Patrick Early. car is recovered, the car should have been totaled but wasn't, and it's still not been fully repaired after somewhere around 6 or 7 months. That's insult. And insured the vehicle takes and cancels the comprehensive insurance on that vehicle. And if anyone's familiar with the bank or the finance company, and now you have to either pony up the full value of what's left on the loan, or you have to surrender the vehicle. Think about that. Person, through no fault of their own, in their locked home, has a thief break in, grab the pocketbook, grab the keys, take the car on a crime spree. The car gets virtually totaled. Unfortunately, the insurance company didn't total it. The car is yet to be fixed, and they had their comprehensive claim, coverage, I should say, canceled. We were able to get that straightened out, only to have her husband have his comprehensive insurance canceled next. And that, I think, is almost resolved, but it took numerous calls, Connecticut unfair insurance practice complaint, and calls to executives at the insurance company to get it resolved. Regardless of what you do with the bills tonight, that language needs to be in some vehicle, some form, somewhere, because that's just not right. It's bad enough to be a victim of the juvenile crime crisis. It's worse when you get victimized a second and third time by your insurance company. I'm ready, willing, and able, and happy to answer any questions anyone may have. And I'm here to answer anything. Thank you, Representative. Comments or questions from members of the committee? Comments or questions? Seeing none, Representative Nicky, thank you for that offer. Perhaps we'll take you up another day. Thank you for being around to testify this evening. I thank you for the opportunity, and I hope you take the Section 18 to heart.
Thank you very much. Next we'll hear from George Harris. George Harris, be there.
Yes, Honorable Chair, Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee, good evening. I am Reverend George Harris, and I am speaking in support of SB 387, SB 392, and I am speaking in strong opposition to the following: SB 365, SB 388, HB 5418, HB 5417, SB 386, and SB 16. I testify this evening as the senior minister of First Church of Christ in Simsbury. I have lived and served in Simsbury with my family, my wife, and 19-year-old daughter for the past 6 years. I also represent the Greater Hartford Interfaith Action Alliance, or GIA, the organization comprised of dozens of faith communities working for justice in the Greater Hartford area. I understand that the bills I oppose are ostensibly meant to restore public safety in response to an alleged spike in juvenile crime, particularly car thefts, especially in suburbs like Simsbury. As a minister, of course, I care about the safety of my congregation and my family. But as a minister, I also care about the truth. Every Sunday when I get up to preach, I have to give careful thought to representing the issue I am speaking to as correctly and honestly as possible. If I fall short, if I get it wrong, I will lose credibility in my members, and I can hurt the very people I claim to serve. In this case, if we get our juvenile justice policies wrong, we will hurt some of the most vulnerable people in our communities, Black and brown children. And I have reason to believe that much of the information being shared about juvenile crime in our suburbs and towns is at best misleading and at worst is being manipulated to target the very children that our Connecticut juvenile justice system is designed to help. I worry that perspectives being shared to support a get tough on juvenile crime approach are long on frightening anecdotes and short on an honest reporting and interpretation of the data. Mine is a congregation with many people who work in the insurance industry, actuaries and the like. While a sincere community of faith, mine are also a data-driven people. Numbers and their interpretation matter. Now, every month, about a dozen Simsbury clergy meet together to compare notes about what is happening in our churches and synagogue and in our Simsbury community. Last Thursday, we were joined by Simsbury's police chief, Nicholas Bolter. Chief Bolter visits our meeting about once a year to provide an update from his perspective and to respond to our questions and concerns. I have come to know Chief Bolter as a very fine man of great integrity, and he is well respected in the community. We asked Chief Bolter to speak to us about car thefts in Simsbury. He acknowledged the concern,
Mr. Harris,
saying that, yes.
Your time has elapsed. If you could make your point, summarize.
I will indeed. Chief Bolter acknowledged the increase in car thefts in 2019 and 2020, but said the number came back down in 2021. In fact, he said that after seeing numbers in the 20s in the previous 2 years, 2021 numbers were back in the single digits, much more consistent with pre-COVID numbers. Chief Bolter said such a decrease is representative not just of Simsbury, but of the region, and suggested that the bump had been COVID related, and that he expects a return to more typical levels this year and in the future. So I think that that is not consistent with what the rhetoric I've heard, and I would just like to offer that in response.
Thank you very much. Comment or question from members of the committee? Comment or question? Thank you very much for joining us to offer your testimony. Stick around. Enjoy the rest of your evening.
Thank you. Thank you so much.
Next, we'll hear from Barbara Fair.
Hello. Well, you can't see me. My camera's on.
I don't know, but we can hear you. So
you can hear me? Okay, that's good enough. Okay. Hello, my name is Barbara Fair. I'm a mother, grandmother, and great-grandmother, and a licensed clinical social worker, and a West Haven resident voter, and a longtime advocate for equal justice. Good evening, members of the Connecticut Judiciary Committee, and thank you for allowing me this time to speak. I've been on since 10 o'clock this morning, and so I heard a lot of rhetoric around, a lot of themes around criminals and lawful gun owners. So before I go on, I wanted to say that I'm here in support, some concerns and oppositions to Senate Bill 16, 365, 386, 387, 392, and House Bills 5417 and 5418. I submitted written testimony that will actually tell you what I found was concerned, what I support, and what I was opposed to. So I won't take up time with that. I just want to talk about some of the stuff I heard today. I heard a lot about, like I said, criminals and lawful gun owners. I was thinking about lawful gun. One of the first things I was thinking about with a lawful gun owner was George Zimmerman. And there's been many cases like his, but Trayvon Martin came to mind. This young kid who was walking home from the store with a hoodie and was shot to death because the legal gun owner, Mr. Zimmerman, believed that Trayvon was up to something. And so those are the scenes that I'm always worried about, because someone thought somebody was up to something because of the way they looked, that they get to shoot them dead, and was not, I mean, he was prosecuted, but he was found innocent. So I worry about things like that. Another thing, I heard a lot about criminals. The reality is our young people are not the only criminals that we need to be concerned about. We have criminals among police, legislators, corrections, all levels of government, even our state's attorneys. But I'm sure we're not talking about those people when we talk about criminals. Another person I consider a criminal that we won't be talking about is this wealthy family from Greenwich, the Sackler family, who manufactured and distributed highly addictive drugs with the cooperation of highly intelligent medical doctors who wrote prescriptions, causing the opioid crisis that thousands have lost their lives, yet not one person's going to jail. We actually protecting them from any civil lawsuits, yet they contribute to the deadly poison across this state and did not face any criminal charges. No one's going to be prosecuted, convicted, or sent to jail, but yet our prisons are full across this nation with people who did this very same thing, sold drugs. So I'm going to end it there because I know my time is up. But I do want to summarize and say Robert Goodrich gave us the solution, and all we have to do is listen to him.
Thank you. Representative Porter.
Thank you, Mr. Chair, and good evening, Ms. Barbara. Thank you for hanging in there.
Hi, how are you?
I'm well. How are you?
I'm tired, but I hung in there.
Yeah, we all are. Thank you for hanging. As a licensed clinical worker working closely with young people in an urban center, what do you see? What do you see as factors in reducing youth crimes such as car theft and gun violence, and how do you think we can effectively address it equitably as well?
Yeah. Well, as far as car theft, I remember car theft happening way back when my kids were little. So I don't know about the increase in car theft, but I do know that just recently I heard Lieutenant Governor state that car theft was down. And I've been hearing that in a lot of data reporting. So I'm not really sure why we're spending a whole lot of time on something that seems to be decreasing. Around gun violence, that's something that's going to take a lot, because what I see in our community are kids who feel disconnected. They don't feel safe themselves. I mean, there's a lot of kids that carry guns, not because they'll ever shoot anybody or because they're part of a gang or any of these narratives out there. Some kids just carry guns because they don't feel safe and they don't feel like the police are going to protect them. So they carry a gun just like a legal gun owner carries a gun. It's about their own safety. And so I see them, I see safety and security very important for young people, a sense of belonging, feeling connected, being in a healthy environment. And a lot of these things are not happening for kids that I see in the urban centers. I see a lot of trauma that goes untreated. And people should understand trauma is like a psychological wound that depending on how early they face that trauma, it could have long lasting effects. And a lot of these kids have been in violent environments in their homes, on the street, in schools. And if violence becomes a way of their life, like America, that's American way, if we want to be honest. Violence is as American as apple pie. So we're not going to rest ourselves out. We as adults have to start doing the work and start modeling what we want to see our kids. Right. I mean, I'm 73 years old. I've never had a gun, never cared about having a gun. I felt safe. The only time I didn't feel safe is when I was in an environment where there was a gun. So a lot of the stuff around SB 16, I didn't even pay attention to, but it wasn't of concern to me. But what was that I liked at SB 16 is that the governor at least is making an attempt. He's not doing it the right way, but he's making an attempt to provide some kind of funding for organizations that are going to provide preventative and intervention. And I think that's very, very important, as opposed to throwing our kids away. Let's start providing some of the resources that they need so they can be better.
I appreciate that, Ms. Barbara, and I can certainly relate. I spoke earlier about how my son was, robbed at gunpoint at a bus station, waiting on transportation twice while he was in high school. And What I didn't state is that, he did feel a need that he needed to get a gun to protect himself for the same reason that you just stated. And, he wasn't from the streets. He had a BB gun, and he could have lost his life out there, with a real gun too. Don't get me wrong. Right. I mean, it was a BB gun, but that's the kind of pressures and the real life issues that we're dealing with on top of that trauma. So thank you so much for hanging in there tonight and being with us and sharing those experiences. And I thank you, Mr. Chair, for the opportunity.
Thank you.
Hold on. Sorry, I gotta do it again. Comments or questions from other members of the committee? Comments or questions? If not, Barbara, thank you for hanging out with us today. It's been a long day. Thank you for your 3+ decades of advocacy.
Thank you. Good night. Well, no, I'll stay hanging here a little longer.
All right. Well, let's hear from Marty Isaac.
Thank you. Good evening. Senator Winfield, Representatives Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Martin Isaac, and I live in Trumbull, Connecticut. I'm a board member with Connecticut Against Gun Violence, and I'm here today to speak in support of that part of SB 16 that directs the Office of Injury Prevention within the Department of Public Health to create a gun violence intervention and prevention program. Over the years, this legislative body has passed strong gun laws to protect the populace, and it's worked. As ranked by the Giffords organization, Connecticut is ranked 3rd in their gun safety index and 45th for gun death rates per capita. That is not a surprise. Strong gun laws yield lower death rates. And while on a comparative basis that sounds good, last year, gun homicides in our state were the highest in 25 years, nearly double the level in 2018, and this brutal carnage demands a response. The primary issue we need to address is the violence in our cities. It does not often make the news, but day after day, month after month, our city residents are terrorized by shootings and death. The sad fact is, it does not have to be this way. Years ago, we did not understand how to stop violence in our cities. Carnage was unanswered because seemingly there were no answers. That is not where we stand today. Connecticut needs to invest in intervention and prevention mechanisms, evidence-based programs with a proven record of success. These programs work because they are aimed at individuals at high risk of perpetrating or being victims of gun violence in high violence communities. We need to have the will to put resources and structure in place to put these solutions to work here in Connecticut. Many of you in this room are familiar with one of these programs, Project Longevity. The good news is that there are additional programs that are even more effective. Hospital-based violence intervention and violence interrupters have a proven track record of reducing gun violence. We have a moral calling to act. Financially, it's equally compelling to act. It's estimated that gun violence of all kinds costs Connecticut taxpayers between $60 and $90 million annually. Every dollar invested in saving lives saves money too. It's time that Connecticut puts into place an evidence-based mechanism to deploy resources to save lives. While I commend the governor for directing DPH to establish a gun violence prevention and intervention program and for allocating $3.6 million from the ARPA fund for the program, I urge the legislature to establish an Office of Gun Violence Prevention in the DPH and to permanently fund this initiative as proposed in HB 5397. I appreciate the opportunity to testify today.
Thank you very much. Comment or question from members of the committee? Comment or question from members of the committee? Seeing none, Mr. Isaac, thank you very much for joining us this evening.
Thank you.
I am told that for the Zoom that we're on, we need to take a slight break and reset since we're going over 12 hours. I believe that is correct.
Yeah, just a moment.
So we're going to recess at this point and then come right back. So we'll be back shortly. Deb, let me know. Deb, let me know we're ready to go.
Okay. Okay, we're all set.
All right, we will reconvene the committee. Slight pause there. Next, we will hear from Lynn Dawson.
Hi, my name is Lynn Dawson. I'm a practicing attorney and I live in Cheshire, Connecticut. And I just want to thank everybody. I thank the committee for being on, listening to everyone for, I think, for 12 hours now. So I just want to start by saying that I understand why this committee and why the public at large might think that the answer to crime is incarceration or tougher penalties, but I just want to tell you that it's not. That's really not the answer in the long term or in the short term. I have worked in the criminal justice system for over 30 years, and I've worked in the juvenile justice system for more than 20. Few people within the Department of Correction are actually corrected. In fact, I think in Connecticut, the recidivism rate is close to 40%. So people that go through the Department of Correction do not typically reemerge into society a better person. They reemerge into society a felon, a person with a criminal record. They're often unable to find a job. They have very few job skills. They're unable to access student loans or get access to housing assistance. People that go through the Department of Correction leave with very few resources to allow them to thrive or become productive members of society. I'm saying that because we don't want to put our juveniles there. The juvenile courts have tools and they have resources that the adult courts and the prisons do not have. They have resources that can bring about change in an adolescent, in a family, and in a community. They can make referrals to counseling, to therapy, to mentors, to parenting programs, and also to other diversionary programs. The juvenile court's entire system is designed to bring about change, to correct behavior, and to set these young people on a path towards being contributing members of society. Does it always work? No, probably not, but our young people deserve that chance. They deserve that chance. Science tells us that the human brain does not fully develop until the mid-20s. The last part of the brain to develop is the prefrontal cortex. I know you've heard testimony about this today. That area of the brain is responsible for the inhibition of actions based on impulse, desire, and emotion. This is the part of the brain that says, stop, walk away, don't overreact, take 10 seconds. Adolescents act on impulse and emotions, primarily because that part of the brain has not developed. I just want everyone to ask themselves, think back to when you were 13, 14, 15 years old. Did you ever make a mistake? I did. I'm sure you did too, okay? And at 13, 14, 15, we were just learning about the world. We were learning about what our role was. It was hard to remember. It was hard to be an adolescent. Our emotions were intense and unpredictable.
Ms. Dawson,
I just want to say, I don't think our young people should be forever defined by decisions they made when they were 14. They should not be penalized. They should be kept in the juvenile court. We shouldn't saddle them with felony convictions, and there should be no automatic transfer to adult courts. They should remain in the juvenile court and in the juvenile court in the district where they live. Thank you.
Thank you very much. Comment, question from members of the committee. Senator Chikora.
Thank you. And through you, just a quick question. I appreciate your testimony, and it seems like you have a lot of experience in criminal justice, especially in the juvenile courts, based upon your testimony. I do agree that somebody should not be judged on one mistake they make in their life. I also have a fair share of experience both in law enforcement and in criminal defense work as an investigator, so I understand where you're coming from. But I ask you, with your experience, what do you do with somebody at the age of 15, 16, in that area that has already committed numerous violent crimes, and they're not going to these programs or following up with some of the resources that these juvenile courts may have. What do we do with those individuals that go out and continue to be violent in the community?
So here's what I think about the juvenile court is that that we need to have, first of all, we need to have judges there that understand juveniles, that understand the law and have the discretion to make decisions based upon individual cases. Are there going to be kids that are going to go into the system and we're going to provide them with services and it's not going to work, and we're going to provide them with more services and it's not going to work? There are going to be kids like that. There are people like that. That's just the way it is. But that's not everybody. And I think what I don't like particularly about House Bill 5418 is the automatic transfer idea. I think it shouldn't be based upon the crime necessarily, but about the individual. If you haven't, I think every young person should have the opportunity to be corrected, to make some changes. Maybe they need some services, maybe they need some therapy, maybe they need some counseling, and maybe they need a mentor. They should have the opportunity. So if you have, in the scenario that you just gave, you have a young person who's maybe already been through all of those services, been through everything. We've thrown every service we have at them. That's a different. I think that now you're dealing with maybe. I mean, depending on the age, depending on the crime. I'm not. Do I think any child under the age of 18 should be transferred to the adult court? I mean, in my perfect world, no. But I think that there are going to be some kids that are not going to benefit from. That there's a limit to how many services you can get. Well, my concern is that we don't treat every child the same. We don't base the decisions. Obviously, if we're talking about A felonies, that might be different. But we can't. We have to look at each child as a child. We have to be able to address services to meet their needs, to give them the opportunity to correct their behavior. If that doesn't work, if after a year of work of providing those services, 2 years maybe of providing those services, it looks like that's not going to help, there isn't going to be a change, then we make a new decision. And that's why we need to give the judges discretion, because they're the ones that are there making those decisions, seeing those families and dealing with those issues. And I hope that answered your question.
It did. Thank you very much for your time today.
Thank you for yours.
Thank you, Senator Chicarella. Comment or question from members of any comments or question? If not, thank you very much for joining us this evening. Representative Stastrom.
Thank you. Next up will be Erica Bromley, followed by Leanne Neal.
Senator Winfield, Representative Stafstrom, Senator Kissel, Representative Fishbein, and members of the Judiciary Committee. My name is Erica Bromley, and I'm the Juvenile Justice Consultant for the Connecticut Youth Services Association. I'm here today to discuss several bills. My full testimony has additional information, but I'll just highlight a few areas. I'm speaking in support of SB 387, an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee, but I'm also in general opposition to bills 5418, 365, 5417, 386, and 16. As a member of the JJPOC and chair of its diversion committee, I'm in support of the recommendations approved by the JJPOC in Senate Bill 387. The pre-arrest diversion language for first and second time offenders for specified low-level offenses will allow for more youth to stay out of the juvenile justice system and also decrease disparities. The best way to prevent future arrests is to stop the initial arrest from occurring in the first place. Diverting youth before arrest can minimize recidivism, and youth are 2.5 times less likely to reoffend. Youth who would be referred for pre-arrest diversion through this bill will be referred to the juvenile review boards utilizing the community-based diversion system. One language adjustment in this bill that does need to be made is the correction of the date of the second piece of the recommendation takes effect. It should read January of 2023 instead of July of 2023. Another key recommendation in this bill is in regard to funding the expansion of the community-based diversion system. The language is less specific than the language that was approved by JJPOC, and I encourage you to make adjustments to that language to include the specific language that was approved. Regarding opposed bills, what continues to be the case is that root causes are not being identified and addressed. Without addressing those, behaviors will not improve. Effort needs to be placed on earlier intervention and provision of services targeted to individual needs. Additionally, recommended language in SB 365 calls for the creation of trauma, truancy, mediation, and mentorship program, which is duplicative of the current efforts, including the Youth Service Bureau system, which is statutorily based and has been in existence for 50 years. The community-based diversion system, codified in statute in 2018, identifies YSBs as a community hub in each community. Efforts have been and are currently in place regarding programming and services in the areas of trauma, truancy, mentoring, and more. YSBs are now responsible for truancy cases since their removal from juvenile court jurisdiction. Instead of creating duplicative programming, more support needs to be given to address the current state of crisis. No system is perfect, but you must know that in Connecticut, we have made great strides in juvenile justice reform over the last decade. Instead of rolling back reforms, we need to identify and address gaps and weaknesses in the system, adequately resource our providers, and continue to utilize data and research to make informed and smart decisions. We know that the pandemic, job loss, school engagement issues, and increased mental health issues have had impacts on our young people and their families. This is not the new norm. This is a reaction to horrible circumstances that many have experienced in the last 2 years. Instead of dismantling our system, it needs to be built up stronger and better. What is missing is the individualization of services for our young people. There needs to be more options of programs and services, more programming proven to work, expansion of current programming with positive outcomes, and actual investment.
Ms. Bromley, we're at the
like 3 words, yes. Investment in the lives of our young people. That's all I had.
Great. And I know you said we have your written testimony, which is good.
Yes.
Questions or comments, Representative Porter?
Thank you, Mr. Chair. Eric, I just wanted to thank you for your testimony and hanging in there all day with us today. I know you've been here all day. No questions, just really wanted to express my gratitude. Thank you, Mr. Chair.
Thank you, Representative Porter.
All right, Leanne Neal will be next.
Leanne is joining right now.
All right, let's go to Emmy Wheel.
No, I'm here. It just took a while for.
Okay. All right, go ahead, ma'am.
I've been here all day. So, good evening, Chairman and members of the Judiciary Committee. My name is Leanne Neal. I'm an attorney with the Center for Children's Advocacy, CCA. I have submitted written testimony. I hope that you take the opportunity to read that testimony. But tonight I will focus my verbal testimony in support of SB 387 and in particular sections 4 and 5. CCA fully supports this important and comprehensive bill, which will result in substantial and necessary improvements across Connecticut's juvenile justice system. A variety of stakeholders across multiple groups, many of which include our organization, contributed to the development of this bill, underscoring its importance and legitimacy. The Alvin W. Penn Racial Profiling Prohibition Act prohibits racial profiling by law enforcement in conducting traffic stops and mandates the collection of data on traffic stops to provide oversight and accountability and ensure that police departments are not engaging in discriminatory patterns in the stop, detention, and searches of drivers. While the Penn Act has provided insight into law enforcement practices that disproportionately impact people of color, this view is limited in that it omits a significant portion of the population, those who are stopped by law enforcement while pedestrian on the street. By providing oversight and collecting data only on traffic stops, this creates an almost entirely adult-oriented view of potential racial profiling by omitting any review of stops that impact youth under 16 or youth and adults who do not drive. This limitation also gives a skewed view of racial profiling that takes place in many impoverished communities as a whole, as it does not factor in individuals who cannot afford a car and the fees associated with having a car or do not drive, yet have encounters with the police. This shortcoming in the scope of the Penn Act has a particularly detrimental impact on our young people. Substantial qualitative evidence gathered from our work exhibits that many youth in Connecticut, especially in our urban centers, most often encounter law enforcement as pedestrians rather than as drivers. At present, the state collects absolutely no data to measure whether racial profiling and disproportionality exist in these stops, nor do the other provisions and protections of the Act extend to these young people. Amending the provisions of the Penn Act, this legislation will extend the racial profiling data collected on all stops initiated by police, including those initiated by pedestrians. It is important to note that a number of other jurisdictions currently collect data on pedestrian stops, including Boston Police Department, the New York City Police Department, the Metropolitan Police Department of the District of Columbia, California, Colorado, Illinois, Oregon, the Milwaukee Police Department in Wisconsin, as well as Madison County Sheriff's Department in Mississippi. So CCA does support the passage of SB 387. We encourage amendments to include a multi-year implementation plan of expansion of youth services and the funding of community-based diversion systems. We also ask the committee to include language to pilot 9-1 data collection in opportunity school districts. We strongly support the recommendation to include voting members of the community expertise work groups on the JJPOC. Without voting rights, our youth voices feel inauthentic and tokenized. And I also would like to state that we did have some students who had signed up to testify. Unfortunately, it is late, so that you probably will not be able to hear from them. I would ask that you please take the time to read their written testimony, as their perspective is more important than mine and all of us here, as this all pertains to them. I thank you for your time and attention to these issues. Thank you.
Thank you, ma'am. And yes, I do regret, obviously, as we are 12 hours into this, I'm sure folks have unfortunately dropped off because this has dragged on. I see no questions or comments from the committee, so I appreciate you sticking with us. Next up will be Emmy Wheel.
Hi, my name is Emmy Weil.
Emmy Weil.
I am in favor of HB number 5418, as well as any other bill that will slow the rate of dangerous crime in our communities. We've got a 10% blight on society committing serious and repeated crimes who cannot be rehabilitated. Let's stop the bleeding so our youth can have a chance. Some kids need to be taken off the street for everyone's benefit, even the criminals themselves. While these individuals are in custody, we do have to make an effort to rehabilitate them. If you don't stop this bleeding, you will just have more victims of crime and victims of the system. You will be a crime enabler. Locking them up only solves the problem for a limited period of time. The homes and neighborhoods where those kids live are dysfunctional and breed more criminal behavior. They don't provide support and nurturing every child needs when growing up. These neighborhoods need funding and support. We are paying close attention to how our legislators are representing us on the issue of public safety and safety for these juveniles. I see a crisis situation, a public safety emergency. Proposed changes would not only protect citizens, potential crime victims. Not much is being said about victims during this 12 hours. Thank you, Marissa Boots. I've got to say that. They would help identify and address the child's needs at an earlier point and prevent the child from going down the path to juvenile delinquent and on to career criminal. They need intervention. Getting the kid before a judge sooner so any immediate issue could be identified and addressed earlier would give the judge more flexibility regarding the immediate need to place the child in a detention facility. It allows various agencies to share information and ultimately to protect innocent citizens. There have to be consequences for their actions. There have to be alternatives to incarceration because that doesn't work. People need to feel that they are accountable to be productive members of society. These juveniles need training programs to develop a sustainable future. That is what they are missing today, a chance to be employable and contribute to society, a sense of purpose. Let's put more resources into offender prevention rather than offender rehabilitation.
Thank you. We're at the 3-minute mark.
I could say one more sentence?
Sure.
So instead of passing laws that save offenders from drowning in a life of crime, to paraphrase Desmond Tutu, we need to go upstream and stop them before they fall in.
Questions or comments from the committee? Seeing none, thanks for being with us. Karen Edwards, Amy Cohane. Amy Cohane, go ahead. You're on mute, ma'am.
I can't believe I was that person. Sorry, you've had a long day. Senator Winfield, Representative Staffstrom, ranking members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Amy Ford Cohen, and I'm from Riverside, Connecticut. I've been a lifelong supporter of sensible gun laws that keep firearms out of the hands of those who could harm themselves and others. I've been an executive board member of CAGB for 4 years. I'm testifying in support of the provision in SB 16 that directs the Office of Inquiry Prevention within the Department of Public Health to create a gun violence prevention and intervention program. Gun violence is an urgent public health crisis. Last year, gun homicides were the highest in 25 years, nearly double the level in
That's because
2018.
they've been the lowest in 25
The disproportionate
years.
number of victims of color is a tragic reflection of our state's racial inequities. We need the state to invest more in evidence-based intervention programs that interrupt and de-escalate cycles of violence to save lives. The governor's proposal is a good start, but the legislature can strengthen it. It should allocate more dollars for community-based programs and ensure there's a dedicated staff in the Department of Public Health to support the effort. I also support the other provisions in SB 16, including establishing a gun tracing task force to stop the flow of illegal guns, requiring registration of all ghost guns, creating a state license for gun dealers to ensure compliance with state laws, tightening regulations for carrying guns in public, and making domestic violence convictions an automatic disqualifier for carrying guns in public. There are a number of other bills that I'm supporting and others that I'm proposing. I just want to cut to the chase and say we know violence intervention programs work. I urge you to support SB 16. Thank you.
Thank you. Questions or comments from the committee? Seeing none, thanks for being with us. Lauren Ruth.
Good evening, Representative Staffstrom, Senator Winfield, Senator Kissel, Representative Fishbein, and the esteemed members of the Judiciary Committee. My name is Lauren Ruth. I'm testifying today on behalf of Connecticut Voices for Children, a research-based child advocacy organization working to ensure that one day Connecticut is a thriving and equitable state where all children achieve their full potential. We've submitted the kind of very lengthy testimony you've come to love from us. The testimonies in opposition to the changes in the laws governing youth criminal legal system in Senate Bill 16, 365, 386, House Bill 5417, and 5418. Our written testimony is also in support of Senate Bill 387 and 392. For the sake of time, I'm just going to share a general position, and I'm happy to answer questions after that. As a state and country, we can do a lot more to support our young people thrive, and then by extension, their communities thrive. We need to support our youth and their families by providing healthy food, safe housing, education, and gainful employment. We must also provide our youth with mental health resources and substance use prevention and treatment to ensure that they do not become involved with the criminal legal system in the first place. This is because once young people enter the criminal legal system, it becomes a maze to get out of, and that ultimately gets them stuck there. It's even more so when young people enter the adult criminal legal system, where having a permanent record creates dead ends to securing safe housing, going to school, and finding a job. The pandemic has left our young people scared, lost, and alone. The pandemic has also made the context for social engagement a challenge, and social engagement is what weaves the fabric of community. Most young people learn social engagement skills from school, from friends, and from parents. And these interactions help to strengthen community ties and nurture decision-making abilities and problem-solving skills. But during the COVID-19 pandemic, without regular social engagement, the world has become unpredictable, uncontrollable, and lonely for most children. Responding to young people's mistakes with incarceration then increases these feelings of loneliness, anger, anxiety, and fear. All children and youth need stable routines and strong relationships to learn, grow, and thrive. And this is especially true during the developmental period of adolescence, when young people have been deprived of both over the last years. When we provide stable routines and community, paired with appropriate interventions such as restorative practices, credible messengers, intensive community-based programs, and wraparound family services, we help young people learn from their mistakes, increase public safety, increase community connections, and prevent problems down the road. Think of it this way. It's easier to ride a bicycle up a hill if you have multiple gears to shift when you need more help. If you only have one gear, it's a lot harder to bike up the hill.
And it's the same for youth regarding the criminal legal system. If we just use this one gear of incarceration, we're not taking advantage of the many other possible interventions that we know are effective, easier, and more equitable. Young people and families are suffering in the wake of a once-in-a-lifetime pandemic, and that's not a problem we can incarcerate our way out of.
Thank you, Ms. Ruth. Good job on timing. Questions or comments from the committee? If not, thanks for being with us. Christopher DeBella.
Yep, I'm here.
Go ahead, sir.
Good evening, ladies and gentlemen of the committee. My name is Christopher DeBella. I'm co-owner of Tobacco Valley Gun, a federal firearms licensee. I've been in the industry for 15 years, and I obviously oppose Governor Bill 16 and 5416. One thing that's been brought up all day, and I've been here since 10 a.m. like everyone else, is this whole thing with domestic violence and carrying a gun. If you look at the state DPS 67 form, if you look at the domestic violence, you cannot own a firearm. On the state 4473, it has the same thing. If you are convicted of domestic violence, you cannot own a firearm. I don't know why this keeps getting brought up, but one thing I'd like to point out is I understand that there's two proponents here. There's pro-gun and anti-gun people. We all have the same goal. No one wants gun violence. No one wants to have children die or anything like that. What I don't get is why don't the anti-gun people reach out to the gun stores? We are your first line of defense. Instead of passing a bill without talking to us, why don't you have a conversation? We are willing to talk to you. One thing that we have in place right now by federal law is something called straw purchases. If you are an ineligible person, you get a person trying to buy a gun for you, it is our job to stop it. And many gun stores stop straw purchases all the time. It's something that, again, I don't know why this doesn't get brought up more often. Earlier today, there was a guy named Norm that was a big straw purchase person. A gun store turned him in and got him arrested. The other thing on Bill 5416 about bulk firearms deals, every time a person buys two handguns within a 5-day period, we are required to report them to the ATF. And if someone doesn't have a job, or if someone's buying too many handguns, the ATF goes out there and investigates them. A lot of these laws that are being put into place are already in place. I just encourage people on the anti-gun community to reach out to the gun community, and maybe together we can actually work on something and maybe prevent gun violence and future situations. I don't think banning more guns is the answer. I'm open for questions.
Thank you, sir. Representative Bitsky.
Thank you, Mr. Chairman, and thank you, Mr. DeBella, for coming in. You mentioned a reporting requirement with regard to multiple handguns in a given period of time. Is that a federal law? Is that a
federal law?
Is it an ATF regulation, or is it
It's an ATF regulation. So every time a individual comes into our store and purchases 2 handguns within a 5 business day period, we are required by federal law to submit a copy of those 2 handguns or multiple handguns, depending on how many they buy, to the ATF for review. If the ATF, and I've seen it happen, if they find that a person may be straw purchasing, they pay a visit to their house. I will get and also the other thing too is that I don't understand is they talk about gun tracing. The ATF does gun traces. If a firearm is used in a crime or found, on the streets, we get a phone call saying, hey, where's this gun? What happened to it? And we have to submit paperwork to the ATF of where the gun went to. And at that point, they'll contact the customer and figure out how the firearm ended up on the street. So a lot of this stuff that people are talking about, I don't understand why no one else has brought up the fact that we have a lot of these regulations in place. And to me, I just seem like we're all battling for the same thing. No gun dealer wants gun violence. Gun violence does not help us. We are human just like everyone else.
And I know this might be a tough question off the top of your head, but do you happen to know the regulation number for that dual purchase reporting requirement?
I do not, but I could always send something to you in a further email. We've been in business for 6 years at our location. We work a lot with the state police, our local town detectives and everything. It's one of those things that just
such a common thing that we do. I actually never looked up, actually, hold on, my wife here just brought it. It was ATF form 3310.4. Is the report of multiple sale or other disposition of pistols and revolvers. And we also have to send that to local town police departments too.
Oh, you do. So you send it not only to the feds, but also do you send it to the state as well, or just the local police?
No, this when we sell a firearm, a customer is required to complete a 4473, which is a federal paperwork, and that's basically who they are, Social Security, things like that. Obviously, the questionnaire. When are you convicted of violent crimes? If they lie on that, the background check that the state performs kicks it back to us, and either the cops come out and apprehend the person, or they get denied, and we have to submit the paperwork for a potential other arrest for lying on a federal document. There's also a state form, which is the same type of thing. You know, are you convicted of domestic violence? Are you convicted of assault? Things like that, which all bar you from owning a gun. That goes with our 4473. And then there's a DPS form that is sent on every transaction to the state. So if you come into my store and buy a gun, I take your pistol permit. Everyone is required to have a permit either to handle a gun in our store. Again, we've had no firearms theft since we've ever opened. We maintain a very tight ship. And at that point, you have to have a background check done with the state, and I submit it that second to the state. So they have records of what you have, and everything is individualized with a special authorization number that the state provides us, including incoming firearms, which we also run a stolen gun check on.
Great. Well, I very much appreciate it. Obviously, it isn't as you know, just walk into a gun store and walk out with a gun. There's an awful lot to it, and a lot of people are under the impression that you can just go throw some cash on the table and walk away. It just ain't right.
Another thing I'd like to point out to everyone here, and again, this goes for the pro and anti-gun people, right before the COVID lockdown, we were actually in the Journal Enquirer for stopping straw sales. So that means that we were preventing guns from ending up on the streets, which is our job. If the state and the Fed send sting operations, so if you're a firearms dealer that is selling guns illegally to someone, they shut you down and arrest you. That is very common knowledge, and we've had 100% record. No one, like I said, no one in the gun industry wants gun violence. We don't support that.
Understood. Thank you very much for your testimony, and thank you for being one of the good guys. Thank you, Mr. Chairman.
Further questions or comments? If not, thanks, Ben Willis. Olivia Rinkus.
Thank you. Good evening, and thank you to the Judiciary Committee for the opportunity to speak. My name is Olivia Rinkus from Restorative, Connecticut. I'm testifying in opposition to several bills. I'm firmly opposed to Senate Bill 16, Senate Bill 365, House Bill 5392, House Bill 5417, and House Bill 5418. As a resident of Connecticut, I have serious concerns about these bills. Many suggestions in these bills, including pretrial GPS tracking and pretrial detainment of juveniles, prolonged solitary confinement of detained juveniles, pedestrian stops, the banning of firearms in public transport, the denial of a person who has served a prison term and then released the right to bear arms, and the prevention of a lawful firearm owner from expressing their First Amendment rights are all blatant violations of constitutional rights. I would like to add my voice to those who have already expressed concern that these infringements on civil liberties, and particularly those of minors, are not necessary for public safety. There are many serious flaws in the logic of these juvenile justice reform suggestions. Charging children as adults and placing them in adult facilities will not be doing anything to prevent crime, nor will it help the victims of violent crime in any way. All it does is take a juvenile who is already exhibiting red flag behaviors and put them in an even worse situation. once they are released, now with a permanent barrier to re-entering society as a productive citizen. Those who point to individuals who are beyond rehabilitation are simply pandering to the racist, fear-mongering rhetoric that has been used over and over again to prevent meaningful investment in things such as housing, education, healthcare, mental health care, and many other resources that would go a lot further to preventing violent crime than cycling people through the carceral system. For all of these reasons, I'm testifying in opposition to SB 16, SB 365, HB 5417, and HB 5418. I also do not believe police belong in schools, but until Connecticut takes steps to remove them from schools, I do not believe they should be armed, nor should their status as public servants give them the ability beyond that of average citizens to carry firearms into school spaces on or off duty. Therefore, I am also testifying in opposition to HB 5392. Thank you for the opportunity to speak.
Questions or comments from the committee? If not, thanks for being with us. Mark Anderson.
Thank you, Mr. Chairman, ranking members, members of the Judiciary Committee for hanging in there for our citizens and for letting me speak tonight. I'm Representative Mark Anderson of the 62nd District. I'll focus my remarks on opposition to SB 16, the governor's bill, specifically to sections 4 to 8 that seek to close loopholes in current law. This bill would prohibit so-called pre-banned assault weapons, as well as what are known as other firearms, which are not a rifle and not a pistol. We legislators take an oath to support the constitutions of the U.S. and of Connecticut. I expect we agree that keeping this promise is our primary responsibility. Contained in the U.S. Constitution is the phrase, "The right of the people to keep and bear arms shall not be infringed." The Supreme Court has held that this is an individual personal right. Our state constitution has stronger wording. Every citizen has a right to bear arms in defense of himself and the state. A colleague on this committee said to me, the right to keep and bear arms is not an unqualified right. For example, you don't have a right to keep a nuclear weapon in your garage. Well, I agree. But does this right extend to the types of firearms banned in this bill? 43 states place no restriction on ownership of any semi-automatic firearm model or type for adults who pass a background check. The strict Connecticut firearm laws are the outlier. Semi-automatic firearms are not nuclear weapons. They're a personal firearm that has been in common use since 1903. Any firearm can be used unlawfully to deprive someone of their life, limb, liberty, or property. Persons who use firearms unlawfully have no regard for firearm laws. Connecticut's restrictions on particular semi-automatic firearms reduce the ability of lawful citizens to defend themselves. The answer to reducing crime is not to restrict lawful persons, but is to lock up unlawful persons who are usually repeat offenders. When one of my constituents applied for a license to carry, she was told by a local official, "You don't need a permit, you have a state trooper living across the street." But police can't protect you unless you have a semi-automatic armed state trooper assigned to protect you 24/7, like the governor probably does. Being a victim of a violent crime, civil unrest, civil war, or even a foreign invasion are possible. You know that's true if you pay attention to history and to the news. The types of semi-automatic firearms banned in SB 16 and existing law in this state, when in the hands of a trained person, can save that person, their family, and other innocent persons. The police and military are incapable of protecting every citizen all the time. Self-defense is a natural right, protected by the U.S. and state constitutions. This bill is a clear infringement of that right. Please stop SB 16. Thank you for listening.
Senator Kissel with a question.
Thank you very much, Mr. Chair. Well, it's been over about 12 and a half hours. I just wanted to say thank you to Representative Anderson. I haven't seen a lot of my constituents coming to testify today. It's a pleasure seeing someone from the 7th Senatorial District. He does an awesome job in Granby and North Central Connecticut. I just want to thank him for hanging in there during our public hearing, where I've just recently learned that we're almost halfway through. So thank you, Representative, and thank you, Mr. Chair.
Thank you, Senator.
Thank you. I'm afraid, Senator Kissel, we are not even halfway there. So on our list. Next up is Gus Marks Hamilton.
Thank you, and good evening, Representative Staffstrom and Senator Winfield, as well as the ranking member, Senator Kissel, and Representative Fishbein, and distinguished members of this committee. My name is Gus Marks Hamilton, and I work with the Smart Justice Campaign at the ACLU of Connecticut. We have submitted written testimony in opposition to Senate Bill 16, SB 316, SB 365, and House Bill 5418. I would like to take this time, though, to express our support for Senate Bill 387, an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee. As an organization that has been committed to ending mass incarceration and reducing harm to justice-impacted people, the ACLU of Connecticut believes that children need services and resources that will support them, their families, their communities, and wherever else possible, rather than criminalizing them. As we have heard throughout today's hearing, young people face unique challenges when they become involved in the criminal legal system, and the criminal legal system faces unique challenges when it comes to how it treats young people. Young people under the age of 18 involved in the criminal legal system are extremely vulnerable to violence, to self-harm and sexual abuse, worsened mental health outcomes, significant and often permanent interruptions of education, and long-term damages to employment. Connecticut has made important improvements in reducing the number of young people who are incarcerated. However, it has concurrently worsened racial disparities. I looked at the population at the Manson Youth Institution this morning and saw that the population on March 1st was 337 people under the age of 21, 287 of whom were Black and Hispanic, which would make up approximately 85% of the total population. Smart Justice has worked to center the voices and lived experiences of people who have been directly impacted by the criminal legal system, so we strongly support Section 3 of SB 387, which will appoint 4 people, 2 of whom are under 26 years of age, to the JJPOC, where they can be additional voices for communities impacted by the juvenile justice system. We also support Section 4 and 5 of SB 387, which broadens the definition of racial profiling and increases the data the state collects by requiring data collection on pedestrian stops. We all benefit from the better tracking of information and being able to see if disparities exist, then creating data-driven solutions to preventing them. A recommendation from the JJPC that was not, but should be included in SB 387 is that supports and resources be allocated to ban the suspension and expulsion of children in preschool through grade 2, such as funding alternative in-school disciplinary practices and interventions that support students and school personnel. The JJPOC should also create recommendations to reduce to 0 all suspensions and expulsions of students in pre-kindergarten to the 2nd grade. We also support previous JJPOC recommendations that would raise the age of arrest to 12 years of age. Connecticut can and should continue to expand opportunities to provide children with services instead of criminalizing them. And therefore, we urge the committee to pass SB 387 with the additions we have mentioned. Thank you for listening to my testimony today.
Further questions or comments? If not, thanks for being with us. I inadvertently skipped Eric Cruz. Is Eric Cruz with us?
Yep, I'm right here.
Go ahead, sir.
Cool, awesome. Thank you. And this is a short version of my testimony. But Senator Winfield, Representative Staffstrom, and members of the Judiciary Committee, my name is Eric Cruz Lopez. I'm an organizational leader for Connecticut Students for a Dream, and we are members of the Community First Coalition, which is convened by the Black and Brown Student Union. Our coalition consists of 12 grassroots and youth-led organizations fighting to reimagine public safety in our communities. We recognize that our communities must be safe first, and that we must address the negative impacts that police and policemen has had on our communities. We are recommending, pursuant to Public Act 1817, that the Judiciary Committee members and co-chairs request a racial and ethnic impact statement be prepared for bills HB 5417, 5418, SB 16, SB 365, and or amendments for those bills, so that the legislators and the public know exactly who these bills will impact the most. Today, on behalf of Connecticut Students for a Dream, we are testifying in support of SB 387, and we are testifying in opposition to HB 5417, HB 5418, SB 365, and SB 16. As an organization led by undocumented people, we stand in firm opposition to any and all legislation that seeks to criminalize young people, particularly legislation that would primarily criminalize Black and brown young people in our communities. We know that legislation that seeks to criminalize young people will have a deeper impact on immigrant and undocumented youth by way of affecting their legal status and or their adjustment process. The legislation that we are in opposition to today seeks to remediate all of these issues with increased policing, incarceration, and criminalization of young people, even though research surrounding youth and incarceration tells us time and time again that this does not work. As organizers in the state of Connecticut, we understand that these issues arise out of the multiple layers of inequality that Connecticut continues to build on. A 2015 study by the Federal Reserve Bank of New York found that Fairfield County is the most unequal place in the US when it comes to income, and the Sheff versus O'Neill school desegregation case points to the continued inequality in education that students in Hartford have experienced over decades. The legislation that we are in opposition to today does not seek to address any of the issues that are at the root of the problems they claim to want to address. Thank you, committee, for your time.
Thank you. Questions or comments? Seeing none, thanks for being with us. Essam, Poirier, Roger Villa, Cheryl Greenberg.
I'm here.
Go ahead, ma'am.
Okay. Hi, my name is Cheryl Greenberg. Thank you so much for giving me the opportunity to speak. And I've also submitted written testimony. I'm a member of Progressive Women of Greater Hartford, and I support SB 387 and oppose SB 365, 386, and 392, and HB 5417 and 18. I'm a professor at Trinity College where I teach African American history, including race and incarceration, and I'm also a parent. First, I want to reiterate what the evidence you already know. Juvenile brains are underdeveloped, whether they're tossing spitballs or committing crimes. That's just basic developmental biology. They're just not thinking as adults do. So regardless of the crime, you can't treat them as adults. All this hype about rising crime rates scares us into thinking juvenile crime is at record highs and that harsher treatment of young people will resolve the problem. You already know both are false. What is true is that early interaction with a punitive legal system raises the chances a young person will end up in prison later. In fact, that's the way to create a more frequent offender. Instead, better services, counseling rather than arrest at school, social services rather than adult criminal charges, helping them remain productively in their communities increases the chances that these young people will change. That's because kids aren't evil. They're just missing something. A place to live, emotional stability, learning skills, someone to believe in them. If we don't meet that need, they are more likely to offend again. That's why every dollar that goes to mental health and juvenile and family services prevent crime. And you also know that these penalties affect children of color and poor children far more often than they affect wealthier and white children. There are many reasons for this, but the fact is such bills hurt children of color the most. My car was totaled by kids who stole a car and drove it straight into me, head on. Believe me, I understand how angry and afraid people are, but I also know that throwing teens into adult jails or handing out harsher sentences will only harden them for worse things later. The evidence is clear, and that's why the JJPOC must continue to advocate for best practices. You know all this, but I also have a personal experience with it. My daughter was 15 when she started fantasizing about committing mass murder. We didn't know that, but she was behaving strangely, and we got her into counseling. Only then did we discover her homicidal thoughts, because the therapist called us in and pressed us to take her straight to the ER. That turned into a 3-week inpatient stay at the IOL, followed by intensive outpatient programs, a group program, and then work with a therapist and psychiatrist. She finished high school in West Hartford's Strive program for young people with mental health challenges. She just graduated from college this past May, and while she still struggles to some extent with mental health, she has a wonderful future ahead of her. Without such strong support systems, she might have killed someone. If these bills were in place, she could have been in prison. Extensive community services saved her, and they can save other children. Keep troubled young people who commit crimes within the same safety net. Treat them like the kids they are, and will help them prevent far more crime than treating them, punishing them like the adults they have yet to become. Thank you.
Thank you. Question. Representative Powell.
I just want to thank you, Professor, for staying with us and for your very personal testimony and also for your objectivity. I think lots of times we hear from people who are victims of a crime or who have a personal family story, and then it makes them, generalize about the entire world. And so I think it takes a lot of objectivity and litigability to do what you've done. And I just want you to know how much I appreciate it.
Thank you so much.
Yeah, certainly. I want to second that for sure. Representative Bimbis.
Thank you, Mr. Chairman. I just wanted to take the opportunity to thank you for your testimony and certainly sharing those personal experiences. I think very fortunate that your daughter had the support system that she had at home, and certainly practicing in the legal system and being a member of the legislature for, close to well over 13 years. I do know that that doesn't exist for all of our youth. Have you had an opportunity to ever communicate or have conversations with juvenile justice detention center counselors?
Not directly, although I've worked with adult prisoners. I think the point here that I'm making, at least, is that other kids could benefit from the system that my daughter had, including supports, right, if we provided those services instead.
Absolutely. And that's why I was inquiring whether or not you had any conversations with the detention center counselors, because those are exactly the services and the resources that they're attempting to get to some of our youth that unfortunately don't have the amazing support family system that they have at home. So I would encourage you to have those conversations, because I think we all agree that we want to get to them as quickly, diagnosis-wise, resources, as humanly possible. Just unfortunately, not everyone has the dynamics at home support system. But thank you so much for sharing your story. Thank you, Mr. Chairman.
And I have spoken with DCF folks before, and my point is they are doing what they need to do, but they don't have enough resources. So thank you so much.
Thank you. I appreciate that. I've spoken to them as a leader of this committee as well as through my professional legal work. It goes way beyond resources, as well as not only the staffing, but the lack of training. And unfortunately, we can probably, discuss DCF in a different context. But what I'm trying to explain is the resources that are being provided to those youth that don't have the family amazing resources that some others do. Again, thank you for your testimony, and thank you, Mr. Chairman.
Thank you. Thaddeus Zentek is next.
Thank you, Mr. Chairman. Thaddeus Zentek, and I'm here to oppose SB 16, oppose HB 5416, and in support of SB 388, HB 5415, HB 5412. Sitting here today, is very concerning how members of this panel and other people that have spoken today have shown really no regard to the gun community, and the gun community is probably one of the most law-abiding branches, within society today. There was a 2-year study done by the National Center of Health Research showing that having a background check at the local level resulted in 27% lower rate of gun-related suicides and 22% lower rate of gun-related murders. We already have that today in Connecticut, so what more do we actually really need? In 2016, there was a study by the Bureau of Justice, and statistics examined how prison inmates obtained firearms they used during crimes. The study found that only about 10% obtained the firearms through a retail source. So this shows you that guns are not being used by law-abiding citizens to commit crimes. They are being used by criminals, and criminals in definition commit crime. Georgia just passed a concealed carry without a permit today, and we're looking at imposing one of the most strictest gun laws in the country. I've heard it already said in this panel this whole day. I've been on since 10 a.m. Connecticut is the 4th safest state. What more are we trying to achieve? You are literally putting the chains and shackles on the law-abiding citizens in this state, because you are basically saying that we are guilty before proven innocent, and that's not how things should be going in this state. So I have a new son, and he's 8 months old, and I want to shoot with him. I want to teach him about gun safety. That's the biggest proponent in every gun person's life. So, I want to teach him about that. I go to church. I want to be able to protect my son and my family in any situation possible. I would, on even in public transportation, if I took an Amtrak down to New Haven, I want to be able to, know that my family is safe because of, a crazy person that are going to do crazy things for whatever reason. And we do not know what those crazy reasons are. But, that's all I wanted to say. And I hope my voice is heard. And thank you very much, Chairman.
Thank you. Representative Jabitzky with a question.
Thank you, Mr. Chairman. And thank you, Mr. Zentek, for coming in. Congratulations on your new kid. Having a baby changes everything, doesn't it?
It sure does. Thank you very much.
Well, thanks for coming in and testifying. Very much appreciated. And just know that, I and other members of the legislature will do everything we can to make sure that you can always protect your kid and your family. Thank you.
I really appreciate that. Thank you.
Thank you, Mr. Chairman.
Next up will be Jackie Santiago Nazario.
Yes, I'm here. Thank you. Thank you, Judiciary Committee and Representative Stavstrom. My name is Jacqueline Santiago Nazario, and I'm the CEO of Compass Youth Collaborative, a nonprofit that works with the highest risk youth in the city of Hartford. We meet with youth wherever they are, on the streets, back alleys, or in the juvenile detention center. Using evidence-based curricula and cognitive behavioral skills, we provide youth with life-saving skills to help them become ready, willing, and able to succeed in education, employment, and in life. I want to tell you about one of our youth, Danny. Our peace builder, Brian Evans, met Danny in the juvenile detention center, arrested for stealing cars. While in the detention center, Danny began attending Compass's Life Skills program. Danny resisted at first, but through Peace Builder's relentless efforts, Danny realized he needed help and skills. This is why we never give up on you, ever. Brian and our Peace Builder team encouraged Danny to think about his actions. Using a cognitive behavioral approach, they provided him with the skills he needed to make those better decisions. They taught Danny to stop and think before acting. Danny began to change his thinking and act on his values, not on his emotions. After his release from the detention center, Danny continued working with Brian, attending life skills at our Peace Builder site in Hartford. Danny also Danny continued to come to life skills with Brian after he left the detention center in Hartford. It was not a straight line to success, and it wasn't easy, but today, Danny has a full-time job and is supporting himself. He has his commercial driver's license permit, and he attends CDL classes on the weekends. He takes his license test later this month. Danny went from stealing cars to studying to be a professional commercial driver. It costs $10,000 a year for a young person to go through the Compass Peace Builders program. Compare that to $62,000, the low estimate to incarcerated youth in the state of Connecticut. Our program reconnects youth to education, provides them with job readiness skills, and delivers life-saving mental health. Many of our youth we serve are disconnected from education. Our team really works to reconnect them to education, whether it's a traditional classroom, earning their GED, obtaining a license, or attending a trade school. The youth we serve are not ready for traditional job placement programs. They need basic job readiness skills, soft skills, time management, financial literacy education. And we give youth a safe place to fail, learn from their failure, and try again. And we support our youth's mental health. Our licensed clinical social workers and peace builders provide life-saving skills, helping youth navigate trauma and live more peacefully. Today, I ask you to support SB 16, specifically Section 33, to support organizations like Compass Youth Collaborative, organizations working tirelessly to reduce violence in the community through that relentless coaching and intervention and helping to restructure the developing brains of young people in our community. Thank you.
Thank you. Questions or comments from the committee? Seeing none, Thanks for being with us.
Thank you.
William Boyning. William Boyning.
Mr. Boyning, number 111, will not accept the promote panelist offer.
All right, well, let's move on. We'll try to figure that out. Addie's Castillo. Addie's Castillo. Diana Martinez.
Hi. Good evening, members of the Judiciary Committee. Thanks for giving me the chance to speak today. My name is Diana Martinez. I'm with the Middletown Racial Justice Coalition, which is a member organization of the Connecticut Black and Brown Student Union. I'm also a mother and a Middletown resident. I'm testifying today in support of SB 387 and in opposition to HB 5417, HB 5418, SB 16, and SB 365. We offer our support of Section 5 of SB 387. Specifically, we endorse the collection and reporting of data around police interventions in traffic and pedestrian stops. However, we urge the committee to strengthen the language so that police interventions in schools are also collected and reported on in the same exact way. We know that there are thousands of police-led interventions in schools each year that go uncatalogued. Regarding HB 5417, HB 5418, SB 16, and SB 365, we are recommending that pursuant to Public Act 18-78, that the Judiciary Committee members and co-chairs request a racial and ethnic impact statement to be prepared for these bills so that both legislators and the public know who these bills will impact the most. The majority of youth transferred to adult judiciary processes are Black, and the only facility housing youth charged as adults is currently under federal investigation for civil rights violations. For those reasons alone, a racial impact statement should be requested and reviewed before these bills are considered. We all want safe communities. In order for that to happen, our families need to feel secure. Real security for children cannot come, and studies show has not come, by way of police surveillance or incarceration. Real security comes from waking up in a home without the fear of being evicted, in a home with a fridge full of food your parents can afford. Real security comes from attending schools that are culturally responsive and equitably funded, where children are allowed to be children, where their development is understood and nurtured, and where conflict is treated with the goals of restoration and mutual respect and not punishment. Real security looks like financial stability, steady employment, affordable healthcare, especially mental health care, affordable and accessible recreation, and investment in the social services and infrastructures that ensure communities can properly support healthy child development. It's our belief the measures in these bills are weaponizing the biased racist lie of super predator children of color stealing property or hurting people in order to stoke fear. It's our belief this is a knee-jerk reaction not based on data, made to make residents feel as if you're doing something to make them feel safer, when in fact what's actually happening is a reversal of hard-fought juvenile justice reforms, and you're putting children of color at even higher risk of system involvement and harm. We ask that you do all you can to keep children out of prison and focus your legislative energies on supporting their actual needs. Thank you.
Thank you. Questions or comments? If not, thanks for being with us. I think we have William Boyning who's joined. Mr. Boyning there. Okay. Let's try Joseph Daudelin. Joseph Daudelin. Gerald Berletta. Michael, and oh, there's Mr. Boyning. Mr. Boyning, you with us? You're on mute, sir.
Mute.
There you go.
There we go.
Go
Can
for
you
it.
hear me?
Yep, go for it.
I'm William Boning, and I live in Lyme, Connecticut. It's nice to talk to all the members of the Judiciary Committee. I oppose SB 16. I find almost everything about this bill is offensive. Governor Lamont is clearly out of touch. The majority of firearms-related crimes in the state are committed by repeat criminals and not by law-abiding citizens. The majority of guns are used by citizens who belong to gun clubs and people who do competitive shooting. To put micro-stamping on ammunition, it would raise the price of ammunition, which is already high. Legal gun owners and gun stores should not be treated with executive orders that restrict gun sales in obtaining and renewing gun permits. Does the governor know that in 2020 and 2021 set records for new legal permit gun holders in Connecticut? Yes, these new law-abiding citizens of all ages, genders, races, sexual orientation, and political affiliations reject SB 16. I oppose Bill HB 5416, an act of prohibiting bulk purchase of firearms, pistols, and revolvers, to limit a law-abiding citizen to every 30 days from purchasing a firearm. This would not affect the acquisition of illegally trafficked firearms. I support HB 5412 to be able to retreat to a religious house of worship. I support HB 5415, the transferring of assault weapons and large capacity magazines. I also support SB 388, the defense of a person's dwelling place of work or a motor vehicle. Thank you very much for listening. It's been a long night.
Thank you, sir. Questions or comments? If not, thanks for being with us.
Thank you.
All right, I think we had Joseph Daudelin, Gerald Burlett. Somebody? No. Gerald Burletta, Michael Enders, Susan Schiefelin.
That's me.
All right, I don't think I got that name right at all, so I apologize for that.
Not the worst I've ever heard.
Well, you should hear how people pronounce Dashton. So go ahead, ma'am. I apologize about that.
No, don't worry. Good evening, senators, chairman, and members of the Judiciary Committee. Thank you for allowing me the opportunity to speak tonight. My name is Susan Scheffler. I'm from Greenwich, Connecticut. I strongly oppose SB 16. Connecticut is already one of the most restrictive and regulated states for gun ownership. Additional restrictions unnecessarily burden law-abiding citizens, and it simply defies common sense and will not effectively address rising crime in Connecticut. According to CCDL, roughly 70% of gun offenses in Connecticut are not prosecuted to the fullest extent of the law, with the overwhelming majority committed by people who cannot legally possess a firearm in the first place. Quite simply, legally owned gun owners are not the cause of crime. This bill is unreasonably punitive to law-abiding citizens while creating measures that lead to discrimination that are nearly impossible to enforce on criminals. The National Shooting Sports Foundation found that in the first quarter of 2020, 40% of gun buyers were first-time buyers and 40% of the new buyers were female. I believe these numbers are a direct reflection of the unwillingness of the state and local prosecutors to follow the law and fully prosecute criminals. This leaves law-abiding citizens, particularly minorities, unsafe and finding it necessary to be prepared to have to defend themselves. Please do not try to restrict my right to bear arms and limit my ability to defend myself and my family. This bill is not reflective of the growing positive public sentiment towards firearms in the state and has nothing to do with stopping juvenile crime or keeping criminals behind bars. Please stop targeting the law-abiding citizens' constitutional right to bear arms, start enforcing the laws we already have, and focus on the real root causes of crime in the first place. I oppose SB 16, HB 5416, and I support bills SB 388, HB 5415, and HB 5412. And thank you for your time. I know it's been a very, very long day for all of us.
I think there's a quick question for you from Representative O'Day.
Thank you very much, Mr. Chair. Just real quick, I want to thank you, Susan, for your testimony, and just want to let everybody know we're now past the halfway mark, and it's not my fault. Last year, I still owe everybody pizza from the marijuana debate, but this time it's not my fault. But I want to thank you, Ms. Schiflin. I know it's very important testimony. I don't mean make light of it, but it's very late and I'm trying to keep everybody awake. So thank you, ma'am. And
Humor's good. Humor's good.
I will stipulate that we are not blaming you, Representative O'Day. All right. Let's try to move on and see how many we can get through here. Diane Malcioni. And folks, just on this point, I know it is getting late. I know folks have waited, and we certainly want to try to get to you. If you have written testimony and you've submitted it, particularly if it's on ground we've covered today, feel free to just note that, and we will look it up. All right, Diane Malcioni, Tracy Riley. Ms. Riley, you're on mute. Still on mute, ma'am. All right, we're going to go on and we'll come back to you after we get your audio figured out. Jack Doyle.
Good evening. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Jack Doyle. I'm an Executive Assistant State's Attorney, and on behalf of the Division of Criminal Justice, I want to thank you for the opportunity to address you this evening. The Division of Criminal Justice submitted written testimony on several of the bills that are on your agenda for today, but given the time and the length of your day here, I'll just briefly comment on a few proposals that the Division of Criminal Justice supports. With respect to juveniles, the Division of Criminal Justice strongly supports the proper funding of current juvenile programs in the community and within the judicial branch, as well as the creation of the Trauma, Truancy, Mediation, and Mentorship Program. The division particularly supports the latter's focus on truancy, as study after study shows that chronic truancy is a red flag for future involvement in the criminal justice system. In conjunction with that, the division supports any study or assessment of the currently available juvenile programs, and any such study should not only focus on the effectiveness of the programs available, but also where improvements can be made, as well as identifying any gaps in programming that need to be filled. The division also supports the Juvenile Justice Policy Oversight Committee's recommendation, ensuring that certain level offenses always be diverted to youth service bureaus and juvenile review boards, rather than being handled judicially or part of the criminal justice system. The division is very supportive of a change to Connecticut General Statutes 46133D to include murder and manslaughter in the first degree, along with serious sexual offenses. The division is supportive of a creation of a separate and distinct offense for the stealing of motor vehicles from other larceny offenses. It only seems logical that a stealing of a motor vehicle for the person whose motor vehicle was stolen, that regardless of its Blue Book value, should be treated the same. On a final note, the division does not support Senate Bill 392 for the reasons laid out in our written testimony. I'd be happy to answer any questions that you may have about our written testimony or forward you additional information should you request. Thank you for your attention this evening, and thank you for your dedication for this very long day. Thank you.
Thank you, Attorney Doyle, for obviously for sticking with us and for submitting comprehensive testimony on this. I know the members have a good line of communication with your office. I'm sure they'll take you up on that offer to follow up specifically on stuff. All right. Do we have a quick question, Representative Vitsky?
Thank you, Mr. Chairman. Thank you for coming in, Mr. Doyle. What do you think about removing the requirement that police need a reasonably articulable suspicion of a crime before stopping and demanding to see a pistol permit? Do you have any opinion on that? That's in SB 16.
We are aware of that provision, I like you, I was here this morning during Commissioner Ravella's testimony. That is, the reality is, I think that's a policy decision that's going to be made by you folks, in deciding what the particular law was. But, I would note to kind of, in addition to Commissioner Ravella's testimony, it should be noted that if that was to pass, I think there's two things that prosecutors would have concern about. Whether, if there was one section of the bill, and I don't know if you're still considering changing this or adding this, but the section that indicates that a local municipality may determine whether they're going to make that requirement of their police officers or not. I think that it would be difficult to enforce that in different jurisdictions, or different cities are going to have a different requirement. But if it is, what I will note that is, if it is wiped out, one of the questions that a representative asked this morning that I took note of was what would happen if somebody refuses. Okay? And I do think that it'd be our position under Connecticut General Statutes 53A 167C, which is interfering with an officer, that you would have a situation if somebody was not to comply with that request, that they could face arrest under that particular statute. Now, I would indicate, as a prosecutor, I would agree with Commissioner Ravella's assessment, that that's going to be an individual assessment situation on that police officer, and based how that individual responds to that situation or the request for a permit. But I understand that you folks, as the Judiciary Committee, are in a contentious spot with people having different views of that particular line of legislation.
Okay. Thank you very much. Appreciate it. Thank you, Mr. Chairman.
Yep. All right. Senator Champagne.
Thank you. Thank you, Mr. Doyle, for coming in today. That statement was made by me this morning about the interfering.
Sorry. Thank you.
That's okay. Interfering with an officer for failure to provide your permit, to me, it's the same thing as violating that law. You got a legally carrying person not doing anything wrong, and somebody wants to see the paperwork. If you fail to provide it, you're going to get arrested for interfering with the officer. Do you see any problems with the Constitution on that?
Senator, I think as a former police officer, certain situations when you make requests of citizens, okay, if you have a basis to ask for it, and somebody decides not to comply with your reasonable requests or your reasonable demands, they could be subject to an arrest or even a summons or a citation for an interfering charge. Okay? So if this body was to choose to pass that is an outset or something that could occur upon that failure to show a permit. It's going to be up to you folks whether or not that becomes an actual law. And I think for as an attorney, whether you pass that and then the constitutional scrutiny is subjected to and reviewed by a court, presumably at some point, our Supreme Court, if somebody is arrested under that scenario, that is going to be who's going to decide that. We always say, it's the Supreme Court in Washington, or in this kind of a situation, our Supreme Court, that would decide whether something is going to be constitutional or not.
You're right. I don't know. To me, that's kind of one of those laws that you, as an officer, you really have to think about before taking part in. And I think it's a bad law. And I think we've heard from a lot of people today who don't like it. And hopefully, the committee's been listening. Thank you. Thank you for sticking with us today.
Thank you for having me.
Further questions or comments? If not, Attorney Doyle, thanks for being with us.
Thank you, Representative Stafford. Have a good evening.
Do we get Tracy Riley's audio figured out?
Can you hear me?
We can. Go ahead, ma'am.
Hi, good evening, distinguished members of the Judiciary Committee. My name is Tracy Riley, and I reside in North Haven, Connecticut. I'm a law-abiding citizen who is also a permit holder and pistol carrier. I'm writing to you today, talking to you today, because when I was watching the governor's press conference, where he said there are too many legal guns in Connecticut, all when he announced what his plans are to address juvenile justice. Comparing legal gun owners to juvenile crimes in the same bill is appalling. 46 pages of this 54-page bill, 88% of it calls for gun control, gun bans, gun registration, more gun-free zones, limits on how and where you can carry. In the 1994, the 2013, and 2022 Connecticut assault weapons ban all included common firearms owned by the good citizens of Connecticut. And now the claim is homicide is at a 25-year high, meaning within the last 30 years of gun control didn't address the issue of crime. Maybe that has to do with the fact that criminals do not obey our gun control laws. You must oppose SB 16 legislation. In addition, I also oppose HB 5416. I support 388. I support HB number 5415, and I support HB 5412. I thank you for your time and consideration.
Thank you, ma'am. Questions or comments? Seeing none, appreciate you being with us. Ryan Boyle.
Representative Saftrom, he has not accepted the promotion to testify, so.
Okay. Well, we'll go on and maybe we'll get him figured out. Carrie Nicewander.
Hello, I am Reverend Carrie Nicewander, speaking in support of Senate Bill 387 and in opposition to 365, 388, 392, and 386, as well as in opposition to 5418 and 5417. I serve as Senior Minister of Emmanuel Congregational Church in Hartford, and I'm a resident of the town of Newington. I have two boys, ages 14 and 16. In addition, our church youth group has 20 teenagers who live in West Hartford, Hartford, Middletown, Newington, Rocky Hill, and other surrounding towns. At our church and in my life, we care a lot about young people. My oldest son is white and my youngest son is black. Well, my youngest son, when he was a small child, I didn't worry about his safety. But now, as the mother of a black teenager living in Newington, I'm worried because the rhetoric about the rise in crime puts his life in danger. I'm all too aware of the ways that neighborhood watches and tip lines have led to the deaths of other young black men. The legislation that seeks to get tougher on youth crime only puts children like my beautiful son at risk, and it will not actually get to the root causes of the crime that is actually happening. My youngest, Johnny, plays piano and guitar and flute. He's always ready to help put away groceries and still snuggles with me on the couch when we watch Amazing Race. He's an incredible kid. I am afraid when he is out for a run in his own neighborhood that people will assume he is a car thief and not this beautiful, kind, artistic, amazing child. He is a black teenager, and that is what they will see. The legislation that allows for people to use force if they suspect their property is being stolen directly puts my beautiful boy's life at risk. It is racist, but more than that, it is murderous. And as a mother, I want to say shame on you to anyone who promotes this and supports this. My son is beautiful, and he is a runner, and he has every right to run in our suburban neighborhood without having his life put in danger with racist policies. Finally, my kids had access to mental health services during the pandemic when they were struggling with depression, which was a normal response for teenagers in that stressful time. They could talk it through with his therapist and find healing. What we need to do is care for the needs of all teenagers and invest in mental health services, housing, good education, after-school programs, and nutrition programs that make an actual difference. When we invest in these things, we will truly create a safer Connecticut. Don't waste money on things that don't work. GPS tracking systems are shown to be ineffective. Putting kids in prison does not rehabilitate them. Trying 14-year-olds as adults does not lead to their healing. It only makes it more likely they will recidivate. Instead, give them access to the services that they need and make our state more safe for everyone, including my beloved son. Thank you for your time.
Thank you, ma'am. Representative Dubitsky.
Thank you, Mr. Chairman, and thank you, Reverend, for coming in. You said that one of these bills allows people to use force when they think their property is being stolen. What bill is that?
I'm talking about 388, the Stand Your Ground bill.
388 applies when somebody believes their life is being threatened, isn't with regard to protecting property. Do you read it differently? Is there something in here that you think says that somebody can use force to protect property?
So if somebody sees my son running down the street, if they see him pulling out a cell phone, they are afraid for their safety. That is what happened with Trayvon Martin. That's what happens with neighborhood watches. That's what happened. I mean, yeah, there's so many examples. So it is an actual threat to the safety of my child.
Okay, but I understand you think that this bill is a threat to your child, but it does not allow for the use of deadly force to protect property. That's not what this bill is about. Is there some line you could point me to that says that it is?
I think it's related to the increasing fear around car thefts, which then increases the fear around carjacking, which then increases people's fear around their safety. So it's all intertwined. And so even if it is just saying the threat to their lives, people can interpret it as a threat to their lives. My son's running up towards their car. It's just true.
But people should be allowed to protect themselves if there's a threat to their life, shouldn't they?
This legislation goes way too far in terms of making it acceptable to use deadly force in situations like that.
All right. Thank you very much. Thank you, Mr. Chairman.
Thank you. Next up will be Sarah Raskin.
Hi, yes, thank you. Senator Winfield, Representative Staffstrom, Ranking Members Kissel and Fishbein, and distinguished members of the Judiciary Committee. My name is Sarah Raskin. I'm from West Hartford. I'm a member of the Board of Directors of Connecticut Against Gun Violence and a professor of psychology and neuroscience at Trinity College. I'm testifying in support of the provision in SB 16 that directs the Office of Injury Prevention within the Department of Public Health to create a gun violence intervention and prevention program. My support for this comes from two perspectives. The first is as someone who has had the honor to know many of the people in the city of Hartford who work tirelessly, day and night, to provide programs to prevent gun violence and provide support to gun violence survivors. And I serve on the Connecticut Hospital Violence Intervention Program Collaborative. I have seen why it is so important to have an advisory arm made up of stakeholders involved in community gun violence prevention that have been living, working, and thinking about the problem of community gun violence for decades. I've seen the good these evidence-based groups can do, and the research bears it out. My other perspective is as a neuroscientist. My research is in the area of experience-based brain plasticity. What I mean by that is the effect of what you do all day and what you're exposed to in your environment on your brain. And by that, I really mean your brain, the way the cells in your brain communicate and the tasks that each part of your brain can focus on are affected by what happens to you in your environment. I use this to create treatment programs to help people with brain injury, but it can have negative effects like a neurotoxin. Children exposed to violence, fear, and stress develop measurable changes in their brains. These changes set them up to have an impaired immune system, poor ability to focus and pay attention, poor academic achievement, higher rates of mental illness, and lower impulse control. And the children most likely to be living with this kind of chronic stress are Black and brown children who are already dealing with the effects of racial trauma. If we want to tackle racial injustice, it must include programs to reduce community gun violence. And that's why I'm pleased that the governor is directing DPH to establish a gun violence prevention program and using funds from the American Rescue Plan. But I would argue strongly that there needs to be a dedicated staff in DPH whose focus is on community gun violence and that there be permanent funding. Both these measures are proposed in HB 5397. Thank you so much for your time and for staying up so late with us.
Thank you, ma'am. Seeing no questions, appreciate being with us. Okay, I think next up is Juan Forseca Tapia.
It's Juan Forseca Tapia, sir.
Sorry about that.
What the fuck?
Hello, sir. Winfield, Representative Statram, and members of the Judiciary Committee. My name is Juan Forseca Tapia, and I am a community organizer at the Center for Leadership and Justice, home of the Greater Hartford Interfaith Action Alliance. I am speaking in support of SB 387, SB 392, and in strong opposition of SB 16, SB 365, SB 386, SB 388, HB 5417, HB 5418. The Center for Leadership and Justice and GIA opposes bills rooted in white supremacy, permeated with racist systems designed to harm and dehumanize people of color. GIA is comprised of 50 institutions and representing over 20,000 individuals. And we are tired of politicians continuing to ignore the requests from our communities to invest in services that make us feel secure. We are tired of solutions that are deficit-based and designed to maintain, protect, expand prisons that punish and further disenfranchise Black and brown youth. Over the past 2 years, Facebook groups, newspapers, and meetings in white suburban towns have all been used to push the fear and lies by focusing on upticks in car thefts and tone crime narratives about urban youth infiltrating these white suburban neighborhoods. This disingenuous rhetoric is based on the same pattern that birthed the war on drugs and destroyed an entire generation of Black and brown men and their families and communities along with them. The bills we are opposing are short-sighted and have been drafted by political agendas under a public safety banner. We cannot allow racist groups of people and politicians to continue equating incarceration, punishment, and policing as public safety. This psychological manipulation makes it more and more difficult for people to realize that unsafe communities exist because of the absence of the resources and systems that make us secure, such as housing, food, and physical and mental health. While politicians like Representative Fishbein push fear-based, racist, and misleading dog whistle campaigns, students and educators continue to face mental and mental health crises. While Republicans caucuses hold tone crimes press conferences, the Connecticut Free Housing Center reported that since 2019, 1,148 victim evictions were filed. 292 families were thrown out into the streets. These actions show that lawmakers continue to conflate Blackness with criminality and claim that the way to achieve public safety is by disposing of Black and brown and poor white children and locking them away in jails and prisons. When we meet people like Representative Fishbein, we need to ask ourselves,
I gotta stop you. Okay, the first time I probably should have cut you off. I was a little slow on the draw. I understand. I hear the passion in your voice. I understand the position you're trying to argue, but we are not going to resort to personal attacks, and we are certainly not going to call or impugn the motives of the vice chair, of the ranking member of this committee. Okay, so I will refrain. I will take a deep breath. Last 30 seconds of your testimony, but you're going too far.
I understand, sir. I will just share data from the Connecticut Justice Alliance. In 2019, 43% of youth admitted to detentions in Connecticut were Black, 40% of them were Hispanic, and 6% of them were white. Yet, both of them only make up 13% of the population, the youth population in the state. It seems like that.
Okay, thank you, sir. Questions from
can I just conclude with my testimony? Representative Stratton?
There's a bunch of questions for you, so I'd like to get to those, and I think we can hopefully we can move through this quickly.
Okay.
It is getting late, and I know emotions are getting raw, so I want to keep
I would
on track. Right?
And I totally understand that. I have been here since 10 a.m.
I understand, sir. All right, so Representative Fishbein, you have the floor, sir.
Thank you, Mr. Chairman. Sir, I'm just trying to figure out what is your acumen and the basis for your accusations of racism? What do you do, sir? Who do you work for?
I am a community organizer.
Okay, so what is that? I mean, have you been arrested? You've been through the system. You represent people in the system. What's the basis of your accusation, sir?
I work with youth. I major in sociology. I know the history of our country that is not necessarily taught in our schools.
Have you ever stepped foot, sir, in a juvenile court in this state?
I have sat in a courtroom, yes.
No, sir.
Now,
juvenile
no,
court.
I have not. No, I have not.
Okay. And have you, not to pry, but you've made a lot of very defamatory statements here tonight. Have you been through the system? Have you been arrested as a juvenile and you have experience with the system?
No, Representative Fishbein, I have not been arrested. I have not been through the system. I have talked to and worked with many youth that have. The statements that I had made in my testimony were, if I can just finish to respond your answer, were based on the meetings that I attended that you held, and based on how some of that data that was being presented was misleading and accurate. That is
okay. Sir,
all right. Representative Fishbein, I tried to correct the record on this. I just want us to be cognizant. It is 11:30 at night. We've been going for almost 14 hours. There are still folks who would like to testify. I would like to try to get to them. You have a right to respond to him, but let's try to keep this and bring this back towards the language of the bill if we can, and not to community meetings or something that happened outside of the purview of this committee.
Agreed, Mr. Chairman. I just, unfortunately, this gentleman has been permitted to impugn the integrity.
He has not been permitted.
He called politicians that have submitted these bills racists. So that was what this gentleman said, and I'm just trying to figure out where that comes from, because that is a very troubling accusation that this gentleman, he's nodding his head, he testified to. So, I mean, is he just a kid who's, or is he actually has facts that show that individuals that have submitted these bills are racist?
Representative Satram, can I respond to that?
Briefly.
Sir, I said racist agendas. The same racist agendas that I heard our past president used to refer to Mexicans. I am a Mexican immigrant, and that rhetoric has been recycled throughout, again, political agendas. That is what I mentioned in my testimony.
And sir, you mentioned that you work with children. I'm just trying to figure out where this all comes from. In what capacity?
That is correct. I am the former director for the Quest Queer Union Empowerment Support Team, which is an organization based out of Waterbury, and we work with LGBTQIA youth in Waterbury, many of them who came in contact with the system.
Okay, so not exclusively in the system, just individuals that identify with that certain group. So I understand where you're coming from. So thank you, and thank you, Mr. Chairman, for the opportunity.
Representative O'Day.
Thank you, Mr. Chair. Sir, it seems you may have backed off a little bit. I have to say I was very taken aback and upset at your comment that you seemed to infer that a member of this committee was racist. And that was very upsetting to me because I don't know a single racist on this committee. And I will defend anybody on this committee, Republican or Democrat, white, black, or brown. There is nobody on this committee that's a racist. And I take extreme offense to that inference. And I took it as I thought you said it. So if you're backing that off and saying that you simply are saying that it was what you interpreted to be a racist legislation, that's different. Is that what you're saying?
Sir, I said racist groups of people, which we know that exist, and racist political agendas, which we also know that exist. Many of the laws that have been created, again, are rooted in racism to uphold white supremacy. We can look at the Jim Crow, we can look at the war on drugs, which I stated, and I have added several different resources in my written testimony, which I'm more than happy to share with you.
You're not answering my question. Just to be clear, you mentioned a member of this committee. Are you claiming that a member of this committee is racist?
That is not what I'm claiming, sir.
Okay, so and that's what I appreciate that. You're claiming that you interpret some legislation that's being proposed as potentially racist. That's what you're saying.
Dropped it, correct.
Okay, then I you can have your opinion, and I respect it. I appreciate you've been here all day, but I'm here. I'm going to defend any member of this committee from any allegations from any side, right or left. This committee is a very good committee, and I wanted to make sure I cleared that up. Thank you very much, Mr. Chair.
And I appreciate that, sir. Again, that I am not making allegations. I am simply referring to history and our past. And
Understood.
That's what I'm grounding my statements on.
Understood. Thank you very much, Mr. Chair.
Yeah, thank you.
Representative Members.
Thank you, Mr. Chairman.
Representative, you're on mute.
Thank you. I hope you take this as a learning experience, because if there's something that we have done on this committee and this public hearing process is to be respectful to the people who come before us. The respect is certainly earned, and no member of this committee or any committee should ever be disrespected. And I think my colleagues were a little too kind. I did hear your exact words, and I can appreciate opinions. I can appreciate interpretations of history. But when you talk about Republicans as a group, if we look at history, I can name many occasions where I would argue the opposite. As a Portuguese American, married to a Mexican American with Latinas, I can assure you that the individuals on this committee are well-intended and there is no racist agendas. So to come onto this committee in a public hearing setting and name names is not acceptable at any time and should have been cut off early on, but it did continue, and I think in the hopes that we thought you might catch yourself as it's being inappropriate. So again, I do hope you take this as a learning experience, and also as an attorney who practices with youth in the greater Waterbury area and directly works with youth in many other situations and occasions. I caution you from continuing to make mischaracterizations of either individuals or groups and look at their characters and individually and their merits. So again, I hope this is a learning experience. Thank you, Mr. Chairman, for the opportunity.
Thank you, and thank you both. We're going to move on. We're going to move on.
Representative Stratton, if I can just
We're going
conclude.
to move on to the next person.
Thank you so much, sir, for allowing me to speak tonight.
Absolutely. All right. I inadvertently skipped Charles Allen, so we're going to go back to Mr. Allen.
Mr. Chairman, thank you for hearing.
Sir, you're.
Thank you to the rest of the Judiciary Committee.
So you're cutting in and out on us. Your internet's a little unstable there.
Is that any better?
Give it a shot. Let's see what happens.
Thank you for allowing me to speak tonight. I'll make this brief. Senate Bill 16, bad idea. We're opposed to House Bill 5416, and we're for House Bill 5415. I think the number that everybody's missing tonight is the number of gun sales in Connecticut. We're at a historic high. I think this goes to both the pandemic and the feeling of insecurity of the residents of Connecticut. I would like to compliment you. You're the first group that's been able to bring Black Lives Matter students and gun owners together on an issue. That making gun owners the villains of these bills is a bad idea. That giving law enforcement protection for stops that don't rise to the level of reasonable suspicion is a bad idea.
Sir, you know what? You're cutting out on us again.
I've served 3 years in the military.
All right, sir. I think unfortunately we're losing you. I think we got the gist of your testimony, though. So I appreciate you being with us today.
Thank you.
All right. Next, we will move on to Erica Nowakowski.
Good evening, Erica Nowakowski. Thank you. Can you hear me?
We can. Yes.
Okay, thank you. My name is Erica Nowakowski. I reside in Farmington, and I am the Associate Director of the Cal Youth Justice Institute at the University of New Haven. I am here today to oppose Race Bill 5418 and support Race Bill 387. First, I'll start with I have worked with the Juvenile Justice Policy Oversight Committee for the past 5 years and have been and continue to be impressed by the commitment of its members in creating reform for our juvenile justice system that has repeatedly improved public safety by implementing policies that hold youth accountable while at the same time understanding brain development and how trauma affects youth behavior. This bill calls for youth to be more easily transferred to the adult system. Studies by the U.S. Department of Justice, the Department of Health and Human Services Task Force on Community Prevention Services, the National Juvenile Defender Center, and the Justice Policy Institute, to name a few, have all found that transferring youth to the adult system is not effective in preventing or reducing violence. This bill will undo successful reform that has been proven through research and confirmed by national experts to be the most effective strategy in reducing juvenile crime and creating public safety. This bill also calls for the establishment of a committee to evaluate the criminal justice system for juveniles and adults. The Juvenile Justice Policy and Oversight Committee is the entity that has been effective in producing legislative reform and have made our state safer and more rehabilitative. Our state has already been evaluated by the Council of State Governments, headed by a bipartisan committee, and has provided its recommendations just last year that are being carried out by the JJPOC. These recommendations are based on research and best practices that focus on improving public safety and implementing interventions and strategies that are effective across the full juvenile justice system from the front end to the deep end. I would also like to express my support for Race Bill 387 and an act concerning the recommendations of the Juvenile Justice Policy and Oversight Committee. This bill includes legislation to fully implement a community-based diversion system that already exists in state and has been codified by this committee. This supports the bipartisan agreement that providing resources to communities is the best interest of youth and their families. It also ensures that efforts be coordinated between juvenile justice, behavioral health, education, and prevention services to ensure the long-term and sustainable development of child serving system. The 387 also focuses on increasing the membership of the JJPOC to include the voice of individuals with first and second-hand justice experience. One of the best ways to understand the impact in community dynamics is to authentically engage youth and families who have lived experiences in these situations. As Rev Porter, an active member of the JJPOC, has said many times, those closest to the problems are closest to the solutions. This bill will ensure that their voices are heard. Thank you.
Thank you, ma'am. Questions or comments from the committee? If not, thanks for being with us. Next up is Derek Reeves.
Good, very late evening. Thank you very much. Okay, 2013, I spoke at the first public hearing response to what is now SB 1160. During that time, I came to the revelation that no matter what, I was not going to change anyone's mind. As a matter of fact, one of the committee members took the time to update her Facebook page while people were testifying. After 2013 and the passage of SB 1160, the general consensus among owners of firearms was never again. Yet here we are at the gates of yet another ban and a double registration scheme neatly packaged with the recycled talking point of gun safety laws. I'm going to make this very clear. There is no difference whatsoever between being killed by any specific firearm, dying in a bomb blast at a federal building, being crushed in a collapsing high-rise tower, being stabbed to death for turning down a prom date. But it seems the only implement that garners any attention that sends you to the White House to introduce the president is clearly a firearm and a very specific one. Lamont has told you clearly as to his intentions in his press conference leading up to his governor's bill number 16. He stated, quote, "There are too many damn guns in the state, too many legal guns and too many illegal guns, and more guns on the street and in the home lead to an increase in gun violence." He just said the quiet part out loud. He has let you know that there's no discernment in his mind between firearms purchased legally or trafficked illegally. But after you've taken an approved training course, paid all the required fees, submitted to a background check, waited several months, the state allows you to exercise that right and then tells you in what manner you may do it. I can't blame Lamont for his stance against the Constitution, as he has his 24/7 security at our expense, just as you can't blame a snake for biting you. That's what snakes do. This is a really bad attitude, as real rules for thee, not for me. They tell you, let's wear a mask when you gather in a group. But if you're celebrating a 60th birthday party in the Hamptons with 400 people, you don't need a mask because the virus won't be an issue, because science. I'm appealing to all constitutionalists and gun owners in this state, whether you have a 50 BMG or a 22 Cricket. I can't fathom why you won't stand together and say enough is enough. You can't rely on this doesn't affect me because I don't own a so-called assault weapon. And because you were ill-informed, House Bill 5416 is now in play and it affects every gun owner directly. When the state tried to put into tolls, the response from the public was so overwhelming, the legislature could not dismiss it. They could summarily dismiss us because we won't stand together. What will it take? Yearly gun fees, forced firearm insurance, outright ban on semi-automatics? Every restriction on the Second Amendment is a restriction on all of us, and to dismiss it as it doesn't affect me is a naive and eventually a destructive attitude, because they will get to you. It will take time, but they will create legislation that will directly affect you. And all the while, they'll be parading the same idioms in deciding how you, we the people, can exercise a right under the guise of public safety. Either we unite on this issue or we accept the consequences of inaction. With all the freedoms that this country was founded on, framed within the longest living governing document in the history of this planet, which clearly states that I have a right.
Thank you, sir. We're at the 3 minutes. I think I have a quick question for you from Representative Dubinsky.
Right, sure.
Thank you, Mr. Chairman, and thank you, Mr. Reeves, for coming in. To your point about people standing together, I think that if you've seen the variety of people from all different backgrounds who have testified against the governor's gun control bill today, I hopefully that'll give you some solace that although it isn't there yet, there's certainly a lot of people working towards trying to make sure everybody from whatever background is cognizant of their Second Amendment rights. And I appreciate your coming out and you're trying to bring together all the peoples of Connecticut opposing the restrictions on their constitutional rights. Thank you for coming in and talking to us about it today.
Thank you.
Mr. Chairman.
Representative O'Day.
Just real quick, thank you, sir, very much. I hope you run for state rep and you don't live in Stamford, Northern Stamford, or any part of New Canaan. Thank you, sir.
Thank you very much.
We wouldn't be talking politics on a government Zoom, would we, Representative O'Day? I don't think
No.
Okay, just want to make sure we don't want anybody getting in trouble with the ethics rules here, sir.
Yeah, thank you. Sorry.
You're welcome. All right, moving on. Pastor Dorn Wright.
Good evening, Senator Winfield, Representative Staffstrom, my good neighbor, distinguished members of the Joint Committee of the Judiciary. My name is Doran Wright, and I am the Connecticut coordinator of Straight Ahead Ministries, a New England-based, faith-based provider of programming to youth in detention and under court supervision throughout New England. I'm also pastor of Neighborhood Church Blackrock here in Bridgeport, where I reside. I'm a member of the Bridgeport School District Social Emotional Learning Task Force, and a facilitator of restorative practices. I'm a longtime juvenile review board panelist, and I've also served on the diversion work group of the JJPOC. I advocate for youth in juvenile court, and I'm a liaison between families and youth with the Department of Probation. So I work for an organization that provides faith-based and strength-based programming inside our 2 juvenile facilities, as well as Regent's House at Boys and Girls Village. I've been privileged to meet almost every youth detained by this state over the course of the pandemic when COVID-19 protocols have allowed me entrance into facilities. What I consistently observe are children who've been dramatically and devastatingly impacted by a pandemic over which they've had no control. The adverse childhood experiences that they have evidenced all would rate high on the ACEs scale, if you're familiar with that, as would likely some of us, have only been exacerbated by confinement, incarceration, contact with law enforcement, and generally the court process. Regardless of the length of incarceration, they have been impacted. Life circumstances of most of our detained youth include chronic poverty, high levels of trauma they did not choose. In short, I observe most of all young people, and honestly, mostly Black and brown children, and a minuscule percentage of all youth in Connecticut that are in need of more and enhanced educational opportunity, community-based services long before an act of crime is committed. And this is why punitive measures are just not going to work. What does work are services, age and developmentally appropriate services available in our low-income communities, such as what I work with. Now, I'm just going to keep it real short because I've submitted 3 pages of testimony, which I encourage you to read. But just today, I was able to have lunch in Hartford Detention with several young people who are evidencing the most remarkable commitment to growth and development. People who are growing in self-awareness as their brains develop. We need to give them more opportunity for that through our juvenile justice system, as others have testified to. And for God's sake, and I tell these kids, I will do anything. I will lay across the train tracks so you don't go into Manson. Because just last Tuesday, as I was with a young man surrendering himself in Bridgeport Superior Court to Manson, he's in the first floor bathroom, throwing up. Why? Because his body keeps the score. He knows what awaits him in Manson because he has other friends and contacts in Manson. That is the last place you ever want to put a child.
Pastor Wright.
Thank you.
Thank you. Questions or comments from committee? If not, Pastor Wright, I just obviously want to thank you, not just for all your work in the system and trying to keep the youth of Bridgeport and really the state sort of out of the system, but obviously you and I have had the occasion to speak about some of these really nuanced issues on multiple occasions, and I know, I think we all could learn from the sheer number of hours you spend in the system studying these issues, and I want to just publicly thank you for that.
It's my privilege and honor, and honored to be with you all tonight. Thank you for the time and effort you put in working to address these issues. They're not easy to address. Thank you.
Thank you. All right, I am going to turn this over to Vice Chair Flexer.
Thank you, Mr. Chair. Good evening. Next, we will hear from Christine Sinopoli and Madam Administrator, Madam Clerk. If I missed anyone, please feel free to chime in. Welcome, Christine. The floor is yours.
Hi, my name is Christine Sinopoli. I live in Suffield, Connecticut. I want to say thank you for your attention to my testimony. I'm here to oppose SB 16, oppose HB 5416, support SB 388, support HB 5415, and support HB 5412. I also submitted written testimony. And I want to emphasize in my testimony, I did quote the federal Constitution, Second Amendment, the state Constitution, Article 1st, Section 15. And I wanted to let you know that recently in Suffield, I was appointed to the Library Commission, and I also was elected to Planning and Zoning. And the town called me down to be sworn in. And, I asked them, what exactly am I swearing to? And, the admin said, well, let me send you some information. And she did. She sent me Connecticut General Statutes, Chapter 4, Sections 1 through 25, the code that covers oaths. So I read it and I digested it. And I had sworn an oath to the Constitution, both the state and federal. So my question is, have you all read your oaths? Because the oath is what is your responsibility. This is what your job description is, to uphold the Constitution, to protect my inherent constitutional rights, including my Second Amendment rights, not to remove them. So the bottom line is, are you going to honor your oaths and uphold my Second Amendment rights? Or are you going to violate your oaths and infringe on the freedoms guaranteed to the people, including me? Thank you.
Thank you. Thank you for your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony this evening. Madam Administrator, is there another person to testify that's before number 154?
Yes, on number 140, 145, they come in a little bit late, but because we were jumping so far ahead.
Thank you. Next, we will hear from Jenny Hamilton, who will be followed by Alon Cohen. Jenny, welcome. The floor is yours.
I am opposed as a facilitator for a grown gun, and I'm opposed to it because I feel that this is an attack on women and minorities, having to get stopped. And also the possibility that cases that are listed are considered soft targets. Being a victim of domestic violence, it is very important that we're able to carry in some of these areas that are listed on SB 16.
Thank you. Have you concluded your testimony, Ms. Hamilton?
Yes.
Okay, thank you. It was a little hard to hear you, but thank you for your time and your testimony. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony this evening. Next, we will hear from Alon Cohen. And I apologize if I am mispronouncing your name.
Senator Flexer, number 151 is also here.
Okay. Okay, well, we'll call on Alon first and then Jeanette Munoz. Alon, welcome. The floor is yours.
Evening. My name is Alon Cohen. I'm a registered voter from Portland. And I want to say I oppose SB 16, oppose HB 5416, support SB 388, support HB 5415, support HB 5412. I just want to make sure I might have said this wrong, but support SB 388. My mother lives in a town not far where another elderly woman in Marlborough was kidnapped in her vehicle, beaten and robbed. Luckily, the victim survived, but this elderly woman could have been my own mother. And my own mother has survived through COVID and was able to see her first grandson with a granddaughter on the way. Please support SB 388. So criminals will have to think twice before attacking vehicles with people inside. Thank you.
Thank you. Thank you for your testimony this evening. Are there any questions or comments from members of the committee? Seeing none, thank you again for your time and your testimony this evening. Next, we will hear from Jeanette Munoz. Jeanette, welcome. The floor is yours.
Hi, glad to be here. Thank you for having me. I'm going to share my testimony, not based on stats and research, but as my own personal experience being a minority woman living with these bills that are probably...
I'm sorry to interrupt you. Do you mind identifying yourself by name? And if possible, if you could turn your camera on, that would be helpful.
Sure.
But if you can't, please continue.
There we go. My name is Jeanette Munoz, and I am from New Haven, Connecticut. And as I was stating, I would like to share my testimony based on my own personal experience. Being a minority woman living with the bills that are being proposed or opposed today, I am strongly opposed to HB 5418 because it will only make a bad situation worse. It is widely known that at least 30% of juveniles introduced to adult prison become new products of recidivism. Why? Because children are like sponges and absorb their surroundings. Children are a product of the environment. Why else? Because integration back into society now becomes difficult due to the lack of employment and housing because of the criminal records. We also know that these laws disproportionately affect minorities more. I'm led to believe that this bill is merely a means to weaponize flagrant personal opinions that have shared inappropriately leading to censoring in 2020, assumptions that continue to keep being shared. It's baffling to me that there's such an eagerness to spend $40,000 a year for an adult or $800 a day for a juvenile. But there's an issue when it comes to funding to implement school-based programs and community resources in order to deter at-risk juveniles from offending to begin with. It is also, I find it also quite hypocritical that some of the members claim to be so interested in public safety and juvenile and for I feel like they're basically saying they don't want to solve the problem. They just want to send kids to prison, go directly to jail, do not collect $200, not pass up. I don't expect a person who has grown up privileged, gone to good schools, lived in a good area, and went to work at Daddy's law firm fresh out of school to understand the plight of an at-risk urban youth. If these youths had a chance growing up, then I'm pretty sure they wouldn't have don't expect a person that has no children of their own to understand how children act and work. However, what I do expect is for someone who is paid by our tax dollars to not abuse their seats as a public servant to advance their grandiose idealisms. The only benefit.
Jeanette, your time has expired.
Thank you.
Thank you very much for your time and your testimony this evening.
Thank you very much.
Next, we will hear from Richard Souza, followed by Sean Barrett. Richard, welcome.
Does this microphone work?
The floor is yours.
Here? I never even thought about that. Can I talk in here?
Richard?
Can you hear me? I don't know if anybody's even
Okay,
watching.
I don't think that Richard is here. So if Richard is not here, then the next person who signed up to testify that I believe is here is Sean Barrett. Sean, welcome. The floor is yours.
Good evening. I'd like to thank the committee for spending these long hours. I don't often do this, but I feel it's important in this case. So here's my testimony. I was born and raised in Connecticut. I'm a veteran of the Navy and feel strongly in the Second Amendment and constitutional rights, both from the United States government as well as from the state of Connecticut. I'd ask that you consider that in your deliberations on these topics. Specific to the bills at hand, SB 388, HB 5392, HB 5412, and HB 5415. I'd ask that you support these common sense reforms that would actually probably lead to improvements of security and protections for people that have to use deadly force. Regrettably, it's an essential thing sometimes. Regarding HB 5416, I would ask that you reject this bill as an unreasonable infringement on law-abiding citizens. Commissioner Ravella earlier this morning actually made a good point that it wouldn't make a difference anyway. The criminals aren't getting their weapons in any kind of a legal capacity. In HB 5417, I'm asking that you oppose the bill without some modifications. Specific to that, making sure that you work from a presumption of innocence, being that the federal NICS database is 90% wrong in the initial denials that they may make. So I'd ask that there be some kind of a confirmation process to make sure that people that are being pursued for criminal charges or an investigation have that confirmed before that happens. Next item is SB 16, which I have a lot to say about. I'll try and cut this down. I think for me, I suffer from multiple sclerosis. I actually use pistol braces on some of my firearms, and they are an accommodative tool that allows for a person with disabilities to be able to utilize a firearm safely and effectively. And I'd ask that that be contemplated because, again, it's a pretty big restriction. There's a lot of the other type firearms in the state of Connecticut already that are being used legally by law-abiding citizens, and that really becomes another avenue of cutting off a hobby as well as protection for people that would be affected by that. Second part of that, the concealed carry in public spaces and transport. It seems to me that that is really overreaching. The purpose of having a Second Amendment is to be able to protect yourself. And in the case of the disadvantaged, and poor, as even call it a racist policy, where you're depriving the ability of citizens that are forced to take.
Mr. Barrett,
Yes.
Mr. Barrett, your time has expired.
Okay.
But thank you for your time and your testimony this evening. We appreciate it. Are there any questions or comments from members of the committee? Representative Jubitsky.
Thank you, Madam Chair. Thank you, Mr. Barrett, for coming in. You mentioned something about SB 16 that we haven't really heard already today or tonight with regard to people with disabilities that use arm braces on firearms to help them secure the firearm while firing.
Yes, sir.
Could you expound on that a little bit about how that works?
Sure. In the case of multiple sclerosis or combat veterans, et cetera, where you don't have the muscle strength or the muscle control to take and safely hold a weapon or aim it, or even in fatigue with MS, that generally is it's a neurological disease that prevents your body from being able to use its nervous system to control your muscles effectively. And a brace provides the ability to really use leverage and a cantilever to effectively use a gun. So yes, you can get lighter weight weapons, but the same as having the same ability as a person that's not suffering from a disability like that. Likewise, combat vets, people that have had amputations. There's a significant portion of people that would be adversely affected by not having that capability to participate as a full citizen, really, and enjoy their Second Amendment rights.
And how would SB 16 affect your ability to use a firearm as a person with a disability?
As it's proposed right now, registering any weapons that are currently in possession is great, but something new comes out next year, or something that's better. If you can no longer purchase current technology and adaptations and improvements that are made, you're really shut out of the market. I wouldn't say that's fair.
So is it fair to say that this bill would essentially prevent you from purchasing any new firearm that had a similar brace designed for people with disabilities?
Yes. If I don't have it today or as of whatever the sunset in the governor's proposal, yes, definitely.
Thank you very much. I appreciate your coming out and explaining that to us. As I said, you're the first person to mention that would affect people with disabilities, and thank you for bringing that to our attention. Thank you, Madam Chair.
Have a good night.
Thank you, Representative. Seeing no other questions or comments from members of the committee, thank you again for your time and your testimony this evening. Next, we will hear from Charles Bow. Charles, welcome. The floor is yours.
Okay, thank you everybody for taking me on here. I'm gonna try and keep this short because obviously it's very late and we all want to go to bed. So I respectfully ask that you vote in opposition to SB 16 and also HB 5416.
I'm sorry to interrupt. Can you just identify yourself by name, please?
Oh, I'm sorry. My name is Charles Baugh.
Thank you.
And I ask that you vote in support of SB 388, HB 5415, and HB 5412. Like everybody, I am absolutely in favor of reducing and eliminating violence, especially gun violence. But at the same time, I'm against encroaching on the rights of law-abiding citizens in order to do that. I feel some of the points in SB 16 come from the right place and, are trying to reduce violence, but at the same time, they're not going to be effective. All these gun laws, it's kind of veiled as gun control, regardless of what they say. And it's all that ends up doing is punishing legal, lawful gun owners. We need to get tough on and enforce the gun laws that we have, and we need to get tough on criminals. I have a personal case that's actually going on as we speak, and from what it looks like, the offender in this case against me is going to get let off with very little punishment, if any at all. And they used the gun in this crime against me. No shots were fired, but at the same time, a gun was used improperly, and
Can you hear me say that?
it's a very
Is it louder?
frustrating thing to see when a criminal doesn't get the full punishment that perhaps the law allows. Also, many may not know that us legal gun owners, especially in Connecticut, are to be what I would consider extra safe and extra low risk, because in order to get our very expensive permits, we're subjected to exhaustive scrutiny. We first go through training, which is required, and that's fine. Everybody should be trained. But then we have background checks, and we also get fingerprinted. So if anything ever happens, the law knows very well who we are. So once we're permitted, when we go to purchase a gun, we go under more checks, more background checks. We're run through I believe the federal system as well. And so, we pop up with law enforcement more than people may realize. And because of that, gun owners are, I don't want to say burdened, but we have an extra responsibility of, following the laws more closely, because almost anything we can do against us.
Thank you. Your time has expired. Thank you for your time and your testimony this evening. Are there any questions or comments from members of the committee? Being none, thank you again for your testimony. Next, we will hear from Christopher Patel. Welcome, Christopher. The floor is yours.
All right, perfect. Sorry, I was on mute. All righty. I'm going to go through a few of the bills and then a couple comments on the state of the Second Amendment in Connecticut, and that'll be it. So, good evening, morning, whatever it is. I'm asking the committee to oppose SB 16, oppose HB 5416, support SB 388, support HB 5415, and support HB 5412.
Can you please identify yourself by name? Thank you.
Oh, I'm sorry. My name is Chris Patel. I'm from Middletown, Connecticut. And so for years, the residents of Connecticut have had their lives put at the mercy of the state legislature by their interpretation of public safety. In the wake of Sandy Hook, Connecticut legislators took advantage of a tragedy in order to use power they did not have, ban firearms and common use of everyday citizens in the name of public safety. Then, when you think it couldn't get any worse, because we were told that was the last law, that was the one that was going to solve it. Then they allowed the removal of firearms on a whim without due process before a judge, once again in the name of public safety. If that still wasn't enough, all of a sudden trigger enhancements were then banned overnight, and everyday law-abiding citizens were made felons instantaneously. Then hobbyists building homemade firearms in an American tradition dating back before the American Revolution of 1776 was suddenly outlawed. The rationale for this was, of course, public safety. Through all of these years, our state infrastructure keeps crumbling. Our cities and now our suburbs and even our rural towns are becoming less and less safe. This was exacerbated by the legislature last year with the passing of the Police Accountability Act. In fact, it should be called the Criminal Enhancement Act. But now, after all of this inaction on actual crime, the poll numbers have finally come home to roost. And in election year, the legislature is looking to pass even more of the same unconstitutional nonsense in the name of fixing juvenile crime and public safety. Banning a pistol brace or creating a registry for specific firearms will not prevent the theft of your neighbor's catalytic converter. Residents of the state are finally waking up, though. Everyday people have had it with the corruption, the dishonesty from a lot of state legislators. Not all, but a good chunk of them, some of whom are on this committee. If these bills are passed, you can expect the full ire of the lawful citizens of the state come November. And this is for both Democrats and Republicans. Voting for bills like SB 16 and HB 5416 is a disgrace to the value of our Constitution state and a total abuse of power, and I can assure you it will be remembered in November. Thank you. I'll take any questions if anybody has them.
Thank you.
That was very good.
Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony this evening.
Thank you.
I wonder if that guy's got a
Next, we'll hear
YouTube.
from Bryant Mercado, who will be followed by Brendan Hatley. Bryant, welcome. The floor is yours.
Good evening, Madam Chairman and honorable members of the committee. My name is Bryant Mercado, and I am speaking in opposition to SB
Brooke is keeping track of the number of good and bad.
which I oppose. I will focus on just a few in my testimony today. SB 16 contains a provision that would ban the carry of firearms on any bus, train, or ferry operated by a government entity. Many Connecticut residents, especially in cities like Newton, where I reside, rely on public transportation as their only form of transportation. For these people, banning the carry of firearms in these locations would have the practical effect of banning carry nearly everywhere they need to travel. More than 1 in 10 Americans rely on public transportation daily or weekly. This bill would strip hundreds of thousands of Connecticut residents of their constitutional rights. Whether or not you as a legislator agree with the Second Amendment, this provision should be concerning to you. It should be concerning in the same way that any piece of legislation that would create or exacerbate any inequity in the ability of people to exercise any constitutional right should be. In asking you to oppose this bill, I am not simply asking you to support a right that you may or may not agree with. I am asking you to oppose the dangerous inequity that it would create. This ban would create a disparity in those who are allowed to exercise their Second Amendment rights. Only those who are wealthy enough to express their rights would be able to do so. This provision is entirely un-American. SB 16 also contains provisions that would needlessly expand Connecticut's assault weapons ban. As many other individuals have testified today, these firearms are used in an extremely small percentage of crimes. These provisions would not help prevent crime in the state of Connecticut. They would only serve to make some of the most commonly sold and owned firearms in Connecticut illegal. It would also affect historically significant firearms the ATF recognizes as while SB 16 is marketed as closing loopholes in Connecticut's assault weapons ban, it changes explicit provisions in existing laws, such as exemptions for decades-old firearms and the number of specific features allowed on firearms. These are not and never were loopholes. These provisions would have sweeping effects on legal gun owners, but no effect on crime in the state. Thank you for your time.
Thank you. Thank you for your time and your testimony this evening. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you for your time.
Next, we will hear from Brendan Hatley, who will be followed by Joseph Sperry. Welcome, Brendan. The floor is yours.
Good morning. Thank you to the members of the committee for allowing us to the public to give our testimony here throughout today. My name is Brendan Hatley. I work for Connecticut Gun Exchange, a local family-owned and operated business for more than 30 years. I am here tonight to give my testimony in opposition to SB 16 and HB 5416. However, although there are quite a few disturbing things about SB 16, I will only focus on a few, given the time constraint. First and foremost is the addition of certain firearms and features and an update to the 2013 assault weapons ban. Most of these are based on arbitrary and cosmetic features and have nothing to do with curbing crime. We have sold many of these over the past few years, and this is the first time that I've never heard of them being used in crime. and this being the first time that we've heard the legislature looking at banning them, leads me to believe that the update to this assault weapons ban, is based on emotion, malice towards law-abiding gun owners, and or out of sheer ignorance. I also have zero confidence that even with some of the hardest working government employees, that an undervalued, underfunded, and understaffed SLFU could effectively process the proposed state licenses for FFLs or the massive influx of assault weapon registrations were this bill to pass. For example, what used to take me a 20-minute process now takes 3 months for permit holders to get while their permits expired, and they cannot purchase firearms or ammunition during that period. As for HB 5416, Connecticut citizens undergo background checks when purchasing firearms, whether it be every time they purchase firearm, whether it be from an FFL like us or through private transfers. They're always running background checks and contacting SLFU. They have the make, model, serial numbers all registered to their names. It would be very dumb for them to go and try to traffic those firearms, as the laws in Connecticut already link it to them. As an FFL, I mentioned earlier, we are required to report multiple sale of handguns to an individual within 5 days of the ATF, as well as the DESPP. So the information is already there. That aside, most of the multiple purchasers of handguns are hobbyists and collectors. A small store like us can generate over $150,000 of sales tax for the state each year. Limiting gun owners to one handgun a month does not address the criminal issue at hand, punishes law-abiding gun owners, but will also lead to a massive loss of tax revenue stream for the state. This revenue could be used to fund the intervention and prevention programs discussed here today, that most of us seem to agree upon.
Nice. That was great.
Over the past 2 years, our community has grown immensely in all facets. I've sold guns to people of all races, genders, backgrounds, financial situations, and political persuasions.
Thank you. Thank you for your testimony. Your time has expired.
Okay.
But thank you for your time and your testimony this evening. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony.
Thank you.
Next, we will hear from Joseph Sperry, who will be followed by Mary
SB 16 is the one that.
Joseph, welcome. The floor is yours.
Hello, how are you? Can you hear me?
Yes, we can hear you.
Okay. Good evening, and thank you, chairs, vice chairs, ranking members, and all members of the Judiciary Committee. My name is Joseph Sperry, and I'm strongly opposed to Senate Bill 16. Mine is Section 1.
That's what we want to hear every time.
I also oppose to House Bill 5416. However, all's not bad news. I am in support of Senate Bill 388, House Bill 5415, and House Bill 5412. Being that I am number 170 on the speaker list tonight, most of my talking points have already been discussed, so I would like to be associated with all previous points for the record. If I can continue, I would like to talk more about Senate Bill 16, though. It's an act addressing gun violence and juvenile crime. It's a massive bill. It's over 50 plus pages and over 19,000 words. I was like, wow, 19,000. The word juvenile is mentioned 11 times. This bill is not about juvenile crime. Matter of fact, crime is mentioned 11 times. And violence is mentioned 13 times. However, anything dealing with weapons and firearms, pistol, 783 times. So this is clearly not a bill about juvenile crime or gun violence. This bill is just an attack and an infringement on everyone's rights. The other thing I want to mention is there's 27 committees in the General Assembly. We have children, education, environment, housing, human services, public health, and public safety. I understand that senators and reps are in more than one committee, so maybe someone can help me. In my limited research, I found that out of 27 committees right now, there's only one committee that has a bill dealing with juvenile issues. And it's this committee. It's judicial. Once it's in the hands of the Judiciary Committee, haven't we all failed? So if somebody can answer if there's any other bills out there dealing with juvenile issues, I'd like to know. And in sum up, Senate Bill 16 will do the following, I believe. It will restrict permit carrying citizens. It's racially profiling. It hinders small businesses. It overburdens an already understaffed state police. And it creates victims. It doesn't protect anyone. Thank you for your time.
Oh, this one.
Thank you for your time and your testimony this evening. Are there any questions or comments from members of the committee? Seeing none, thank you again for your testimony. Next, we will hear from Mary Forges, who will be followed by Jim Adams. Mary, welcome. The floor is yours.
Hi, can you see me and hear me? This is my first time testifying.
Yes, you can.
All right, so my name is Mary Forges. I'm a small business owner, a mother of 2 teenagers. I vote as an independent, and I oppose SB 16 as well as HB 5416. I survived a home invasion in November of 2019. I am here testifying today thanks to my ability to get to my firearm to protect not only my life, but my daughter's life. Unfortunately, my incident is not included in the statistics in which a gun saved lives. In the moments of my attack, I feared not only that my daughter would come home to my beaten and lifeless body, but that she would be the next victim. If I did not have my firearm, I would not have the means to defeat my attacker, and my daughter would not be here as the happy cheerleader that she is, growing up with her friends and living a life. We would both have been the statistics that nobody wants to see. My attacker did not have a gun. His weapon of choice was his hands. However, my gun saved my life. I am against all violence. Violent crimes are committed by those that wish to commit violent crimes, regardless of the tool used to commit such crimes. Regardless of the blatant agenda to cite guns as the root of evil, the reality is that guns save lives. My sole duty as a parent is to protect my children, not only physically, but also to protect their future. When they become adults, my hope is that they have the same means of protection that I currently have to meet my constitutional right. By continuing to restrict law-abiding citizens from their means of protection is not only disgustingly unconstitutional, but it is a direct threat to future generations. I would hope that other parents listening to my testimony today could relate to me as a parent and would recognize that this is not a political battle, yet this is a battle to protect our future generations, to have the right to protect themselves from true evil and crime, rather than setting a bar at a very low height.
This is Mary, the Connecticut Citizens
I
Defense
do believe that regardless of what
League
side
project.
everybody is on this bill, that we all have the same goal to lower the juvenile crime. I just don't believe that these bills are the solution. As a mother of teenagers and witnessing the faults within their peers at school, I recognize the pressure of raising children, and it takes the community to encourage positive behaviors. My belief is that focusing on youth programs as well as holding criminals of all ages to their full accountability is the answer we are all looking for. I encourage you to consider the fact that education is the key to what we are all trying to achieve here, rather than legislation. I do not believe that SB 16 will result in decreased juvenile crime, as the title suggests, but will result in women like me having a more difficult time lawfully acquiring and possessing the firearms in which we rely on. Okay.
Thank you. Thank you for your time and your testimony this evening. Are there any questions or comments from members of the committee? Representative Jubinski.
Thank you, Madam Chair. And thank you, Ms. Forges, for coming in. I really appreciate your ability to talk about what must have been a horrendous attack. Understanding that very often a larger male doesn't need a firearm or any type of weapon to be able to severely injure or kill somebody who's smaller and weaker. So I appreciate you being able to come in and talk about it. I understand that you also did some research with regard to some of the laws around the country, specifically with regard to the proposal that we have for one gun a month. Could you tell me a little bit about that?
I heard a testimony earlier today. Honestly, again, this is new to me with providing testimony in general. So there was a testimony earlier that had referenced Virginia, I believe it was, that it's working for them as far as like the one gun a month law that they have down there. From my understanding, after looking it up, it was actually that does not apply to legal permit holders. So I just don't think it's necessary here for Connecticut because it's not working there the way that he referenced that it is working there. I think he put the information wrong.
So that was testimony of Jeremy Stein?
Yes, Stein.
Okay, and he indicated that in Virginia they have one gun a month?
Yes.
But that doesn't apply to anybody who has a pistol permit. That's only people who have no pistol permits, no permit, right?
Correct.
So, but in Connecticut, you can't purchase a firearm without a permit, right?
Correct.
Okay,
different.
Okay, so unsurprisingly, he was providing us with either irrelevant or distorted data. So I appreciate you setting the record straight on that.
Thank you.
And thank you very much for coming in and testifying. And thank you again for agreeing to relay your story to us. Unfortunately, it's all too common.
Thank you very much.
Thank you, Representative. Senator Chigarella.
Thank you. And I just wanted to, again, repeat what Rep. Dubinsky stated. I really appreciate you taking the time to tell such a personal story. I do feel that these stories really shed some light on personal experiences that maybe we wouldn't have or hear about.
I missed her testimony. Was she pro or anti?
She's the state
director
or the assistant director for the DC project.
But do you feel if
So she's a good guy. Okay.
your firearm?
She's the one that I think Brooke's been staying up to listen to.
It's not just that I feel it, I know it. I heard her dead. And my daughter was at the movies, and when she came home, that would have been more of a chance. Like maybe she wouldn't have been that second victim if my attacker had left the home afterwards. But I wouldn't be here, and my kids would not have a mother. So yes, the outcome would have been much different.
Again, I'm sorry that you had to go through that, and I thank you for sharing that with us. Thank you again.
Thank you.
Thank you, Senator. Representative Rivera.
Thank you, Madam Chairwoman. I wanted just to take an opportunity. It's 12:30 in the morning, and the fact that you stayed with us to share that story when we really don't have statistics as to how often guns may save lives is just absolutely amazing in light of the fact that you're a parent, a business owner, and I'm sure you've got a full week ahead. But I just want to let you know that we're here, we're listening, and more than that, we're obviously taking everything that you say to heart. So thank you very much for sharing that story, and I think it's important for us to be able to maybe somehow react to these kinds of situations.
It's encouraging that so many people are talking to her. Like, I find it interesting who has questions and who doesn't.
Can save lives
for sure.
when properly used. So thank you again for staying with us and for sharing that.
It seems like they really only ask questions if they like agree with the person. Because their questions like, so what you're saying is you're right?
Telling your story.
Well, no, what they're doing is the person only has like whatever it is, 3 minutes to talk. So it's like, here's a softball. Would you like to say more about this direction or this facet? Did you see when John Lott was on?
I didn't see it. I saw that you posted about it, but I didn't watch John Lott.
I tried to run my Instagram while he was live, but then my phone died. So I don't know if it recorded or whatever Instagram does when you don't have
in some areas that's quick. And having a gun to protect yourself and protect your home is essential. So
my problem is, I'll let this guy talk and then I'll tell you.
Thank you.
I think this is the last guy usually.
Seeing no further questions or comments, thank you again for your time and your testimony this evening.
Thank you.
Next, we will hear from Jim Adams, who will be followed by Tom Maloney. Welcome, Jim. The floor is yours.
Good morning, and thank you, everyone. I can't believe I'm still saying good morning. It's been a long day. And I must say, it's been amazing listening to some of the testimony today. Mary's testimony was no exception. Again, my name is Jim Adams. I live in Bolton, and I'm a member of the Greater Hartford Interfaith Action Alliance. And thank you again.
I'm testifying in support of SB 387 and 392 and in opposition to SBs 16, 365, 386.
So this guy is for kids not going to adult jail and prison and stuff. So they are all pro. They're anti-hooliganism. They're on our side because they see it all as bad law. So it brought together ACLU, Black Lives Matter, and gun owners, plus even more people. There's only been like very few people against it.
Based on a false and politically motivated narrative.
But my problem is that they're all saying, like, oh, yeah, you know what, you're limiting my right to carry a gun or whatever. None of them are bringing up the point that when there's the potential of a firearm, criminals choose other occupations. Like, they don't even continue this path. So it's not like there's going to be gunfights in the street, but instead, when there's the potential, when it could be a gunfight in the street, then what happens is the crime goes down because criminals either go somewhere where they do have easy victims or they do something else with their time. And they can be pointing to that fact. Like, that's not hypothetical, that's like, fact or whatever.
The focus needs to be on addressing the root causes of youth crime, that is prevention, versus a punitive approach that will further harm, especially the Black, brown, and low-income youth of our state.
Well, what I'm going to do then is
I care about
put out that fire. Since I was hoping that a bunch of people would show up and we could chat, but I guess
I live in a rural town where I'm somewhat insulated from their problems, and it would be easy for me to be frightened by the ongoing disinformation campaign and to believe that these bills would make things better. They won't. And as a rural resident of Connecticut, I'm concerned that this critical issue affecting the lives of youth is based on misleading and divisive narrative. Again, I urge you to support this 392 with the recommendations submitted by the Connecticut Justice Alliance and not support the other bills. And regarding HB 5412, I wasn't originally going to talk about this one, but I'm opposed to that bill because I'm fairly certain that under current law, someone is allowed to use deadly force in counts of worship. I believe that's the way it should stay. Here's an example that someone mentioned this morning about an assailant entering a church and using an illegal firearm at one end of the church with an easy exit route. Under current law, that person is not required to retreat.
Thank you.
They could stay there.
Thank you for your.
So
I'm sorry,
again,
your time is expired.
Just one last comment. The proposed changes would mean that a person could use deadly force even if they could have saved themselves. So I oppose to 54.
Thank you very much for your time and your testimony this evening. Are there questions or comments from members of the committee? Representative Fishbein.
Yes, thank you, Madam Chair. Sir, what statute do you refer to when you say when you're opining about the law and the House of Worship?
Well, what I was looking at is the existing the bill. The bill, the way it's written that I saw online, it shows what the changes are that are going to be made. And if you read it without the changes, what it says is, notwithstanding provisions of subsection A law, a person is not justified in using deadly force on another person if he or she knows that he or she can avoid the necessity of using such force with complete safety by retreating, except that the actor shall not be required to retreat if he or she is, and today it says, is in their house or dwelling. So in other words, a person is not required to retreat today if they're at home. They're allowed to stand their ground in their home. But in any other place, if they're allowed to use deadly force unless they...
You can't hear it if I put this on, huh?
Yeah, it's like super quiet in the background. I can't understand any of the words.
You could hear me when I had it before, though, because I basically had it sitting on my monitor so you could have the mic over by the microphone.
Yeah, I could hear it good, and then you were a little quiet, but it was doable.
Okay. Oh, and try it this way. I'm going to put it where the microphone's on this side of the monitor, so it's closer. But
Well, again, since I was saying provisions subsection A of the section, the person is not justified in using designated force on another person if he or she knows that he or she can avoid with complete safety.
Oh yeah, it's pretty quiet now. I can't really even hear the dude.
oh, I can't hear him right now either. This guy's super.
Mr. Adams, no one
I hear her fine.
Can you hear her okay like this?
the question, but Representative Fitzpatrick, do you have another question?
No, I'm just trying,
Oh yeah, I can hear that.
mine on the status of the law, and I'm just trying, that's not my understanding of the law, so maybe he was attempting to educate, but I just don't see this in the statute, and I guess Adam, what do you want? Not in the statute.
Why don't you just sit down?
No, I don't have.
I'll agree with the one that said that I'm not an expert at this, but I will read through this again, but I'm believing the way it's written. It says that if a person only needs to retreat if they can do so with complete safety in any situation. And the only place right now that's an exception is in your own house. And what they want to say is that, in other words, you are not forced to leave, even if you can retreat and do so completely safely for everybody in your house, you're not required to do so. And what they want to do is add that in a house of religious worship, the same is true. That even though you can retreat and do so completely safely, it now means that in a house of worship, you don't have to do that. You can stand your ground and confront someone when you actually have an option to retreat and do so safely. And that, I think, is a bad idea. If I'm misreading today's legislation, then
Okay, just the status of the law, so I well, due respect to the reading. Otherwise, I'll see what happens.
I can't believe
the duty to retreat stuff is so stupid.
What?
The duty to retreat is so stupid. It's like, obviously, if I can get out of here safely, like, I'm going to wherever I'm at, but I shouldn't have to be required by law that after the fact you decide, well, you could have actually gone this way, but you didn't, so you're in trouble.
Representative Stepson, Senator Flexer, distinguished members of the Judiciary Committee. I'm Tom Loney from North Stonington. I urge you to oppose the following bills: Senate Bill 16, House Bill 5416. I urge you to support the following bills: Senate Bill 388, House Bill 5415, and House Bill 5412. Regarding SB 16,
I don't like it when they do this. When they have all their family pictures behind them. I don't like that business.
This bill is yet another attempt to address the very real problem of crime in Connecticut by deflecting the focus from those committing
So what are the pro 2A bills? Like,
law-abiding segment of our society, legal gun owners.
because I think I figured out the anti ones, like it's basically adding more to the like assault weapons ban. But I don't know what the pro ones are for.
And House Bill 5416 appear to be solutions in search of a problem. I've heard no examples all day of the firearm type others being used in the crime. I haven't heard any example of 22 rimfires being used in crimes. No examples have been given of legal gun owners committing crimes on public transportation, in polling places, or demonstrations. And yet here we are debating adding to Connecticut's bloated slate of gun laws once again. Representative Rabimbas just a few minutes ago mentioned that Connecticut does not have any data on defensive gun uses. I think that's probably true for Connecticut. The defensive gun use statistics are actually pretty solid nationwide. There was a study by Professor Gary Kleck in the early 90s that found between 600,000 and 3.5 million times a year Americans use guns legally in self-defense. During the Obama administration, the CDC took a look at that topic and found almost exact same numbers, verifying that. that data was sort of buried until I think it was actually John Lott that brought that data to light. And I think that is what made me sort of add that to my testimony at the last minute. These discussions always seem to focus on the hypotheticals of what could happen with these guns and why we need to ban them or restrict them. And yet so rarely do we ever hear of them being used in the defense of gun use. And yet one of the previous speakers, 2 or 3 before me, gave a very personal example of exactly that. And that happens very frequently. And I think we do the justice system a dishonor to not consider the benefits of access to firearms.
Thank you. Your time has expired.
Thank
you for your time and your testimony this evening. Are there questions or comments from members of the committee? Representative Jaguski.
Thank you, Madam Chair, and thank you, Mr. Maloney, for coming in. I'm looking at your written testimony that you submitted, and you don't mention anything about any of the studies that you just spoke of, the Gary Kleck study or the CDC study. Any chance you could supplement your written testimony to include that information? Because we don't have it, and that's the first we're hearing about those studies, I believe, since this hearing started.
Okay. When you say supplement, do you mean submit additional testimony or speak out to it at this time?
No, submit written testimony with the information, perhaps supplement
Homework, basically,
the
dude.
testimony that you've already submitted, or provide something additional that indicates the identity of the studies and what they found.
Okay. Both of those studies were quite interesting in the number of defensive gun uses.
But they're also both disputed.
Population set was examined, and in fact, it appears the CDC study was set out to disprove the original study, and actually verified it almost exactly. They came up with, I think the upper number was 3.47 million, which is pretty close to Gary Kleck's 3.5.
Oh, look who DJ came over and was talking over here now. He's scared to join in, even though he's got links all over the place.
As you probably
We're not afraid to talk on this side. It's not like the other side where they're all quiet and scared to talk about it.
That's the exception. It's only a few percent, or only a few percent where someone actually dies. It's not much larger for people actually being shot. The overwhelming number of defensive gun uses involves just the display of.
God, these guys literally just heard him say, like, "Oh, I'm adding this to my testimony last minute because, like, it just popped into my head." Because somebody said, "We don't have the numbers." Well, actually, we do. And then the other guy's like, "Oh, can you write that down for us? Because I don't want to look it up."
Thank you, Representative.
Like, I bet you a Google search of defensive use, like national study, it would pop up in the first thing.
Next, we will hear from Emily McAvoy, who will be followed by Robert Starr. Welcome, Emily. The floor is yours.
Thank you, Senator. It's good to see you this evening.
Oh, I'm sorry. I don't even have the volume all the way up. I'm a
I'm a
dumbass.
resident of Middletown and an organizer on the board of the New Britain Racial Justice Coalition. Today I'm testifying in support of Senate Bill 387, the JUD Senate Bill 365, and House Bill 5418. A lot of points have already been made today about the data and science that directly contradict the policies proposed in Bills 365 and 5418. I would echo testimony you've heard already on the development of the prefrontal cortex, the decision-making part of the human brain not happening until age 25. Inadequate resources in adult courts for youth who have unique developmental and educational needs, as well as the testimony from the Connecticut Justice Alliance about how we have no guarantee that this uptick in car theft.
Oh, you know why they're talking about 5418? Is because it's about the
how this push to further criminalize
juvenile use with a firearm.
I'm from and has been since last summer. I'm speaking to you today as an organizer, researcher, and student.
Would it make like more penalties if a juvenile uses a firearm or something?
At Woken High School in a program called SHAPE, Self-Help and Personal Exploration. This was a program that helped struggling students get on track, and take personal accountability for their actions. Most of us in the program suffered from complex trauma that impaired our daily decision making in the school building and made life a lot harder. A lot of my peers had been through the foster care system or currently were in the foster care system in this program. When I saw in summer 2021 that two of Wolcott's state legislators, as well as Wolcott's mayor, were at the Capitol advocating for further criminalization of youth, doing a press conference.
She's talking about the kids one anyway, so I'm going to mute her. So it says this 5418, person suffers a physical injury or loss, life, sexual assault, 47 serious juvenile crime offenses involving a firearm, such as parents shall be on the business. So basically, if they commit a crime with a firearm, then they get to go to jail the next day. And I forgot why they are upset about that.
To deal with their complex trauma, I was offended and saddened. The root
Well,
cause of
this lady is kind of like, well, kids are stupid, so they shouldn't be held accountable or something. I don't know.
Yeah, they're all reading boilerplate, 100%.
This is why I support measures in SB 387, like the expansion of the JJPOC to include systems impacted youth, as well as expanding the community-based diagnosis system. We've seen great successes here in Middletown, where youth once
Basically, the governor was like, oh, I got a great idea to fight crime. Why don't we make all the little kids go to jail with adults? That's a great idea. Also, all guns should be illegal. The hell? Just makes no sense.
Comments from members of the committee? Thank you again for your testimony, Emily. Thank you. Next, we will hear from Robert Starr, who will be followed by Patrick Tutek. Robert, welcome. The floor is yours.
Brooke said that they basically just everybody puts in their interest in testimony, and then they shuffle, and everybody gets a random lottery.
I'm the treasurer of the Connecticut Citizens Defense League, and I'm a lifelong resident of Torrington. I'm speaking today in opposition to SB 16. If the part of this bill that would fund the statewide firearms trafficking task force was a standalone proposal, I would support it. But there are other parts that I could never support. For instance, the part that would allow a law enforcement officer to stop a person and demand to see a permit when there is no crime or even a suspicion of a crime in progress or about to occur. Also, this bill unfairly singles out people of lesser means or even middle-class folks who are simply trying to be a little more environmentally responsible by using public transit. In addition, the bill seeks to take away the authority of municipalities to set their own policies about what is and isn't allowed in their buildings. I also oppose HB 5416. This seems to be aimed at preventing straw purchases, but those are already banned by federal law, and law-abiding Connecticut gun buyers don't need to be restricted in this way. I also want to state that I support HB 5415, an act concerning the transfer of assault weapons and large capacity magazines. Since the transfers in question would not in any way increase the number of these items located within the state of Connecticut, it seems to me that no harm comes from allowing people who have already shown that they follow the law by registering and declaring assault weapons and large capacity magazines to buy and sell these things among themselves. Thank you.
Thank you. Thank you for your testimony. And seeing no questions
Looking
or
straight
comments
up
from
looked
members of
funny.
the
I didn't
committee,
expect
thank you for
that.
your time this evening, and thank you again for your testimony. Next, we will hear from Patrick Tutek, who will be followed by Kevin Alvarez. Patrick, welcome. The floor is yours.
Good morning, legislators and fellow citizens. My name is Patrick Tutek. My family and I are Trumbull residents. And like many of you, the safety of my family and the safety of my community is paramount to me.
Ooh, maybe my first auntie.
Unfortunately, I need to completely oppose SB 16 because it doesn't do anything.
Oh, never mind. I thought maybe he was going to be an auntie the way he's like, the safety of my family. Think of the children. But he opposes, so he's good.
Looking at the rise in DUI fatalities between 2019 and 2020, if you really wanted to move the needle on public safety versus layering on superfluous regulations to legal gun owners, as many have testified, we're probably the best behaved part of the population because we value our rights and are willing to go through the different strictures in order to enjoy those rights. Everyone has already really well articulated main problems with 16, such as the inability to carry on public transportation and how that is discriminatory, as well as the Fourth Amendment violations, which just seems to be a solution in search of a problem that doesn't exist and will just cost the state needless taxpayer money to fund litigation. I also oppose HB 5416,